They're not complying the orders of the court, and now we are hauling them up, and you people don't take it seriously. You will complain madadre. Should you not go and tell them that the office objects is a complaint? Yes.
My lords, this matter was listed on 18. A date was given for today. However, the matter is not listed, my lords.
ನೋಡಿ ಚೆಕ್ ಮಾಡಿದ್ ಯಾಕೆ ಬಂದಿಲ್ಲ?
They have verified, my lord.
ಹಾ? ಆಯ್ತು ತರ್ಸಿ 2:30 ತರ್ಸಿ.
My lord, for end of the list, my lord, this day before yesterday, Saturday, my lord, in the Lok Adalat, my lord, I am a party to the suit, my lord. Some of the parties are not made party. Lok Adalatali settlement ಮಾಡ್ಕೊಂಡು compromise. Advocate he himself, my lord, entered into agreement and his final decree draw ಆಗಕ್ಕೋಸ್ಕರ ಇದಿದೆ ಸ್ವಾಮಿ urgency.
ಆಯ್ತು. Yes.
Serial number 81.
Please wait.
Yesterday's matter, my lord.
Please wait. Yes.
Urgent means,
Correct.
urgent means page wise, list number 1, page number 9, serial number 44 to 47. Page number
46 mil.
serial number
Yes,
8.
time per hearing mil.
Number
46 mil. Fresh matter. Application on date mil.
46. Non-counsel for the petitioner seeks time list after vacation.
After vacation.
Page number 10, serial number 48 to 57.
Serial number 56, my lord.
Hmm.
Kindly it may be posted, my, after vacation, my lord.
Learned counsel for the petitioner seeks time list after vacation.
Page
Much
number
obliged.
11, serial number 58 to 66.
Serial number 63, my lord, appearing for petitioner, my lord. 63. 3 matter.
Hmm.
In light after vacation.
After vacation. Learned counsel for the petitioner seeks time list after vacation.
Page number 12, serial number 67 to 74.
Serial number 67, my lords, I appear for the petitioners. Date after vacation may be fixed because today some of the
We'll
parties
not
are
fix
not
any date, madam. If you want, you can, we'll.
after
generate
vacations.
List after vacation.
Serial number 71, madam.
Eh?
Some of the parties are not in station, my lords. '67.
List after vacation.
Serial number 71, my lord, for the petitioner.
Serial number?
71, my lord,
Ah,
may be called after vacation.
list after vacation. Learned counsel for the petitioner seeks time list after
Serial
vacation.
number 8. Serial number 8, complaints.
Serial number?
8. Page number 13, serial number 75 to 77. Page number 14, serial number 78 to 81.
Serial number 80, my lord.
Ah.
Respondent. Kindly enter petition.
Suit is filed in which year, madam? ಎಷ್ಟನೇ ಇಸ್ವಿದು? Learned counsel for the respondent number 1, 4 and 5 seeks time list after vacation.
Serial number 42, my lord.
Serial number?
42.
We are not still start.
My lord is also present.
Yes, serial number?
81. Yesterday's matter, I requested for the matter to be taken up. For want of time, the matter could not be today. My request, my lord,
ಏನು urgency ಏನು?
the appointment of a court commissioner, my lord, has been ordered by the airport. That has been
What is the urgency?
that now the document has been ordered to be sent to the, for expert opinion, my lord.
Hmm.
The reason the matter may be taken up.
ಅದು urgency ಏನಿದೆ ಅಂತ ನಂಗೆ ಅರ್ಥ ಆಗ್ಲಿಲ್ಲ. What is the great urgency?
Submitted by the court commissioner, my lord.
ಹಾ.
Then, my lord, it will have the effect on.
We'll can consider it later also, isn't it?
Can it be taken up?
We can consider it later also. Report of the court commission, ಏನಕ್ಕೆ for comparison of some.
Signature comparison.
ಏನಾಗುತ್ತೆ?
95.
ಏನಾಗುತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಡಿ.
At the last stage of the case, my lord, after the evidence is considered, when the matter is heard for some time.
ಆಯ್ತು ಮಧ್ಯಾಹ್ನ ಮೂವ್ ಮಾಡಿ, ಎಸ್ ಮೆನ್ಷನ್ ಮಾಡಿ. ಮಧ್ಯಾಹ್ನ ಮೆನ್ಷನ್ ಮಾಡಿ. ಎಸ್ ನೆಕ್ಸ್ಟ್.
Page number 15, serial number, last is.
Hmm.
List number
Yes.
1 for non.
Serial number 42, my lord.
Serial number?
42. List 1.
That is for orders, please wait.
Serial number 8.
Correct.
List number 1 for non-compliance first time, serial number 1,
My lord, on
Mohan
submission.
Chandra.
Mohan Chandra, 1 week.
Yes.
Serial number 2, Shekhar LS.
Taker, 1 week.
Serial number 3, T Sheshgiri Rao.
1 week.
Serial number 4, Gadlingappa, GM.
For the petition, kindly pass over the matter, my lord.
ಏನ್
KVT ಕಾಪಿ ಸರ್ ಮಾಡಿದ್ದೀವಿ ಸರ್ ಅಷ್ಟೇ ಬೇರೆ ಏನಿಲ್ಲ ಸರ್
ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು?
ಅಲ್ಲ ಡೆಲಿವರಿ ವಾರೆಂಟ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸರ್ ಅದಕ್ಕಾಗಿ ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ರೀಸನ್ ಮೇಲೆ
ಡೆಲಿವರಿ ವಾರಂಟ್ ಇಸ್ ಚಾಲೆಂಜ್.
ಆಗಿದೆ ಸರ್
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಸರ್ ಕೊಡ್ಬೇಕು ಸರ್ ಕೊಟ್ಟು
ಕಾಪಿ ಕೊಡಿ.
ಆಯ್ತು ಸರ್ ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ರೆ
ಪಾಸ್ಪೋರ್ಟ್.
ಪ್ಲೀಸ್ ಮತ್ತೆ ಸರ್
Serial number 5.
For the
Mohan
petitioner,
Singh.
my lord. My lord, there is urgency in the matter, my lord.
ಏನ್ ಅರ್ಜೆನ್ಸಿ?
My lord, the respondents, they are proceeding with the construction, the suit for specific performance of the contract, my lord. After I issued notice for seeking specific performance of the contract, the respondents, they sold the portion of the property, major portion of the property to respondent number 3, respondent number 6, my lord. Thereafter, they started construction. I sought for the stay, interim stay of temporary injunction, my lord, from proceeding with the further construction. Court has passed an order based on the memo filed by the respondents, my lord, saying that they will hand over the constructed house if they decree the suit. My lord, already they have sold the portion. Again, if they proceed, permitted to proceed with the construction, my lord, again, the petitioner will be put to difficulty, my lord. I produced the photographs also. Just based on the memo, my lord, they even.
But injunction is not to alienate.
There are two applications, my lord. One is not to alienate. IA number 2 is for not to put up any first construction. On the IA, my lord, they said the impugned order, my lord, the order passed by the honorable lower court, my lord. You can page number 133, my lord. It says let them not alienate the property, but since they have said that they will not, they will hand over the property. They said just they have not even said they can proceed with the construction. The memo filed by the defendant, my lord, page number 125, page number P, annexure P, my lord. They say they also admit that they have sold it after I issued the notice, my lord. Initially, they executed the
Will
sale.
restrain them from alienating.
My lord,
Instead, let the construction go on.
my lord, portion of the property, the conduct of the respondent, my lord. After I issued notice, they initially executed the sale agreement to third person. Thereafter, again, I issued the notice. No, you already executed sale deed.
Mr. 2018 agreement, you filed a suit in 2024.
My lord, they admit it. The understanding between the parties, my lord, they will get the conversion of the property. Thereafter, they will execute the sale deed. That is the,
Whatever it is worth, you let us.
my lord, let them maintain status quo, my lord.
No, we can only maintain status quo insofar as alienation is concerned.
Alienation, the court has already passed, my lord. My
Yes, but
application,
Court has passed some order regarding alienation.
yes, my lord, the court has passed the order. But insofar as
That's
the IA number 2 is concerned, is not passed any order, my lord.
That is enough. For put, you want to argue further?
My lord, this is my, because if they proceed with the construction,
List after vacation. Yes.
great, my lord.
1 week time is granted to do the needful.
Please, my lord.
Serial number 6, Chandrasekhar, GM. 4 officer.
List 1 week,
Number 7.
1 week.
My lords, I'm appearing for the petitioner, my lords.
Ah.
Matter is very urgent. I complied all the office objections, my lords.
Ah.
This objection is, my lords, to furnish the documents, my lords. My lords, 3 to 6, my lords, they are the objectors, my lords. I have furnished all the applications filed by the objectors, my lords. So office is asking to produce the documents to verify.
What is the impugned order?
My lords, actually, my lords, this is an execution petition, my lords. Land has been acquired by the respondent 1 and 2, my lords, and they have deposited the amount, my lords. That is 1,27 lakhs.
Land
The
is acquired.
Land is acquired, my lords.
Ah,
In the execution petition, my lords, respondent number 3 to 6 here in, my lords, they are the objectors and they filed their objections by saying that even they are having the right over the particular property, my lords. My lords, here, my lords, actually the amount was released, my lords. This land was acquired in the year 2003, my lords. Now in the 2024, they have come up with the application, my lords, not to, my lords, disperse the amount and to recall the order. And at the IA number 12, my lords, for redepositing the amount, my lords.
Yes,
That is the impugned order, my lords.
yes,
The trial court has ordered to redeposit the entire amount, my lords.
yes.
My lords, to their extent, my lords, to their share, we are ready to deposit, my lords. Not to the entire extent, my lords, from.
What is their
2000
share according to them?
1/6 share, they are entitled for 1/6 share, my
There are
lords.
3 objectors who have each 1/6 share in the property. This petitioner has got only 11 lakhs rupees he is entitled for.
Now, how much are you entitled for?
I am entitled for 34 lakhs each one of them.
Yes, madam.
No, my lords.
Complete
My lords,
amount is not deposited by
My lords,
What
in
is the total compensation
2
determined?
crores 8 lakhs,
2
2
crores, 8
crores?
lakhs.
8 lakhs.
What is the 1/6 share?
My lords, we are
What would
ready.
be 1/6 share?
That
That's a
is
34
42
lakhs.
42,000, my lord.
No, 34
42.
lakhs,
40
2 crores?
8 lakhs. Divided by 6.
42 lakhs 65,000, my lords, 252. My lords, still 80 lakhs respondent 1 and 2, they have to deposit the amount, my lords. Even that amount is lying there only, my lords.
No, that amount is not at all still deposited by the authorities. And they have misled the honorable court. They did not disclose all the legal errors even before the district legal service authorities and in the execution petition.
My lords,
And
actually,
one
they
of
have,
the
No,
brother,
see, please wait.
please,
Now, your entitlement is 1 crore 33 lakhs.
yes, ma'am,
There's some 1 crore to 2 crore 8 lakhs, which is the amount determined.
yes, ma'am.
my lord.
What is the amount including the interest?
My lord, that interest amount is not at, including interest, that is 2 crore 8 lakh rupees as on the date of application.
She has to deposit how much?
His share is only 11 lakhs. It come.
Forget her share. What
Please.
is your share?
My share would be a 34 lakh rupees, each one of the objectors. There are 3 objectors.
Yes.
That would be about 1 crore and odd, my lord. And my lord, the
1 crore is
authorities are,
already- 1 crore is already there.
it's not there, my lord.
What happened?
The authorities have deposited 1 crore 27 lakhs rupees to the honorable court.
Yes.
That 1 crore 27 lakhs all got there released.
What about the remaining?
Remaining is not yet deposited by the authorities.
Take your share there.
Please, my lord.
My lord, it's
Take your
unsaid.
share there. Why should
No,
she
my lord,
deposit?
not only that, my lord, there are other legal errors, other 3 brothers.
Don't worry about them. You have come before the court. You take your pound of flesh.
Yes, ma'am. My lord,
Why are
lords.
you bothered about others?
no, not only that,
In
my
fact,
lord.
they have executed
way-
reluctant deed, my lords, and they've taken 1 lakh each, my lords.
Do one thing, whatever amount that she has withdrawn, let it be apportioned to her share or let her take it. Whatever amount that is yet to be deposited, you collect it.
My lord, that would not meet my amount.
I
My
think it's-
amount is 1 crore 34 lakhs rupees.
Yes.
1 crore and odd amounts.
How much is
I'll-
your-
That
in
is
My lord,
estimate?
that is suit
1
for
crore 12 lakhs
partition is
rupees.
still pending, my lords. Their share
There
has
is
to
a-
be
I
determined.
1 crore 12 lakhs rupees.
33 lakhs, 33,333
Yes,
will be each share
yes, ma'am.
into 3.
3.
One crore.
Yes, ma'am.
Crore 27 lakhs she has withdrawn.
Yes,
So
ma'am.
we can direct her to deposit how much? Another maybe 15 lakhs, 15 or 20
no,
lakhs.
27 lakhs.
No.
1 crore.
Crore 8 lakhs.
80 lakhs still pending, my lords.
2 crore 8 lakhs minus 1 crore 27 lakhs. It's about 80 and odd lakhs.
Yes, my lord. 80 lakhs is authorities yet to be deposited in the court. And
24 lakhs.
in out of 1 crore 27 lakhs,
We'll ask her to deposit another 20 lakhs,
24 lakhs. It would.
20 lakhs.
24, my lord.
Huh?
24.
24 ಹೆಂಗಾಗುತ್ತೆ?
1 crore 4 lakhs for 3 share. They have withdrawn
2
1 crore.
crores 8 lakhs.
They have withdrawn 1 crore 27 lakhs and odd.
Crores 8 lakhs is the amount which is deposited.
Please.
6 shares ಅಂದ್ರೆ 33,33,334 ಆಯ್ತು. Into 3 is 1 crore 3 rupees.
Hello.
One crore. So she has withdrawn
1 crore 27 lakhs.
1 crore 27 lakhs, my lords, 95,758.
minus 1 crore 27 lakhs 95,738. So it is how much is remaining? 72 lakhs. 72 lakhs is what is remaining.
Yes.
My lords, 2 crores 8 lakhs 63,670, my lords.
Another maybe 18 lakhs you have to deposit.
Please,
Workful.
And there's one more submission.
my lords.
If other claimants who comes objectors, other
is
legal
different.
heirs, my lord, they may not, should not claim from
We will
my
deal
share.
with it- We'll deal with it when they come before the court.
They should not claim with my share, my lord, which would be
Deal with
there
it
in
when
the
it
court.
comes.
He has only share of only 11 lakhs rupees and other claimants.
Issue emergent notice to the other respondents. Stop. Till the next date of hearing, the impugned order passed by the Senior Civil Judge Maddur in EP number 101/2022 is stated, subject to the petitioner depositing 18 lakhs before the executing court.
That's one.
So the executing court is directed not to release any amount to either the petitioner or the respondent until further orders from this court.
Please, my lords.
Highly obliged.
Time, my lords. Time,
Huh?
my lords. To deposit the amount, time, my lords.
You
8 weeks. my
Already 2 months.
already have the money, you have to only bring it and
Yes.
deposit within
My
2
lords.
weeks.
Yes,
My
they-
lords, at least 1 month, my lords.
No, sorry. Yes.
Serial number 8, Lokesh B. Para petition.
1 week time is granted to do the need.
Serial number 9, Jayant V.
Petitioner, my lord, can I just take one moment? There's
1
a
week.
slight no, there's a slight
1
urgency.
week.
There is a slight urgency, my lord.
Light can wait.
Construction is, they're trying to
Light can
put up,
wait, mister.
and they are seeking to put up construction, my lord.
Light can wait. That is what I told you. Yes, next.
Serial number 10, Sidmalappa PM.
It is very urgent, only matter, then we'll take it.
Just that they're seeking to put up construction over the property. I had
I-
the benefit of an interim order for like 11 months, my lord, which was vacated by the appellate court.
When was the order vacated?
24th of November. I filed it on the 4th of December.
You can wait for 10 days. Nothing will
If
happen.
he
Yes,
is
next.
already,
Serial
he's
number
already
10.
at a stage of finishing the construction, my lords. That's the reason.
Then let it be completed. If the construction is already completed,
It's not completed, but he is trying to do it at a fast pace. That is why we immediately filed this petition.
anyway, the superstructure is already done.
Not the, is somewhere about 50-60% done, my lord.
Yes,
That's-
let it happen. Yes, next.
Serial number 10, Sidmalappa PM.
Petitioner.
1 week.
Serial number 11, Hirapati
week.
Maheshaya. Serial number 12,
My
Rajesh
lord,
Patil.
on serial number 11, my lord. The defendant number one, who is the, I'm sorry, plaintiff, who is the respondent number 1 in this petition, my lord, trying to connect a sewage pipe to public well, my lord.
Hmm.
That is the
Sewage trying to
petitioner
connect
is, my lord, the petitioner is PDO, my lord. The
Trying to connect what to what?
sewage, or maned bachalodu toilet in his affidavit, he himself stated that, my lord, in para number 89, there is some vacant land, my lord, pertains to PDO, my lord, Department of Panchayat, my lord. The petitioner, I'm sorry, the plaintiff and respondent number 2 here in, my lord.
Oh,
Order 39 rule 112 filed by the respondent number 1 herein came to be rejected, my lord. Thereafter, in MA court, my lord, the MA court opined that, my lord, in para number 29, page number 89, if there is any encroachment of public property by the plaintiff as claimed by the defendants, it is for the defendants to initiate appropriate proceedings against plaintiff in accordance with law to take the possession. This is not a question of possession, my lord. There is a vacant land, my lord, in front of the house of the plaintiff, my lord, which is belongs to the panchayat, my lord.
so what is it you want?
My lord, in an interim order on the judgment of MA, my lord.
For
But-
what? What is your urgency? What is the urgency?
By virtue of the interim order granted by the MA court, my lord, that respondent number 1 herein trying to complete the construction and connecting the sewage pipe to public well, my lord. He himself in affidavit, my lord,
Connecting the sewage to
public well, my lord.
public?
Well, ಬಾವಿಗೆ ಸುಮ್ನೆ.
ಎಲ್ಲಿದೆ
ಹಳೆ
ಅಂಗಡಿ?
ಬಾವಿ. My lord, kindly come to the para number, page number 16. I am sorry, page number 89, MA judgment, page number 16. ಅದ್ರಲ್ಲಿ ಅವರೇ ಹೇಳ್ತಾರೆ affidavit ಅಲ್ಲಿ ಸ್ವಾಮಿ.
ಪಬ್ಲಿಕ್ ವೆಲ್ ಇದೆ ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ? Where is the public well?
My lord, kindly come to the page number 44, my lord. Para number 5. It is affidavit by the plaintiff who is respondent
Para?
number 1 here in, my lord. Para number 5, my lord.
Para 44.
Page 44, my lord. I'm sorry. Page 44, para 5, my lord.
Yes, please.
I submit that in the eastern side of the suit schedule property, there exists an open well which was neglected due to supply of water from the panchayat. Anyway, the open well and its adjacent area covers an extent of approximately 15 feet in the east-west direction and 15 feet in a north-south direction. Even though the said property comes within the schedule of the purchased area, I am not making any claim over the area covered by the open well as stated above. Now, my lord, the respondent number one herein, who is plaintiff before the trial court, my lord, trying to connect
ನೀವೆಲ್ಲಿ ಹೇಳಿದಿರಾ? He is trying to connect the sewage to the open well ಅಂತ ಎಲ್ಲಿ ಹೇಳ್ತಿದ್ದೀರಾ?
in petition ಹೇಳಿದ್ದೀನಿ sir.
ಎಲ್ಲಿ ಹೇಳಿದ್ರು?
My lord, in the synopsis, my lord, third paragraph. The petitioner also filed his written statement denying the plaintiff affirmance and specifically pleaded that the plaintiff is owner of the property measuring 24-30 feet and the petitioner has sanctioned the constructing license for the same, but the plaintiff has encroached the public and its surrounding vacant place situated to east of the property and projected 6 by 35 feet covering the public well and its surrounding vacant place. Apart from this, the plaintiff has set up a sump lavatory pit and plaintiff has set all to drain the sewage water in the open well.
Could issue emergent notice to the respondent number 1 and 2. In addition, learned counsel for the respondent number 1, notice to respondent number 2 is dispensed. In addition, learned counsel for the petitioner is directed to serve the learned counsel who represented the respondent number 1 before the trial. Till the next date of hearing, the respondent number 1 is restrained from connecting any sewage pipe from his house to the open well situated on the eastern side of his property. The respondent number 1 is restrained from discharging any sewage into the open well till the next date of hearing. Full stop. The counsel for the petitioner is directed to comply with the provisions of Order 39, Rule 3A. Full stop. This order shall not be uploaded until the office objections are complete. Yes.
Serial number 12, Brijesh Patil.
I appear for the respondent number 1. The appeal is already pending.
1 week time is list after vacation.
Please.
1 week time is granted to do the needful.
Serial number 13.
DT Sharan, 1 week,
Serial number 14,
1 week,
15, serial number CG Gopal Swami.
1
Yes,
week.
my lord, I appear for the petitioner.
Ah,
The office objection is that we should give a proper prayer. But the prayer is, but the subject matter is an order that your lordship passed in a petition. Last paragraph of the prayer, your lordship has stated this plot. The petition is dismissed. Like that's the relief I wanted, and I've got relief in the petition. The para 9 of the order, your lordship.
petition is disposed of.
Yes, madam. Disposed of. That is in the sense that the trial court order is upheld. Trial court implemented me as one of the respondents in the FDP. Thereafter, your lordship has said that if the decree in OS number 7410/1993, which is the subject matter under which I have purchased the property, it is also a portion of the property I have purchased. The remaining I have purchased from the plaintiff in that suit. So this.
It says if the decree in OS number is held to be not binding on the plaintiff, then her 1/4 share in the suit share property shall remain unaffected.
Please, my lord.
What
In
is
so far
wrong
as insofar her having 1/4 share, there is no dispute. They rely on a will. The subject matter is that before the will came into effect, the testator had divested herself of the rights to the property in question. There is a larger interest involved. She may kindly hear this matter and dispose of whenever she.
No, please comply the office objections. Yes. 1 week time is granted to do the need.
Serial number 16, Nandish Gowda GB.
1 week. 1 week.
Serial number 17, Mohan
1
Chandra.
week.
My lord. I am dependent number 2, so read petition, my lord. I filed a
Interim order is granted, notice is ordered.
order, yes, sir.
You not comply the.
Comply, but a written statement is not filed in this case, my lord. And secondly, IA number 56, no objection is filed.
Chandra, We have granted interim order even before you complied the office objection.
There is no office objection, my
You have
lord.
not complied the office
One
objections
submission.
from
Two,
night
two office objection raised.
20, Mr.
Agila,
We will
two
vacate.
office regarding written statement, no written statement filed.
Sorry, we will vacate the interim order.
No written statement is filed in this case, my lord.
You should say that to the office.
Secondly,
February 2024, you have not even visited the office. You copy it on mail.
all is setting aside expert order, my lord. That is all.
Whatever it is.
Because orally oppose your plaintiff.
Really the interim order is like
Interim,
28 to. And you don't comply the office objection.
office objection illa alli adu objection hakilla alli.
Nodi, you are bound to comply the office objections.
Alla,
From February 2024, you are not complete, though we have granted an interim order.
Because my submission that no written statement and the objection is filed in this case, my lord. And so office object kindly be overruled.
Office objections are ruled. If you do this again, I am going to vacate the interim order. The order court will comply ಮಾಡಬೇಕು. ಇಲ್ಲ, we will not grant an order unless you comply the office objection. This become the habit. The order ತಗೋತಾರೆ comply ಮಾಡೋದು. And it affects all other advocates who want urgent orders and cannot comply interim office objections. Because of people like you, other advocates get affected. And you seem to be not willing to change. This is not the first time it's happening. This is the second or third time it's happening before me. ನೀವೇ ಎರಡು ಸತಿ ಆಗಿ ಒಂದ್ಸತಿ ವೆಕೇಟ್ ಮಾಡಿದೀನಿ. Yes. Next.
Serial number 18. Basappa.
I am withdrawing this.
Learned counsel for the petitioner has filed a memo to withdraw the writ petition. The memo is taken on record
My lord, one
and the
submission.
petition is dismissed as withdrawn.
17, interim order kindly be. In the meantime, I will comply office objects.
ನೀವು ಕಂಪ್ಲೈ ಮಾಡಿ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ.
Alla, kindly, during the course of the, I will
You
comply.
should also be under pressure. ಕಂಪ್ಲೈ ಮಾಡಿ ಆಮೇಲೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
Serial number 19, GS Prasanna Kumar.
My lord, we have complied the office objection. However, on oversight, they have mentioned the same office
There's some
objection.
small minor office objections, please.
We have complied, my lord.
Case number to be corrected at prayer, interim prayer as well as writ petition.
Classification raise ಮಾಡಿದ್ರು ಅದೆಲ್ಲ ಮಾಡಿದೀವಿ oversight.
ಸತಿ ಮಾಡಿದಾರಮ್ಮ. Case number to be corrected at the prayer, interim prayer as well as in the writ petition.
ಮಾಡಿದೀವಿ.
ನೋಡ್ರಿ ಮಾಡಿದಾರಂತ.
Just pass over, my lord. ಮಾಡಿದೀವಿ.
ಬೆಳಿಗ್ಗೆ ತೋರಿಸಿದಾರಂತಲ್ಲ.
ಮಾಡಿದೀವಿ.
ಬರ್ಕೊಳ್ಳಿ, 1 week time is granted.
My lord, ಮಾಡಿದೀವಿ. I'll pass over, my lord. I'll just.
ಮಾಡಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದಾರೆ, ನೀವು ಮಾಡಿದಿರಿ ಅಂತ ಹೇಳಿ.
My lord, ನಾವೇ ಹೋಗಿ personally have checked it.
Yes.
Pass over kindly.
What is the urgency? What is the urgency?
The suit is not maintainable ಅಂತ ಹೇಳಿ 151 CPC ಅಲ್ಲಿ ನಾವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ರಿಜೆಕ್ಟ್ ಆಗಿದೆ. Only on the basis of column number 12 ದಲ್ಲಿ cultivator's name ಇದೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು they have filed an injunction suit, my lord. And I had preferred RRT proceedings.
What is the urgency, madam? Can it wait after vacation? List after vacation. 1 week time is granted to do the need. Yes,
Number
next.
20, Shantraj KG.
KG Shantaraj.
Petitioner, my lordship, in this case, I have complied all the office objection except filing of the typed copy. Now I brought it, urgency is there in this case.
Office objection.
Already I complied.
12.
During the course of day, I will comply the office objection and matter is urgent, my lordship.
Yeah.
Sale, in the execution petition, sale proclamation notice has been issued and for report today is only the reporting this day. The questions schedule property already mortgaged in some other bank, syndicate bank. In the Loka Adalat, they got the decree and they filed the execution petition in that case and it is also pending before the same court. On that order, this petitioner has challenged the Loka Adalat decree before this honorable court. In that case, this honorable court has passed the stay order.
Whether any spot sale is held.
The questioned property.
Whether any spot sale is held.
One vacant site.
Sir, whether the court has held any spot sale.
Not partial.
Mate, what is the urgency? List after vacation. Yes, next.
Serial number 21.
My lordship, with permission, one sentence. I will
Complain. Spot sale agidre I can understand. Spot sale in agilwala.
ಯಾಕೆಂದ್ರೆ ಮಾರ್ಟಿಗೇಜ್ಡ್ ಪ್ರಾಪರ್ಟೀಸ್ ಒಮ್ಮೆ ಆಲ್ರೆಡಿ ಅಂಡ್
ಪ್ರೊಕ್ಲಮೇಶನ್ ಇಶ್ಯೂ ಆಗಿದೆ ಅಷ್ಟೇ ತಾನೆ.
ಹೌದು
ಮತ್ತೆ
ರಿಪೋರ್ಟ್ ಅಂತಂದೇಳಿ ಇವತ್ತಿಗೆ ಡೇಟ್ ಇತ್ತು ಫಾರ್
Report of
ಸೇಲ್ ಅಂಡ್
what?
ಫರ್ದರ್ ರಿಪೋರ್ಟ್ ಅಂತ.
ರಿಪೋರ್ಟ್ ಆಫ್ ವಾಟ್ ಕೋರ್ಟ್ಸ್
ಸೇಲ್ ಆಕ್ಷನ್ ಸೇಲ್ ಪ್ರೊಕ್ಲಮೇಶನ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗ್ಬಿಟ್ಟು ಸೇಲ್ ರಿಪೋರ್ಟ್ ಅನ್ನ ಇವತ್ ಮಾಡಿ ಅಂತಂದೇಳಿ ಆರ್ಡರ್ ಇವತ್ತಿಗಿದೆ.
ಸೊ ಇನ್ನ ಸ್ಪಾಟ್ ಸೇಲ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ
ಮತ್ತೆ ಇಲ್ಲಿ ಬರ್ಲಿ ಆಮೇಲೆ ರಜಾದ. Yes, next.
ಫಸ್ಟ್ ಆಫ್ಟರ್ ಇಮಿಡಿಯೇಟ್ಲಿ
1 week time is granted to do the needful. ಬೇಗ ಕಂಪ್ಲೈಂಟ್ ಮಾಡ್ಬಿಡಿ ಬರುತ್ತೆ.
ಇವತ್ತೇ ಮಾಡ್ತೀನಿ sir.
ಮಾಡಿ.
Much obliged.
Yes.
Ah.
My lord, I have prepared the chart,
Yes.
the situation, location of the.
Hi, my lords, kindly, my lords, permit me to pass one, my lords, one rough sketch, my lords, for reference.
I am ready. According to the schedule shown in the partition deed. There,
My lords.
B. A. Nagesh is the plaintiff. He was allotted the share that is survey number 2, 20 acres, 20 guntas, and 2 acres, 20 guntas is survey number 81, partition deed. And they have given the schedule as Annegoda's property so far as east is concerned. West is concerned, Mastikon estate. And so far as north and south is concerned, roads are situated, there is no dispute. My lord, so far Annegoda is concerned, he was allotted 3 items of the properties. That is 2B, measuring 8 acres 10 guntas, and 2A, 9 acre 10 guntas, and also wetland of 3 acres 11 guntas. So this in the
No, suit
partition
is-
deed.
Suit is filed by Nagesh.
Nagesh,
ಏನಂತ ಚೆಕ್ ಬಂದು ಏನಂತ
In
ಕೊಡ್ತಾರೆ?
respect
ಚೆಕ್
of
ಬಂದು ಏನ್
payment.
ಕೊಡ್ತಾರೆ ಅಂದ್ರೆ ಈಸ್ಟ್ ಬೈ ಡಿಫೆಂಡೆಂಟ್ಸ್ ಪ್ರಾಪರ್ಟಿ. ಅಂದ್ರೆ ಎಲ್ಲಿ ಹೋಗುತ್ತೆ ಡಿಫೆಂಡೆಂಟ್ ಪ್ರಾಪರ್ಟಿ? ಅನ್ನೇಗೌಡನ ಪ್ರಾಪರ್ಟಿ
That
ಬಿಟ್ಟು
is
ದಾಟುತ್ತೆ.
B2, my lords, in my rough sketch.
ದೆನ್ ವೆಸ್ಟ್ ಬೈ ಮಸ್ತಿಕಾನ್ ಎಸ್ಟೇಟ್. ಅದೇ ವೆಸ್ಟ್ ಬಂದ್ರೆ ಅವ್ರಿಗೆ ಏನಾಗುತ್ತೆ, ಈ 8 ಎಕರೆ 10 ಗುಂಟೆ ಜಾಗಕ್ಕೆ ವೆಸ್ಟಿಗೆ ಬರ್ಬೇಕಾದ್ರೆ ಹಿಸ್ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಅಲಾಟೆಡ್ ಟು ಹಿಸ್ ಶೇರ್ in the partition deed. Now he shows the boundary of my land also 9 acre 10 guntas. If what a boundary is taken into consideration for so far as 8 acre 10 guntas is
Sir,
concerned,
9 acre 10 guntas
it has gone to me.
ನಿಮಗ್ ಬಂದಿದ್ಯಾ?
ವಿಲ್ ಅಲ್ಲಿ ಬಂದಿರೋದು ಅಲ್ಲ, ಇದರಲ್ಲಿ ಪಾರ್ಟಿಷನ್ ಡೀಡ್ ನಲ್ಲಿ.
8 acre 10 ಗುಂಟೆ it has gone to Ramesh.
Yes, because they said
Nagesh.
that it is abutting, Nagesh,
Acre 10
it's abutting
guntas is
to his
Nagesh.
property,
8 acre 10 guntas has got to Nagesh.
Nagesh.
ಹಾ,
ಅದು suitable property is 8 acre 10 guntas.
ಹಾ.
Schedule ಕೊಡಬೇಕಾದ್ರೆ he gives schedule to the 37 guntas acres of land.
ಹಾ. East by property of Ramesh.
East by property of Ramesh.
ಹಾ.
ಅದ್ರ ರಮೇಶ್ ಅಂದ್ರೆ ಈ 9 ಎಕರೆ 10 ಗುಂಟೆ ಅಂತ ಹೇಳ್ತಾರೋ ಅಥವಾ 12 ಎಕರೆ 7 ಗುಂಟೆಗೆ ಹೇಳ್ತಾರೋ ಗೊತ್ತಿಲ್ಲ.
ಆಯ್ತು. ವೆಸ್ಟ್ ಬೈ
ವೆಸ್ಟ್ ಬೈ ನಾಗೇಶ್ ಪ್ರಾಪರ್ಟಿ ಆಗ್ಬೇಕು, ಬಟ್ ಮಸ್ತಿಕಾನ್ ಎಸ್ಟೇಟ್ ಬರ್ತದೆ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ.
ಬಟ್ ಇಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ನಾಗೇಶ್ ಅಂತಾನೆ ಇದೆ.
ಇಲ್ಲ ಪ್ಲೇಂಟ್ ಅಲ್ಲಿ
Schedule mentioned in the
Yes.
application.
ಪ್ಲೇಂಟ್
Come to the application. Application
That
B
is
and
IA2, my lords, which is.
IA2 is mine.
filed by
IA2
defendant.
is filed by the defendant. IA number 1 your lordship.
My lords, on western side. my lords,
23,
property of
page
defendant,
23.
West by
West by Mastikan estate. North by Kalasa Kotigere, Kotigehara.
north to south in dispute ಇಲ್ಲ.
Dispute ಇಲ್ಲ. Dispute ಇರ್ತಕ್ಕಂಥದ್ದು ಇವಾಗ if at all this boundaries.
Let him say that east is by 9 acre 10 guntas in survey number 2
Yes, my
ಅಂತ
lords.
ಹೇಳಿ ಅಷ್ಟೇ.
9 acre 10 guntas defendant's property. I
Tell
agree
therefore.
that.
But now they are within that. They are showing the boundary.
So they simply say property of defendant.
Yes.
The property of defendant is 9 acre 10 guntas.
That is your lordship may kindly make it the.
Please, my lord. 9 acre 10 guntas of a defendant property, my lords, I have not.
The defendant in OS number so and so on the file of so and so is before this court challenging an order dated so and so by which an application filed by which challenging the order passed in MA 9/2023 dated 26/11/2024, passed by the senior civil judge and JMFC Moodgere, allowing the appeal and setting aside the order passed by the trial court dated 6/4/2023, and granting injunction in respect of the suit shall property. Next para, the suit in OS number 82/2022 was filed for perpetual injunction in respect of land measuring 8 acre 10 guntas in survey number 2 of Kelagura.
ಕೆಲಗೂರ್ ಅದು 2B ಆಗ್ಬೇಕು, 2 ಹಾಕಿದ್ದಾರೆ ಅವರು. ಪಾರ್ಟಿಷನ್ ಹಿಡಿದ್ರೆ 2B.
Kelagur estate.
2B ಪಾರ್ಟಿಷನ್ ಹಿಡಿದಿರೋದು.
Kelagur estate ಯಾವ ಊರಿದು?
ಕೆಳಗೂರ್ ಎಸ್ಟೇಟ್
ಬಾಲೂರು ಹೋಬಳಿ,
ಬಾಲೂರ್ ಹೋಬಳಿ,
ಮೂಡಿಗೆರೆ ತಾಲೂಕು.
Moodgere ತಾಲೂಕು. Full stop. The plaintiff's case was the case of the plaintiff was that in terms of a partition deed dated 14/9/1979.
4/9 ಮೇಲೆ.
Huh?
4/9.
14/9 ಅಂತಿದೆ.
ಸಾರಿ my lords, in
plaint ಅಲ್ಲಿ ಹಾಕಿರೋ 4/9
plaint ಅಲ್ಲಿ 4/9 ಇದೆ.
Huh?
Plaint ಅಲ್ಲಿ 4/9 ಇದೆ, para 3 my lords.
It is actually
14/9 ಅಂತಿದೆಯಲ್ಲ ಇಲ್ಲಿ.
it is actually
Ink page 16 my lords.
16
4
4/9.
ಏನ್ ಮಾಡಬೇಕಾಯ್ತು?
ಕೆಳಗಡೆ there is wrong my lords. First line is a 4/9.
4/9/1979, comma, the Kelagur estate belonging to the family was divided between the plaintiff, comma, defendant and their father. As per the partition, comma, 8 acres 10 guntas in survey number 2B and 9 acre 10 guntas in survey number 2A
of Kelagur estate.
of Kelagur estate
Coffee land.
and survey number and 3
Coffee land ಅದು.
of coffee land and 3 acre 11 guntas in survey number 10 of Durgadahalli
Wetland.
allotted to the share of the father, while 20 acres 20 guntas of coffee land was in survey number 2 and 2 acre 20 guntas in survey number 81 of Velagalli. 2 acre 20 guntas of wetland in
Yes.
survey number 81 of
Coffee land my
Velagalli.
lords, that is also
No, he
2
says
acres 20 is a
that's also
Wetland.
wetland.
Wetland ಅದು.
was allotted to the share of
Plaintiff.
the plaintiff. And 12.07 acres of coffee land in survey number 2 of Kelagur estate, comma, 6.5 acres of coffee land in survey number 11 of Sunkasale, and 3.20 acres of wetland in survey number 10 of Durgadahalli was allotted to the share of the defendant. Full stop. It is a case of the plaintiff that out of the land allotted to the share of his father, 8 acre 10 guntas in survey number 2B of Kelagur estate was made over to him, while 9 acre 10 guntas in survey number 2A of Kelagur estate and survey number and 3 acre 11 guntas of in survey number 10 of Durgadahalli
And remaining all properties ಅಲ್ಲಿ ಕೆಳಗಡೆ ಬರ್ದಿದ್ದಾರೆ.
and other properties were allotted to the share of, were made over to the defendant. Full stop. The plaintiff claimed that he thus became the owner of the suit shell property, which was 8.10 acres of coffee estate in survey number 2B of Balur village.
After death of his mother.
Full stop.
After
After the
his-
death of his mother. Full stop. The plaintiff claimed that the defendant, who is his brother, though having no manner of right, title or interest, was trespassing over the suit property and was obstructing to cultivate the suit property. Therefore, the plaintiff was advised to sue for perpetual injunction against his brother to restrain his brother from interfering with the possession of the plaintiff in the suit property. Full stop. The defendant contested the suit and contended that the suit property was not allotted to the share of the plaintiff and denied that the plaintiff was in possession of the suit property. He contended that as per the partition deed, the suit property had to, he contended that it was not mentioned in the suit partition deed that the suit property had to go to the plaintiff after the death of his mother. He also denied having trespassed into the suit property or obstructing the plaintiff from cultivating the suit property. Full stop. An application for injunction was filed by the plaintiff to restrain the defendant from interfering with the cultivation and enjoyment of the suit property. This application was also contested by the defendant on similar terms. The defendant also filed an application under Order 13 Rule 1 and 2 for an interim injunction to restrain the plaintiff from interfering with the peaceful possession and enjoyment of the property mentioned in the schedule to the application. Full stop. Next para. The trial court, after considering the contentions of the plaintiff and the defendant, held that
Para 10.
held that the entire extent of survey number 2 of Kelagur measured 81.03 acres. Full stop. It held that the identification of the suit property was not certain, and therefore granting an order of injunction in favor of the plaintiff would cause injury to the defendant. More particularly, since the defendant claimed that he too had some portion of land in survey number 2 of Kelagur, and that the property was not yet bifurcated. Being agreed with the said order, the plaintiff filed an appeal before the appellate court. The appellate court, after perusing the partition deed and the recitals contained therein, was of the opinion that the plaintiff had made out a case that the suit property measuring 8 acres 10 guntas in survey number 2B of Kelagur was made over to the share of the plaintiff. Therefore, it held that the plaintiff had proved his title to the suit property, and consequently held that the plaintiff was in possession of the suit property, and hence reversed the order of the trial court and granted injunction in favor of the plaintiff, restraining the defendant from interfering with the peaceful possession, cultivation, and enjoyment of the suit share property. Being agreed by the said order, the defendant is before this court. Next para. The learned counsel for the defendant, though admitted the partition deed dated 4/9/1979, contended that the boundaries mentioned in the suit did not correspond with the actual holding of the plaintiff. He contended that the eastern side of the suit property was mentioned as property of defendant, giving an impression that the plaintiff is claiming not only 8.1010 acres of land in survey number 2B, but also the land measuring 9.10 acres and in survey number 2A of Kelagur, and survey number 10 measuring 3.11 acres at Durgadahalli. It therefore contends that the order of injunction is likely to harm the plaintiff with an order to interfere with his possession. Full stop. The learned counsel for the plaintiff, on the other hand, contended.
Error, may make one submission. This is just suffering. Whether the schedule is taken into consideration, this 8 acre 10 guntas of land falls within 20 acre 20 guntas of land. ಅವ್ರೊಳಗೆ ಬಂದ್ಬಿಡ್ತದೆ.
ಏನಂತ?
8 acres 10 guntas schedule is taken into consideration, what client schedule is taken into consideration. The 8 acre 10 form part of the land allotted to his share.
ಕರೆಕ್ಟ್.
ಹಂಗಾಗೋದು 20 ಎಕರೆ 20 ಗುಂಟೆ ಬಂದ್ ಹೋಗುತ್ತೆ.
ನೀವೇ ಮಸ್ತಿ ಖಾನ್ ಎಸ್ಟೇಟ್ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಿ ನಿಮ್ಗೇನ್ ತೊಂದ್ರೆ ಆಗಲ್ವಲ್ಲ?
ಅಲ್ಲ ಮಾಸ್ತಿಕಾನ್ ಬಂದ್ರೆ ಅಲ್ಲಿ 20 ಎಕರೆ 20 ಗುಂಟೆ.
That is my lord, sir, typographical error, my lord, that will correct it.
ಬೇಕಾದ್ರೆ
So
correction
far as
ಮಾಡಿ.
eastern portion is concerned, my lord.
They have to make corrections.
You're only concerned with the
Eastern portion.
Full stop.
You said they shall not actually
Full
make
stop.
any this one so far as.
The learned counsel for the plaintiff fairly conceded that the eastern boundary mentioned in the suit schedule is 9.10 acres in survey number 2A of Kalagur Estate and survey number 10 of Durgadahalli, which is allotted to the defendant.
My lord, sir, actually 10 minutes do not fall nearby, my lord, therefore without reference to that.
ಇದೇನು ಕೊಟ್ಟಿದ್ರೆ ಹಂಗೆ ಇದೆಯಪ್ಪ.
ಅಲ್ಲ, ಅದು 10 ಇಲ್ಲಿ ಬರೋದೇ ಇಲ್ಲ, ಅದು ದುರ್ಗನಹಳ್ಳಿ somewhere else, my lord.
ಪಕ್ಕನೇ ಇರೋದು ಅದು.
ಅದು
1 by 1, 1 by 1.
9.10 acres in survey number 2A of Kalagur Estate. And not survey number 2 of Kalagur Estate measuring 12.07 acres that was allotted to the share of the defendant. He also admits that the suit property was mentioned as survey number 2B in the partition.
Partition 2B.
And not survey number 2. And that he would make appropriate corrections before the trial court. Similarly, he admitted that the western portion of the western boundary of the suitable property was the remaining portion of the plaintiff and not Masti Khan estate, and that he would make appropriate corrections in the cost title, in the boundaries mentioned in the schedule to the suit. Full stop. Since the plaintiff has now restricted the boundaries and has also restricted the boundaries and also undertaken to correct the survey number mentioned in the schedule to the suit, the interest of the defendant is sufficiently protected as the order of injunction shall be construed only to the extent of 8 acres 10 guntas of land lying within the boundaries that may be amended by the plaintiff in accordance with law.
One submission.
That way of the matter, this
A commission may be appointed because what has happened.
This petition stands disposed of on the above terms.
ಅಲ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ವೇರ್ ಡೆಮಾರ್ಕೇಶನ್ ಬರುತ್ತೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ.
ಏನಿಲ್ಲ.
ಡೆಮಾರ್ಕೇಶನ್ಸ್ ಬರಲ್ಲ, ಬೌಂಡರೀಸ್ ಇಲ್ಲ.
ನಿಮ್ ಜಮೀನ್ ಎಲ್ಲಿ ಅಂತ ನಿಮ್ಗೆ ಗೊತ್ತು, ಅವ್ರ ಜಮೀನ್ ಎಲ್ಲಿ
ಗೊತ್ತಿದೆ. Now what has happened that.
Will not do all those things in the preliminary stage. Will not appoint a commissioner, division.
But just joint survey ಮಾಡ್ಕೊಂಡು ಅವರ ಪ್ರಾಪರ್ಟಿ ಅವ್ರ.
To file a joint application before the concerned revenue officer, survey officer, ಅವ್ರು ಬಂದ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ ಅದನ್ನ ಒಂದು ಹೇಳಿದ್ರೆ ಸಾಕು. I can make.
The law provides you to
Sir,
file an
what happens that is a harvest season.
You file an application.
It is a liberty to, your lordship said liberty to. 22. Liberty to go file.
Please approach the revenue survey authorities. ಅವ್ರು ಮಾಡದಿದ್ರೆ ಬನ್ನಿ.
Responded.
After vacation. ಯಾವ್ದಿದು? 22. Non-filing of revenue records and mutation extract of the suit property by advocate for petition.
After vacation.
List after vacation.
23.
H. Devendrappa. Non-furnishing of.
For respondent.
3 and 7 necessary.
Already infractions, my lord. It has already, OS has already disposed of.
Yaವಾಗ ಕೊಡಿ ಇದು. Learned counsel for the learned counsel for the petitioner is absent. The learned counsel for the respondent submits that the suit from which the present writ petition arises was disposed of on 11th January 2024. He has placed on record a copy of the judgment passed in the said suit. In that way of the matter, this writ petition is dismissed as having become infructuous.
24, Chandrasekhar R.
List after service of notice.
Interim order earlier granted may be extended, my lord.
Interim order granted is extended to the next date of hearing.
25.
Oblige.
Satish R. DJ.
For the.
Bharat Gogi.
Lords, your lordships had passed an order on 12/11/2024.
ಇಷ್ಟೊಂದು ಮ್ಯಾಟರ್ಸ್ ಇದೆಯಲ್ಲ ಇದು.
ಹೌದು, ಎಲ್ಲ ಒಂದೇ ಆರ್ಡರ್ ಮೇಲೆ ಬಂದಿರೋದು. Plaintiffs and D7 to D10
ಮೊನ್ನೆ ಬಂದಿತ್ತು, I had moved the matter.
ನಾನು ಯಾವ್ದ್ರಲ್ಲಿ?
Lords, the Lordship may kindly see the order, my lords, 1211.
ನೋಡ್ರಿ, 12 order.
11 passed by this court.
ತಾವೇ ಮಾಡಿ.
ಹಾ.
12-11 ಒಂದು ಆರ್ಡ್ರು, ಆಮೇಲೆ
11.
ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕ್ರಾಪ್ಸ್ ಏನು ಮಾಡ್ಬಾರ್ದು. ಅದಾದ್ಮೇಲೆ ಇನ್ನೊಂದು ಆರ್ಡರ್ ಮಾಡಿದ್ರಿ ತಾವು 20-11ಕ್ಕೆ.
ಹಾ.
Last para of that 2011 order, if your lordship sees, government advocate was to verify whether. So,
2011.
ಹಾಕಿರೋ ಅಪ್ಲಿಕೇಶನ್
2011 ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ.
Milords, 2011 order ಇದೆ ಒಂದು. ಅದು probably Milords, it's connected, I have the order.
2011.
20-11ಕ್ಕೆ.
ಹಾ.
ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ learned high court government pleader is directed to verify ಅಂತ ಬಂದಿದೆ ತಮ್ಮ. Because I pointed out the LRRP, we were tenancy claims.
Yes, madam.
Now under RTA, we have got records.
Can I just
learn-
point this out, Milords? Allow
I have not even completed, my learned friend wants to point out. I am just.
ಆಯ್ತು.
ಹೇಳ್ಬಿಡಿ ಪೂರ್ತಿ ಹೇಳ್ಬಿಡಿ.
ಹ್ಮ್.
ಲಾಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ ಸಿಟ್ ಮಾಡ್ಕೋಬೇಡಿ.
Our government advocate, Lords, our claim was I had pointed out, Lords, our tenancy applications were remanded and an order of status quo had been directed to maintain till our applications are considered by this.
ಇದನ್ನ ಓದ್ಬಿಡಿ ಒಂದ್ಸಲ. Learned High Court government directed to verify from the officer.
Verify from the office of Deputy Commissioner Hassan District whether Srimati Jayamma Manjunath and Radhamani as legal representatives of Tirumala Shetty and Prabha, Yogesh, Prakash, Girish as legal representatives of Venkata Shetty had filed appropriate applications for amendment of Form 7 as per order dated 5/3/2004 passed by the court in LRRP number so and so. Order dated 12/11 shall continue. That LRRP order, we had pointed out to your lordships that it was remanded back. Initially, we had been granted.
I don't remember the facts.
Yes, my lord. My lords, I'll just point out, please, if your lordships have 29684 in your lordships hand. That's a 29684 of 29891, sorry, 29891.
29891.
That is 25.1, my lords.
ಕೊಡ್ರಿ ಅದು ಯಾವ್ದು?
Alva. Correct, Alva. Because I have marked in that, my lords, that's why I'm sorry.
ಅಲ್ಲ ಇದನ್ನ can it not go after vacation?
My lord, my problem is today is there are standing crops there. Areka ide, coffee ide, paddy ide. I have to harvest it. Now, if I don't harvest it, my lords, in that, please come to page 307 for a moment.
307.
307. ಅದರಲ್ಲಿ ಅನ್ನ HR ಅಂತ ಇದೆ. That's the order dated 5/3. Anna HR was the inamdar at the landlord against whom, my lords, the plaintiffs in the present suit and D7 to D10, they are two brothers, my lords. Under Anna HR was the original inamdar and owner, my lords. One Manjappa Shetty, lords, had got a lease deed from him. Manjappa Shetty had two sons, Tirumala Shetty and Venkata Shetty.
Manjappa Shetty.
Yes, my lords.
Two sons, Tirumala
Shetty and Venkata Shetty. So we are, my lord, the currently we are all the plaintiffs and D7 to D10 are, my lords, Venkata Shetty's and Tirumala Shetty's children. Now, my lords, in that LRRP, Anna HR, my lords, filed the LRRP challenging the grant, my lords, in our favor. And Tirumala Shetty's name, your lordships would get at page 308. And Venkata Shetty is at 309. But this honorable court, my lords, considered the facts and remanded the matter back to the deputy commissioner. If your lordship comes to page 314 at para 9. Accordingly, therefore, in my view, the orders impugned in these revision petitions cannot be sustained. Accordingly, revision petitions are allowed. Impugned orders are set aside and claims made by the respondents are directed to be sent to Deputy Commissioner Hassan District, Hassan, for fresh disposal in accordance with law, having regard to principles laid down in this court and decisions referred to supra. Applicants who have filed Form 7 are directed to mention the boundaries in respect of extent of land claimed by them in Forum 7 by making necessary corrections in Forum 7 within 8 weeks. After making necessary corrections regarding boundaries, Deputy Commissioner is directed to issue fresh notice in Forum 9, showing the boundaries to Inamdar and thereafter hold fresh orders and pass appropriate orders in accordance with law. Respondent, if the respondents herein who are applicants in Forum 7 do not do the needful within 8 weeks from the date of this order, then the Deputy Commissioner shall reject their applications, Forum 7.
Yeah, what was to be done?
Lords, the entire extent is about 83 acres. Both the brothers had filed for different survey numbers, my lords, different extents. So we had to give the boundaries of each extent. If we do not file the revised giving the boundaries, he was to reject our applications. Then, my lords, para 13 at page 316. Parties are directed to maintain status quo till fresh orders are passed by the. Now, my lords, based on this, the Deputy Commissioner, the next page at 317 is the notice issued, calling upon all of us to be present. Lords, it's our case that, my lords, we have filed our applications. Thereafter, my lords, by virtue of a circular issued by the government, the applications were transferred by the Deputy Commissioner to the Tahsildar. Till date, that has been kept pending. No orders are passed. In between.
What is the nature of this land?
Lords, these are coffee, paddy, areca, everything. Lord. And we have been in there from 1955. Now, during the pendency of these.
Charitable inamsa?
My lords, according to us, it was charitable. Then they claimed it is religious. But they also claim in the written statement filed in the suit that there has been an inam vesting, regrant order in their favor. Now, my lords,
it should go before the Deputy Commissioner.
Deputy Commissioner madidru idu yenagide, government has passed a circular. Circular alli he has sent it to the Tahsildar. Adu alle bidkondidu.
MB Ramchandran case.
Adalla. My lords,
No, if it's a personal and miscellaneous inam, then it should go before the land.
Deputy Commissioner, if it is miscellaneous inam, it is before the land tribunal. If it is a religious inam, it is before the Deputy Commissioner.
Deputy Commissioner. Then why was it sent before the?
ಅದು ಮೆಮೊ ಹಾಕಿದಾರೆ ಒಂದು ನಾವು ಹಾಕಿದೀವಿ 3/12/2024 ಅದರೊಳಗಿದೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್ ಇದೆ ಒಂದು.
RTL, we have got the information, my lords. Government is supposed to get. Now RTA haki, RTA. That it is pending, it has gone to the Tahsildar on copy.
Correct, but if this is a religious inam, idadme innond judgment bantalla MV Ramchandra admele the position in the case of
Kudli Shringeri Mutt, which was
Kudli Shringeri Mutt,
which set aside the judgment. Supreme Court set aside the judgment. That lady's name.
Adr melene circular issue.
No. Adadmele whether the law laid down in MB Ramchandran, what should be the effect anta one judgment bantu nodi. MB Ramchandran anta haki barutte.
Now, my lords, what has happened today, the dispute has arisen because during the pendency of this, if your lordship kindly come to the last document annexure, my lords, yes, at page 329. The LRs of 329 tamg sigatte. LRs of Annayachar execute a sale deed, my lords, on 23/2/2024 of 108 acres in favor of D7, defendant number 7, or D6, sorry, for 1 crore rupees.
Even before the land is granted.
Nam claim ide alli. Adu ಏನು ಆಗಿಲ್ಲ, ರಿಜೆಕ್ಟ್ ಆಗಿಲ್ಲ, ಹಂಗೆ ಬಿದ್ದಿದೆ, ಸ್ಟೇಟಸ್ ಕೋ ಅಂತಿದೆ.
But then they sold it.
ಅವರು 23/2/2024 they sell the land in favor of D6, 108 acres. Please come to page 331. 331 ಅಲ್ಲಿ total measuring 108 acres ಅಂತ ಕಾಣುತ್ತೆ ತಮಗೆ. Bottom ಅಲ್ಲಿ totally measuring 108 acres, 11 guntas. Lords, for a sum of 1 crore. That your lordships would get at page 335. Just before this, my lord, this sale deed takes place on 23/2/2024. Just before that, the AC had passed an order, my lords, changing the entries to the name of the Annayachar's children, which we filed a writ petition. We obtained an interim order of stay in those writ petitions. Those writ petitions are pending consideration before this court.
Gauram.
Now, based on this, they come and try to interfere. We file a suit seeking injunction against the
Gauram.
defendants.
Again,
The suit, trial court had granted an injunction.
Sama is the respondent.
Now, the appellate court rejects my injunction, grants an injunction in favor of D6 against me. So in these circumstances, your lordships ask the government advocate to find out if our applications are indeed filed pending.
Yes,
We have got the records, my lords.
Lords, may I just-
Entire-
I'll just point this out, my lords, because that exercise,
Let me get the flow.
yes,
Adenaಗಿದೆ no.
lords,
Yes, ma'am.
whatever, my lords, if I wanted to submit this, my lords,
Sure.
lords, I'll just say this, my lords, court of,
ನಾವು ನಿಮ್ಮಷ್ಟು ಕ್ವಿಕ್ ಇಲ್ಲ.
ಅಯ್ಯೋ, ನಂಗೆ ಸಮಸ್ಯೆ ಆಯ್ತಾ? ಇದ್ರಲ್ಲಿ ನಾನು ಇಷ್ಟೇ ಹೇಳ್ಬಿಡ್ತೀನಿ. ಅವ್ರು ಏನ್ ಹೇಳ್ತಿದ್ದಾರೆ, ಅದ್ರೊಳಗೇನೆ ಸತ್ಯ ಅಡಗಿದೆ. ಅವ್ರು ಪೇಜ್ ತೋರಿಸಿದ್ರಲ್ಲ, ಪೇಜ್ ನಂಬರ್ 303, ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡ್ಬಿಡಿ, ನಾನು ತೋರಿಸ್ತೀನಿ. ಅಷ್ಟರಲ್ಲೇ ಸತ್ಯ ಅಡಗಿದೆ.
ಪೇಜ್ ನಂಬರ್
ಅದೇ ಅವರು ಹೈಕೋರ್ಟ್ ಅವ್ರು ಸ್ವಲ್ಪ ಪೇಜ್ ನೇಷನ್ ಏನೋ ವ್ಯತ್ಯಾಸ ಆದಾಗಿದೆ. ಅದೇ ದಿ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇನ್ ದಟ್ LRRPs. ಅದು ಪೇಜ್ ನಂಬರ್ 303 ಅಂತಿದೆ. ಎಲ್ಲಿ ಶುರು ಆಗುತ್ತೆ ಅದು? LRRP ಆರ್ಡರ್
307.
307 ಇಂದ ಶುರು ಆಗುತ್ತೆ. ಅದರೊಳಗೆ ನೆಕ್ಸ್ಟ್ ಪೇಜು, ಫಸ್ಟ್ ಒನ್ ಯಾವುದು ಅಂತಂದ್ರೆ 3084 ಅಲ್ಲಿ ತಿರುಮಲ ಶೆಟ್ಟಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ನೆಕ್ಸ್ಟ್ ಪೇಜು LRRP 2841 ಆಫ್ 1918. ಇದರಲ್ಲಿ ವೆಂಕಟ್ ಶೆಟ್ಟಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ಇಬ್ರು ಬ್ರದರ್ಸು, 2 ಅಪ್ಲಿಕೇಶನ್, 2 ಪ್ರೊಸೀಡಿಂಗ್ಸು, ಡಿಫರೆಂಟ್ ಸೆಟ್ ಆಫ್ ಪ್ರಾಪರ್ಟೀಸ್. ಸರ್ವೆ ನಂಬರ್ ಒಂದೇ ಇರ್ಬೋದು, ಬೇರೆ ಬೇರೆ ಎಕ್ಸ್ಟೆಂಟ್ಸು, ಬೇರೆ ಬೇರೆ ಸೆಟ್ಸ್ ಆಫ್ ಪ್ರಾಪರ್ಟೀಸ್ಗೆ ಅವ್ರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು. ಸೀರಿಯಲ್ ನಂಬರ್ ಅದರೊಳಗೆ ಅದೇ ಪೇಜ್ ನಲ್ಲಿ ಕೆಳಗಡೆ ಫಸ್ಟ್ ಅನ್ನಂಬರ್ಡ್ ಪ್ಯಾರಾಗ್ರಾಫ್ 3084 ಸಂಬಂಧಿಸಿರ್ತಕ್ಕಂಥದ್ದು LRAA 72 ಆಫ್ 87. ಇದು ಯಾರ್ದು? ತಿರುಮಲ ಶೆಟ್ಟಿದು. ಅಲ್ಲಿ ಹಿಂದ್ಗಡೆ ತೋರಿಸ್ಬಿಡ್ತೀನಿ ಇನ್ನೊಂದ್ಸಲಿ, 1 ಪೇಜ್ ಬಿಫೋರ್ ದಟ್. ಇದು ತಿರುಮಲ ಶೆಟ್ಟಿದು. ನೆಕ್ಸ್ಟ್ ಪೇಜು ಇಂಟರ್ನಲ್ ಪೇಜ್ 4 2814 ಅಲ್ಲಿ ಇರ್ತಕ್ಕಂಥದ್ದು LRAA 65 ಆಫ್ 87. ಇದು ವೆಂಕಟ್ ಶೆಟ್ಟಿದು. ಈಗ ಅವರು ಒಂದು ಮೆಮೊ ಹಾಕಿದ್ದಾರೆ, ಕೊಡಿ ಅದನ್ನ. ಅವ್ರು ಹೇಳ್ತಿರೋದು ಯಾರು ಅಂದ್ರೆ, ಪೇಜ್ ನಂಬರ್ 10 ಇನ್ ದಿಸ್ ಮೆಮೊ. ಯಾರು ಹಾಕಿದ್ದನ್ನ? ನಾವು ಈಗ ಕೊಡ್ತಾ ಇರೋದು ನಮ್ಮ ಮೆಮೊ. ಪೇಜ್ ನಂಬರ್ 10
of this memo.
Which I have now passed on. LRAA 65 ಆಫ್ 87 ಏನಿದೆ, ಅದರಲ್ಲಿ ಅವ್ರು ಅರ್ಜಿ ಹಾಕಿದ್ದಾರೆ, ವೆಂಕಟ್ ಶೆಟ್ಟಿ. ಇದಾದ್ಮೇಲೆ ಇದರೊಳಗೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ನಂಬರ್ 11 ಅಲ್ಲಿ ಏನೇನು ಅಮೆಂಡ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಅವ್ರು ಹಾಕೊಂಡಿದ್ದಾರೆ. ಸೊ ಈ ಅಮೆಂಡ್ಮೆಂಟ್ ಹಾಕಿರ್ತಕ್ಕಂಥ ಅರ್ಜಿ ಇದೇನಿದೆ, ಈ ಅರ್ಜಿಗೂ ಕೂಡ ಮತ್ತೆ ತಿರುಮಲ ಶೆಟ್ಟಿ ಪ್ರಾಪರ್ಟಿಗೂ ಸಂಬಂಧ ಇಲ್ಲ. 2 ಡಿಫರೆಂಟ್ ಸೆಟ್ ಆಫ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್.
Yes.
Now your lordships may kindly see the previous on the order sheet ಇದೆ. Page 70. ಎಷ್ಟು ಪೇಜ್ ನಂಬರ್ ಅದು ನೋಡ್ಬೋಣ. ಪೇಜ್ ನಂಬರ್ 97. ಅದೇ ತೋರಿಸ್ಕೊಡ್ತೀನಿ. ಚೂರು ಹಿಂದೆ ಮುಂದೆ ಆಗ್ಬಿಟ್ಟಿತ್ತು ನಾನು ಪೇಜ್ ನಂಬರ್ಸ್.
ನಿಧಾನಕ್ಕೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಕೇಳ್ಬೋದಲ್ಲ?
ಅಲ್ಲ, ಈಗ ಆರ್ ಟಿ ಸಿ ನನ್ನ ಹೆಸರಲ್ಲಿ ಇದೆ. ನನಗೆ ರೀಗ್ರಾಂಟ್ ಆರ್ಡರ್ಸ್ ಆಗಿತ್ತು. ವಿ ವರ್ ರೀಗ್ರಾಂಟೆಡ್ ವಿತ್ ದ ಲ್ಯಾಂಡ್ಸ್ ಅಂಡರ್ ದಿ ಇನಾಮ್ ಸೊಲ್ಯೂಷನ್ ಆಕ್ಟ್. ಅವ್ರದ್ದು ಫಾರ್ಮ್ ನಂಬರ್ 7 ಹಾಕಿರೋದು ಅವರು. ರೀಗ್ರಾಂಟ್ ನನಗಾಗಿತ್ತು. ಅದಾದ್ಮೇಲೆ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮುಂದೆ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಡೀತು. ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಮುಂದೆ ಏನಾಯ್ತು ಅಂದ್ರೆ, ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ನಡೆದಿದ್ದು ಇಷ್ಟು, ನಾವು ಅರ್ಜಿ ಹಾಕಿದೀವಿ ಅಂತ ಅವರು, ಯಾವ ಅರ್ಜಿನೂ ತಮ್ಮ ಫೈಲ್ ಮೇಲೆ ಇಲ್ಲ ಅಂತ ನಾನು ಅದನ್ನ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊಂಡ್ರು ಡೆಪ್ಟಿ ಕಮಿಷನರು. ಟು ಹಿಯರ್ ಆನ್ ವೆದರ್ ದೇ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ದ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ ನಾಟ್ ಅಂತ ಒಂದು ಹಿಯರಿಂಗ್ ಡೇಟ್ ಕೊಟ್ಟರು. ಆರ್ಡರ್ ಶೀಟ್ ಇಟ್ ಸೆಲ್ಫ್ ಡಿಸ್ಕ್ಲೋಸಸ್. Then the matter was posted for orders before the deputy commissioner. The question is whether or not they have filed the application or not. There's two page number. I'll also just, because there is nothing to show that they had ever filed an application. There's two page number.
No, but what was challenged in the LRRP?
LRRP ನಲ್ಲಿ ಫಾರಂ ನಂಬರ್ 7 ಅವ್ರಿಗೆ ಗ್ರಾಂಟ್ ಆಗಿತ್ತು, ಆಕ್ಯುಪೆನ್ಸಿ ರೈಟ್ಸ್ ಗ್ರಾಂಟ್ ಆಗಿತ್ತು. Anyacharya is the owners of the property because they were re-granted with the properties under the Inams Abolition Act. They challenged it under LRRP. LRRP ನಲ್ಲಿ all those orders were set aside. Granting occupancy rights in favor of Tirmalachar was set aside.
Yes.
And the specific direction was given saying that if only you amend your farm number 7, your farm number 7 will be alive, otherwise it will not be alive. That's the substance of the order. Now the question is, after so many years they are coming, after now what they say is we have filed it. Now that is what we have filed. Ade page number 97 kudi. Ade nan page number tally ಆಗ್ತಿಲ್ಲ. Same ಇದೆ. ಅದು ಒಂಚೂರು ನನಗೆ ಅದನ್ನ ಕೊಡಿ, ನಾನು ನೋಡ್ಬಿಡ್ತೀನಿ ಯಾವುದು ಅಂತ. ಅಲ್ಲ ಇದು ತಾವು ಸ್ವಲ್ಪ ಪೇಜ್ 97 ತಾವು ನೋಡಿ ಒಂಚೂರು. ಪೇಜ್ 97 ಅವರೇ ಹಾಕಿದ್ದಾರೆ.
ಈ ಪಿಟಿಷನ್ ಲಾ 28891
ಅವ್ರ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ಅವ್ರು ಹಾಕಿದ್ದಾರೆ.
ಯಾವ್ದ್ರಲ್ಲಿ?
29891 ಆಫ್ 2024 ಅಲ್ಲಿ ನಮಗ್ ಕೊಟ್ಟಿಲ್ವಾ ಅವ್ರು ಕಾಪೀಸ್ನ? ಇದನ್ನ ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ವಲ್ರಿ ಇದನ್ನ? ಇಲ್ದೇ ನಾ ಓದಿರ್ತಿದ್ದೆ. ಅದರಲ್ಲಿ ಮೇಲ್ಗಡೆ LRAA ಆ 65 ಹೊಡೆದ ಹಾಕಿ 72 ಮಾಡಿದ್ದಾರೆ ಆಫ್ 87.
ಪೇಜ್ 87.
ಪೇಜ್ 97 ಆ ಮೆಮೋನಲ್ಲಿ. ಅಲ್ಲಿ LRAA 65 ಹೊಡೆದ ಹಾಕಿ ಮೇಲ್ಗಡೆ 72 ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಇದಕ್ಕೊಂದು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇಲ್ಲ, ಏನಿಲ್ಲ. ಇದನ್ನ ಹಾಗೆ ಇಟ್ಕೊಳ್ಳಿ, ನನಗೆ ಇದೆಯೋ ಇಲ್ಲ ನಂಗೆ ಗೊತ್ತಿಲ್ಲ. ಈಗ ನೀವು ಕೊಟ್ಟಿರೋ ಕಾಪಿನಲ್ಲಿ ಇಲ್ಲ. ಅದಕ್ಕೆ ಈ ಪೇಜ್ ನಂಬರ್ 10 ನಾನು ಕೊಟ್ಟಿರೋ ಮೆಮೋನಲ್ಲಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ. 29/4/2004 ಮೆಮೋ ಇದೆ. ಅದ್ರ ಲೆಫ್ಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ. ಪೇಜ್ ನಂಬರ್ 10 ಇದೆ. ಇದು ಜೆರಾಕ್ಸ್ ಕಾಪಿ. So now the only question was this: whether or not form number 7 was filed. Deputy Commissioner had reserved this matter for orders.
Name also has changed. Tirumala Shetty, Venkat Shetty ಅಂತ ಎರಡು ಚೇಂಜ್
ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ RA 65 ಅಂತ ಇರೋದನ್ನ ಹೊಡೆದಾಕಿ 72 ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಯಾಕೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಅದು ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಏನ್ ಹೆಂಗ್ ಬರ್ದಿದ್ದಾರೆ ನನಗೂ ಗೊತ್ತಿಲ್ಲ. ಅಲ್ಲ ಒರಿಜಿನಲ್ ಈಗ ನಾ ಹೇಳಿದ್ನಲ್ಲ, ಒರಿಜಿನಲ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿರ್ತಾರೆ, ನಿಮ್ಮ ಹತ್ರ ಇರೋದಿಲ್ಲ. ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇರುತ್ತೆ.
ಆಯ್ತು, ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಒರಿಜಿನಲ್ ಇದೆ ಅಂತ ಹೇಳ್ತಿರೋದು.
Now the question with the Lord says the Deputy Commissioner had posted the matter for orders as to whether they have filed the application or not. Notes the RTC or the revenue entries is even today continuing in our name. Prior to almost 6-7 years, it is continuing in our name, and the whatever the interim order it says, Notes is not disrupted the continuance of the interim orders. Notes even if your Lords were to appoint a commissioner to find out, Notes, as to who is in possession of the property, it is not difficult because we are cultivating the properties. We sold the property to the purchaser. It is not that they were in possession of the property at any point of time. If that be so, from 2004 to 2023, my lords, they never raised their little finger. They never went before any court. Revenue entries were standing in our names.
Yes.
And kindly have a look at page number 277 in writ petition number 29891.
Now, when was the original order passed granting occupancy rights?
My lords, that is
ಆಯ್ತು, ಯಾವಾಗ ಫಸ್ಟ್?
my lords, that is 5587. 5587. ಇರ್ಲಿ. It's page 277, the findings, my lords, of the appellate court in that writ petition. Internal page 46 of the order impugned.
Page
277 ಅದೇ ಒಂಚೂರು ನಂದು ಪೇಜಿನೇಷನ್ ಹೆಚ್ಚು ಕಮ್ಮಿ ಇದೆ. Para 36 in MA order, page 277, 36, 281 plus 4 ಇವೆಲ್ಲ. It is pertinent to note that the plaintiffs have not taken any pain to produce the order sheet or any supporting document to show that they have filed application before the District Commissioner Hassan pursuant to the direction issued by the Honorable Court in LRRP. Plaintiffs, without producing any documents, is laid upon the circular issued by the government dated 31/2006, where the Deputy Commissioner Hassan, by relying on the said circular as per the letter dated 23/3/2006, has transferred the case to so and so Tahsildar Land Tribunal, Sakleshpura. It is pertinent to note that Tahsildar had issued the notice on 19/4 to the parties to appear on 5/4. Circular is issued on 3/1/2006, nearly lapse of 2 years. What happened before the District Commissioner Hassan for a period of 2 years is not forthcoming and no record is placed either by the parties. It is seen that pursuant to the circular in so and so was transferred to the Tahsildar Sakleshpur.
Trial court ಅಲ್ಲಿ ಏನಾಯ್ತು ಇಲ್ಲಿ?
Pardon me, Lords.
What happened to the?
Lords, trial court had granted an order of injunction. The first appellate court has upset the findings.
ನಿಮಿಷ ತಾಳಿ, you mean you people know the facts. I do not know the facts. I am new to this case. Let me understand the facts. Trial court granted injunction, huh?
And yes, two Lords, trial court had granted an injunction and rejected my application. There were 2 MEAs filed. MEA number 13, 14 and 15, 3 MEAs were filed. And the MEA which was filed, Lords, by the present respondents was allowed.
Purchaser is allowed.
Yes. Purchasers contesting this.
And also filed an injunction application. It came
IA 1 and 2. IA 1 and 2 ಒಂದು ಆಮೇಲೆ IA 4. IA 3. IA 1 and 2, IA 3, IA 4.
So what is the basis for allowing this MA?
Lords, this is essentially the finding, Lords, paragraph number 36.
Paragraph number?
36. Lords, because it's a 227 jurisdiction, your Lordships have already called upon this. No, absolutely no difficulty. But what was not placed before the first appellate
Please
court?
read this, let me understand.
Para 36 minutes at page 277, 281.
Yes.
It is pertinent to note that the plaintiffs have not taken any pain to produce the order sheet or any supporting document to show that they have filed application before the District Commissioner Hassan pursuant to the direction issued by the Honorable High Court in LRRP. The plaintiffs, without producing any documents, has relied upon the circular issued by the Government of Karnataka dated 31/2006, wherein the Deputy Commissioner Hassan, by relying on the said circular as per the letter dated 23/3/2006, has transferred the case number so and so to Tahsildar Land Tribunal, Sakleshpura. It is pertinent to note that DC Hassan has issued notice on 19/4/2004 to the parties to appear on 4/5/2004. Circular issued by the Government of Karnataka is 3/1/2006, nearly after lapse of 2 years. What happened before the District Commissioner Hassan for a period of 2 years is not forthcoming. No record is placed by either parties. It is seen that pursuant to the circular in so and so were transferred to the Tahsildar Sakleshpur. Tahsildar maintained an order sheet in number so and so wherein it discloses that the Tahsildar on 14/5/2019 has passed an order that the tenancy committee needs to be formed and case was disposed. It is to be seen that the proceedings RRT for 4 proceedings before the court of Tahsildar Sakleshpur and not the proceedings under the Land Reforms Act. Under the Land Reforms Act, the tribunal has to be constituted and Tahsildar has no power to conduct cases and pass an order which Land Tribunal Committee ought to have passed the orders. The core contention of the plaintiff that they are the owners and in possession of the suit properties. Property in question under defendant number 1 to 5 has no right to sell the same in favor of defendant number 6. It is an undisputed fact that even according to the plaintiffs, that Annayachar is the landlord of the suit properties in question and revenue entries is standing in his name. This is standing in his name, Lord. That's what it is. Their contention that Manjab Shetty is the tenant and after his demise, Thirmal Shetty, Venkat Shetty have become the tenants. Plaintiff and the defendant 7 to 10 are claiming occupancy rights through their father and grandfather. Whether Manjab Shetty was a tenant or not is not purview of this court to decide the case. As such, the said jurisdiction rests with the Land Tribunal. Since it is a suit for bare injunction, the only question that has to be looked into is who is the owner and in lawful possession of the property in question as on the date of filing of the suit. It is an admitted fact that according to the plaintiff, the defendant 7 to 10, that Annayachar is the landlord and is in the owner of the scheduled property in question. There is no dispute at all regarding the ownership of Annayachar. And even according to the plaintiff's defendant number 7 to 10, the revenue entries RTCs produced by both parties clearly discloses since from the year 1974 till 2023-24, the name of Annayachar finds place in column number 9 as the owner in question. In some records, the name of the Manjab Shetty finds place at column number 12 as a cultivator. Hence, it is undisputed fact that Annayachar was a owner of the properties in question. Even the latest RTC extracts the name of Annayachar is shown in both column number 9 and column number 12. This court has to bear in mind that since The suit is for bare injunction whether the plaintiffs or owners are in lawful possession of suit properties as on the date of filing of the suit is to be looked into. It is an undisputed fact that plaintiffs are not the owners of the suit properties. They are claiming to be the tenants under the ownership of Annayachar. Next question arises whether the plaintiffs are in possession of the suit properties as on the date of filing of the suit. Plaintiffs relying upon the order passed by the Honorable High Court of Karnataka, wherein the Honorable High Court of Karnataka has directed the parties to approach the District Commissioner and directed the parties to file Form number 7 with specific boundaries within 8 weeks, failing which directed the District Commissioner to reject the application as stated earlier. The defendant number 7 to 10 herein have produced an endorsement issued by the DC Hassan for having filed application as directed by the High Court of Karnataka. This court, as discussed above, has already stated that defendant number 7 to 10 are the legal heirs of Venkat Shetty. As stated above, defendant number 6 has obtained information under Right to Information Act, wherein no such application is filed before the Deputy Commissioner Hassan. Suit filed by the legal heirs of Tirumali Shetty. Plaintiff being the legal heirs of Tirumali Shetty have not produced any single piece of document before the court to show that they have filed an application by mentioning the boundaries within 8 weeks from the date of remand as per the orders of the Honorable High Court in LRRP petitions. Further documents such as the RTC extracts and other documents which are produced by defendant 7 to 10 shows the name of Venkat Shetty as the cultivator.
Again,
As-
what is the significance of this,
Which one, Milords?
this observation?
Venkat Shetty. Milords, that is Tirumali Shetty, what they are LRs of Tirumali Shetty, Venkat Shetty.
But there's some Venkat Shetty as a cultivator.
As a cultivator, Milords, defendants number 7 to 10 shows that the name of Venkat Shetty as a cultivator. As stated earlier, the suit is filed by legal heirs of Tirumali Shetty and the properties claimed by Tirumali Shetty and Venkat Shetty are entirely different. The suit scheduled properties are not claimed by legal heirs of Venkat Shetty. Hence, the documents produced by defendants 7 to 10 cannot be considered. The plaintiffs have not produced any document standing in the name of their father, that is Tirumali Shetty, pertaining to the scheduled properties. Learned counsel for the plaintiff has mainly relied upon the circular of the government and also transfer of case by the Deputy Commissioner Hassan and the order of the Tahsildar Sakleshpur. Prima facie, there is no material filed by the plaintiffs to show that after the remand, the application is filed by the District Commissioner as directed by the High Court. The next contention of the plaintiff that Honorable High Court has directed the parties to maintain status quo. It is an undisputed fact that the order with respect to possession of the suit properties, plaintiffs only cultivators of the land in question by way of tenancy. Suit is filed in 2024. RTC extracts of the suit properties is standing in the name of Annayachar, which clearly goes to show that Annayachar is the owner of the property in question as on the date of filing of the suit. Defendant number 6, who is claiming to be the purchaser, steps into the shoes of the original landlord.
Long and short of it is, they have to establish that they have filed some application.
Filed some application.
Yearly. How do you prove that you have filed an application?
Your Lordship, that's why you wanted the record.
Yes, madam. Let the government advocate say, yes, madam, what are the documents?
Sorry, I was not here on the matter.
Let the government advocate.
Tahsildar report ಓದ್ಬಿಟ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ.
Huh?
Report, Tahsildar report.
Form 7 ಹಾಕಿದಂತ. Sorry, I was not here on the matter.
ಇಲ್ಲ ಅದಲ್ಲ. ಈಗ
ತಹಸೀಲ್ದಾರ್ ರಿಪೋರ್ಟ್ ಈಗ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಈ ಕೊಟ್ಟರೆ ರಿಪೋರ್ಟ್.
RTI ಯಲ್ಲೂ ಅದೇ ಇದೆ.
Huh?
Let's me just read that, what is now served upon me by the government. ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ILR 3084, 3085, 3086, 2814 ರ ಪ್ರಕರಣಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವೆಂಕಟ್ ಶೆಟ್ಟಿ ಅಥವಾ ಇವರ ವಾರಸುದಾರರು ಜಯಮ್ಮ, ಸೋನ್ಸೋ, ತಿರುಮಲಿ ಶೆಟ್ಟಿ, ರಾಧಾಮಣಿ, ಪ್ರಕಾಶ್ ಹಾಗೂ ಗಿರೀಶ್ ನಮೂನೆ 7ರಲ್ಲಿ ತಿದ್ದುಪಡಿ ಮಾಡಿರುವ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಬಗ್ಗೆ ದಾಖಲಾತಿಗಳೊಂದಿಗೆ ದಿನಾಂಕ 25/11 ನ್ಯಾಯಾಲಯಕ್ಕೆ ದಾಖಲಾತಿಗಳನ್ನು ಹಾಜರುಪಡಿಸುವಂತೆ ಉಲ್ಲೇಖ ಇಮೇಲ್ ಸಂದೇಶದಲ್ಲಿ ಸೂಚಿಸಲಾಗಿರುತ್ತದೆ. ಸದರಿ LR ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ಪ್ರಕರಣಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ನಮೂನ 7 ರೆಡಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿರುವ ಕಡತಗಳು ಹಿಂದಿನ ಹಳೆಯ ಕಡತಗಳಾಗಿರುವುದರಿಂದ ಸದರಿ ಅರ್ಜಿಗಳನ್ನು ಕಚೇರಿ ಅಭಿಲಾಖಾಲಯ ಶಾಖೆಯಲ್ಲಿ ಸದರಿ ಕಡತಗಳನ್ನು ಹಾಗೂ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಯವರ ಕಚೇರಿಯಿಂದ ಸ್ವೀಕೃತವಾಗಿರುವ ಕಡತವನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಮೇಲ್ಕಂಡ ವೆಂಕಟ್ ಶೆಟ್ಟಿ ಅಥವಾ ಅವರ ವಾರಸುದಾರರು ಜಯಮ್ಮ, ಸೋನ್ಸೋ, ತಿರುಮಲಿ ಶೆಟ್ಟಿ, ರಾಧಾಮಣಿ, ಪ್ರಕಾಶ್ ಹಾಗೂ ಗಿರೀಶ್ ಅವರು ನಮೂನೆ 7ರಲ್ಲಿ ತಿದ್ದುಪಡಿ ಮಾಡಿರುವ ಯಾವುದೇ ಅರ್ಜಿಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ ಎಂಬ ಅಂಶದ ಬಗ್ಗೆ ದಿನಾಂಕ 27/11/2014 24 ಹಾಗೂ 3/12/24 ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಖುದ್ದು ಹಾಜರಾಗಿ ರನ್ಸ್ ವಸಂತಿ DL ಸೋನ್ಸೋ ನಿಮಗೆ ಮಾಹಿತಿಯನ್ನು ನೀಡಲಾಗಿರುತ್ತದೆ. ಈ ಬಗ್ಗೆ ಪುನರ್ ಪರಿಶೀಲಿಸಿ ಮಾಹಿತಿ ಪಡೆದು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರುಪಡಿಸುವಂತೆ ಮೌಖಿಕವಾಗಿ ತಿಳಿಸಿರುತ್ತೀರಿ. ಅದರಂತೆ LRF ಸೋನ್ಸೋ ಪ್ರಕರಣಗಳಿಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವೆಂಕಟ್ ಶೆಟ್ಟಿ ಅಥವಾ ವಾರಸುದಾರ ಜಯಮ್ಮ, ತಿರುಮಲಿ ಶೆಟ್ಟಿ, ರಾಧಾಮಣಿ, ಪ್ರಕಾಶ್, ಗಿರೀಶ್ ಅವರು ಘನ ಉಚ್ಚಲಾಯಿಕೆ ಆದೇಶದಂತೆ ನಮೂನೆ 7ರಲ್ಲಿ ತಿದ್ದುಪಡಿ ಮಾಡಿರುವ ಯಾವುದೇ ಅರ್ಜಿಗಳನ್ನು ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ ಎಂಬ ಅಂಶವನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಧೀಶರಿಗೆ ಘನ ಅವಗಣನೆಗೆ ತರಬೇಕೆಂದು ಈ ಮೂಲಕ ಕೋರಲಾಗಿರುತ್ತದೆ.
But there is one more aspect that is important.
Let me please. One after the other, please. So according to you, no applications are filed for amendment.
In a span of 8 weeks, they are supposed to file before the DC hasn't.
Uh.
No such application forthcoming.
Whether the application was filed before the Tahsildar or before the DC.
The office states that should be filed before DC hasn't.
Uh.
But however, the Tahsildar, when I wrote.
Custodian of the records minutes.
Yes.
Hmm.
I,
But it is an application book reference.
The Tahsildar may not have any information about the document.
But I'm told that the office has been transferred. DC in that it has moved to the Tahsildar, what the order should be. What is the reason?
Ido-
that Tahsildar is not
I,
doing?
No, whether the file is.
that files
transferred to the
close
Tahsildar.
ಆಗ್ಬಿಟ್ರೆ DC office ನಲ್ಲಿ,
Goes to Tahsildar.
it goes to Tahsildar. Tahsildar becomes the custodian.
So the
That
Ta-
they can ascertain because that's
That's
what,
the point out.
ಅದು ಅವರೇ ascertain.
Madam.
That is all.
There is no amendment application filed to form number 7.
Oh, I'm so sorry, but please take it. Yeah.
ಏನೋ RTL ತಗೊಂಡಿದ್ರಲ್ಲ ಏನದು? You said that you had taken some application through RTI.
Index, whatever is given.
Yeah.
ಅಲ್ಲಿ ಮೇಲ್ಗಡೆ.
There's some Tirumala Shetty. Tirumala Shetty. Nim client Tirumala Shetty, na?
ಒಂದೇ ಇರೋದು. That's a very important point there. Claimant is
ಅಲ್ಲ,
filed
ವೆಂಕಟಶೆಟ್ಟಿ ನಿಮ್ಮವರಲ್ಲ
asserting
ಅಂತ.
right over 84 acres. There are two brothers.
Ah.
At best, one brother can get only half. One brother, my lord, would say that entire area he should get an injunction over. It can't be.
This,
Ah,
some
so you can't
application,
file a suit on
some
behalf of
application, Mr. All of us start shouting it leads us nowhere.
ಏ, ಒಂದು
Tirumala Shetty is the one who has filed some application as per this endorsement of some register, whatever. Tirumala Shetty, the number is also not mentioned, LRRA/87 ಅಂತ ಇದೆ.
ಅವ್ರಿಗೊಂದು ಕಾಪಿ ಕೊಡಿ.
And this,
ಒಂದ್ ವಿಚಾರ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬಿಡ್ತೀನಿ. ತಿರುಮಲ ಆಯ್ತು. ವೆಂಕ್ ಶೆಟ್ಟಿ's LRs are not before the court as plaintiffs.
ಆಯ್ತು, ಕೊಡಿ ನೋಡೋಣ ಅದು ಏನು.
May I just pass this on, my lords? I have made a table of the applications filed. ಅಲ್ಲ, ಈಗ ವೆಂಕ್ ಶೆಟ್ಟಿ LRs are not before the court.
ಅಲ್ಲ, anyway, now the Tahsildar is here.
Yes. ಇಲ್ಲಿ ಅಸರ್ಟೈನ್ ಮಾಡ್ಲಿ, ನಮ್ದೇನಿಲ್ಲ.
ಎಲ್ಲಿದೆ ಇದು?
ಇದೆ ಇಲ್ದಿರಿಲ್ಲ.
Yes, where do you get this? Venkat Shetty ಎಲ್ಲಿದೆ ಇಲ್ಲಿ? 1, 2, 3, 4, 5, Venkat Shetty. RA 65.
ಈ application form 7 ಅಂತ ಹೇಗೆ claim ಮಾಡ್ತಾರೆ sir?
DC office.
ಅಲ್ಲ, ಒಂದು ಕೆಲಸ ಮಾಡಿ, ಎರಡು ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ, ವಿಲ್ ಆಸ್ಕ್ ದಿ ತಹಸೀಲ್ದಾರ್ ಟು ಫೈಂಡ್ ಔಟ್.
Yes.
ಕೊಡಿ, ಒಂದು ನಿಮಿಷ ತಾಳಿ, ಪ್ಲೀಸ್ ವೆಯ್ಟ್. ವಿಲ್ ಆಸ್ಕ್ ದಿ ತಹಸೀಲ್ದಾರ್ ವೆದರ್ ದಿಸ್ ಟೂ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನೀವೊಂದು ಕೊಟ್ರಲ್ಲ ಈಗ, ಕೊಡಿ. ಮಿಸ್ಟರ್ ರವಿಶಂಕರ್.
ಇದು ಮೆಮೋ ಜೊತೆ ಕೊಟ್ಟಿದ್ದೀನಿ ಅದು. ಅದೇ ನೀವು ನೋಡಿದ್ರಲ್ಲ ಈಗ ವೆಂಕ್ ಶೆಟ್ಟಿ ಹಾಕಿದ್ದು.
ನಾನು ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಸರ್. ಇದೆ
ಪೇಜ್ ನಂಬರ್ 10.
ಪೇಜ್ ನಂಬರ್ 10. ಆಮೇಲೆ ನೀವು ಕೊಟ್ಟಿದ್ದು ಕೊಡಿ, ಎಲ್ಲಿದೆ? ಅಲ್ಲ, ಈ ತರದ್ದು
Tirumala Shetty
ಕೊಡಿ ಇಲ್ಲಿ. You ask the Tahsildar to take photos of these two documents and find out whether these two documents are there in the file or not. Have you got the file?
We'll give a photocopy.
Let her take a photo. It becomes easy for her to send it by WhatsApp or whatever. ಕೊಡಿ ಅದೊಂದು.
ನಾನು ನೋಡ್ತೀನಿ. ಅವ್ರು ಕೊಡಿ.
ಹುಷಾರಾಗಿ ವಾಪಸ್ ಕೊಡಿ.
ಇದು ಕೊಡಿ.
What is that?
ನೀವು ರೆಡ್ಡಿಗಳ ಕೇಸ್ ಹ್ಯಾಂಡಲ್ ಮಾಡಿ ನಿಮ್ ಶೆಟ್ಟಿ ಬಾಯಿಗೆ ಬರ್ತಾ ಇಲ್ಲ.
No, but the entire file must have come to you then. See, if the file is transferred to you, even these applications must have come to you because RA number is mentioned. Pass over ಮಾಡ್ತೀನಿ ತಿಳ್ಕೊಂಡು ಹೇಳಿ.
ಆಯ್ತು.
Pass over.
Additional documents are come down in the 107. The BTPL file, along with additional documents. 107 GG the order sheet of the proceedings.
DC ನಾನೇ ಕೊಟ್ಟನಲ್ಲ ಮೆಮೊ ಜೊತೆ ಅದರಲ್ಲೇ.
Yes.
Case called under 2004.
Starting.
ನನ್ನ ಮೆಮೊನಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 6.
Yes.
Posted for orders. ಆಮೇಲೆ posted for orders ಅಂತ continue ಆಗುತ್ತೆ. ಆರ್ಡರ್ಸ್ ಆಗ್ಲೇ ಇಲ್ಲ. ಆಮೇಲೆ ಟಿಪ್ಪಣಿ ಅಂತ ಇದೆ, ಕಚೇರಿ ಟಿಪ್ಪಣಿ ಆಮೇಲೆ 117 ಇಂದ. ಆ ಟಿಪ್ಪಣಿ ಅವರು ಫೈಲ್ ನೋಟಿಕ್ಸ್ ಅಲ್ಲಿ the last
ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರಾ ಕಾಪಿ ಅದು?
122 page 122. ದಿನಾಂಕ ಅಂತ ಕಚೇರಿ ಬಾಕಿ ಇರುವ ಎಲ್ಲ ಪ್ರಕರಣಗಳನ್ನು ಆಯಾ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿಗಳು ಸಲ್ಲಿಸಿ ಕೊಡಬಹುದು. ಆಮೇಲೆ ಏನು ಆಗಿರುತ್ತೆ ಯಾರು that is why we say our applications are in fact this
Yes.
court has said should be rejected.
Yes, madam. Can you find out? No, if you can get it verified from your office, send it by WhatsApp and get it checked. They say that some we'll appoint some receiver, let the receiver till the next date of hearing.
ಇದು ಎಲ್ಲ
ದುಡ್ಡು ಗಿಡ್ಡ ಅದು ಬೇರೆ ವಿಚಾರ. Let a receiver be appointed. Let somebody harvest the crop.
But 3 crops, there's coffee, paddy and blood.
Areca.
ಎಲ್ಲ
Let we'll deposit whatever it is in the court.
No, you harvest it
Please.
in the presence of a receiver.
No difficulty. Your lordship may appoint a commissioner or a receiver, no difficulty. February. Predecessor is here.
No, he says that he has raised it.
Correct.
ಇಷ್ಟು ವರ್ಷ
Purchaser in his written statement says, I have now leased the entire land for ginger cultivation to somebody else. In the written statement is the same.
If you want a commissioner to be appointed to go and see what is there in the land, we'll appoint. ಅಲ್ಲ ಸರಿ, ನಿಮ್ ಪ್ರಕಾರ ಏನಿದೆ? ಹಾರ್ವೆಸ್ಟ್ ಇದು ಕಾಫಿ ಏನೋ ಜಿಂಜರ್
Paddy no ಇದೆ. I'll place photographs.
ಆಯ್ತು.
ನಮ್ಮ ಹತ್ರನೂ ಇದೆ ಬಿಲ್ಸು.
Any advocate who wants to have a vacation in exotic
ಎಲ್ಲಿರೋದ್ರಿ ಇದು?
But your lordship says paid vacation.
me harvest rice. Let somebody do it. Let it be done in the presence of a
Please, I have no difficulty.
receiver or a commissioner. ಶ್ರೀನಿವಾಸ್ ಅವರು ಏನು ಫ್ರೀ ಆಗಿದ್ದೀರಾ? ಮಾಡ್ಬೋದಾ? ಹೇಳಿ, ತೀರ್ಮಾನ ಮಾಡಿ ಹೇಳಿ ಏನು ಅಂತ. ಶ್ರೀನಿವಾಸ್ ಅವರು ವಿಲ್ ಅಪಾಯಿಂಟ್ ಹಿಮ್ as the ಕಮಿಷನರ್. ಅವ್ರಿಗೆ ಅಲ್ಲಿ ವಾಸಕ್ಕೆಲ್ಲ ಮನೆ ಇದೆಯಾ? ಅಲ್ಲಿ ಮನೆ ಇದೆಯೋ? ಯಾರು ಕಮಿಷನರ್ ವಾಸ ಮಾಡೋದಕ್ಕೆ ಮನೆ ಇದೆಯಾ ಅಲ್ಲಿ? ಆಯ್ತು, anyway, I'm only concerned with the commissioner.
Correct.
I'm not concerned about you or them, commissioner. Commissioner ಗೆ ಎಲ್ಲ ಸುವಿಧೆ ಇರಬೇಕು.
ಅದ್ ನಾವು ಅನುಕೂಲ ಮಾಡ್ತೀವಿ.
ಹಾ.
Approximate.
ಆಯ್ತು, pass over. In the meanwhile, try to find out. Pass over. ಆಮೇಲೆ ಇದು ಕಮಿಷನರ್ಸ್ ಫೀಸು ಅಷ್ಟೇ ತೀರ್ಮಾನ ಮಾಡ್ತಾರೆ.
ಅದು
ಎಷ್ಟು ಎಕರೆ ಇದೆ?
ಕಮಿಷನರ್ ತಾವೇ ಹೇಳ್ಬಿಡಿ, ಫೀಸು ತಾವೇ ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಡಿ, ನಾವು ಯಾವ್ದಕ್ಕೂ ತಕರಾರು ಮಾಡಲ್ಲ.
ಅಲ್ಲ,
ಅವರು ವೆಕೇಶನ್ ಅಲ್ಲಿ ಹೋಗ್ತಾ ಇದಾರೆ, ಅದನ್ನ ಗಮನದಲ್ಲಿ ಇಟ್ಕೊಂಡು ಫೀಸ್
ಅದಕ್ಕೆ ನಾನು 100 ಎಕರೆ ಅಲ್ವಾ?
ಹಾ ಹೌದು, ಅದನ್ನ ನಮ್ದೇನಿಲ್ಲ, ತಕರಾರಿಲ್ಲ.
ಆಯ್ತು.
ಅವರು ಸೀನಿಯರ್ ಏನಿಲ್ಲ ಅಂತ ಹೇಳೋದು.
ಅಲ್ಲ, ಪೊಸಿಷನ್ ಅಲ್ಲ, ನಿಮ್ ಪ್ರಕಾರ ಪೊಸಿಷನ್ ನೀವಿರೋದು, ಪೊಸಿಷನ್
ಇಲ್ಲ, ಕೊಡ್ತೀವಿ, ನಾವೇ ಕೊಡ್ತೀವಿ. ಆಯ್ತು ಆಯ್ತು.
ಅಂದ್ರೆ ಕಮಿಷನರ್ಸ್ ಫೀ ಕೊಡೋದಕ್ಕೆ ಅವರು ಪಾಸ್ ಓವರ್.
Appearing for the respondent in this case, sir, your lordship, this is regarding the blood samples which need to be collected at 3 PM by petitioner 1.
ಬಂದ್ರೆ Madam, the medical superintendent is going to come at 3 PM. Because we asked the
It was at 3
officials to come at 3 PM. We'll take it up at 3 PM.
27, Vijay Kumar T. Please, ma'am, for the response.
To submit report by court commissioner. ಬಂದಿದ್ಯಾ?
ಬಂದಿದೆ. Just come. Just come.
ಎಲ್ಲಿದೆ ರಿಪೋರ್ಟ್ ಇದೆನಾ? ಹಾ.
No, what was said is whether it is being put up, construction is put up in the first floor or not.
Plain tower moves. ಹೇಳಿ. Page? 13. ಹಾ. ಎಲ್ಲಿ ಓದ್ತಿದ್ರು? ಪೇಜ್ 13 ಅಲ್ಲಿ ಮನೆಗೆ ವಿದ್ಯುತ್ ಇಲಾಖೆಯಿಂದ ಸಂಪರ್ಕ.
ಪಾವತಿ ಮಾಡಿಕೊಂಡು ಯಾವುದೇ ತಕರಾರುಗಳಿಲ್ಲದೆ ವಾಸ ಮಾಡಿಕೊಂಡು ಕೊಟ್ಟಿರುತ್ತಾರೆ. ವಾಸ ಇತ್ತೀಚೆಗೆ ಹಳೆಯ ಮನೆಯಲ್ಲಿ ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳನ್ನು ನಿರ್ಮಿಸಿಕೊಂಡಿದ್ದು ಅವುಗಳನ್ನು ಬಾಡಿಗೆಗೆ ನೀಡಿರುತ್ತಾರೆ. ವಿದ್ಯಮಾನಗಳು ಹೀಗಿರುವಂತೆ ವಾಸಿಗೆ ನೆಮ್ಮದಿ ಸ್ವಾತಂತ್ರ್ಯ ಸಾರ್ವಜನಿಕರಿಗೆ ಪ್ರತಿವಾದಿಗಳು ಯಾವುದೇ ಹಕ್ಕು ಸ್ವಾತಂತ್ರ್ಯ ವಾಸಿನ ಹಕ್ಕು ಮಾಲೀಕತ್ವಕ್ಕೆ ಒಳಪಟ್ಟಿರುವ ಪ್ರತಿವಾದಿಗಳು ಸಂಬಂಧ ಸೃಷ್ಟಿ ಮಾಡಿಕೊಂಡು ತಂದೆ ತಕರಾರು ಮಾಡುತ್ತಾರೆ. ವಾದಿಯರು ಒಕ್ಕಲುತ್ತಿರುವ ಪ್ರಯತ್ನ ಮಾಡುತ್ತಿರುತ್ತಾರೆ. ನಿವೇಶನದಲ್ಲಿ ನಿರ್ಮಿಸಿರುವ ಕಟ್ಟಡಕ್ಕೆ ಬಂದಿ completed and deciding and this premises and this base where the defendants have disputed the very allocation of the property. According to that, there is a free share and the share which has been given to the
ಇವೆಲ್ಲ ಅಣ್ಣ ತಮ್ಮಂದ್ರ? both of them are brothers?
ದಾಯಾದಿಗಳು ಅಲ್ಲ, ದಾಯಾದಿಗಳು ಒಂದು ಅಷ್ಟೇನೆ, ಅದಕ್ಕೆ ಯಾಕೋ
has been given in the middle, and whereas the other two brothers were given on either side. But she has been putting up of construction in the share which has been allotted to me. Therefore, I have disputed the very possession of the plaintiff so far as the scheduled property is concerned. Now, Rashmi, kindly come to the commission's report. Page 3, page 4. C ಮತ್ತೆ D ಓದ್ತೀನಿ.
Page
4. After entering the passage, there is a staircase found on the left side, which leads to the floors above, where new constructions are being put up. This staircase, as is seen from annexure D9, begins right behind the existing building and in front of the new building. The new constructions being put up on the floors above are being laid down in such a manner that it spreads across the area on top of the new building as well as the already existing buildings, which are all contiguous, so and so. My lord, I have no objection insofar as the present existing building. And the guise of this interim order, my lord, they have been putting up a construction. This is my grievance.
No, but where is the finding of the commissioner that construction is being put up outside this area?
ಅಲ್ಲ ಅದೇನೆ ಹೇಳಿದ್ನ ಇನ್ನೊಂದ್ಸತಿ. After entering the passage, ಮೇಲಿಂದ ಓದ್ತೇನೆ. On completion of the inspection. Para 5. Subject property, the undersigned respectively submits that there is already an existing structure building on the subject property, which can be seen at annexure D3.
D3.
Kindly say annexure D3.
D3.
ಇದು old building. The passage. ಇದಕ್ಕೆ ನನ್ನ ಇದೇನಿಲ್ಲ, ಅದು ಮುಂದಕ್ಕೆ ಇದು ಮಾಡ್ಕೋಬಹುದು.
D3 ಇರೋದು ಸಬ್ಜೆಕ್ಟ್ ಪ್ರಾಪರ್ಟಿನಾ?
ಅಲ್ಲಲ್ಲ, ಹಿಂದೆ D3 ಅಲ್ಲ, ನನ್ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಬೇರೆ, ಹಿಂದ್ಗಡೆ ಇವು ಹೊಸದಾಗಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಅಲ್ಲ ಸರ್, ಕಮಿಷನರ್ಸ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಿರುವಂತದ್ದು ಸಬ್ಜೆಕ್ಟ್ ಪ್ರಾಪರ್ಟಿ D3 ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು, ಅಲ್ಲಲ್ಲ, ಇದು D9 ಅಲ್ಲಿ ಇದೆ. ಅದು D9 ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಾ ಇರೋದು. ಪೇಜ್ 20. ಪೇಜ್ 20 ಮೇಲೆ
ಸಬ್ಜೆಕ್ಟ್ ಪ್ರಾಪರ್ಟಿ ವಿಚ್ ಕ್ಯಾನ್ ಬಿ ಸೀನ್ ಅಟ್ ಎಕ್ಸಿಬಿಟ್ ಅನ್ನೆಕ್ಷರ್ D3 ಅಂತ ಕಮಿಷನರ್ ಹೇಳಿದ್ದಾರೆ.
ಹೌದು,
ಈ D3 ಎಲ್ಲ ನೋಡಿದ್ರೆ ಏನೋ SLV ಎಂಟರ್ಪ್ರೈಸಸ್ ಅಂತ ಇದೆ.
ಹೌದು.
Is that the only property or bigger one?
D1, D2 are all the
ಬಿಗ್ಗರ್ ಒನ್ ಇದೆ.
D1 and D2.
ಪ್ರಾಪರ್ಟೀಸ್ ಬಿಗ್ಗರ್ ಒನ್ ಮೈ ಲ್ಯಾಂಡ್. ಈ ಯಾವ್ದಾದ್ರು ಈ ಫಸ್ಟ್ ಇದಿದೆಯಲ್ಲ ಫೋಟೋಸ್, ಇದು ಹಳೆ ಬಿಲ್ಡಿಂಗ್, ಅದು ಹಿಂದೆಗಡೆ ಕಾಣಿಸ್ತಾ ಇದೆಯಲ್ಲ D1 ಅಲ್ಲಿ, ಅಲ್ಲಿ adjacent to this existing building, my lord, they have been putting up a construction on the guise, my lord, that they have already let out the premises in question. This is under construction behind this old building. D1, Lashma Kandi annexure D1.
Yes.
When there is a pleading, my lord, that it has been let out and construction is completed, they are not supposed to put up construction on the guise of this interim order.
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆಯಲ್ಲ.
ಆಗಿಲ್ಲ, ಅದೇನೆ ಹೇಳ್ತಾ ಇರೋದು. C ನಲ್ಲಿ, D ನಲ್ಲಿ
ಅನ್ನೆಕ್ಷರ್
ಅಲ್ಲ, ಪೇಜ್ 4 ನಲ್ಲಿ ಆಫ್ಟರ್ ಎಂಟರಿಂಗ್ ಪ್ಯಾಸೇಜ್ ಪ್ಯಾರಾಗ್ರಾಫ್ C ಮೇಲೆ
ಫಸ್ಟ್ ಇಂದ ಓದ್ಬಿಡಿ. ABC. There is
On
already
completion
an
of the inspection
existing
subject
structure.
matter so and so. There is already an existing structure building on the subject property which can be seen at annexure D3. That is old building ಮೇಲೆ D3 ನಲ್ಲಿ ಫೋಟೋಗಳು. The passageway of the said existing structure building leads to the area where a new building has been constructed.
ಇದ್ರ ಹಿಂದ್ಗಡೆ.
ಹಿಂದ್ಗಡೆ.
D3 ಹಿಂದ್ಗಡೆ.
ಹೌದೌದು. Which can be seen at annexure D4, D5.
ನೋಡಿ, what is D4, D5? D4 and D5. Yes.
ಹೌದು, ಇದನ್ನ ಕಟ್ತಾ ಇರೋದು ಹೊಸದಾಗಿ.
Then
the said new building is annexed to the already existing building.
Yes.
The entry to the new building, as can be seen from annexure D4, D5, is created by a partition in the existing building structure, and the entry is in the nature of a passage which is part of existing building. After entering the passage, there is a staircase found on the left side which leads to the floors above where new constructions are being put up. This staircase is as seen from annexure D9, begins annexure D9 notice.
Yes.
ಇದು ಈ ಕಡೆ ಹೊಸ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ. ಅದಕ್ಕೆ ಹಳೆ ಬಿಲ್ಡಿಂಗ್ ಗೆ ಸ್ಟೇರ್ ಕೇಸ್ ಅಡ್ಜಾಯಿನ್ ಮಾಡ್ಕೊಂಡು ಹೊಸ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ತಾ ಇದ್ದಾರೆ. Begins right behind existing building and in front of the new building. The new constructions being put up on the floors above are being laid down in such a manner that it spreads across the area on top of the new building as well as the already existing buildings, which are all contiguous, as can be seen from annexure D1, D2.
Now, where is this building constructed? Annexure B series ಇದೆಯಲ್ಲ, ಇದು ಯಾವ್ದಿದು?
ಯಾವುದು?
What is annexure B series?
B, my lord.
B for Bangalore. The petitioners had handed over 2 photographs.
ಇದು after demolition ಮಾಡಿದ್ದು.
ನಿಮ್ದು ಹಳೇದಿದೆ. ಹಳೇ ಫೋಟೋಗ್ರಾಫ್ ಹಾಕ್ಬಿಟ್ಟಿದ್ದೀರ.
ಹೌದು, ಹಳೇದಿದು.
ಸೊ ಆಗ್ಲೇ ಬಿಲ್ಡಿಂಗ್ ಆಗೋಗಿರೋದನ್ನ ಇವಾಗ ಹೇಳ್ತಾ ಇದಾರೆ ಬಿಲ್ಡಿಂಗ್
ಇಲ್ಲ ಇಲ್ಲ, ನೀವು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರಲ್ಲ ಕಮಿಷನರ್.
ಬಿಲ್ಡಿಂಗ್ ಇಸ್ ಆಲ್ರೆಡಿ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್.
ಇಲ್ಲ,
ಇಟ್ ಇಸ್ ಆಲ್ರೆಡಿ ಕನ್ಸ್ಟ್ರಕ್ಟೆಡ್ ಸರ್. ಈ ಫೋಟೋಸ್ B series ಏನ್ ಕೊಟ್ಟಿದ್ದೀರೋ, this photographs which you have furnished to the commissioner B series was the construction which was put long earlier, long ago.
No, it can't be. New construction ಅದ ಮೀನಿಂಗ್ ಏನ್ ಅರ್ಥ ಹಾಗಾದ್ರೆ? ನ್ಯೂ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಅಂತ ಹೇಳಿದ್ರೆ
ನ್ಯೂ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂದ್ರೆ ನೀವು ಕೊಟ್ಟಿರೋ ಫೋಟೋಸ್ ಇದೆಯಲ್ಲ ಅನೆಕ್ಷರ್ ಬಿ ಸೀರೀಸು, ಅದು ಫೌಂಡೇಶನ್ ಹಾಕುವಾಗ ನೀವು ತೆಗ್ದಿರ್ಬೋದು, ಇಲ್ಲ ಅಂತ ನಾನು ಹೇಳೋದಿಲ್ಲ. ಫೌಂಡೇಶನ್ ಹಾಕುವಾಗ ತೆಗ್ದಿದ್ದೀರಿ. ಬಟ್ ಇವಾಗ ಕಮಿಷನರ್ ಹೋದಾಗ ಬಿಲ್ಡಿಂಗ್ ಇಸ್ ಆಲ್ರೆಡಿ ಕಂಪ್ಲೀಟ್.
ಎಲ್ಲಿದೆ ಸಿ ನಲ್ಲಿ ಡಿ ನಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ?
ಯಾವುದು?
ಪೇಜ್ 4 ಮತ್ತೆ ಸಿ ಅಂಡ್ ಡಿ ಓದ್ದೆ ನಾನು ಇವಾಗ. ಕಂಪ್ಲೀಟೆಡ್ ಅಂತ ಎಲ್ಲಿದೆ?
ನೀವು ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇದೆ.
ಫೋಟೋಗ್ರಾಫ್ಸ್ ಬೇಡಿ ಸ್ವಾಮಿ. ಅನೆಕ್ಷರ್ ಸಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ಸಿ ಅಂಡ್ ಡಿ ನಲ್ಲಿ ವೇರ್ ಇಸ್ ಇಟ್ ಇಸ್ ಕಂಪ್ಲೀಟೆಡ್ ಅಂತ.
Why do you get annoyed?
ಅಲ್ಲಲ್ಲ ಅನಾಯ್ಡ್ ಅಂತ ಹೇಳಿದ್ರೆ,
Mr. Senior Counsel, I have not gone to the spot.
therefore I
have not gone to the spot. I am trying to understand.
My lord, I have also
I am
not.
trying to understand your case.
Yes, my lord.
Don't make round faces in the court.
ಇಲ್ಲ, I am not making
ನಿಮ್ಗೆ ಕೋಪ ಬಂದ್ರೆ please spit it out. Don't make round faces.
ಅಲ್ಲ, ಇಲ್ಲಿ ನಾನು ಹೇಳ್ತಾ ಇರೋದು,
Don't make round faces. I am telling you.
I am not making any round faces, my lord.
You did make.
Sorry, my
We
lord.
respect you, but you should also respect the court.
True, my lord. Sorry.
If you don't respect, you will not get any the least respect.
Sorry, my lord.
We respect you. ನೀವು ಹತ್ತಿರ ಗೌರವ ಕೊಡಿ. ನೀವು ಗೌರವ ಕೊಡ್ತಿದ್ರೆ you don't deserve any respect.
Lordship, kindly see, my lord, my submission to your lordship, my lord, I have read the plain.
ಸರಿ, ನಾನು
According to them.
I am asking you, these series photographs are the photographs that you gave to the commissioner at the spot.
ಇಲ್ಲ, ನಾನು ಕೊಟ್ಟಿರೋದಲ್ಲ.
ಓದಿ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಓದಿ.
ಈ ಸೀರೀಸ್ ನಾನು ಕೊಟ್ಟಿರೋದು.
ಓದಿ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 3 ಓದಿ.
My lord, both the para 3, my lord. Both the parties have commonly identified the subject property. During the time of inspection, the case of the petition is that the constructions being put up by the respondent is on the first floor of an entirely new building and not on the building that is already existing on the property. On the other hand, it is the case of respondent that there are no separate buildings and that the building that is being constructed is in continuation of an already existing building. The petitions had handed over 2 photographs during the time of inspection, which are produced here with Annexure B series.
Yeah.
The respondent had handed over a copy of the East Swattu to support their case that all the properties form part of the
At
consolidated
least will
portion
you
of the-
now accept that B series photographs are given by you?
ಅಲ್ಲ, ಬಿ ಸೀರೀಸ್ ನಲ್ಲಿ ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥದ್ದು
ಅಲ್ಲ,
weakness ಅಲ್ಲ
ಇರ್ಲಿ.
ಸ್ವಾಮಿ.
ನೀವು ಕೊಟ್ಟಿದ್ದು ಅಂತ ಒಪ್ಕೋತಿರ್ತಾನೆ.
ಆಯ್ತು.
So it's a mistake on your part.
Maybe.
ಅಲ್ಲ ಮೇಬಿ ಅಲ್ಲ, say yes.
Yes, my lord. ಇದು ವೇಕೆಂಟ್ ಪೋರ್ಷನ್.
ಸೊ ಇದು ಈ ಅನೆಕ್ಷರ್ D3 ಇರೋ ಪ್ರಾಪರ್ಟಿ ಹಿಂದ್ಗಡೆ ಇರೋದು, ಕರೆಕ್ಟಾ?
ಹೌದು.
And whatever is found in annexure B series is the property, is the photograph of the property which is behind annexure D3.
ಹೌದು.
Correct ಅಲ್ವಾ?
ಹೌದು.
Now the commissioner says ಈ D3 ಗೆ ಒಂದು ಪ್ಯಾಸೇಜ್ ಮಾಡಿದ್ದಾರೆ.
ಪಕ್ಕ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಬಿಲ್ಡಿಂಗ್ ಪಕ್ಕ
ಮಾಡಿದ್ದಾರೆ, ಅದರಿಂದ ಹೊಸ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿದ್ದಾರೆ.
ಪಕ್ಕದಲ್ಲಿ ಕಟ್ತಾ ಇದ್ದಾರೆ.
ಕಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. And see the photograph.
ಒಂದ್ ನಿಮಿಷ. ಅಲ್ಲ, ಸಿ ಇನ್ನೊಂದ್ಸತಿ ಓದ್ಬಿಡ್ತೀನಿ. After page 4, after entering the passage, there is a staircase found on the left side which leads to the floors above where new constructions are being put up.
Yes.
This staircase, as seen from annexure D9, begins right behind the existing building and in front of the new building. ಅಂದ್ರೆ are being put up ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
Commissioner is here.
She is here.
Yes, madam. Madam, what was your observation? Is the building complete superstructure?
Superstructure constructions are still going on the.
No, what is it? The walls are built?
There are the pillars have been laid down.
The walls are not built?
Ground floor ಅಲ್ಲ, first floor ಅಲ್ಲ.
I'm talking about the floors above now.
First floor.
First floor.
First-
First floor, only pillars have been laid
The
down.
ground floor, the construction is, building is complete?
Inside, there are still some works that are being carried.
So the superstructure in the ground floor is complete?
Yes.
And the pillars are being put on the first floor?
ನಾನು ಹೇಳೋದು ವೆರಿ ಪ್ಲಿಂಟ್ ನಲ್ಲಿ ನಾನು ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನೆಕ್ಷನ್ ತಗೊಂಡಿದ್ದೀನಿ, ರೆಂಟ್ ಔಟ್ ಮಾಡಿದ್ದೀನಿ. ಐ ಹ್ಯಾವ್ ಬಿನ್ ಇನ್ ಪೀಸ್ಫುಲ್ ಪೊಸಿಷನ್. Building is complete. This is the averments.
That's okay. Now what is the application filed?
Application on the same line only.
Injunction ಏನ್ application ಆಗಿ?
Not to interfere.
Annexure B, my lord.
Annexure?
B, page 15.
15.
ಹೌದು.
ಸೇಮ್
ತಾತ್ಕಾಲಿಕ ಅವರ ಕಡೆಯಿಂದ ಬರುವ ಬೇರೆ ಬೇರೆ ಅತಿಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ತಂಟೆ ತಕರಾರು ಮಾಡದಂತೆ ಈ ದಾವಾ ಸೋ ಅಂಡ್ ಸೋ ಅಂತ ಇರ್ತಾರೆ. ರೀಸನ್ ಮಲಾಟ್ at page 16 ಮಲಾಟ್.
Page
16 affidavit.
ಹಾ,
ನಾನು ಈ ದಾವೆಯಲ್ಲಿ
ಹಾ,
ವಾದಿಯಾಗಿದ್ದು ದಾವಾ ಶೆಡ್ಯೂಲ್ ಸೊತ್ತು ಮೂಲತಃ ನನ್ನ ಮಾವನವರಾದ ಸೋಯನ್ಸ್ ಅದು ಬಿಟ್ಬಿಡ್ತೀನಿ,
ಹ್ಮ್.
ಮಿಡ್ಲಲ್ಲಿ ಓದ್ತೀನಿ. ದಾವಾ ಸ್ವತ್ತಿಗೆ ಇಲ್ಲಿಯವರೆಗಿನ ಸಂಪೂರ್ಣ ಕಂದಾಯವನ್ನು ನಾನು ಪಟ್ಟಣ ಪಂಚಾಯತಿಗೆ ಪಾವತಿ ಮಾಡಿರುತ್ತೇನೆ ಹಾಗೂ ಮನೆಗೆ ವಿದ್ಯುತ್ ಇಲಾಖೆಯಿಂದ ಸಂಪರ್ಕವನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತೇನೆ.
ಹ್ಮ್.
ವಿದ್ಯುತ್ ಬಿಲ್ ವಗೈರೆಗಳನ್ನು ಪಾವತಿ ಮಾಡಿಕೊಂಡು ಯಾವುದೇ ತಕರಾರುಗಳಿಲ್ಲದೆ ವಾಸ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿರುತ್ತೇನೆ. ತಾನು ಇತ್ತೀಚೆಗೆ ಹಳೆಯ ಮನೆಯನ್ನು ಕೆಡವಿ ವಾಣಿಜ್ಯ ಮಳಿಗೆಗಳನ್ನು ನಿರ್ಮಿಸಿಕೊಂಡಿದ್ದು ಅವುಗಳನ್ನು ಬಾಡಿಗೆಗೆ ನೀಡಿರುತ್ತೇನೆ.
ಹ್ಮ್.
ಮೈ ರೆಸಲ್ಟ್ ಸಬ್ಮಿಷನ್ my lord. It is a new construction ಅಂತ ನನ್ನ ಇದು
Yes.
ಇಂಜಂಕ್ಷನ್ ಬೇಕಾದ್ರೆ ಇರ್ಲಿ, ಲೆಟ್ ದ ನಾಟ್ ಪುಟ್ ಅಪ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಅಂತ ಮೈ ರೆಸಲ್ಟ್ ಸಬ್ಮಿಷನ್.
ಇವು ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಕಟ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಆಗ್ಲೇ.
ಅಲ್ಲ, ನಾನು ಹೇಳ್ತಾ ಇರೋದು ಕಾಂಟ್ರರಿ ಟು ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಟೇಕನ್ ಇನ್ ದಿ ಪ್ಲೇಂಟ್ ಆಸ್ ವೆಲ್. ಬಾಡಿಗೆ ಕೊಟ್ಟಿದ್ದೀವಿ,
ನಾವು ದಿ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಕಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಮೇಲೆ ಕಟ್ಟೋದು ಬೇಡಿ ಸ್ವಾಮಿ.
My lord, this is what exactly happened. This is where my lord was pleased to appoint the court commissioner. I handed over the photograph. I said ground floor ಅಲ್ಲಿ ಆಗೋಗಿದೆ, ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ನಾನು ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಿದ್ದೀನಿ ಅಂತ. ಅವ್ರು ಹೇಳಿದ್ರು ಇಲ್ಲ ನಾನು ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಅಲ್ಲೇ ಮಾಡ್ತಾ ಇರೋದು ಅಂತ. ಆ ಫೋಟೋಗ್ರಾಫ್ ವಾಸ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್. The mandate, my lord, for the court commissioner is, my lord may kindly see 16/12/2024 order. My lord was pleased to pass. Please see this, my lord. Learned senior counsel for the petitioner submits that the respondent, after obtaining an order of injunction, is constructing a building in the vacant portion of the property adjacent to a building which already exists. This is, however, countered by the learned counsel for respondent, who contends that the construction is put up on the first floor on the existing building and it does not affect the petitioner in any manner whatsoever. In view of this dispute, this court felt it appropriate to get a local inspection of the property. Then, my lord, so and so is appointed. Now, please see the para 3. Consequently, Mrs. Aditi Gurjar is appointed as court commissioner to visit the suit property on 17/12/2024 at 3 p.m. and submit a report as to where exactly the respondent is putting up the construction. So what was sought to be?
ಮಾಡ್ಕೊಳ್ಳಿ. If you want to amend your written statement, amend your written statement and counter claim ಕೇಳ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ, ನನ್ನ ಸಬ್ಮಿಷನ್ ಆಫ್ಟರ್ obtaining this interim order, they have started put up construction. ಕೆಳಗಡೆ ಕೋರ್ಟ್ ನಲ್ಲಿ ಫಸ್ಟ್ ಇಂಜೆಕ್ಷನ್ ತಗೊಂಡ್ರು, ತದನಂತರ ಇದನ್ನೆಲ್ಲ ಕಟ್ಕೊಂಡು ಬರ್ತಾ ಇದ್ದಾರೆ. When the pleading itself, my lord, that I have been putting up a construction, it is not their pleading. It is there that, my lord, building is completed.
Don't put up any concern in the first floor.
My lord,
Complete your construction.
ಅಲ್ಲ, ಈಗ the ground floor ಅಲ್ಲಿ ಇದ್ದಾಗ first floor ಅಲ್ಲಿ there is no reason, my lord, why I should not put up
ತಾವು
construction.
injunction
I do not understand this, my lord. This was pointed out. I'll only make this submission. My lord was pleased to appoint the court commissioner only to see this. ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಇದ್ರೆ ಮಾಡಿ, ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಇದ್ರೆ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿದ್ರೆ, ನಾನು ಐ ಸೆಡ್ ಆಲ್ ರೈಟ್, ನಾನು ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಆಗ್ತಿಲ್ಲ, ಫಸ್ಟ್ ಫ್ಲೋರ್ ಅಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದೇನೆ.
Nature of the construction pending dispose of the suit.
Pardon, my lord?
You have changed the nature of the.
No, I have not changed. What has happened is, my lord will kindly see the court commissioner report. Dayavittu note. What has happened is, my lord, serially, my lord, the photos have been furnished. Please see Annexure D1, my lord. I'll just explain how this happens. My lord, Annexure D1 is page number 13 of the commissioner report.
Yes.
My lord, there is, my lord, the shop premises. My lord, now D2, my lord, they are showing this SLV enterprise. That portion of the property, my lord, is opened. Opened, my lord, in a manner that it leads into a passage.
Yes.
That is Annexure D4, page number 15.
Yes.
My lord, after, my lord, we proceed further. D5, my lord, this is where, my lord, the hind portion of the property. To the left, my lord, the commissioner says that there is a staircase. Now, my lord, D6, D7, my lord, is all constructed portions.
D6 is in the ground floor.
It's in the ground floor.
D7.
D9, everything. D7 and D8 are the ground floor. D9, my lord, as I go further, my lord, there is a staircase. That is what the court commissioner says. To the left, my lord, the staircase would proceed. Then, my lord, the construction is going on. This is in the first floor. Now, if at all I am putting up construction in the first floor, my lord, it is not going to affect anybody. It's a suit for permanent injunction. I have been in possession of the property. My lord, ground floor alla first floor ನಾನು construction ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಅಂತ ಹೇಳಿದೆ. This was disputed by them, saying that ಇಲ್ಲ, ನಾನು ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಅಲ್ಲೇ ಇದೇ ಫೋಟೋನೇ ತೋರಿಸ್ಬಿಟ್ಟು ಇವೆಲ್ಲ ಗ್ರೌಂಡ್ ಫ್ಲೋರ್ ಅಂತ ಹೇಳಿದ್ರು. That is where the commissioner was appointed. When everything is done, my lord, first floor ನಾನು ವಾಸಕ್ಕೆ ಅಂತ ಒಂದು ಮನೆ ಕಟ್ತಾ ಇದ್ದೇನೆ. My lord, when I am in possession, my lord, how can anybody, my lord, object to it?
No, my research submission, my lord, the pleading is something different. My lord, whenever lordship is going to grant an interim order,
Yes.
basis of the pleading. The pleadings is, my lord, that we have completed the construction and the electricity connection has been obtained and rented out. But
We will say that any construction put up shall be subject to the outcome of the suit.
Rashmi, can you direct the
We'll direct
trial
it.
court to dispose of the matter? Till then, my lord, let them not put up further
Say
construction.
that any construction put up shall be subject to the outcome of the suit. You take whatever steps that you are entitled to in case you succeed. Because of the developments. it is
Because my very suit for permanent injunction is not maintainable, because I have disputed the very
No, we will say
title.
that the trial court shall not be influenced by any construction put up by the plaintiff during the pendency of the suit and shall determine the suit as on the date of the filing of the suit, when the land was fully vacant. And any construction put up by the defendant plaintiff shall not confer any equity or right upon the plaintiff. ಅದನ್ನ ಮಾಡ್ಬೋದಲ್ಲ.
No, while filing the suit, my lord, it was not vacant. They only say and admit that the constructions were there.
Construction was the front portion, the shop.
Yes, yes.
Not the back
That
portion.
the court will have to necessarily see. That was the status as on the date of filing of the suit.
Yes.
Now, my lord, as on the date of the suit, if at all
If that is the case, then we'll have to go through the plain governments and say, ಇಲಾಖೆಯಿಂದ ಸಂಪರ್ಕವನ್ನು ಪಡೆದುಕೊಂಡಿರುತ್ತಾರೆ.
ಮಳಿಗೆ ಮಾಡಿದ್ದೇನೆ, ನಾನು ಇದು ಕೊಟ್ಟಿದ್ದೇನೆ.
The commissioner says the building is still now, ground floor is still completed just now. Still civil works are going on. Current ಎಲ್ಲಿದೆ building ಗೆ? Ground floor current ಇದೆಯಾ? Ground floor current ಇಲ್ವಲ್ಲ? Was there electricity, madam?
My lord, page 3 ನಲ್ಲಿ, C ನಲ್ಲಿ, page 3. Photograph of the entrance of the newly constructed building is produced here with as annexure D5. Photos taken inside the new building on the ground floor are produced here with as annexure D6.
This old building was in L shape or? The old building was in a L shape or?
ಅಲ್ಲ road ಪಕ್ಕ ಬರ್ತದೆ ಹೀಗೆ.
No, the old buildings were in the form of an L. L for London. So L shape ಅಲ್ಲಿ ಇದ್ರೆ ಮುಂದ್ಗಡೆ ಇವ್ರದಾದ್ರೆ ಹಿಂದ್ಗಡೆ ನಿಮ್ದು ಹೆಂಗಾಗುತ್ತೆ?
I don't know. ಅಲ್ಲ road shape ಅಲ್ಲಿ ಬರ್ತದೆ.
ಅಲ್ಲ, commissioner says that the old building is in L shape.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ರೋಡ್ ಪಕ್ಕ ಬರ್ತದೆ ನನ್ನ ಪ್ರಕಾರ. I don't know.
No, she says it's L shape.
Two sides, my lord, it is bounded by road.
Instruction road ಪಕ್ಕ ಬರುತ್ತೆ ಅಂತ.
ಈಗ two sides boundary, please see the boundary. The east wattu, my lord, is also produced by the court commissioner and also, my lord, the plain governments. Two sides, my lord, it is bound by road. So it has to come in L shape only.
ಪಶ್ಚಿಮಕ್ಕೆ ರಸ್ತೆ, ದಕ್ಷಿಣಕ್ಕೆ ರಸ್ತೆ.
ಹೌದು.
So therefore L shape property or maybe corner property.
Corner property.
ಅದನ್ನ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದೀವಿ ಆಕ್ಚುಲಿ.
Corner
ಆಕ್ಚುಲಿ ಅವ್ರದ್ದು ಮಿಡ್ಲ್ ಅಲ್ಲಿ ಬರ್ತದೆ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಒಂದು ಫೋಟೋ ಕೊಟ್ರಿ ನೋಡಿ, ಯಾವ್ದೋ ಒಂದು, ಐ ರಿಮೆಂಬರ್ ದಟ್ ಫೋಟೋಗ್ರಾಫ್. ಅದ್ರಲ್ಲಿ 2 side ರೋಡ್ ಕಾಣ್ತಿತ್ತು ಅದ್ರಲ್ಲಿ. Somebody handed over one photograph. ಯಾವ್ದೋ ಬೇಕರಿನೋ ಏನೋ ಒಂದು.
This is the one.
Some bakery, if I remember.
ಅಲ್ಲಿ ಇದೆ, ಇಲ್ಲೇ ಇದೆಯಲ್ಲ, ಫೋಟೋದಲ್ಲಿ ಇದೆ ಅದು.
ಕೊಡಿ.
ಇನ್ನು ಫೋಟೋ ಇದು ಕೊಟ್ಟಿದ್ದು.
ಇದು ನೋಡಿ.
ಅದೇ ಅದು ಹಿಂದೆ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡ್ತಿರೋದು.
So this is an L shape proper building which is existing, old building is L shape.
ಒಟ್ಟು 8 ಗುಂಟೆ ಜಮೀನಿದೆ. ಅದು ಆಕ್ಚುಲಿ ಅಲಾಟೆಡ್ ಆಗಿರೋದು ನಮ್ಮ ಫಾದರ್ಗೆ. ಅದನ್ನ ಎನ್ಕ್ರೋಚ್ ಮಾಡಿ ಓಲ್ಡ್ ಬಿಲ್ಡಿಂಗ್ ಇತ್ತು. ನಾವು ಅದನ್ನ ನೆಲಸಮ ಮಾಡಿದಾಗ ದೇ ಹ್ಯಾವ್ ಬೈ ಒಬ್ಟೈನಿಂಗ್ ಇಂಟ್ರಿ ಮಾಡರ್ ದೇ ಹ್ಯಾವ್ ಪುಟಿಂಗ್ ಅಪ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್. ದಿಸ್ ಇಸ್ ಮೈ ಕೇಸ್. ಅದು ಹಿಂದೆ ಒಟ್ಟು 8 ಗುಂಟೆ ಇರೋದು ಅದು ಜಮೀನು.
ಈ ಹಳೆ ಬಿಲ್ಡಿಂಗ್ ಅವ್ರಿಗೆ ಸೇರಿದ್ದ?
ಅವ್ರಿಗೆ ಸೇರಿರೋದು. ಅವ್ರಿದ್ದಾರೆ. ಅದ್ರ ಹಿಂಭಾಗ ನಮಗ್ ಬಂದಿರ್ತಕ್ಕಂಥದ್ದು. You Lashma kindly see the schedule itself. According to them, Lashma kindly see the schedule. ನಮ್ಮ ಹೆಸರನ್ನ ಹೇಳ್ತಾರೆ ಆ ಕಡೆ ಈ ಕಡೆ ಎಲ್ಲ.
We'll say that it will not confer any equity on either the plaintiff, on the plaintiff.
ಇದರಲ್ಲಿ Lashma kindly see the schedule.
ಬರ್ಕೊಳ್ಳಿ. ಇದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಕೇಸ್ ಡಿಸೈಡ್ ಮಾಡೋದು, ಇಟ್ಸ್ ನಾಟ್ ಎ ಹ್ಯಾಪಿ ಥಿಂಗ್.
Sorry, madam.
It's not a happy thing for you, it is not a happy thing for me.
Sorry, madam.
ನೀವು ಕೋಪ ಮಾಡ್ಕೊಂಡು
Sorry.
vitiate the atmosphere of the court.
Sorry, madam.
ಬರ್ಕೊಳ್ಳಿ. The defendants 1, 2, 3, 4 in OS number 97 of 2024 on the court on the file of the civil judge and JMFC Arkulgood are before this court challenging the order of the trial court granting injunction to restrain them from interfering with the possession of the plaintiff. They are also aggrieved by the order of the appellate court in MA 24/2024, by which the order of injunction granted by the trial court is confirmed. Next para. The suit in OS number 97 of 2024 was filed for perpetual injunction in respect of a building
Please.
measuring 139.16 square meters.
Concerning the property measuring, my lord, east to west 15.72 and north to south 9.14, what to 146.6 chadar meter.
And madam, measuring 146.6 square meters, where a building measuring 139.16 square meters was constructed. Full stop. The plaintiff claimed that the suit property was earlier owned by her father-in-law, Shri A.N. Papanna. Full stop. A.N. Papanna, and he derived it at a partition. Full stop. They said Mr. A.N. Papanna died in the year 2004. Full stop. During his lifetime, comma, his 3 children, not 2 children.
ಗಂಡ ಸತ್ತೋಗಿದ್ದಾರೆ.
ಪಾಪಣ್ಣನಿಗೆ 6 ಜನ ಮಕ್ಕಳು. Papanna has 6 children.
Yeah, I think. During his lifetime, his children partitioned the properties. In terms of which, comma, the suit property fell to the share of her husband, who died on 24/7/2015.
He's asking on the group Khalili matter question mark.
She contended that she got the municipal records of the aforesaid property transferred to her name and was in possession of the said property. She also claimed that the suit property was provided with electricity and other civic amenities.
It's not over yet, or what?
She claimed that she had demolished an old house existing on the suit property and had constructed a new one and had let it out to tenants. Full stop. She alleged that the defendants, though having no manner of right, title, or interest, were interfering with her possession, and therefore she was advised to seek protection of the court, advised to seek a perpetual injunction to protect her possession in the suit property. Full stop. Along with the suit, an application was filed. Madam, you can leave if you have any other work. You got your fees? Do you need anything extra? Yes. An application for injunction was filed to restrain the defendants from interfering with her possession. Full stop. The suit was contested by the defendants, who contended that the land bearing survey number 37/6 of Arkalagud village, Kasba Hubli, measured 23 guntas and was owned and possessed by Kalasi Puttaya. Full stop. After his death, his 3 children named Sannadu Gowda
alias Nallura.
ಮೂರಿದೆ ಸಣ್ಣದು ಗೌಡ alias Nallura.
ಮೂರು ಅಲಿಯಾಸ್ಗಳು.
And his brother's children, namely A.N. Puttaya and A.N. Papanna, succeeded to it. Full stop. Therefore, they contended that, further they contended that in an area measuring 1.04 guntas, a house was constructed where they were living. Full stop. They claim that on 29/5/1964, they partitioned the aforesaid property including the properties that stood in the name of Mr. A.N. Puttaya and A.N. Papanna. Full stop. As a result, out of survey number 37/6, an extent measuring 8 guntas fell to the share of Sanna Duge Gowda, 8 guntas fell to the share of A.N. Papanna, and 7 guntas fell to the share of Puttaya. They claim that all three of them were enjoying the aforesaid extent. Full stop. They contended that the property that fell to the share of A.N. Puttaya lay on the northern side. On the northern side of the property which fell to the share of A.N. Puttaya was 8 guntas that fell to the share of A.N. Papanna.
ಅಲ್ಲಲ್ಲ ನಾರ್ದನ್ ಸೈಡು ಸಣ್ಣದು ನಲ್ಲೂರ
ಅವ್ರು ಹೇಳೋದು ಹಾಗಾಗಿ ಸರ್ವೆ ನಂಬರ್ 37/6 7 ಗುಂಟೆ ಪ್ರದೇಶವು A.N. ಪುಟ್ಟಯ್ಯನವರ ಹಿಸ್ಸೆಗೆ ಬಂದಿರುತ್ತದೆ. ಸದರಿ A.N. ಪುಟ್ಟಯ್ಯನವರ ಹಿಸ್ಸೆಗೆ ಬಂದ 37/6 7 ಗುಂಟೆ ಜಮೀನಿನ ಉತ್ತರ ದಿಕ್ಕಿನಲ್ಲಿ.
ಅದೇ ಉತ್ತರ ದಿಕ್ಕಿ ಕರೆಕ್ಟ್.
ಸೊ ಅದೇ ಹೇಳಿದ್ ನಾನು.
ಸಾರಿ.
On the northern side of 7 guntas that fell to the share of A.N. Puttaya was 8 guntas of land which fell to the share of Papanna. Full stop. The house that lay on the western side of 7 guntas allotted to the share of Sanna Dugge Gowda.
ಅದರಲ್ಲಿ ಅರ್ಧ ಇವರಿಬ್ರಿಗೆ ಅಂತ.
ಅದರ ಜೊತೆಗೆ
ಸಣ್ಣದಿಗೆ ಮಕ್ಕಳಿರ್ಲಿಲ್ಲ, ಹಾಗಾಗಿ ಒಂದು ಮನೆ ಇತ್ತು.
The house that lay on the western side of the property that fell to the share of Sanna Dugge Gowda was inherited by A.N. Puttaya and A.N. Papanna. Full stop. They said Mr. A.N. Puttaya, after the death of Mr. A.N. Puttaya, his children were in possession of possession. Full stop. They claim that in addition to the above, there was an area measuring 7 guntas on the southern side, which belonged to the state government.
ಇಲ್ಲ
ಕಂದಾಯ ಇಲಾಖೆಗೆ
ಅಲ್ಲ, ಅಲ್ಲಿ ಬಾರ್ಡರ್ ಮೊದಲು ಆಕ್ಚುಲಿ ಶ್ರೀಕಂಠೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಬಾರ್ಡರ್ ಇತ್ತು ಈ ಟೋಟಲ್ ಇದಕ್ಕೆ. ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅಲ್ಲಿ ಕಂದಾಯ ಇಲಾಖೆಯವರು ವಿಧಾನಸೌಧ ಕಟ್ಟಿದ್ದಾರೆ, ಅಲ್ಲಿ ರೋಡ್ ಬಂದಿದೆ ಇವಾಗ. ದಟ್ ಪೋರ್ಷನ್ ಬಿಲಾಂಗ್ಸ್ ಟು ದಿ ಡಿಫೆಂಡೆಂಟ್ಸ್. ಸದರ್ನ್ ಪೋರ್ಷನ್.
ಕಂದಾಯ ಇಲಾಖೆ ಜಾಗದಲ್ಲಿ ಮಿನಿ ವಿಧಾನಸೌಧ ನಿರ್ಮಿಸಿದ ನಂತರ ಪುಟ್ಟಯ್ಯನ ಹಿಸ್ಸೆಗೆ ಬಂದ 7 ಗುಂಟೆ ಜಮೀನಿನ ದಕ್ಷಿಣ ದಿಕ್ಕಿನಲ್ಲಿ ಕಂದಾಯ ಇಲಾಖೆ ಪೂರ್ವ ಪಶ್ಚಿಮ 20 ಅಡಿ ರಸ್ತೆ.
ಆಸ್ ಪರ್ ದಿ ಪಾರ್ಟಿಷನ್.
In addition, madam, they claim that on the southern portion of 7 guntas of land allotted to A.N. Puttaya was the land belonging to the Revenue Department where mini Vidhansauda was constructed. And a road measuring east to west 20 feet was formed by the Revenue Department. Full stop. They alleged that the plaintiff, in order to grab the property that had fallen to their share, had filed the suit. Full stop. They also and hence contended that the suit for injunction was not maintainable. The application for interim injunction was also contested on similar lines. Next, for the trial court, after considering the contentions of both the parties, granted interim injunction to restrain the defendants from putting up any construction. From
prayer.
interfering with the possession of the plaintiffs in the suitable properties. Huh?
ಬರೀ not to interfere, not to put up ಅಂತ ಏನು?
Not to interfere with the possession of the suitable properties. Full stop. An appeal was preferred by the defendants in MA 24 of 2024, which was also rejected. Full stop. Being agreed by the said orders, the defendants are before this court in this petition. Full stop. When this petition was listed for preliminary hearing, the learned senior counsel for the defendant submitted that the plaintiff after obtaining an order of injunction was putting up construction in the rare portion of the property which belonged to the defendants. Full stop. This was, however, contested by the plaintiff, learned counsel for the plaintiff, who contended that the plaintiff was putting up construction in the first floor on the rare portion of the buildings that was already in existence. Full stop. Therefore, this court, in order to ascertain the exact place where the plaintiff was putting up construction, appointed a commissioner. Full stop. The commissioner has submitted her report stating that some old buildings were in existence as per the photographs that are attached to the report. Full stop. She has reported that the plaintiff had opened a passage through the existing building to reach the rare portion of the building where the plaintiff had put up constructions in the ground floor and was undertaking construction in the first floor. Full stop. She has also reported that when she visited the property, there was no electricity to the ground floor, to the building constructed in the ground floor.
She has not said that.
Full
because
stop.
there is
That is not mentioned in the report of the commissioner.
My lord, I have it. I have the photographs and she was sitting there. It's all there, man.
No, that is right. Electricity itta?
Electricity ಇದೆ.
Idya?
Photographs, I'll show that.
You want me to appoint one more commissioner or send her to this?
ಹಳೆ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲಿ ಇದೆ.
ಹಳೆ ಬಿಲ್ಡಿಂಗ್ ಅಲ್ಲ, ಹೊಸ ಬಿಲ್ಡಿಂಗ್, ಹೊಸ ಮೀಟರ್
ಅದರದ್ದೇ ಇದೆ. ಅಲ್ಲಿ ಪೋರ್ಷನ್ ಕೊಟ್ಟೆ.
ಏನ್ ಮಾಡಮ್ ಆಯ್ತು, ಆಯ್ತು ತೆಗೆದು ಬಿಡಿ. ಅದು ಏನಾಯ್ತು? ಅದು ಹೊಡೆದಾಕ್ಬಿಡಿ.
D6 ಅಲ್ಲಿ annexure A6 ಅಲ್ಲಿ
ಡೆಮಾಲಿಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲಲ್ಲ, ಈ
ಬೇರೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ವುಡ್ ಐಟಮ್ಸ್ ಎಲ್ಲ ಅಲ್ಲೇ
ಅಲ್ಲ, ನೋಡೋಣ ಇಲ್ಲಿ ಎಲ್ಲಿದೆ.
D6 ಫೋಟೋ ಹೀಗಿದೆ, ಇವ್ರು ಕೊಟ್ಟಿರೋ ಫೋಟೋ ಹಳೇದು ಯಾವ್ದೋ ಒಂದು ಕೊಟ್ಟಿದ್ದಾರೆ.
ಶಿಫ್ಟ್ ಮಾಡಿರೋದು D6 annexure D6 ಅಲ್ಲಿ ಅವರೇ ಕೊಟ್ಟಿರೋ ಫೋಟೋ.
ಅಲ್ಲೆಲ್ಲ ಸ್ವಿಚ್ ಲೈಟ್ ಎಲ್ಲ ಇದೆ.
ವೈರಿಂಗ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ, ವೈರಿಂಗ್ ಮಾಡಿದ್ದಾರೆ. ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಇದೆಯಾ?
D7 ಎಲ್ಲ ಇದೆ.
ವೈರಿಂಗ್ ಮಾಡಿದ್ದಾರೆ. ಎಲೆಕ್ಟ್ರಿಸಿಟಿ they have stated that they have obtained electric connection ಅಂತ.
ವೈರಿಂಗ್ ಮಾಡಿದ್ವಿ. ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಇದೆಯಾ? ಒಂದಕ್ಕೂ ಬಲ್ಬ್ ಹಾಕಿಲ್ಲ, ಒಂದು ಬಲ್ಬ್ ಇಲ್ಲ, ಒಂದು ಟ್ಯೂಬ್ ಲೈಟ್ ಇಲ್ಲ, ಒಂದು ಫ್ಯಾನ್ ಇಲ್ಲ.
ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಇದೆ ಅಂದ್ರೆ ಇದನ್ನ ರೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ ನಾವು.
ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಇದೆ. D6 my lord, electricity connection is taken. It is my instruction.
D6 ಅಲ್ಲಿ ಕಾಣ್ತಾ ಇದೆ.
D6 ಅಲ್ಲಿ ಸ್ವಿಚ್ ಇದೆ, ಆಮೇಲೆ ಇದಿದೆ.
ಹೇಳ್ತಿದ್ದೀನಲ್ಲ, ಕರೆಂಟ್ ಬೇಕಲ್ಲ. ಏನಾಯ್ತು ಮೇಡಮ್? ಹೊಡೆದಾಕ. Though that is not mentioned in the report. Full stop. The learned senior counsel for the defendants as well as the learned counsel for the plaintiff did not dispute the fact that the commissioner had conducted a thorough inspection of the property and the report submitted by her is in respect of the property which is the subject matter of the dispute in the suit. Therefore, as per the report of the commissioner, building is already put up in the ground floor. And the construction that is now undertaken by the plaintiffs is in the first floor. Therefore, it is appropriate to temper the order of injunction granted by the trial court and confirmed by the first appellate court on the following terms. Number one, the order of injunction granted by the trial court and confirmed by the appellate court shall continue till the disposal of the suit. However, while considering the suit, the trial court shall decide the suit. Trial court, while deciding the suit, shall take into consideration the question whether the construction put up by the plaintiff in the ground floor was already in existence as on the date of the suit or not. Number three, if it is found that the construction was not existing as on the date of the suit, and if the suit is not decided in favor of the plaintiff, the trial court is at liberty to pass appropriate orders to restore status quo ante as on the date of the suit. Full stop. It will be for the plaintiff to establish that the construction put up by the plaintiff was in existence prior to the suit, prior to the date of filing the suit, and that the plaintiff had obtained electricity and other facilities, amenities to the newly constructed property. Full stop. The writ petition stands disposed of on the above terms.
My contention that electricity connection was there may kindly be noted, because
said-
if my lord has
No, I
said
have
that
said-
commissioner hasn't said so,
Commissioner has stated, though she has not mentioned that in the report.
please, that
So if you-
I object, because my lord is putting an
also
onus
prove it.
on me now.
You can also prove it. that
No, and since the onus is put, that
it-
my
it is
objection to
also-
that.
It is also, the plaintiff shall also establish that the electricity and other facilities were obtained prior to the filing, obtained to the newly constructed building prior to the filing of the suit.
No.
You
What
prove
I'm
it.
saying is, no, I'm saying that the court commissioner has orally said that there is no electricity connection. To that, I'm taking an exception and saying that there is an electricity connection. That contention may be
I
recorded.
one
that's what
made
I'm saying.
though it is not mentioned in the Eldala. This is however disputed by the learned counsel for the
That's all.
plaintiff, who contends that electricity supply was obtained even prior to the filing of the suit.
No, it is there, it is taken is what I'm saying.
ಎಲ್ಲದಕ್ಕೂ
ಅಲ್ಲ ನನ್ನ contention ಏನು ಅಂತ
ಫೀಡಿಂಗ್
ನಾನು ಹೇಳ್ತಾ
ಇರೋದು
ಇದ್ದೀನಿ.
ಎಲೆಕ್ಟ್ರಿಸಿಟಿ
Contended
ಕನೆಕ್ಷನ್
that,
ತಗೊಂಡಿದ್ದೀವಿ ಅಂತ.
Though this is contested by the learned counsel for the plaintiff, who contends that the building was provided with electricity.
And that's all, please.
ನೀವು ಪ್ರೂವ್ ಮಾಡಿ, ಎಲ್ಲ ನೀವು ಪ್ರೂವ್ ಮಾಡಿ.
Smart.
Yes.
Number 28. Ajay Kumar S.
I am sorry, Mr. Senior Counsel. You also don't lose your cool henceforth. I should also not lose my temper in the court. Yes.
Number 28, Ajay Kumar S.
Well, I spoke to the client, my lord, regarding to their payment. He spoke to the new developer. In fact, they had even made a demand draft, my lord. This is regarding the,
No, I don't remember the facts. What are the
no,
facts?
this is regarding an execution proceeding.
Yes.
That- I can facilitate a meeting between the, because they have to issue the check. In fact, they had made one demand draft, my lord, earlier, which has.
No, don't juggle words. Show the money.
My lord, I'm just showing, my lord. This is a demand draft.
Show it to him.
No, he's aware of it.
He should be
Demand
happy.
draft, my lord, made by the builder, the new builder, but they are expecting the sum as per the award. That's the difference. Therefore, what I'm suggesting, my lord, that I'll facilitate a meeting, because the new builder is ready to make the payment, but they have to have a discussion in person.
Yes, Mr. Giridhar. Would you want to have the money or the building?
We don't want the building. The proceedings was always for recovery of money.
My lord, but since I'm not paying, I'll
The
show
award
my-
is only for payment
Right,
of
but
money.
How you do, no, how you do it, it is left to you. Whether you arrange a meeting with the new builder, do whatever you want, ensure that the money reaches them.
No, my lord, I had made a demand, the new builder had even made a demand draft for some 92 odd lakhs.
Hmm.
Now for them, they are expecting the sum as per the award. Now, the award is against me. I'm a non-party to the proceedings insofar as the transfer of the project to the new builder. Therefore, the new builder has made a demand draft. I can facilitate a meeting, my lord. I am under insolvency because of the Section 95 application.
Yes.
Personally, there's a Section 95 application under the Insolvency Bankruptcy Code as against the petitioner itself.
Hmm.
Therefore, my lord, let the matter be deferred, my lord. I will.
So why don't you get this 92 lakhs?
My lord, they are willing to receive it without prejudice to their claim in the execution proceeding. The new builder is saying that I want to close this because
So
it's.
let him pay 92, remaining you pay it.
My lord, I have no money. That's why I have transferred the project.
May I just make one submission, my lords? The petition by him is not maintainable.
Hmm.
Warrant is issued to him in his capacity as a director of another company, not against him in person in his personal capacity.
That I'll argue on merits, my lord. Any date may be fixed. I'll argue on merits.
There is no arrest warrant against Aditya Raheja, my lords, in his individual capacity.
I'll argue that on merits, my
After
lord.
we secured a decree in our favor, my lords.
But the award is against.
Award is
Company.
against a company by name Pebble Bay Developers Private Limited.
Ah.
My lords, we filed an execution proceedings. They did not file objections. They said that they have filed an appeal.
But the, what do you call, the arrest notice is issued to this Aditya Raheja.
Yes, my lord, sir. In his capacity as a director,
Ah.
we filed an application under Order 21, Rule 41, calling upon the judgment debtor to provide details of the assets.
Hmm.
The details of the assets were furnished, in which it was demonstrated that this judgment debtor company had invested money in another company, which was a garnishee. We made an application to bring the garnishee on record. Garnishee was brought on record.
Hmm.
75 lakhs, which is in custody of the garnishee, was directed to be deposited in court. That was not deposited.
Hmm.
This Aditya Raheja is incidentally the director of the garnishee company also and the judgment debtor company.
Hmm.
When we requested for an arrest warrant as against non-compliance of the payment, court felt a warrant cannot be issued, arrest note be issued for him to show cause, my lords. That's all.
Hmm.
It is not in his individual capacity.
But he's a minority. He's not even a shareholder.
No, no,
There's
that
some-
is a different issue, my lord.
It is the
There's some
issue.
finding that the garnishes have appeared before the court and made some payments.
Yes.
My lords?
There's a finding in page number 20
Yes, my
that
lords.
the garnishes have appeared and made some payments.
My lords, when we requested him to furnish the details of garnishee, he gave 3 bank accounts and he gave the details of his assets and liabilities.
Of the company. The order, my lord, is that in page 20. Can I just take my lord to the application, my lord, what they filed?
Yes.
The application which they have filed is at in page 135.
Hmm.
For the reasons stated in the accompanying affidavit, the decree holder prays that the Honorable Court be pleased to issue a warrant of arrest and detention in civil prison and detention of the director of the garnishee number 123 as detailed herein. Now, please see, my lord, para 4, where they talk about the debt. The affidavit, just before para 5, the last 4 lines. I submit that, my lord, please see, no?
Yes.
That the total amount paid by the judgment debtor on account of the debentures to the garnishee number 1, 2, and 3 is 75 lakhs, 3,75,000 and 3,75,000, and the said amount is payable by the said garnishee to the judgment debtor and which has been directed to be deposited in this case. I submit that the director of the garnishee is none other than the director of the judgment debtor, and the said director has always attempted to frustrate the said execution. Now, in that background, please see the order, my lord, which is in page 20. Page 19 at the bottom, my lord, 22, 23. Counsel for the DHR and JDR present, JDR and JDR praise time. This case is posted. So the same day when the application is filed, this case is posted to pass an order as to whether an opportunity has to be given to the JDR to file objections to IA number 8 filed by the DHR on 39/25/24 under Order 21, Rule 30 and 46B of CPC, where DHR has sought for issue of arrest warrant against the director of garnishee number 1, 2, 3. When the application filed by the DHR, the learned counsel for the JDR submitted that the JDR company has many other directors, but DHR is only seeking arrest warrant only against Mr. Aditya Raheja, one of the director. Further, he submitted that some dispute is pending before NCLT and he wants to bring all those facts before this fact by filing the objections to IA number 8. I have carefully perused the order sheet dated 29/5/25 on the date when this court allowed IA number 4 and 6 filed by DHR as JDR did not file objections. Therefore, this court passed an order of attachment warrant against garnishee. Further, the order sheet shows that some of the garnishees have appeared before this court and have made certain payments. In my opinion, since the JDR and the garnishee have not come forward to make full payment, question of permitting the JDR to file objections to IA number 8 does not arise. Anyhow, this court of the opinion that instead of issuing warrant of arrest, it would be proper to issue arrest notice to so-and-so. Accordingly, the office is hereby directed to issue arrest notice to so-and-so as to why an arrest warrant shall not be issued against him, returnable by so-and-so. My lord, I have filed the application which is pending before Insolvency Bankruptcy Court, which is at ink page 177. This is under section 95. Before the NCLT, Mumbai.
This is as director of which company?
No, as an individual.
As an individual.
Individual. Aditya Raheja, the
No,
IDBI trusteeship services has, because he had given guarantee for certain loans of the companies in which he is a shareholder and director. And the details
are. We are not
are.
concerned about it. We are not concerned about it.
No, then moratorium kicks in. That's what I'm saying.
That is not. We are concerned with it.
Please, my lord.
This is here. It's a director of a company.
My lord, I'm just
Director
placing
of a
for my
company.
lords that they should have said that he is in charge. My lord is pleased to see the idea for them is that there's some debenture trustees which they stated in the affidavit. I do not even own a share in this company. My company, that is Pebble Bay, owns 20% shares in this particular garnishee companies. I'm not in charge of the affairs of the company, nor I'm in control of the company. Now, they are absolutely right in contending as they would in the affidavit. If I may be permitted to place the statutory report and records of the said garnishee companies, which will show the details.
We'll not go into all those things. Please tell us whether the garnishee owes any money to this JDR.
To that, that's what I'm showing, my lord. These are the records. These records show that there are. You have extra copy. My lord, I just have one copy. I'll read it with my learned friend. Page 5, my lord is pleased to see the first company. Page 5, promoter name. At the first, second, third, it's shown Pebble Bay Developers. List of shareholders, 20%.
Yes.
Then similarly, my lord is pleased to see page 6. Debenture holders. Name of debenture holders, Pebble Bay Developers, 75,000 into 10, 75 lakhs. This is similar. Again, please see page 14. Page 14.
Yes.
And page 32, page 32. Page 32 again, Pebble Bay developers. The majority shareholders, my lord,
Oh, that's okay. If debentures are issued, let the
by
company.
the company.
The company pay.
My lord,
Who is helming? You are 20%, you're holding 20% as
not me as an individual.
company, as a company.
Pebble Bay is having with those companies. They would have to summon the managing director of those companies.
Yes.
And that company's managing director would deposit whatever the debenture. If they have the means, they will have to explain. By, my lord, will please to see.
Who is the managing director of this Adira Hotels? Who is the managing director?
I'll find out, my lord. I'll just, I
Now?
think it is either Mr. A.M. Emmanuel or Mr. or his wife H.L. Emmanuel. I'll just, because I don't want to say something off the record. I will.
Pass over. Please
Pass
find out and let us know. If not this man, somebody else will go.
Yes, yes. My lord, if that debenture trustee is there, they issue a notice to them, then whatever the debenture trustee is to give, they will be authorized by getting me arrested if their intent is to recover that amount of money, which according to them is recoverable. That's a matter which I don't need to place.
That will be rounded off in the accounts of Adira.
Yes.
So therefore, how are you concerned?
My lord, now they're summoning me. I have nothing to do with.
Show cause if that is it. All that is the
My
court
lord,
has done is the court has only issued a.
two aspects, my lord.
So go and
No,
find
no,
out.
my lord, two aspects. I request my lord to kindly defer this matter because these companies are in Kerala.
Not deferring you, please appear before the.
No, I have appeared yesterday.
Appear before.
No, I have appeared. I have appeared.
Ah.
That's why I requested when the matter was instead of today, it's adjourned to 16th of January. This matter can be adjourned. No. And I will.
Will dispose it of.
No,
Now
I will
that you have
please.
appeared, now that you have appeared.
My lord, I'm saying two aspects. One is whether I as an individual, without them even making a pleading, that I am in charge of those companies, because that's the question which
You go and tell this to the executing
my lord,
court.
that is the reason
Tell this to the executing court. Let the executing court decide.
My lord, my submission is this, that even before issuing this arrest notice, because it's an interference under Article 21
Yes.
of threat of arrest, I'm submitting this, my lord. It was well within the jurisdiction of the trial court to permit me as the JDR, as the director of the JDR, of the judgment debtor, to place objections exactly what I'm saying.
Yes.
Where I would have stated that, sir, these are the persons who are in charge of the affairs of the company, that these are the persons, and my lord, I have obeyed the direction and I have appeared. But the legal question is whether the trial court could have denied me an opportunity as a JDR from even filing objections.
Yes.
And what is written in the order is, it says two things. It says that you are also the director of the JDR and you are also the director of this company.
Yes.
So if it would say that as a director of the Garnishi company is one.
He's going to explain all these things. Barkul. The petitioner has challenged an order dated 1/10/2024 passed by the so-and-so court in commercial execution 46 of 2023, by which it issued a notice of arrest to the petitioner. Full stop, next para. The respondent herein initiated proceedings for arbitration of a dispute between him and the JDR. Full stop. The proceedings resulted in an award to recover, authorizing the JDR, the respondent herein to recover rupees 145,90,825 along with interest.
Yes.
Along with interest. Full stop. The respondent filed commercial execution 46/2023 to execute the award. Full stop. During the course of the proceedings, the respondent sought directions to the Garnishi to deposit the amount lying with it against which it had issued debentures to the judgment debtor. Full stop. The executing court had passed an order calling upon the garnishes, Yavagadu?
So the
There's an order of attachment, my lord, in page 134. It's only an order of attachment.
Attachment of the amount lying with the garnishes.
Yes.
no, it was called for, my lord. Certain garnish is paid, the other garnish
Page
did not pay.
134.
Executive court had passed an order dated 29/1/2024 attaching the debentures and the bank accounts of the garnishee as sought for in IA number 3 and 4. Full stop. Later, the respondent filed an application, IA number, bracket IA number 8, under Order 21 Rule 30 and 46B of CPC to issue a warrant of arrest and detain the director of the garnishee 1, 2, and 3 in civil prison. Full stop. The name of the person against whom the notice of arrest was to be issued was also mentioned in the application. Full stop. The executing court, after being satisfied that the garnishee was satisfied that that the
My lord, the payment is at ink page 169.
What payment?
Notice to the garnishees, ink page 169, await notice to garnishees on 37/24.
167 would be the actual order of attachment of the
Yes.
debentures, page 167.
That is noted.
And page 170, notice issued to garnishee 3 and 5 duly served. Garnishee 3 and 5 called absent, takes fresh steps.
Why was this notice issued to the garnishee?
To deposit the value
That's
of the
at ink page
debentures in court.
169. Ink page 169.
Third counsel sponsored for objections. As thereafter, you filed some IA to IA number 4 and 6.
Those first 4 and 6 were allowed.
3 and 5 was allowed.
3 and 5 was the subsequent order, my lords. 3 and 5 was for attachment. Then they sent a issue attachment warrant. They received notice, they did not deposit.
Where is the order on IA number 4 and 5? Where is IA number 4 and 6?
3 and 5 is at ink page 134, my lord.
Now, where are these applications, IA 4 and 6? IA number 4. Here, Madam Aisha. After being satisfied that the garnishee was in possession of funds belonging to the JDR, issued notice on an application filed by the respondent, bracket IA number 4 and 6. Full stop. The notice issued to the garnishes were served, and since they did not contest the applications, IA number 4 and 6 were allowed, and a warrant of attachment was issued against the garnishee. Full stop. Later, notices were issued to the garnishee to deposit the attached amounts held by the JDRs and the value of the attached debentures. Full stop. The notice issued to the garnishee number 3 and 5 were though duly served, they remained absent. Therefore, the respondent was compelled to file an application, bracket IA number 8, to issue an arrest warrant against the director of the garnishee number 1 to 3. Full stop. the executing court, after being satisfied that the garnishee number 1 to 3 had not appeared before the court and had not deposited the amounts attached, passed the impugned order issuing an arrest notice to the director of the garnishee, full stop. Being agreed with the said order, the director of the garnishee has filed this writ petition. Full stop. Next, the learned counsel for the petitioner contended that the petitioner contended that certain insolvency proceedings is initiated against the petitioner, which is pending consideration, and therefore there is a moratorium against all actions against the petitioner. Thus, he contends that the executing court could not have issued a notice of arrest. Besides this, he contends that he is not the one who is responsible for the affairs of the garnishee company, and therefore
He undertakes to furnish details.
And the executing court, before proceeding to issue a notice of arrest, ought to have verified whether the petitioner was the one responsible for conducting the affairs of the garnishee company. Thus, he contends that the impugned order is liable to be interfered with. Full stop. Per contra, the learned counsel for the respondent decree holder contends that the petitioner cannot maintain this writ petition, as he, being the director of a garnishee company, is bound to fall in line with the order passed by the executing court to deposit the value of the debentures issued to the judgment debtor. Full stop. He contends that the petitioner cannot therefore now claim that, being a director of the JDR or in his individual capacity, insolvency proceedings are initiated, and therefore he could avoid the impugned award passed by the award passed by the arbitrator, which is the subject matter of the execution. Next paragraph.
Just one more submission. Lords. His contention that he should be the person in charge of the management of the business, my lords, would not arise in these proceedings. This is not a proceedings under section 138 for me to show that he is the person in charge of the business.
Yes. He also contended that the question whether the petitioner was in charge and responsible for the affairs of the garnishee company would not arise for consideration in these proceedings. Full stop. I have considered submission of the learned counsel for the petitioner and the learned counsel for the respondent. Next paragraph. The impugned order, by the impugned order, the executing court has only issued notice, only issued an arrest notice to the petitioner to show cause why a warrant of arrest should not be issued against him. Full stop. Therefore, if the petitioner is aggrieved, therefore, it is for the petitioner to show cause why the executing court should not proceed to issue a warrant of arrest against him. Full stop. The contentions that are raised in this writ petition, are to be raised before the executing court, and this court cannot short circuit the process by passing any orders on the contentions raised by the petitioner. In that view of the matter, this writ petition is dismissed. However, liberty is reserved to the petitioner to raise all contentions that are raised in this writ petition before the executing court. Yes.
Grateful.
Yes. Ambaji Rao.
I am the plaintiff before the trial court, my lord.
Antaraj.
Yes, please. My lord, I filed the suit for declaration. Page number 62 is the prayer, my lord, plaint prayer.
Page number 62.
62, my lord.
Ah,
To declare that the plaintiff is the absolute owner of the suit schedule B property, to declare that the plaintiff is entitled to vacant possession of the suit schedule B land as the owner of the same, coupled with the directions of the defendant to quit and deliver the vacant possession of the same, grant mandatory injunction, permanent injunction restraining the defendant herein, so and so, so and so. My lord, along with this plaint, I filed.
what is the
application.
suit property?
Suit property is the vacant land, my lord.
Vacant land.
Yes, my lord.
Ah,
That there are two scheduled properties, my lord. In page number 62 and 63 is the schedule, my lord.
yes.
I am the owner of Schedule A property. The disputed property is shown as a Schedule B, wherein the defendant has encroached. Therefore, I filed a.
Whether the Schedule B property is also vacant?
Yeah,
No,
there
it's
is a
constructed,
house.
Melissa. According to me, is a vacant property.
Yeah.
But
Your
according to the plaintiff,
Ah.
whereas what we have purchased the property from Ravish, we have put up construction, that is separate property, not included in the B schedule property, what is described in the plaint.
But the trial court has granted a.
Ibro photographs haki.
ಅಲ್ಲ ಇದೆ
B
photographs.
B shell property do photographs ibro haki.
ಅಲ್ಲ ಈಗ ಏನಾಗಿದೆ ಇದರಲ್ಲಿ one more submission.
No. There should be some consensus as to what is the B shell property.
What is the B shell property? They will have to file photographs.
They will have to. What according to is B shell property, you also produce a photograph.
For that, I'll make submission. During the pendency of the application IA number 1, the plaintiff has filed an application for appointment of commissioner. That application was opposed, notwithstanding that the trial court has passed an order appointing commissioner as a Taluka surveyor to appoint, to survey the land and submit a report. On 30/10/2020, you will also turn to page 160, page 160. Sorry, 149.
160 is the
operative portion. 160.
Yes. Wherein the
Application filed by the plaintiff under R 26 Rule 9, and section on 10, Redvis section 75B of CPC is hereby allowed. The Taluka surveyor of the office of the Tahsildar Bengaluru South Taluk is appointed to conduct the survey work and to submit the report. The court commissioner so and so, so and so, so and so. Both parties are directed to file memo of instruction. Plus on 16/12/2024, we have also filed memo of instruction before the trial court, and they have also filed a memo of instruction. Now, the matter is next posted to 8/1/2025 for reporting commission report. Matter is rest at that time. Let the commissioner examine the.
Let them not put up further construction, Millard.
There is
Once, Millard, my submission is.
Let the commissioner give his report.
Yes,
Please,
Millard. Till such time, they may be directed not to, status quo may be maintained.
That can't be, Millard. That can't be. You will ask him.
Submission is.
You will ask him to look at the photographs, Millard. There is no further construction. Construction has already been completed. Page 202, 203, 204. You will ask him to look at the.
In the commissioner report, if I get back my measurement of 9.5 guntas, Millard, I will withdraw my suit. I don't want to contest the case at all.
Let him wait till
If
such
the
time.
commissioner reports.
Is it your case?
Please.
Is it your case that they are putting up construction in the B shell property?
Yes, Millard.
Is that your case?
Yes, Millard.
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
Yes, Millard. That is my.
Where have you said that they are putting up construction in the B shell property?
Plaint, Millard.
Plaint ಅಲ್ಲೇ ಹೇಳ್ಬೇಕು ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
Please, Millard, please.
Construction is already over.
Completed,
So
Millard.
therefore, don't put up any further construction.
No question of construction. It's interior work.
Commissioner report ಬರೋವರೆಗೆ wait
Don't
ಮಾಡ್ತಾರೆ
put up
ಅಷ್ಟೇ.
any construction of
No,
any
Millard, no.
building.
No,
If
Millard.
you want to clear or maybe finish a construction, you can do it.
Interior work is going on, Millard.
No further construction.
Please, Millard, please. Please.
Barkul. The learned counsel for the petitioner and the learned counsel for the respondent submits that that the trial court has appointed a commissioner to identify the property of the plaintiff, namely the suit schedule A property.
A and B both, Millard.
A and B property. And that the commissioner is yet to submit his report. Full stop. Therefore, full stop. The learned counsel for the petitioner, however, contends that the respondent should be stopped should be restrained from putting up any construction till the commissioner visits the property and submits his report. This is however contested by the learned counsel for the defendant or defendants are.
Only, sole different.
Defendant who contends that the construction is already put up as found in page 207 of what? Illa ಹಾಕಿಲ್ವಾ photographs?
ಇಲ್ಲ ಅವ್ರು ಹಾಕ್ಲಿಲ್ಲ.
Reply ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ.
207. ಈ photograph ಒಂದು ಕೊಡಿ.
ಕೊಡ್ತೇನೆ sir, ಕೊಡ್ತೇನೆ.
In a photograph which is placed on record before this court. Full stop. He therefore contends that the defendant is not putting up any further construction, but is only finishing the construction already put up.
Interior works.
The photograph produced by the learned counsel for the defendant is taken on record. The defendant is directed not to put up any further construction until the report of the commissioner is obtained. However, this will not come in the way of the defendant finishing the construction already put up or carrying out any interior works within the construction already put up. With the photos good. List this petition after.
Occupy the premises.
First is mad. List this petition after vacation. Photograph memo kudi.
ಕೊಡ್ತೇನೆ sir.
Next. Then office objection then again.
Milord, office objection, Milord, it is, copy is not served, it is complied with.
There are
The another
half a dozen office objections. You please complete.
Milord,
Please complete, Mr. Nazare.
please, Milord, please, Milord, please.
Yes.
Plus photographs will be
The
furnished.
meanwhile office,
Plus at 2:30 I'll furnish the photographs.
ಕಿತ್ ಕೊಟ್ಬಿಡಿ ನಾವೇ ಮೆಮೊ ಬರ್ಕೋತೀವಿ ಕೊಡಿ. Furnish the give the photograph.
ಕೊಡ್ತೇನೆ, ಕೊಡ್ತೇನೆ.
It's made part of the order, Mr.
ಆಯ್ತು, ಈಗ
Don't say
ಕೊಡ್ತೇನೆ sir.
230.
Xerox ಮಾಡಿಸ್ಕೊಡ್ತೇನೆ.
You ಕಿತ್ ಕೊಟ್ಬಿಡಿ. ಇದಕ್ಕೆ ನೀವು ಫೋಟೋ ತಗೊಳ್ಳಿ ಬಟ್ ಆರ್ಡರ್ ಶೀಟ್ ರೆಕಾರ್ಡ್ ಆಗೋಗಿದೆ.
ಆಯ್ತಾಯ್ತು.
ನೆಕ್ಸ್ಟ್. AV Amarnath. 1 week time is granted to do the needful. Entry ಮಾಡಿದ್ಯಾ? List after one do the needful full stop. ಅದೇನ ಇನ್ನ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಿಲ್ಲ. In the meanwhile, office objection shall be complete.
31. Appearing for petition, my lord, the office objection is petitioner says not a party before the trial court. My lord, petitioner's grandfather has purchased the property as per annexure B3. All other objections I have complained, my lord. That petitioner's father has purchased the property on 11/6/1951 from
They are not parties ಅಂತ ಇದೆ. ಏನ್ ಬೇಕಾ ಬೇಡವಾ?
not necessary, my lord. Objection may be
Learned
dropped.
counsel for the office objection seal number 1 is overruled by accepting the submission of the learned counsel for the petitioner that petitioners 1 and 2 before the trial court are not necessary parties.
Are not parties for the reason that on the back of the petition's compromise decree has been obtained. by the respondents.
ಗೊತ್ತಿಲ್ಲದಂಗೆ ಹೆಂಗ್ ಸೆಟ್ ಅಸೈಡ್ ಮಾಡೋದು ಕಾಂಪ್ರಮೈಸ್?
ಅಲ್ಲ, ಅವ್ರಿಗೆ ನೋಟಿಸ್ ಮಾಡಬೇಕು. These petitioners were not party before the trial court. Is the objection raised by the office? The petitioners were not a party before the trial court. The respondent 1 and 2 have filed a collusive suit for partition. They have entered into compromise.
Office objection at seal number 1 is overruled by accepting the submission of the learned counsel for the petitioner. ಆಮೇಲೆ ಇನ್ನೇನು death certificate?
My lord, that is recorded in the order sheet itself, my lord. That's why we have not produced.
In view of the office objection number 2 is also accepted by overruled by accepting the submission of the learned counsel for the respondent number 2
Others I have complained.
of the petitioner, sorry.
Others I have complained.
ಏನ್ ಕೇಸ್ ಇದು?
My lord, the grandfather of the petitioner has purchased the subject property in the year 1951 as per annexure B at page number 15. Khatas were also entered in the name of grandfather of the petitioner, subsequently in the name of the father of the petitioner. The respondent 1 and 2, they are, even though they are not at all related to the vendors of the petitioner, have filed a suit for partition at annexure G, page number 36. And subsequently, they have entered into a compromise. And the compromise decree has been passed. This property has been allotted to one of the sharer. And subsequently, they have got the change of the kata in their names, my lord. By taking undue advantage of this change of kata, they are trying to interfere with. I am challenging the compromise decree, my lord. It is not justifiable as they are not the owner of the property.
Will issue emergent notice to the respondents till the next date of hearing, entry order ಕೇಳಿದಿರಾ?
ಹೇಳಿದೀವಿ.
till the next date of hearing, comma, the petitioner and the respondent shall maintain status quo in respect of the property in question in all respects. List on date could.
And delivery of the interim order, my lord, there is threat of disposition.
Chamegoda.
32, in the matter, also may recall on 17th, Malad had directed me to serve the petition papers on the council appearing before the trial court, defendants 1 and 4. Malad, with great reluctance, Malad, they accepted the copies yesterday, even though we were trying to reach out to them since 3 days. Malad, I kindly see the impugned order, Malad, for a moment.
Yeah, Mr. Giri Babu.
Giri Babu, Malad. I served on him and I filed an acknowledgement also, Malad.
Trial court is in Bangalore or?
Trial court is in Bangalore Rural, Malad. Bangalore Rural. With great reluctance, Malad, he accepted the papers. Then asked a question, how can you serve copies?
Where is he? Has he come? Look around whether he has
in the
come or
morning.
not.
Saw his colleague in the morning, Malad. Did not see him.
Giri Raju. Giri Babu.
Undertake to file wakalat, my lord.
ಯಾಕೆ ನೀವು court notice ಕೊಟ್ರೆ ಯಾಕೆ ನೀವು?
My lord, yesterday the matter was listed before this trial.
My
court,
dear
my
friend, you are an officer of the court.
Yes, my lord.
ಯಾರೇ ತಂದು ಕೋರ್ಟ್ ಇಂದ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಕೊಟ್ಟಿದೆ ಅಂತ ನೀವು ತಗೋಬೇಕು.
We have accepted the notice, my lord. We have accepted the notice. We have taken the notice, my lord.
ಅಲ್ಲ ತುಂಬಾ ಗಲಾಟೆ ಮಾಡಿ.
ಇಲ್ಲ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. Yesterday the matter was listed before the trial.
Otherwise
No, my lord.
will hold you responsible and send you to bar council.
My lord, yesterday the matter was listed before the trial court. The argument was done, my lord. The trial court was not granted interim order, my lord. Then he has served the copy.
No.
Kindly see the acknowledgement, my lord.
Only telling you.
Affidavit also ready.
A request, you can consider this as a request. As an officer of the court, when somebody comes and says the High Court has asked you to receive it, please receive it.
We have received the copy, my lord, at 3:30, my lord. We have mentioned the time also, my lord.
Yes.
Since 17, Malad, please, Malad. The last order that's passed by the trial court, Malad, yesterday, may be permitted to pass it on, Malad. In spite of there being extreme urgency, Malad, the trial court is only hearing. Last time also, Malad, may kindly see the impugned order dated 11/12, 12/12, Malad, since 11/12 was a government holiday. At page number 22, the trial court heard me on IA number 1. And Malad, neither issues emergent notice, it says reissue suit summons in spite of me having served the KV Trust Council.
Yes, we'll direct the trial court, we'll direct both the parties to maintain status quo till this IA is disposed.
IA is disposed of. My only submission is this, Malad. Malad, may kindly see the latest photographs.
The respondent number 1 and 4, my lord.
Whatever it is, we'll
All
say,
family.
let the trial court maintain let the parties maintain status quo in respect of the property till the applications are disposed by the trial court.
Please, Malad, may kindly see Annexure W for a moment. I have only one submission.
What is your name?
P. Mahadev, sir.
Mr. P. Mahadev, the colleague of Mr. C. Giri Babu.
Yes.
Has appeared in response to the notice served by the learned counsel for the petitioner. Full stop. He submits that the applications before the trial court is being heard.
Yes, ma'am.
Full stop.
Trial court, my lord,
however, the learned counsel for the petitioner contends that though the trial court has not contends that the defendants in the suit are trying to change the nature of the suit property, and therefore prays that until the applications are heard, the parties be directed to maintain status. Full stop. In that view of the matter, full stop. He has also placed on record certain photographs which indicate
they are parking their vehicles and they are dumping debris, Malad.
Heavy earth moving equipment.
Please, no, Malad. That was me getting the property clean. No, Malad, that is at page number 54. Page number 91.
Some heavy earth moving equipment is working on a vacant piece of land. Full stop. In view of the above, till the trial court decides the applications, neither the petitioner nor the respondents shall put up any construction or change the nature of the property or part with possession of the suit property in favor of any third party or alienate, encumber or transfer the suit property
One submission, Malats. Malas, may kindly see annexure W for a moment, page number
That is
91.
what you
They are
wanted.
getting everyone's vehicles parked, Malas. They are locals having, let the vehicles be, Malas, at least, let the property be vacant.
Vehicles can always be removed, mister.
Kindly
Next,
see.
next,
Only
next.
please.
Vehicle ಇದ್ರೆ ಏನಾಗುತ್ತೆ? I don't
ಎಲ್ಲ
understand.
vehicles, ಇರೋ ಬರೋರ್ದೆಲ್ಲ vehicles, they are.
ನಿಂತ್ಕೊಂಡು ಏನಾಗುತ್ತೆ?
And also they have dumped debris as well.
ನಿಂತ್ಕೊಂಡ್ರೆ
Para
ಏನಾಗುತ್ತೆ?
number 7 of the client also.
Vehicles are parked there, what will happen?
Please,
You compound it, lay a compound if that is the case.
Malats, may I, please, Malats, after the IA is disposed of, please, please.
Compound ಹಾಕೊಳ್ಳಿ. Put a security, do whatever you want.
Malats, may I be permitted to put up a compound also?
Not now.
Without claiming
Not now,
equities?
not now.
Please.
Yes, next.
Number 33, Mohan Chandra P.
Appearing for the petitioner, my lord.
Hmm.
The case is listed on maintainability.
Hmm.
By
Here,
submit-
what is challenged?
I submit the case may be disposed of, my lord.
Disposed ಅಂದ್ರೆ?
With the liberty to file a appropriate.
The petitioner has challenged an order passed on an application filed under order 13 rule 1 and 2 of CPC. Office has raised an objection regarding maintainability. Full stop. After hearing the learned counsel for the petitioner, this court is of the opinion that the appropriate remedy to the petitioner is to file an appeal as provided under order 43 rule 1R. Consequently, the office objection regarding maintainability is upheld and the petition is dismissed as not maintainable. Office is directed to return the certified copy of the returned order to the learned counsel for the petitioner after retaining a photocopy. It is needless to mention that the time consumed in pursuing this petition shall be deducted while calculating the limitation applicable to an appeal before the appellate authority. Yes, next.
34, please, Manoj. I have to comment. But the office objection is that the first day order sheet should be before page number.
Overruled. Yes, next. Study.
Next, Manoj, in paragraph number 2.
Office objections are overruled.
Please, Manoj. Manoj, after remand of this case by this honorable court, there is a direction that an issue has to be framed. Your lordship gets that.
So what is the suit for?
Suit for recovery of money. Manoj, an issue came to be framed at, your lordship gets it at page 23.
Yes.
Manoj, thereafter I filed a memo requesting the trial court that it must be reserved for rebuttal evidence. So that was an order that has been passed. Subsequently, he files an application order 14 rule 5 saying that the burden should be cast upon me, saying that the defendant did not inherit the property of his father. It's impossible for me to prove such an issue, that I should prove that he did not inherit any property.
Yes.
Therefore, the application has been allowed. Therefore, I would request that it should be quoted.
2008 suit.
Manoj?
This is a 2008 suit.
It was after, it was a remanded.
Going back and forth.
Once it was
Unnecessary.
remanded. Once it was. Only on this particular issue to be framed and decided.
Whether plaintiff proves the defendant number 4 has
Yeah,
succeeded
how can I prove, man?
the estate of his father, late Sri R. Neelakrishna.
Your lordship gets it at page 34. I cannot prove that whether he does not inherit the property.
He does not has succeeded ಅಂತಿದೆ.
No, the plaintiff proves that the defendant number 4 has succeeded to the estate. I had to prove that he succeeded to the property. He is a Hindu. Unless he murders his father, he automatically gets his property. I cannot prove the negative of.
How did the issue number 4 as originally framed arose?
Lordship gets it at page.
He has not succeeded. Whether the defendant number 4 proves
23.
that he has not succeeded to the estate of his father, therefore is not answerable to the claim. Where's the statement of,
23.
where is the statement of defendant number 4?
Statement, your lordship gets it at page.
How does this issue arise?
But there is, but by virtue of remand. What else? Paragraph 12, your lordship may kindly. The defendant has nothing to do with the lease of the properties alleged to have been granted by the plaintiff to first, second, and third defendants. Without prejudice, he submitted the defendant has not succeeded to the estate of his father, R. Neelakrishna. He has taken a concession, he did not yet succeed to the property. Paragraph 13. It's very clear from the above paragraph that he has taken a specific contention that he has not succeeded to the estate of his father, Neelakrishna.
Issue emergent notice. In addition, so and so, interim stay of the impugned order. The
Notice
trial court is directed to proceed with the suit.
notice to 2 to 4 may be dispensed. They have not filed it.
Notice to R1, notice to response 2 to 4 is dispensed. File a memo.
I'll do that.
In the meanwhile, office objection shall be complete.
Yes, overrule ಮಾಡಿದ್ದಾರೆ.
Okay.
Overrule
Yes.
ಮಾಡಿದ್ದಾರೆ.
Yes. Nagarale, Santosh.
My lords, validity of sale deed was challenged, my lords, by the respondents. Apparently, it has become ex parte as well, my lords.
What do you want?
My lords,
Maintainability.
regarding GPA, my lords, GPA has been given to me, my lords.
But there's an office objection regarding
Yes, my lords.
maintainability.
Yes, my
What is it regard? What is it? How is it not maintainable?
They say that, my lords, both the parties have been heard before the trial court and then the IA is rejected anta ಹೇಳ್ತಾ ಇದಾರೆ, my lords. Upon that, it is not maintainable under this court.
So therefore, you cannot file a writ petition. You have to file an appeal.
MFA will be filed.
Good. Petition is dismissed. Yes.
Certificate
Yes, same
copies may be
but-
given back.
Yes, next.
Great.
ಏನಾಯ್ತು?
Two things.
ಹಾ.
ಅವ್ರು ಹೋಗ್ಲಿ.
ಹಾ.
Your lordships can do that.
ಶ್ರೀನಿವಾಸ್ ಅವ್ರು ಇದಾರ?
ನಮ್ಗೆ ಏನ್ ಹೇಳ್ತಿದಾರೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ಪ್ರಿಪರೇಷನ್ ವರ್ಕೇ ಇನ್ನು ನಡಿಬೇಕು 15 ದಿವಸ ಅಂದ್ರೆ ವೀಡ್ ಎಲ್ಲ ತೆಗಿಯಕ್ಕೆ ಅಂತ. ಅವ್ರು ನೋಡ್ಲಿ ಒಂದ್ಸತಿ. ಅವ್ರು ಹೋಗ್ಲಿ.
ಹಾ.
Then my lords, only one more request, D5 to D7 from the date of MA order. ಅವ್ರ ಮನೆ ಒಳಗೆ ಬಿಟ್ಟಿಲ್ಲ. ಅದ್ my lords
ಈಗ ಮಾಡಕ್ಕಾಗಲ್ಲ.
Lords.
That will not, will keep this petition pending. ಮನೆ ಬಿಡೋದು ಅದೆಲ್ಲ we can't do it right away.
Lords, they were there in
That, how can we decide it in an interlocutory application? How can we decide it?
because of this MA order they are not allowed.
Can we restore your possession in interlocutory?
ಅಲ್ಲ ಅಲ್ಲಿ ಗೇಟ್ ಹಾಕ್ಬಿಟ್ಟು their electricity.
ಹೊರಗಡೆ ಇದಾರ ಅವರು?
ಇಲ್ಲ ಇವಾಗ ಬೆಂಗಳೂರಲ್ಲಿ in their sister's house they are there for 1.5 months. ಮಗು ಕೂಡ ಸ್ಕೂಲ್ ಹೋಗ್ತಿಲ್ಲ.
Are they, is someone residing in the house there?
No. ಖಾಲಿ ಮನೆ. ವೈಫ್ ಇದಾರ. ವೈಫ್ ಒಬ್ಬ. ಅಲ್ಲ ಅಲ್ಲಿ
ಅಲ್ಲಿ ಅಂದ್ರೆ ಎಲ್ಲಿ?
ಊರು ಹಿಂದಿ
ಪ್ರಾಪರ್ಟಿ ಒಳಗಿದಾರ?
ಅಲ್ಲಿ ಒಳಗೆ
ಮನೆ ಇರೋದು.
Friend wanted my lord harvesting. Now he's going on to something else.
ಲಾಸ್ಟ್
ಅಲ್ಲ ಮನೇಲಿ ಇದಾರ?
ಏನಪ್ಪ ಇಲ್ಲಿ
ಸರ್ವೆ ನಂಬರ್ 15 ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ಅವ್ರು ಏನಾದ್ರು
ಅಲ್ಲ ಅವರೇ ಇದಾರೆ ಅವ್ರ ಹೆಂಡತಿನೇ ಇದೆ.
ಪ್ರಾಪರ್ಟಿ ಒಳಗೆ ಮನೆ ಇದೆಯಾ?
ಅದು
ಒಳಗೆ ನೀವ್ ಇದೀರಾ? ಫೋನ್ ಮಾಡಿ, ನಿಮ್ ಮಿಸ್ಸಸ್ ಫೋನ್ ಮಾಡಿ. ಇದೆಯಲ್ಲ ವಿಡಿಯೋ ವಾಟ್ಸ್ಆಪ್ ಮಾಡಿ, ವಿಡಿಯೋ ಕಾಲ್ ಮಾಡಿ.
And the court has recorded Aadhaar, telephone bills, electricity bill, house opening ceremony card ಎಲ್ಲ ಹಾಕಿದೀವಿ.
ನೋಡ್, दूध का दूध पानी का पानी ಬರ್ಲಿ. ಲೆಟ್ ಅಸ್ ಓನ್ಲಿ ಮಾಡ್ರಿ, ವಿಡಿಯೋ ಕಾಲ್ ಮಾಡಿ.
ಇನ್ಸ್ಟೆಂಟ್ ಜಸ್ಟಿಸ್
ನೀವು ನೋಡಿ ಸ್ವಲ್ಪ.
ಅಲ್ಲ
ಅವ್ರು ಯಾರು ಇದಾರೆ ನೋಡಿ.
ನನ್ಗೆ
ನಿಮ್ಮ ಕ್ಲೈಂಟ್ ಯಾರು ಇದಾರೆ? ಹಾ ಇರ್ಲಿ ಕೊಡಿ. ಹಾ
ನೋಡ್ರಿ ಅದನ್ನ
ಅಂದ್ರೆ ಅವ್ರೇನ್ ಮಾತಾಡ್ತಾರೆ?
ಅಲ್ಲ ತೋರ್ಸಿ, ಇಲ್ಲಿ ತೋರಿಸಿಲ್ವಾ? ಕ್ಲೈಂಟ್ ಇದಾರ?
ಅಲ್ಲಿದು
ದಟ್ ಇಸ್ ದ ಹೌಸ್
ಒಂದ್ ನಿಮಿಷ ಕೋರ್ಟ್ ಇದೆ. ಒಂದ್ ನಿಮಿಷ ಮನೆದಿಲ್ಲಿ ಅವ್ರದ್ದು ವಿಡಿಯೋ
ನೋಡಿದವ್ರು ನೋಡಿ ನನ್ನ ತೋರ್ಸರ.
ನೋಡ್ರಿ, ನೀವು ನಿಮ್ ಕ್ಲೈಂಟ್
ಅವ್ರು ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ನೋಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟೆ. ನನ್ಗೆ ನಾವು ಪ್ರಾಪರ್ಟಿ ನೋಡಿಲ್ಲ.
ನೇಮ್ ಆ ಮನೆ ವಾಟ್ಸ್ ಹಿಸ್ ನೇಮ್?
ಹೊರಗಡೆ
footage over there. You can show the CCTV
ಅಲ್ಲ
footage.
ಇಲ್ಲಿ
See that Mr.
ವಿಡಿಯೋನೇ ಹಾಕಿದ್ದಾರೆ. ಅಲ್ಲಿ ವಿಡಿಯೋ ಫೋನ್ ಲೈವ್ ಅಲ್ಲಿ ಇದಾರೆ.
ಅಲ್ಲಿ ನೋಡ್ರಿ, ಅದೇ ಮನೆ ನೋಡ್ರಿ ಮಿಸ್ಟರ್.
ಫೋಟೋದ್ದು
ಅಲ್ಲಿ ನೋಡ್ರಿ, ಇದು
ಅದ್ ನೋಡ್ರಿ, ಅದೇ ಅದನ್ನ
ಆ ತೋಟದ ಪಕ್ಕ ಒಳಗೆ ಮನೆ ಇದು.
ಇವ್ರ ಪಕ್ಕದಲ್ಲಿ ಅಂತಾರೆ, ಅವ್ರು ಒಳಗಡೆ ಅಂತಾರೆ. This is not.
ಇಟ್ಸ್ ಇನ್ಸೈಡ್. ಪಕ್ಕದಲ್ಲಿ
ಆಯ್ತು, ಪಿನ್ ಕಳ್ಸಿ, ಲೊಕೇಶನ್ ಪಿನ್ ಕಳ್ಸಕ್ ಹೇಳಿ. ತಾಳ್ರಿ ಲೊಕೇಶನ್ ಪಿನ್ ಕಳ್ಸಕ್ ಹೇಳಿ.
ಸಾಹೇಬ್ರ
ಕಳ್ಸಕ್ ಹೇಳಿ.
ಪಿನ್
ಲೈವ್ ಲೊಕೇಶನ್ ಕಳ್ಸಕ್ ಹೇಳಿ. ಲೈವ್ ಲೊಕೇಶನ್, ಕರೆಂಟ್ ಲೊಕೇಶನ್ ಕಳ್ಸಕ್ ಹೇಳಿ.
CCTV camera footage live I can show.
I don't know. ಎಲ್ಲಿ?
ಅವರು ನೋಡ್ಲಿ. Let them see.
Is the CCTV live?
This is something that you have installed.
Yes.
ಹಳೆ ಮನೆ ಅದು. ಈ ಮನೆ ಅಲ್ಲ, ಮನೆ ಇದೆಯೋ ಇಲ್ವೋ?
There are
ಆಯ್ತು, ಯಾವ ಮನೆ, ಎಷ್ಟು ಮನೆ ಇದೆ ಹೇಳಿ ಅದ್ಮೇಲೆ.
ಕೊಟ್ಟಿಗೆ ಇದೆ, ಹಸುಗಳಿದಾವೆ, ಲೇಬರ್ ಕ್ವಾರ್ಟರ್ಸ್ ಇದೆ.
ಆಯ್ತು ನೀವು ಮನೇಲಿ ಇದ್ರಲ್ಲಿ ವಾಸ ಇರಿ, ಯಾರು ತಡೀತಿದ್ದಾರೆ ನಿಮ್ಮ?
But there are FIRs filed against them. They come with a revolver, arms act, FIR is filed against him, bail is refused.
ಇದೆಯಾ?
I'll place those records, my lord.
ಇದೆಯಾ
I'll
ನಿಮ್ಮ
place
ಹತ್ರ?
those records. Allegations have been no made. I'll place those records. I didn't want to get into that because he's
Okay, I mean,
this is
if-
really
if-
going on to a tangent.
if somebody is living on the land.
My lord, there, it's all,
ಇವಾಗ ಲೆಟ್ ದ ಕಮಿಷನರೇ ಹೋಗ್ಲಿ ನೋಡ್ಲಿ ಅಷ್ಟೇ. ನಾನು ಇನ್ನೇನ್
let
ಹೇಳ್ಬೇಕು?
the commissioner verify that. also.
ಅಲ್ಲಿ ಗೊತ್ತಾಗತ್ತಲ್ಲ.
ಎಲ್ಲಿರೋದು ಪ್ರಾಪರ್ಟಿ ಇದು?
ಲೊಕೇಶನ್ ಕಳ್ಸಿಯಾರ ಸಕಲೇಶ್ಪುರ. They have sent the location also live.
ಏನು ಶ್ರೀನಿವಾಸ್ ಅವರೇ? ಆ? ಇವತ್ತೇ ಹೋಗಕ್ಕಾಗತ್ತಾ?
ಬೇಡ, ಇವತ್ತು ಲಾಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ, ಯಾಕೆ ನಾಳೆ ಹೋಗಿ.
Live location has been sent.
ಶ್ರೀನಿವಾಸ್ ಅವರು ನಿಮ್ ತರ ಅಲ್ಲ ಬಿಡಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲ ಮನೇಲಿ ಎಲ್ಲ ಹೇಳಿ ಅಕಸ್ಮಾತ್ ಯಾರು ಕರ್ಕೊಂಬರಂಗಿದೆ ಜೊತೆಲಿ
ಮನೆಯವ್ರನ್ನ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
Even the live location ಕಳ್ಸಿಯಾರೆ.
ನಿಮ್ದು ಲೈವ್ ಲೊಕೇಶನ್ ತರಿಸ್ರಿ.
Get the live location.
ಯಾರಿದಾರಲ್ಲ ನಿಮ್ಮವರು?
ಎಲ್ಲರೂ ಇದ್ದಾರೆ.
ಲೈವ್ ಲೊಕೇಶನ್.
Send a live location right now.
ಎಸ್ ಇದು ಗವರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್. ಎಸ್ ಮೇಡಮ್. ಎಸ್ ವಾಟ್ ಹ್ಯಾಪನ್? ಅಂದ್ರೆ ತಹಸೀಲ್ದಾರ್ ಆಫೀಸಲ್ಲಿ ಇಲ್ಲ.
ಅಲ್ಲೂ ಇಲ್ಲ.
ಈ ತರ ಕೂತಿರೋದು ಫೋಟೋಸ್ ಎಲ್ಲ ಜನಗಳು ನಮ್ಮ ಹತ್ರ ಅಂತೂ ಯಾರು
ಫೋಟೋಸ್ ಎಲ್ಲ that we can't decide it right now.
I'm only saying live location also she has sent.
Live
She is
location
house.
of what place? The point is that
That's
there are trespassing cases filed
100.
against them. They are living
Do not-
outside of the farm.
That lady is in the house, we do not know which is that
Whose
house.
house? Where is that house? Nobody knows.
He is a purchaser today he
No, no,
comes.
let me just pass it.
Hmm.
Come with my lord, a
ಅಲ್ಲ ಈಗ
revolver and try and listen. All I'm saying is,
Now I don't
question was on harvesting. That my lord,
let them
be complete.
let that be completed, my lords. Other issues can be decided after vacation.
I would
ಏನಿದೆ? ಕಾಫಿ ಇದೆ, ಆಮೇಲೆ
ಕಾಫಿ, ಅರೇಕ ನೆಟ್ಟು, ಪ್ಯಾಡಿ.
Areca nut can be little later.
ಇದೆಲ್ಲ
ginger.
ಪೆಪ್ಪರ್ ಇವಾಗ್ಲೇ ಆಗಲ್ಲ, ಹಾರ್ವೆಸ್ಟ್.
Lords,
Ginger has to be
ಯಾವ್ದು
harvested.
ಆಯ್ತು, ಅವ್ರು ಹೋಗಿ ನೋಡ್ಕೊಂಡ್ ಬರ್ತಾರ.
ಅವ್ರು ನೋಡ್ಕೊಂಬರ್ಲಿ.
He has given it to certain.
In robust.
By tenants to my lord do the.
ಅರೇಬಿಕ ಈಗ
harvest.
ಹಾರ್ವೆಸ್ಟ್ ಆಗಬೇಕಾಗತ್ತೆ.
He's given it to tenants. Therefore, my lord, we will look oversee it. Let the commissioner oversee.
Whatever you want to do it in the presence of the.
Absolutely right. We will do it. Do it in the presence of the commissioner.
ಅವ್ರ ಟೆನೆಂಟ್ ಅವ್ರ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಜಿಂಜರ್ ಕಲ್ಟಿವೇಶನ್.
Correct. Ginger is also there. Of course, ginger is there. Let the
Okay.
commissioner verify.
ಅವ್ರು ನೋಡ್ಕೊಂಡ್ ಬರ್ಲಿ, let him go.
Let the commission, that's why
ಹೌದು.
not, even the house, let him also verify. Because it's a,
Can the commissioner go today? Today ಅಲ್ಲ, of course. ಇವತ್ತೇ ಆಗತ್ತಾ, ನಾಳೆನಾ?
ನಾಳೆ
Tomorrow,
Tomorrow.
let him go.
Let him go.
ಆಯ್ತು.
ಬರ್ಕೊಳ್ಳಿ.
Memo of instructions, what I have to do.
ಅಲ್ಲಲ್ಲ, ನಾನು ಹೇಳ್ತೀನಿ,
ಮೆಮೊ ಆಫ್
I will say what-
Ave ಹೇಳ್ಬಿಡಿ ಸ್ವಾಮಿ, that is better.
ಬರ್ಕೊಳ್ಳಿ. In this writ petition, the dispute relates to a large extent of land. Full stop. While the petitioner contends, petitioners contend that they are in possession of the property. The respondent number. ಇದು ಯಾವ
Lords, the
petition?
respondent in the, if your lordships are holding 29891,
Yeah.
ಅದರಲ್ಲಿ respondent, the purchaser is respondent number first respondent.
ಯಾರು?
Lords, Avinash. Defendant number 6.
Who is the advocate for Avinash?
But I appeal for.
Nandakumar.
Mr. Sharad. ಏನಾಯ್ತು ಮೇಡಮ್? Contends that it is that it is he who is in possession of the property. Full stop. Since coffee, pepper, areca nut, paddy, and ginger are purportedly raised in the sued properties, this court felt it appropriate to ensure that the harvesting of these crops be done in the presence of a commissioner, so that the parties could be put on terms later. Full stop. Shri T.P. Srinivas, who was present in the court, was requested to visit the property to take stock of the situation as to the kind of crops that is raised in the suit properties, and thereafter decide the timelines within which the crops are harvested. Full stop. The commissioner shall ensure the supervision of the harvesting of the crops in the suit property, and also measure the quantity of crops so raised, so harvested, and submit a detailed report to the court about the value of the crop so harvested. Full stop. Since this would be a continuous process that may extend for more than 15 days.
15 to 30 days ಆಗ್ಬೋದು, up to 45 days ಆಗ್ಬೋದು.
My
Up
client
to
says
30 days, comma, this court considers it appropriate to fix the commissioner's fee tentatively at rupees 5 lakhs. 5 lakhs. ಆಗ್ಬೋದಾ?
ಇಲ್ಲಿ ಅವರು ಒಂದ್ಸತಿ ಹೋಗ್ಬಿಟ್ಟು ಬರ್ಬೇಕಾಗತ್ತೆ. ಇನ್ನು 15 ದಿವಸ ಪ್ರಿಪರೇಟರಿ ವರ್ಕ್ಸ್ ಗೆ ಬೇಕು.
ಅದಕ್ಕೆ ನಾನು ಹೇಳ್ತಿರೋದು ಅಲ್ಲಿವರೆಗೂ.
But our labor are there, we will, my lord, assist him in every possible way.
ಎಲ್ಲ they are
This is
taking
only for supervision. See, he has to give up his work for 1 month.
I absolutely, my lord.
No, but my learned friend says we will do. He's claiming as if he is in
He
possession.
will be there in the.
In fact,
he will
anyway,
be
that's
there-
something the court will decide.
He will be there in the property. He will live on the, stay on the property. ಏನಾಯ್ತು? Sum of rupees 5 lakhs. Full stop. The party shall make appropriate arrangements for the stay of the commissioner on the land.
Instead of making it continuously, some breaks may be.
ನಿಮಗೆ ಬಿಟ್ಟಿದ್ದು.
Can I make one further suggestion? Let him take the assistance of anybody locally if it is necessary.
ಅವ್ರಿಗೆ
So that
ಬಿಟ್ಟಿದ್ದು. Let him decide whatever he wants.
then Prince work also will not.
Your lordship is asking him to even give valuation and the entire stock. ಸ್ಕಿಲ್ ಇರೋರ್ಗೆ ಗೊತ್ತಾಗುತ್ತೆ. ಗಿಡ ನೋಡಿದ್ರೆ ನಮ್ಗೆ ಎಷ್ಟು ಕೆಜಿ ಬರುತ್ತೆ.
ಅಲ್ಲಲ್ಲ,
ಅಲ್ಲ.
ಹಾರ್ವೆಸ್ಟ್
ಆದ್ಮೇಲೆ
ಆದ್ಮೇಲೆ, ಆಫ್ಟರ್ ಹಾರ್ವೆಸ್ಟ್ ಎಷ್ಟು ಕೆಜಿ ಬಂತು ತೂಕ?
ಅದೆಲ್ಲ
ಒಂದು ಲ್ಯಾಂಡ್ ಅಲ್ಲೇ ಇರ್ತೀರ ವಾಸ?
3-4 days ಅಂತಂದ್ರೆ how to say that.
My lord, we will make the arrangements for him, no difficulty.
For the comfort, for the comfortable stay of the commissioner. Full stop. The commissioner shall submit a report by ಬೇಡ ಬಿಡಿ, ಲಿಸ್ಟ್ ಆನ್ ಯಾವತ್ ಬೇಕು?
Lord, there is one issue. I just tell your lordship straight away what will happen. According to us, our labor are there. Now they may dispute this. Again, if your lordships, my lord, may make it clear, please permit us to harvest. We will submit the entire proceeds to the court. Otherwise, what happens is that
somebody see it.
no, let him see it. Let him oversee it, my lord. No difficulty. What I'm saying is, if your lordships permit both, again, we don't want a law and order situation.
I
That's
will
all.
permit you to harvest.
I'm very grateful.
I
That's
will
all I'm
permit
pointing.
you to
That's all I'm.
Next, but it is needless to mention that the entire operation of harvesting the crop shall be upon the respondent number 1.
Respond.
Full stop. It is open for the commissioner to engage the services of any localite for the sake of assistance.
So great.
Anything else?
Lords, the commissioner also to verify about the house, my lord.
ಅದನ್ನ ಮಾಡೋದಿಲ್ಲ.
Lords, your lordships are allowing him to harvest.
No.
At least let the commissioner, he is claiming possession today.
ಅದಕ್ಕೆ
which we are
ಹೇಳ್ತೀನಿ,
disputing.
it is made clear that the permission granted to the respondent number 1 to harvest the crop shall not create any equity in his favor. It shall not be construed that the respondent is in possession of the suit property.
Lord, your lordship may also kindly note the presence of Tahsildar because Tahsildar ಬಂದಿದ್ರು ಅದನ್ನ ತಾವು.
The records from DC's office.
ಅದನ್ನ ಮೇಲೆ ಒಂದು ಫಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಹಾಕಿ.
Sorry, my lord.
Tahsildar of Sakleshpur, Tahsildar of Sakleshpur Taluk is present, and she has filed a list of documents, and she also submits that the petitioners have not filed any application for amendment of form number 7 as directed in LRRP number so and so. Full stop. This is, however, contested by learned senior counsel for the petitioner. Full stop. The documents produced by the Tahsildar is taken on record. ಇದೊಂದು ಮಾಡಿದ್ವಿ. ಆಮೇಲೆ ಇದು ಮಿಕ್ಕಿದ್ದು ಬಿಟ್ಬಿಡಿ.
DC office.
ಪಾರ್ಟ್ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ತಮ್ಮಂದೇನೆ
ಕಟ್ಟಡ ಏನಕ್ಕೆ ಬೇಡ ಅವೆಲ್ಲ.
ಅಲ್ಲ, ಅಲ್ಲ,
Otherwise
ತಮ್ಮದೇ
what happens-
ಬಂದ್ಬಿಟ್ಲೆ
ಮುಗಿಸ್ಬಿಡ್ಲಿ ಸ್ವಾಮಿ, we'll complete it.
ಏನೋ ಹತ್ತ ಕಡೆ ಇತ್ಲ ಕಡೆ ಆಗೋಗತ್ತ ಮುಂದೆ ಇದ್ರೆ ಅಂತ.
ಕಲ್ಬುರ್ಗಿ. I am going to ಕಲ್ಬುರ್ಗಿ.
just-
5 ಲಕ್ಷ ಯಾವ ಕೊಡ್ತೀರಾ?
ಅದೇ ನಾಳೆನೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿಸ್ತೀನಿ.
ಕೊಟ್ಬಿಡಿ.
ಒಂದು DC office ಇಂದ ರೆಕಾರ್ಡ್ಸ್ ಬರಬೇಕು, because we have shown my lords that we have submitted all the documents and
Find out where the
ಮಾಡಿ
Pointed
ಹಾಕ್ತಾರೆ.
it out.
Let's
Pointed
Find out where the record is.
lords, we have the certificate
Office ಅಲ್ಲಿ
copies.
ಇದ್ರೆ please tell us in ಯಾವ record, ಯಾವ office ಅಲ್ಲಿ ಇದೆ ಅಂತ
ನಾವು
ಹೇಳಿ.
ಎಲ್ಲ your lordships just saw and ಅವ್ರ ಫೋಟೋ ತಕೊಂಡ್ರು ತಹಸೀಲ್ದಾರ್.
ಇದು ಒಂದು ಮೆಮೊ ಕೊಡಿ, will ask the government advocate to
ಮೆಮೊ
secure.
ಜೊತೆ ಕೊಟ್ಟಿದೀವಿ, ಮೆಮೊ with additional documents.
At this stage, the learned senior counsel for the petitioner has filed a memo enclosing therewith copies of the application filed for amendment of the form number 7. Full stop. Learned government advocate is directed to secure instructions from the office of the deputy commissioner whether the documents as furnished by the counsel for the petitioner is available in the office of the deputy registrar. Deputy commissioner, Chikmagalur, Hassan. Yes, anything else?
So great.
ಹೋದ ಕಮಿಷನರ್ ಕ್ಯಾನ್ ಸಿ ವಾಟ್ ಈಸ್ ಇನ್ ದ ಎಸ್ಟೇಟ್. ಮನೆನಾರ ಇದೆಯಾ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ ಕಮಿಷನರ್. ಆಧಾರ ಬರ್ಲಿಲ್ಲ
Current
ಅಂದ್ರೆ
wants to create evidence.
ಬಿಕಾಸ್
This
ನಾಟ್
is-
ಕ್ರಿಯೇಟ್, ದಿಸ್ ಇಸ್
that's what it
ಸ್ಟ್ರೇಂಜ್
is.
ಥಿಂಗ್.
Fishing
ಮನೆ ಇರೋದು
information it is.
ಸೂಟ್ ಅಲ್ಲಿ ಬಂದಿದೆ.
ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಹೇಳ್ಕೊಡಿ.
ಅಲ್ಲ ಅದು ಮಿಲಾಡ್ಸ್,
Great.
ಸಿನ್ಸ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಹ್ಯಾವ್ ಹರ್ಡ್ ಲೈವ್ ಲೊಕೇಶನ್ ತೋರಿಸ್ತಿದೀವಿ. ಓನ್ಲಿ ಕಮಿಷನರ್, ದಿ ಕಮಿಷನರ್ ಕ್ಯಾನ್ ರಿಪೋರ್ಟ್ ಇಟ್ ಮಿಲಾಡ್ಸ್.
ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದು ಫೈಲ್ಡ್ ಇನ್ ಕೋರ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೀರಾ? ಯಾವತ್ತು ಯಾವ್ದಿದೆ? ನಾವು ಫೈಲ್ಡ್ ಇನ್ ಕೋರ್ಟ್ ಅಂತ ಕೊಟ್ಟಿದ್ದೀವಾ? ನಾವು ಯಾವ ಪಿಟಿಷನ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
68, my lord.
Ah,
Kindly list after vacation, please.
68 list
Serial-
after location.
Please.
Serial number 42, your lordship. Your lordship, I directed to serve a copy on us. Copy is not served, your lordship.
Counsel for petitioner, my lord. Copy, sir.
I request for a next week, your lordship.
Please wait. Correct.
Serial number 83, pronouncement of order. Parthasarthi MS.
The petition is allowed in part. The impugned order passed by the respondent number 2 refusing to grant the benefit of pay scale applicable to a second division assistant to the petitioner is quashed. Respondent number 2 is directed to fix the pay of the petitioner in the scale of rupees 1040-1900 along with dearness allowance and other allowances with effect from 5/7/1998. Consequently, the petitioner is entitled to all consequential benefits as applicable to the post of a second division assistant in the department of the respondent number 2, subject to the condition that the salary of the Archak's servants, including the petitioner, does not exceed 35% of the income of Sri Subramanya Swami Temple, Nagalammadike. However, the petitioner shall not be entitled to any other emoluments. The respondents 1 and 2 shall pay arrears of salary to the petitioner in installments so as to ensure that the salary of Archak's servants of the temple, including the arrears payable to the petitioner, shall not exceed 35% of the income of the temple in that year. Continue.
36. Arvindian.
Petitioner, my lords. Its court fee is paid, my lords.
What do you want?
My lords, this is a writ of mandamus directing the trial court to expedite the trial, my lords. The suit is of year 2005, my lords. Kindly
2005.
see
What is the stage?
My lords, stage is at defendant's evidence cross madavexam. Kindly see page number.
Are you medical or bandidara? Boring hospital. What is the stage of the suit?
My lords, the further chief of defense evidence, my lords.
Further chief of?
Defendant's evidence, my lords. Kindly come to page number 144, my lords.
144.
Yes, my lords. Now, my lords, on 8/6/2022, my lords. After finishing all the plaintiff evidence, my lords, again the plaintiff sought an IA for recalling of plaintiff evidence, my lords. And plaintiff evidence also has been led by the plaintiff.
The defendant number 2 in OS number so and so on the file of so and so is before this court, seeking for a direction to the trial court to dispose of the suit in OS number 1287 of 2006. Since the petitioner has sought for innocuous reliefs, which does not affect or prejudice the respondents in this writ petition, this writ petition is disposed of dispensing notice to the respondents. Next para. The suit in OS number 1287 of 2006 was filed for what is the relief?
Partition and
separate possession of the plaintiff's share in the suitable properties. Full stop. The suit is contested by few of the defendants. The evidence of the plaintiff was adduced, and when the case was listed for
orders on IA number 24.
listed for
Orders on IA number 24, my lords.
IA number 24 is 13 rule 1 and 2.
Yes, my lords.
ಅಲ್ಲ ಡಿಫೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಆಗಿದೆಯಾ?
ಡಿಫೆನ್ಸ್ ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ ಸರ್, ಮತ್ತೆ ಅವರು ರೀಕಾಲ್ ಹಾಕಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
ಪೇಜ್ ನಂಬರ್ 144, my lords. IA number 21 to 23, seeking to reopen and recall PW1 and also seeking production of documents. The D2 has filed IA 24, seeking recall of the D2 for leading further chief.
ಅದ್ ನೀವ್ ಹಾಕಿರೋದು ಅಪ್ಲಿಕೇಶನ್ ಫರ್ದರ್ ಚೀಫ್.
ನಾವು ಯಾಕಂದ್ರೆ ಸ್ವಾಮಿ ಅದ್ರಲ್ಲಿ ಅವರು ಫರ್ದರ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ. Kindly see on 13/7/20.
Trying to protract the proceedings.
But kindly see at 13/7/2022 order, my lords.
ನೋಡಮಾಯ್ತು.
They have
Year number 24. Case was listed for the evidence of PW2, applications were filed to recall PW1 for further chief examination and DW2 for further chief examination. Full stop. The trial court allowed the application to recall PW1 for further chief examination and further evidence was recorded. Full stop. However, till date, the trial court has not considered and disposed of the suit. Next, for having regard to the fact that the suit is pending for more than 10 years, it is appropriate to direct the trial court to dispose of the suit as early as possible, at any rate within 6 months from the date of receipt of a copy of this order. Also, the trial court is requested to take up the suit on a day-to-day basis, if not otherwise inconvenient to it, and dispose of the suit as stated above.
Your Lordship, on submission, Your Lordship. Serial number 83. Pronouncement of order, subject to periodic.
ಅದೆಲ್ಲ ಮಾಡಿದೆ, ಕಾನ್ಸಿಕ್ವೆನ್ಷಿಯಲ್ ಬೆನಿಫಿಟ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿತ್ತು. ಎಸ್, ನೆಕ್ಸ್ಟ್. ಬಂದಿದಾರಾ? ಎಲ್ಲಿದ್ದಾರೆ?
My client could not come.
My client has come.
ಅಲ್ಲ, ಇದು ಡಾಕ್ಟರ್ಸ್ ಹ್ಯಾವ್ ಆಲ್ಸೋ ಕಮ್. ಡಾಕ್ಟರ್ಸ್ ಬಂದಿದ್ದಾರೆ, ಅಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರಾ?
ಅಲ್ಲ, ನಮ್ದು
ಬರಕ್ಕೆ ಹೇಳಿ ಡಾಕ್ಟರ್ಸ್.
ನೋಡ, my case in a suit for partition and separate possession, Your Lordship.
Serial number
37. Has spoken to my client. Lord, he says he has nothing to pay, he has lost everything.
Not 1997.
Persuade him.
ಹೇಳಿ ತಡಿ.
You may have to persuade him further, or else, my lord, yesterday, as of yesterday, his consistent version is he has no means to pay anything.
So what should happen?
Your Lordships have already heard the matter, my lord. In a partition suit, mean profits have been ordered to be paid. 1997 suit.
Then
Till
let
today.
the proceedings go on. Let the proceedings before the court go on.
Execution.
Submission
Now
is
civil
not-
miscellaneous petition.
My submission is it is not maintainable. I have placed reliance on.
That is.
Shall consider, yes.
Please. Oblige.
Reserved, yes, next.
Serial number 38, Gangadharappa AV.
Pritish D'Souza. There is no representation for the respondent. List after vacation.
Serial number 39.
Srinivas.
Respondent in this case, my lord.
ಇಂಟಿಮೇಶನ್ ಮಾಡಿದ್ದೀನಿ, ಅವ್ರಿಗೇನೋ ಹುಷಾರಿಲ್ವಂತೆ. ಇವ್ರ ನಂಬರ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ ಸರ್.
ಅಲ್ಲ,
ನಂಬರ್ ಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ.
ತಾವ್ ಹೇಳಿದ್ರೆ ಸ್ವಾಮಿ ಏನೋ ಸೆಟಲ್ಮೆಂಟ್ ಆಗೋದಾದ್ರೆ ನೋಡಿ ಅಂತಂದ್ರೆ ಅವ್ರು ಇದುವರೆಗೂ ಅವ್ರು ಕಾಲು ಮಾಡಿಲ್ಲ, ಭೇಟಿನೂ ಮಾಡಿಲ್ಲ.
ಹುಷಾರಿಲ್ವಂತೆ.
ಮೈ ಪಾರ್ಟಿ ಇಸ್ ಪ್ರೆಸೆಂಟ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್, ಮೈ ಲಾರ್ಡ್.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡಿ ಏನು ಅಂತ ಮಾಡಿ.
The petitioner is challenging the order passed by the trial court on A number 1. It is set annexure.
ಫೈಲ್ ಇಲ್ವಾ?
ಇದೆ ಸರ್. Annexure V and X man. The Honorable Trial Court granted the interim order in favor of the plaintiff by directing the defendant number 6 to defendant number 7 not to put up construction. In this background, I would like to bring the notice of this Honorable Court. One Muniyalamma suit for partition.
Suit is for partition.
Suit for partition. Suit for partition. There, the case of the plaintiff is that the suitable property is a ancestral property of the plaintiff and defendants. It is their case. The defendant, the deny the case of the plaintiff, it is a content that the Muniyalamma was partition on her property in the year 2001. As per the annexure,
Yes.
Annexure L.
Annexure
LL,
L, my lord,
in page
Ah.
18.
in page number 8.
Hmm.
It is an unregistered instrument,
It's an unregistered
an
partition
unregistered
deed.
instrument. On the basis of the unregistered instrument, the mutation were accepted.
I am not a party to the said partition deed. my
So
lord.
will you wait?
Yes, please.
This unregistered instrument, on the basis of the unregistered instrument, the mutation was successful by the jurisdictional Gram Panchayat. Kindly peruse the page number 81. 81 ನಲ್ಲಿ ಬಿ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಮಾತ್ರ ನನಗೇನು ಅಲರ್ಟ್ ಆಗಿತ್ತು, ಡಿಫೆಂಡ್ ನಂಬರ್ 4 ಏನ್ ಅಲರ್ಟ್ ಆಗಿತ್ತು ಅದನ್ನ ಮಾತ್ರ ಸೂ ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿ ಮಾಡ್ಕೋತಾರೆ. ಅದರಲ್ಲಿ 60/40 ಅದ್ರಲ್ಲಿ ನನಗೇನು ಅಲರ್ಟ್ ಆಗಿತ್ತು ಅಷ್ಟು ಪೋರ್ಷನ್ ಮಾತ್ರ ಮಾಡ್ಕೋತಾರೆ. ಎ ಶೆಡ್ಯೂಲ್ ಅಂಡ್ ಸಿ ಶೆಡ್ಯೂಲ್ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಅದನ್ನ.
You are the daughter of Muniyallamma.
No, I am
Please,
the
daughter.
Please,
daughter,
ma'am.
She is
I am the daughter of the Muniyallamma.
daughter of Muniyallamma.
Defendants yaru?
Defendants,
Daughters and sons, ma'am. And husband.
Yaar defendants yaru?
defend number 8 ಬಂದು plaintiff is a petitioner is a defend number 8, my lord. Defend number 8.
Who are the defendants 1 to 7?
1 to 7. Ramlingaya Muniyallamma, my lord. Ramlingaya D1. His wife is Muniyallamma. She was died in early after the 2001.
No, Ramalinga is no more.
He's alive.
He's alive.
Ramesh is the son.
Savitramma, the first daughter Savitramma is Paradise D5. Sanjeevamma, plaintiff before the trial court, second daughter. Third son is Ramesh, defend number 2. Fourth son D3 Umesh.
ಈ ಮರಿಯಲ್ಲಮ್ಮ ಆಯಮ್ಮನ ಹೆಸರಲ್ಲಿ ಸೇಲ್ಡ್ ಇದ್ದಿದ್ದು.
ಹೌದು,
ಆಯಮ್ಮ ತೀರೋದು.
ಹೌದು, ಅಲ್ಲಲ್ಲ ನಾನು ಹೇಳ್ತಿದ್ದೀನಿ. ಮುನಿಯಲ್ಲಮ್ಮ, ಆಮೇಲೆ ನಿಂಗರಾಜು D4, 6 ಪಾರ್ವತಿ D6, D7 ಅನಸೂಯಮ್ಮ D7, D8 ಅಲ್ಲಿ ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಫಸ್ಟ್ ಆಸ್ ಪರ್ ಅನೆಕ್ಷರ್ F, my lord, ಪೇಜ್ ನಂಬರ್ 43 ಇಲ್ಲಿ 2 ಪ್ರಾಪರ್ಟಿ ಖರೀದಿ ಮಾಡ್ತಾರೆ. 24/4/1981 ಅಲ್ಲಿ. ಅದ್ರ ಡೈಮೆನ್ಷನ್ ಬಂದು ಪೂರ್ವ ಪಶ್ಚಿಮ 40 feet, ಉತ್ತರ ದಕ್ಷಿಣ 60 feet. This item is a property subject matter the suit item. One piece of land ಅಷ್ಟೇನೆ, ಎಂಟೈರ್ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಸಾಂಗ್ ಅದರಲ್ಲಿ 5/1/1984 Muniyallamma purchased another property. It is at annexure G, page number 50. 8/11/1985 Muniyallamma executed the gift deed. Is very important. Muniyallamma executed gift deed in favor of the plaintiff. Here in R1.
Yes.
With respect to the property number 493, measuring to an extent of east to west 15 feet, north to south 12.5 feet. It is at gifted is at annexure H, page number 57.
ಆಯ್ತು.
Very same property na 15/9/1994 ಅಲ್ಲಿ plaintiff has sold very same property in favor of Nagratnamma, wife of Jairamaya. The sale deed is at annexure J, page number 62. Next one, 9/3/2001 ಅಲ್ಲಿ Muniyallamma executed another gift deed in favor of K.R. Anasuyamma, the defend number 7 in the ಇಲ್ಲಿ R8 ಆಯ್ತಾರೆ. ಅವರು ಕೂಡ ಮಾರ್ಬಿಡ್ತಾರೆ ಪ್ರಾಪರ್ಟಿನ. ನೆಕ್ಸ್ಟ್ 10/3/2001 ಅಲ್ಲಿ 2 ಐಟಮ್ ಮಾತ್ರ Muniyallamma ಹತ್ರ ಇರ್ತೈತೆ. 10/3/2001 ಅಲ್ಲಿ ಅವ್ರು 3 ಜನ ಗಂಡು ಮಕ್ಳಿಗೆ ಮಾತ್ರ ಪಾರ್ಟಿಷನ್ ಮಾಡ್ತಾರೆ. ಅದ್ರ ಬೇಸ್ ಮೇಲೆ ಮ್ಯುಟೇಷನ್ ಅಕ್ಸೆಪ್ಟ್ ಆಗುತ್ತೆ. ಪಾರ್ಟೇಷನ್ ಮಾಡಿರೋದ್ರಲ್ಲಿ ಎ ಶೆಡ್ಯೂಲ್ ಬಿ ಶೆಡ್ಯೂಲ್ನ ಪ್ರಾಪರ್ಟಿನ ಸೂ ಶೆಡ್ಯೂಲ್ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ. ಒನ್ಲಿ ನನಗೇನು ಅಲರ್ಟ್ ಆಗಿತ್ತು ಆ ಪೋರ್ಷನ್ ಮಾತ್ರ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಅವ್ರದೆಲ್ಲ ಅವ್ರು ಆಲ್ರೆಡಿ ಕೊಟ್ಟಿದೀವಿ ಅವ್ರಿಗೆ.
Is that a fact?
ಹೌದು.
No, my lord. We have not received any share in the said property, my lord.
Muniyallamma has executed some gifted in
Gift
your
deed.
favor.
Of course, my lord.
ಒಂದು ನಿಮಿಷ ತಡೆರಿ, ಇಲ್ಲ I'll throw away the file.
We have obtained the gift deed from the Muniyallamma that was sold by the ಫಸ್ಟ್
by 60 ಸೈಟ್ ಸೂಟ್ ಪ್ರಾಪರ್ಟಿ ಒಳಗೆ
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ.
ಇದು ಇಲ್ಲ sir.
ಯಾವ್ದ್ರಲ್ಲಿ ಕೊಟ್ಟಿರೋದು?
ಇನ್ನೊಂದು ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ರು ಅದನ್ನ ಕೊಟ್ರು ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. ಅದನ್ನ ಕೊಟ್ಟಿದ್ರು ಸ್ವಾಮಿ.
ಹಾ,
ಅದನ್ನ ಅದ್ ಸೇಲ್ ಮಾಡ್ಬಿಟ್ಟು ಅವ್ರಿಗೆ ಹುಷಾರಿರ್ಲಿಲ್ಲ, ಅದು ಅವ್ರಿಗೇನೆ ಖರ್ಚು ಮಾಡಿದ್ದಾರೆ ಅವ್ರು.
ಹಾ, ಹಾ,
ವಿ ಹ್ಯಾವ್ ಎ ರೆಕಾರ್ಡ್ ಟು ದಟ್ ಎಫೆಕ್ಟ್ ಮೇಲ.
ಹ್ಮ್.
ಸೊ ಈಗೇನು ಅಂತಂದ್ರೆ ಈ ಪ್ರಾಪರ್ಟಿಲಿ ನಮಗೆ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ನಾವು ಕೇಳ್ತಾ ಇದೀವಿ ಪಾರ್ಟಿಷನ್.
ಇದು ಮರಿಯಲ್ಲಂಗೆ ಸೇರಿದ್ದ.
ಹೌದು ಹೌದು ಸ್ವಾಮಿ.
ಎಸ್,
ಅಷ್ಟು ಸರ್. ಮರ್ಯ
if the property belong to ಮರಿಯಲ್ಲಮ್ಮ,
ಹೌದು, ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದಾರೆ.
ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಟ್ಟು, ಬಟ್ ಇವ್ರಿಗೇನ್ ಭಾಗ ಕೊಟ್ಟಿಲ್ವಲ್ಲ?
ಗಿಫ್ಟ್ ಡೀಡ್ ಎಲ್ಲ ಆಗಿದೆ, ಗಿಫ್ಟ್ ಡೀಡ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದು ಪ್ರಾಪರ್ಟಿ ಮಾರ್ಕೊಂಡಿದ್ದಾರೆ.
ಅದು ಹಿಂದೆ ಕೊಟ್ಟಿದ್ದು. ವೆದರ್ ಯು ಎಂಟೈಟಲ್ಡ್ ಆರ್ ನಾಟ್, ಲೆಟ್ ಯು ಪ್ಲೀಸ್ ವರ್ಕ್ಔಟ್ ಯುವರ್ ರೆಮಿಡಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಮನೆ ಕಟ್ತಾ ಇದ್ದೀನಿ. ಯಾಕಂದ್ರೆ ಈಗ ಎ ಶೆಡಲ್ ಪಾರ್ಟಿ ಮಾಡಲ್ಲ, ಬಿ ಶೆಡಲ್ ಅವ್ರು ಪಾರ್ಟಿ ಮಾಡಲ್ಲ, ಒನ್ಲಿ ನನ್ನ ಎಕ್ಸ್ಟೆಂಟ್ ಮಾತ್ರ ಪಾರ್ಟಿ ಮಾಡ್ತಾರೆ. ಮನೆ ಕಟ್ತಿರೋ ಜಾಗ ಅಷ್ಟು. ಕೈಂಡ್ಲಿ ಪೇರಸ್ ದಿ ಪ್ಲೈಂಟ್ ಅವರ್ಮೆಂಟ್ ಸರ್. ಪ್ಲೈಂಟ್ ಅವರ್ಮೆಂಟ್ ಅಲ್ಲಿ
ಆಯ್ತು, ನೀವು ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಏನಪ್ಪ ಹೇಳಿದಿರಾ?
ಎಲ್ಲ ನಾನು
ಅಡ್ಮಿಟೆಡ್ ರಿಲೇಶನ್ಶಿಪ್ ಅಂಡ್ ಆಲ್ಸೋ
ಡೋಂಟ್ ಇಂಟರ್ಫಿಯರ್.
ಪ್ಲೀಸ್
ರಿಲೇಶನ್ಶಿಪ್ ನಾಟ್ ಡಿನೈಡ್, ಇಟ್ ಇಸ್ ಅಡ್ಮಿಟೆಡ್.
ಎಲ್ಲಿ ಹೇಳಿದಿರ ಬೇರೆ ಪ್ರಾಪರ್ಟೀಸ್ ಎಲ್ಲ ಸೇರಿಸಿಲ್ಲ ಅಂತ ಎಲ್ಲಿ
ಇಲ್ಲಿ ಹೇಳಿದೆ ಸರ್, ಎಲ್ಲ ಹೇಳಿದೆ. ವಾದಪತ್ರದ 6ನೇ ಪೇಜ್ ನಂಬರ್ ಅನೆಕ್ಷರ್ ಬಿ ಮೈಲಟ್, ಪೇಜ್ ನಂಬರ್ 24. ವಾದಪತ್ರದ 6ನೇ ಅವೆರ್ಮೆಂಟ್ 4, ವಾದಪತ್ರದ 6ನೇ ಪ್ಯಾರಾದಲ್ಲಿ ವಿವರಿಸಿರುವಂತೆ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿ 1ರಿಂದ 7 ಮರಿಯಮ್ಮನ ವಾರಸುದಾರರಾಗಿರ್ತಾರೆ. ಮರಿಯಲ್ಲಮ್ಮನವರ ಮೃತರಾಗಿರ್ತಾರೆ ಎಂಬ ಅಂಶವು ಸತ್ಯವಾಗಿರ್ತದೆ. ದಾವಾಸ್ತಿ ಒಟ್ಟು ಕುಟುಂಬದ ಆಸ್ತಿ ಎಂಬುದು ಅಸತ್ಯವಾಗಿರ್ತದೆ. ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿ 1ರಿಂದ 7 ಇದುವರೆಗೂ ಯಾವುದೇ ವಿವಾಹ ನಡೆದಿರುವುದಿಲ್ಲ ಎಂಬ ಅಂಶವು ಅಸತ್ಯವಾಗಿರ್ತದೆ. ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿ 1ರಿಂದ 7 ದಾವಾಸ್ತಿಯಲ್ಲಿ ಭಾಗಾಂಶದ ಹಕ್ಕುದಾರರ ಅಂಶವು ಅಸತ್ಯವಾಗಿರ್ತದೆ. ಸದರಿ ಅಂಶಗಳನ್ನು ನಿರೂಪಿಸುವ ಹೊಣೆಗಾರಿಕೆ ವಾದಿಯದೇ ಆಗಿರ್ತದೆ. ನೆಕ್ಸ್ಟ್ ಇಲ್ಲ ಅವರ್ಮೆಂಟ್ ಪೇಜ್ ನಂಬರ್ 25 ಅವರ್ಮೆಂಟ್ 2 ತಿರ್ಗಾ ಮುಂದುವರೆದು ಘನ ನ್ಯಾಯಾಲಯಕ್ಕೆ ತಿಳಿಸಿಕೊಡಿಸಿದ್ರೆ ವಾದಿಯ ಅಶುದ್ಧ ಇಲ್ಲಿಂದ ನಿವೇಶನಗಳನ್ನು, ಪ್ರತ್ಯೇಕ ದಿನಾಂಕಗಳನ್ನು, ಕೆಲ ಆಸ್ತಿಗಳನ್ನು ಕ್ರಯಪತ್ರದ ಮುಖೇನ, ಇನ್ನು ಕೆಲ ಆಸ್ತಿಗಳನ್ನು ಹಕ್ಕು ನಿವೃತ್ತಿಯಂತೆ ಸ್ವಾಧೀನಾನುಭವ ಹೊಂದಿದ್ದು ಮಾಲೀಕತ್ವ ಹಕ್ಕು ಮತ್ತು ಹೊಂದಿರುತ್ತಾರೆ. ವಾದಿಯ ತಾಯಿ, ಪ್ರತಿವಾದಿ 1ರವರ ಹೆಂಡತಿ, ಪ್ರತಿವಾದಿ 2ರಿಂದ 7ರವರ ತಾಯಿ, ಪ್ರತಿವಾದಿ 8ರವರ ಅತ್ತೆಯು ದಿನಾಂಕ ಡೇಟ್ ಮಿಸ್ ಆಗಿದೆ. ಅದರಲ್ಲಿ 1971 ಹಕ್ಕು ನಿವೃತ್ತಿಯಂತೆ ಬಂದಂತಹ ಕಾನೇಸುವಾರಿ ನಂಬರ್ 492/3 ಆಸ್ತಿಯನ್ನು 2ನೇ ಪ್ರತಿವಾದಿಗೆ ಹಾಗೂ 1981ರಲ್ಲಿ ಕ್ರಯಕ್ಕೆ ಪಡೆದ ಆಸ್ತಿಯನ್ನು ಪ್ರತಿವಾದಿ 3 ಮತ್ತು 4ರವರೆಗೆ 2001ರ ವಿಭಾಗ ಪತ್ರದಂತೆ ಹಾಗೂ ವಾದಿಯ ತಾಯಿ ಕ್ರಯಕ್ಕೆ ಪಡೆದ ಆಸ್ತಿಯನ್ನು ವಾದಿಗೆ 1984-85ರಲ್ಲಿ ಹಾಗೂ 7ನೇ ಪ್ರತಿವಾದಿಗೆ 2001ರಲ್ಲಿ ಆಸ್ತಿಗಳನ್ನು ಭಾಗಾಂಶವಾಗಿ ದಾನಪತ್ರ, ಅರಿಶಿನ ಕುಂಕುಮ ದಾನಪತ್ರವಾಗಿ ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಈಗಾಗಲೇ ಮರಿಯಲ್ಲಮ್ಮ ವಾದಿಗೆ ಸಲ್ಲಬೇಕಾದ ಭಾಗಾಂಶವನ್ನು ನೀಡಿದ್ದಾಗಿ ಸದರಿ ದಾನಪತ್ರದ ಆಸ್ತಿಯನ್ನು ವಾದಿಯು ಈಗಾಗಲೇ ಬೇರೆಯವರಿಗೆ ಮಾರಾಟ ಮಾಡಿರುತ್ತಾರೆ. ಹೀಗಾಗಿ ವಾದಿಯು ಸದರಿ ಮರಿಯಲ್ಲಮ್ಮನ ಆಸ್ತಿಯಲ್ಲಿ ಸಲ್ಲಬೇಕಾದ ಭಾಗಾಂಶವನ್ನು ಪಡೆದುಕೊಂಡಿದ್ದಾಗಿಯೂ ಸದರಿ ಸತ್ಯಾಂಶವನ್ನು ಮುಚ್ಚಿಟ್ಟು ಸುಳ್ಳಿನ ಕತೆ ಕಟ್ಟಿ ಪ್ರತಿವಾದಿ 8ರವರ ವಿರುದ್ಧ ಕಟ್ಟಡ ಕಾಮಗಾರಿ ಸ್ಥಗಿಸಿ ಅಕ್ರಮ ಲಾಭ ಸಂಪಾದನೆಯ ದುರುದ್ದೇಶದಿಂದ
ಯಾರಿಂದ ಬಂದಿದ್ದು? ನಿಮಗೆ ಯಾರಿಂದ ಬಂದಿದ್ದು? ಉಮಾ
ನನಗೆ ಗಿಫ್ಟ್ ಇಟ್ ಬಂದಿರ ಸರ್.
ಯಾರು ಮಾಡ್ಕೊಟ್ಟಿದ್ದು?
ನನ್ನ ಹಸ್ಬೆಂಡ್ ಉಮೇಶ್.
ಉಮೇಶ್ ಹೆಂಗ್ ಬಂತು?
ಉಮೇಶ್ಗೆ 2001ರಲ್ಲಿ ಅವ್ರ ತಾಯಿಯವರು ಭಾಗಾಂಶ ಮಾಡ್ಕೊಡ್ತಾರೆ.
ಮರಿಯಲ್ಲಮ್ಮ?
ಹೌದು, ಅದು ಅದ್ರ ಪ್ರಕಾರ ಬಂದಿದೆ ಸರ್. ಅನೆಕ್ಷರ್ ಎಲ್ ಪ್ರಕಾರ ಬಂದಿದೆ.
ಮರಿಯಲ್ಲಮ್ಮ ಮಧ್ಯೆ ಆಗಿಲ್ಲ,
ಎಲ್ಲಾ ಪ್ರಾಪರ್ಟಿನೂ ಆಡ್ ಮಾಡಿಲ್ಲ.
ಇದು ಮರಿಯಲ್ಲಮ್ಮನ ಪ್ರಾಪರ್ಟಿ ಅಲ್ವೇನ್ರಿ?
ಪ್ಲೀಸ್
ಮರಿಯಲ್ಲಮ್ಮ ಉಮೇಶ್ ಗಿಫ್ಟ್ ಮಾಡಿದಾರೋ ಇಲ್ವಾ?
ನೋ ಮೈ ಲಾರ್ಡ್.
ನೋ ಅಂದ್ರೆ
she is not executed any gift deed in favor of the Umesh.
ಎಲ್ಲಿದೆ ಗಿಫ್ಟ್ ಇರೋದು?
ಹಾಕಿದೆ ಅನೆಕ್ಷರ್ ಅಲ್ಲಿ ಕೊಡಿದ್ದೀನಿ ಸರ್. ಇಲ್ಲಿ
Umesh executed a gift deed in favor of his wife, my lord.
ಹೌದು.
ಉಮೇಶ್ ಹೆಂಗ್ ಬಂತಿದ್ದು?
ಉಮೇಶ್ಗೆ 2001ರಲ್ಲಿ ಅವ್ರ ತಾಯಿ ಮಾಡ್ಕೊಟ್ಟಿದ್ರು.
ಎಲ್ಲಿದೆ ಇದು?
ವಿಭಾಗ ಪತ್ರ ಸ್ವಾಮಿ, ಕೈಲಿ ಕರೆಸ್ದಿ.
In page 80, my lord.
In page 79 ಅಲ್ಲಿ ಕೈಪುಟ್ ಕಾಪಿ
ಇದೆ 80.
ಎಲ್ ಪೇಜ್ ನಂಬರ್ ಎಲ್ ಪೇಜ್ ನಂಬರ್ 80 ಎಲ್ಲಲ್ಲಿ ನೆರೇಟ್ ಮಾಡಿದ್ದಾರೆ. ಪಾರ್ಟಿಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು. ಈ ಪಾರ್ಟಿಷನ್ ಮುಖಾಂತರ 2016ರಲ್ಲಿ
ಎಲ್ಲಿ ಬರ್ದಿದ್ರೆ ಹೇಳ್ರಿ ಪ್ರಾಪರ್ಟಿ ಅವ್ರಿಗೆ ಹೋಗಿದೆ ಅಂತ. ಉಮೇಶ್ ಎಲ್ಲಿದೆ?
ಇಲ್ಲೇ ಸರ್, 2ನೇ ಐಟಮ್ಸ್ ಪೇಜ್ ನಂಬರ್ 81. ಪೇಜ್ ನಂಬರ್ 81 ಅಲ್ಲಿ ಶೆಡ್ಯೂಲ್ ಬಿ ಟೈಪ್ಡ್ ಕಾಪಿ.
ಇಷ್ಟೊತ್ಗಾಲ ಇವರು ಮರಿಯಲ್ಲಮ್ಮ ತೀರೋಗಿದ್ರ?
ಇಲ್ಲ, ಆಮೇಲೆ ತೀರೋದ್ರು. ಆಫ್ಟರ್ ದಿ
ರಾಮಲಿಂಗಯ್ಯ ಮುನಿಯಲ್ಲಮ್ಮ ಸಿಗ್ನೇಚರ್ ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಎಬೆಟ್ ಹಾಕಿದ್ರು.
ಎಲ್ಲಿ?
ಎಬೆಟ್ ಹಾಕಿದ್ರು. ಅನೆಕ್ಷರ್ ಎಲ್ಲಲ್ಲಿ 79 ಪೇಜ್ ನಂಬರ್ ಅಲ್ಲಿ ಎಬೆಟ್ ಕಾಣ್ತದೆ.
ವಿಲ್ ಕನ್ಸಿಡರ್ ಟೆಸ್ಟ್ ಬರ್ಕೊಟ್ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬರ್ಕೊಟ್
ಎಂಟ್ರಿ ಮಾಡೋ ಆಕ್ಷನ್ಸ್.
tomorrow's action to the next step. Yes. ನಮಸ್ಕಾರ, ಬನ್ನಿ. ಈಗ ಅದು ಪ್ರಾಬ್ಲಮ್ ಗೊತ್ತಾಯ್ತಾ? ಮೆಡಿಕಲ್ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ನೀವಾ? ಇವಾಗ ಯಾರು ಇದಾರೆ? ಡಾಕ್ಟರ್ಸ್ ಯಾರು ಬಂದಿದ್ದಾರೆ? ಈಗ ಬ್ಲಡ್ ಸ್ಯಾಂಪಲ್ ಡ್ರಾ ಮಾಡಿ ನಾವು 1 ತಿಂಗಳು ಮಟ್ಟಿಗೆ ಸ್ಟೋರ್ ಮಾಡಬೇಕು. ಆಮೇಲೆ DNA ಟೆಸ್ಟ್ ಮಾಡಿಸ್ಬೇಕಾಗುತ್ತೆ. ಅದಕ್ಕೇನು ಪ್ರೊಸೀಜರ್ ಏನು ಮಾಡಬೇಕು? ಸ್ವಲ್ಪ ನಾನು ಹೇಳೋದು ಕೇಳಿ. ಇವಾಗ ಅಪ್ಪ ಅಮ್ಮನ ಮಧ್ಯ ನಿನ್ ಮಗ ಅಲ್ಲ ಅಂತ ತಂದೆ, ಮಗ ನೀನೇ ಅಪ್ಪ ಅಂತ ಮಗ. ಇವಾಗ DNA ಟೆಸ್ಟ್ ಮಾಡಬೇಕು. ಕಾನೂನಲ್ಲಿ ಒಂದು ತೊಡಕಿದೆ. ಕೋರ್ಟಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಆಗೋವರೆಗೂ DNA ಟೆಸ್ಟ್ ಮಾಡಬಾರ್ದು ಅಂತ ಕಾನೂನಲ್ಲಿ ತೊಡಕಿದೆ. ಆದರೆ ತಂದೆಯ ಪರಿಸ್ಥಿತಿ ತುಂಬಾ ಚಿಂತಾಜನಕವಾಗಿದೆ. ಅದಕ್ಕೆ ಬ್ಲಡ್ ಟೆಸ್ಟ್ ಸ್ಯಾಂಪಲ್ ಡ್ರಾ ಮಾಡಿ ಅದನ್ನ ಒಂದ್ ಕಡೆ ಪ್ರಿಸರ್ವ್ ಮಾಡಿ ಸಾಕ್ಷಿ ಆಧಾರದ ಆದ್ಮೇಲೆ ನಾವು ಅದನ್ನ ಕಂಪ್ಯಾರಿಸನ್ ಕಳಿಸ್ಬೇಕು. ನೀವು ಔಟ್ ಆಫ್ ದಿ ಬಾಕ್ಸ್ ಯಾಕೆ ಯೋಚನೆ ಮಾಡಲ್ಲ? ಅದೇ ದಾರಿ, ಒಂದೇ ದಾರಿಯಲ್ಲೇ ಯಾಕೆ ಹೋಗ್ತೀರಿ ನೀವು? ಟೆಸ್ಟ್ ಮಾಡಕ್ ನಿಮ್ಮಲ್ಲಿ ಇಲ್ರಿ. ಡ್ರಾ ಮಾಡಿ ಪ್ರಿಸರ್ವ್ ಮಾಡಕ್ ಆಗಲ್ವ ನಿಮ್ ಕೈಲಿ? ಬ್ಲಡ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಹೆಂಗ್ರಿ ಇರುತ್ತೆ? ಹೌದ್ರಿ, ಅದೇ ಟೆಂಪರೇಚರ್ ಅಲ್ಲಿ ಪ್ರಿಸರ್ವ್ ಮಾಡ್ಬೇಕು. ಹೊರಗಡೆ ಬಿಸಿಲಲ್ಲಿ ಇಡಕ್ಕಾಗುತ್ತಾ? ಬ್ಲಡ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ 1 ತಿಂಗಳು ಪ್ರಿಸರ್ವ್ ಮಾಡಕ್ ಆಗಲ್ವೇನ್ರಿ? ಬ್ಲಡ್ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಪ್ರಿಸರ್ವ್ ಮಾಡಕ್ ಆಗಲ್ವಾ? ಇದುವರೆಗೂ ಯು ನಾಟ್ ಡನ್. ನೀವೇ ಅನ್ಕೊಂಡ್ರೆ ರಾಕೆಟ್ ಮೇಲಕ್ಕೆ ಹೋಗ್ತಾ ಇರ್ಲಿಲ್ಲ. ಇದುವರೆಗೂ ನಾವು ರಾಕೆಟ್ ಬಿಟ್ಟಿಲ್ಲ, ನಾವು ಮೇಲಕ್ಕೆ ಹೋಗಲ್ಲ ಅಂತ. ಬೇರೆ ಥಿಂಕ್ ಮಾಡಿ, ಯೋಚನೆ ಮಾಡಿ ಹೇಳಿ. ನೀವೇನೋ ಬುದ್ಧಿವಂತರು ಅಂತ ನಿಮ್ಮನ್ನ ಕರ್ಸಿದೀವಿ. ನೀವು ನೋಡಿದ್ರೆ ನಮ್ಮಷ್ಟೇ ದಡ್ಡರಾಗಿದ್ರೆ. ನಿಮ್ ಡಿಸ್ಪೆನ್ಸರಿ ಇಲ್ಲ ಕಣ್ರಿ, ಅದಕ್ಕೆ ಮೆಡಿಕಲ್ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಕರೆಸ್ರಿ ಅಂತ ಹೇಳಿದ್ದು. ಅವ್ರು ಇದ್ರೆ ಬರಕ್ ಹೇಳಿ. ಮೆಡಿಕಲ್ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ ಬರ್ಬೇಕಲ್ಲ. ಏನವರು ಹೈಕೋರ್ಟ್ ಗೌರವ ಕೊಡೋದಿಲ್ವ ಅವರು? ನಿಮ್ಗೇನು ಗೊತ್ತಿಲ್ಲ, ಅವ್ರಿಗೆ ಅವ್ರು ಬರ್ಬೇಕಲ್ವಾ? ಕನ್ಫರ್ಮ್ ಮಾಡಿ. ಅರ್ಥ ಆಯ್ತಾ ಸಿಚುವೇಶನ್? ಡಿಡ್ ಯು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್?
Serial number 40, Mohan Kumar D.
For the petitioner, my lordships. My lordships have heard this matter on Tuesday, my lordships. DNA test application. DNA test application. Partition suit dispute ಮಾಡಿದ relationship. Later on, my lords, they says same ಬರ್ಬೋದು ಅಂತ ಹಾಕಿ.
I have sufficient documents to prove that they are not belongs to same family, which are already marked before the under trial court by way of
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬೇಕಾ?
ಅಲ್ಲ, 4ನೇ ತಾರೀಕು ಇದೆ ಸ್ವಾಮಿ ಅದು ಮ್ಯಾಟರ್.
ಏನ್ ಮಾಡ್ಬೇಕು?
ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಯಾವ್ದನ್ನ ಇದ್ರೆ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರಿ. ಮಾರ್ಕ್ ಮಾಡಿಸಿದ್ದಾರೆ. ಎಕ್ಸಿಬಿಟ್ಸ್ ಟ್ಯೂಸ್ಡೇ ಸಂಡೇ ನೀವ್ ಹೇಳಿದ್ದು. ವೆಡ್ನೆಸ್ಡೇ ಅಪ್ಲೈ ಮಾಡಿದೀವಿ, ಬಟ್ ಇನ್ನು ಕೊಟ್ಟಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ.
ಜೆರಾಕ್ಸ್ ಕಾಪಿ ಇದ್ರು ಕೊಡಪ್ಪ.
ಅಲ್ಲ, ನನ್ನ ಹತ್ರ ಇದಾವೆ, ನಾನು ಬೇಕಾದ್ರೆ ಕೊಡ್ತೀನಿ ಅವ್ರಿಗೆ.
ಏನೇನ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ?
ಎಕ್ಸಿಬಿಟ್ಸ್ ಅಂತ 1924 ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅನ್ನ, ಸೇಲ್ ಡೀಡ್ಗಳನ್ನ, ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅನ್ನ 1924 ಇಂದ 77 ತನಕ I have marked more than a dozen of documents. before the trial.
About his paternity.
Yes.
About his paternity.
They are the different family ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ ಅವ್ರೇನ್ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಾರಲ್ಲ ಆ ಫ್ಯಾಮಿಲಿ ಟ್ರೀ ನಲ್ಲಿ ಇರುವಂತ ಹೆಸರುಗಳು ನನ್ನ ಫ್ಯಾಮಿಲಿ ಇರುವಂತ ಹೆಸರುಗಳು ದೇ ಆರ್ ಟೋಟಲಿ ಡಿಫರೆಂಟ್.
List after vacation. Yes.
My lordship, stay may be granted until then.
No.
What stay?
Stay the proceedings.
Before the trial court.
Yes, my lord. Defendant evidence ಗೆ judgment post ಮಾಡ್ತಾರೆ. Petition will become infructuous, my lords. DNA test application ಅಷ್ಟೇ. Relationship ನ dispute
In
ಮಾಡ್ತಾರೆ.
the appeal also you can ask for DNA test.
My lords, then again it will be a problem. Judgment ಗೆ ಹಾಕ್ಬಿಡ್ತಾರೆ ಅದಕ್ಕೆ ಸ್ವಾಮಿ.
ಆಯ್ತಪ್ಪ ಜಡ್ಜ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ ಅಪೀಲ್ ಹಾಕೊಂಡು ಅಪೀಲ್ ಅಲ್ಲಿ ಕೇಳ್ಬೋದಲ್ಲ DNA test.
Will be ಮತ್ತೆ ದೊಡ್ಡ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ ಸ್ವಾಮಿ.
ಯಾಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗುತ್ತೆ?
ಡಿಸ್ಪೋಸಲ್ ಆಗೋದ್ರೆ ಈಗಲೇ DNA test.
ಮಿಸ್ಟರ್ ಡಾಕ್ಯುಮೆಂಟ್ ಯು ಪ್ರೊಡ್ಯೂಸ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಾ?
ಅಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿಸಿ.
ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದಿರಾ?
Yes, my lord.
ಪೆಟರ್ನಿಟಿ ಪ್ರೂವ್ ಮಾಡೋದಕ್ಕೆ?
ಇಲ್ಲ ಅದು ಯಾಕಂದ್ರೆ 1983-87 disputes my lord, no documents. ರಿಗಾರ್ಡಿಂಗ್ ಬರೀ ಮುಟೇಶನ್ ರಿಜಿಸ್ಟರ್ ಒಂದಿದೆ. ಇಲ್ಲಿ DNA ಟೆಸ್ಟ್ ಅಪ್ಲಿಕೇಶನ್ ಅದಕ್ಕೋಸ್ಕರನೇ ಹಾಕಿರೋದು. My lords, earlier they dispute the relationship, my lords. They deny the relationship entirely. And later on, my lords, same ಬರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ. That conduct itself, my lords, is doubtful. ಅವ್ರದೇ ಫ್ಯಾಮಿಲಿ ಇಟ್ಸ್ ಪ್ರಾಪರ್ಟಿ ಹೋಗುತ್ತೆ DNA ಟೆಸ್ಟ್ ಪ್ರೂವ್ ಆದ್ರೆ ಅಂತ ಅಂದ್ಬಿಟ್ಟು they are not allowing, my lords. Their contention is ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲೇ ಹೇಳ್ತಾರೆ. ಸೇಮ್ kindly see, my lords, page number 8.
I remember, yes.
Yes, my lords. ಪ್ರಾಪರ್ಟಿ ಕೊಡ್ಬೇಕಲ್ಲ ಅಂತ ರಿಲೇಶನ್ಶಿಪ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ 1980s ಅಲ್ಲಿ ಆಗಿರೋಂತ.
ಆಯ್ತಪ್ಪ ನಿಮ್ ತಂದೆ ಇವ್ರು ಅಂತ ತೋರ್ಸಕ್ ಏನೋ ಒಂದು ಡಾಕ್ಯುಮೆಂಟ್ ಇರ್ಬೇಕು ತಾನೆ?
ಅದು ಮಾರ್ಕ್ ಮಾಡಿಸಿದೀನಿ.
ಸ್ಕೂಲಿಗೆ ಸೇರಿದ್ದು ಏನೋ ಡಾಕ್ಯುಮೆಂಟ್.
ಮೈ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಅವಾಗ ಯಾರು ಸ್ಕೂಲಿಗೆ ಸೇರಿಲ್ಲ. ಈ 78 years 78 years plaintiff.
ಆಯ್ತು 78 years ಏನೋ ಒಂದು ಪೆನ್ಷನ್, ಒಂದು ಆಧಾರ್ ಕಾರ್ಡ್, ಒಂದು ಏನೋ ಒಂದು ಬೇಕಲ್ಲ.
ಆಧಾರ್ ಕಾರ್ಡ್ ಎಲ್ಲ ಇವಾಗ ಬಂದಿರೋದು ಆಧಾರ್ ಕಾರ್ಡ್ ಎಲ್ಲ ರೀಸೆಂಟ್ ಆಗಿ 78
ಆಧಾರ್ ಕಾರ್ಡ್, ಅದಕ್ಕೆ ಮುಂಚೆ ವೋಟರ್ಸ್ ಲಿಸ್ಟ್, ರೇಷನ್ ಕಾರ್ಡ್.
ವೋಟರ್ಸ್ ಲಿಸ್ಟ್ ಇದೆ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು. ಪ್ಲೇಂಟಿಫ್ ಗಂಡ ರಾಮಯ್ಯ ಅಂತಾನೆ ಇದೆ.
ಅದ್ರಲ್ಲಿ ಇದೆಯಾ ವೋಟರ್ಸ್ ಲಿಸ್ಟ್? ಇದೆಯಾ?
ಅದ್ರಲ್ಲಿ ರಾಮಯ್ಯ ಅಂತಾನೆ ಇದೆ ಗಂಡನ ಹೆಸರು.
ಸಾಕ್ಷಿ ಮಾಡಿಸಿದ್ಯಾ ಬೇರೆ ಊರ್ನವ್ರದ್ದು?
ಹೌದು, ಊರ್ನವ್ರು ಎಲ್ಡರ್ ಮೇಲ್ ಮೆಂಬರ್ ಆಫ್ ಅದು ವಿಲೇಜ್ ಮಾಡಿಸಿದೀನಿ, ಸಾಕ್ಷಿ ಮಾಡಿಸಿದೀನಿ. ಬಟ್ ಅದ್ರಲ್ಲಿ ಪ್ರಾಬ್ಲಮ್ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ಸ್ವಾಮಿ, ಅವ್ರಿಗೆ 98 ವರ್ಷ ಆಗಿತ್ತು. ಅವ್ರ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದು ನರ್ವಸ್ ಆಗಿ ಕರೆಕ್ಟ್ ಆಗಿ ಎವಿಡೆನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ರಿಲೇಶನ್ಶಿಪ್. ಮೈ ಲಾರ್ಡ್ಸ್, ಇಟ್ ವಿಲ್ ಬಿ ದ ಬೆಸ್ಟ್ ಪ್ರೂಫ್. DNA ವಿಲ್ ಬಿ ದ ಬೆಸ್ಟ್ ಪ್ರೂಫ್. ಮೈ ಲಾರ್ಡ್ಸ್,
ಎವ್ರಿಥಿಂಗ್ ಇಸ್ ದ ಬೆಸ್ಟ್ ಪ್ರೂಫ್.
ಲಾರ್ಡ್ಶಿಪ್ಸ್
ಆಫ್ಟರ್ ವೆಕೇಶನ್
ಸ್ಟೇ ಮೇ ಬಿ ಗ್ರಾಂಟೆಡ್. ಮೈ ಲಾರ್ಡ್ಸ್, 4ನೇ ತಾರೀಕು ಇದೆ. ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡ್ತಾರೆ.
ಅವ್ರದ್ದು ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಇರೋದು, ನಮ್ದಲ್ಲ.
ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಮೈ ಲಾರ್ಡ್ಸ್
ಪ್ಲೈಂಟಿಫ್ಸ್ ಫರ್ದರ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಅಂತಿದೆ.
ಆ ಸ್ಟೇಜ್ ಗೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದು
ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ.
Stage of arguments, my lords. I have filed this petition in 7th month of 7.
So at this stage you filed the application?
Evidence, defendant's evidence.
Correct or no?
Yes, my lordship, defense evidence. I will.
At what stage you filed the application?
Defendant evidence stage.
Yes, Mr. Srinivas.
With the liberty by this court, my lords, I have
They have filed the application at the stage of after posting it for the arguments of the plaintiff.
No, the order sheet is there, no deal.
Yes, it is there.
Suit ಎಷ್ಟನೇ ಇದು?
2014 suit. And they filed a writ and they took a direction from this honorable court to dispose of the matter within a year, in the year 2013 itself, 2018 itself. That document also I have produced before this honorable court by.
ಯಾವ stage ಗೆ ಹಾಕಿದ application no deal? Pass over, no date. Next.
ಇಲ್ಲ ಇದರಲ್ಲಿ
number 69, my lordships. 7/4/2022. In the year 2022, I have filed this application.
that application is in respect of the amendment of order under order 6/17.
Kindly see page number 69, my lordships. It is flagrant in the page itself. Page number 69, DNA test application. Dated 7/4/2022.
ಅಪ್ಪ 2022 ಗೆ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇತ್ತು ಅಂತ ಹೇಳಪ್ಪ.
Yes, I will point out that. Page number 195, my lordships. Order dated 7/4/2022. DW1 is present. Counsel for defendant filed application under Order 1 Rule 151 of CPC. Counsel for defendant filed objection colon 21/4/2022.
Page 190?
195, my lordships. 195. Last order dated 7/4/2022. DW1 is present. Defendant evidence time ಅಲ್ಲಿ ನಾನು ಹಾಕಿರೋದು.
151 CPC, that is not for the referring the matter to the DNA test.
Application is filed on the very same date, my lordships. It is in 7/4/2022. It is mentioned in page number 69.
ಏನ್ ಇಬ್ರು ನೋಡಿ ಡಿಸೈಡ್ ಮಾಡಿ ಹೇಳಿ ಯಾವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ದು ಅಂತ.
Lordship may kindly permit me to file the
come
those
after vacation.
exhibits which
Stay
are.
may be-
Let it come after
Stay may be granted, my lord.
list after vacation, interim order granted, release extent to the
No,
next.
no, my lord, entry order ಬೇಡ ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ 2014 ಇಂದ
ಬಟ್ ಪಿಟಿಷನ್ ಇದಾಗ್ಬಿಡುತ್ತಲ್ಲ, ಇನ್ಫ್ರಕ್ಚರ್ಸ್ ಆಗುತ್ತಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಅಲ್ಲ 2014 ಇಂದ ಇವತ್ತೇ ಬೇಕಾದ್ರೆ ನಾನು ರೆಡಿ, ಐ ಆಮ್ ರೆಡಿ ಟು ಅಡ್ರೆಸ್ ದ ಆರ್ಗ್ಯುಮೆಂಟ್. ನಾನು I have sufficient document to show that there is no relationship between the.
He doesn't have any document. He says that he wants.
ಅಲ್ಲ, their own documents ನಾ ರಿಜಿಸ್ಟರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ 2024 ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ to show that there is no relationship there. Our ancestor members ನೇಮ್ ಬೇರೆ, ನನ್ನ ancestors ನಂಬರ್ ನೇಮ್ ಬೇರೆ, ಡಿಫರೆಂಟ್ ಅಂತ ತೋರಿಸ್ಲಿಕ್ಕೆ ನನ್ನ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ, 1924 ಡಾಕ್ಯುಮೆಂಟ್ which are marked before the trial court as exhibits. Lordship may kindly permit me to
Argue, madam.
file those documents, my lord.
Please argue, Mr.
These documents may kindly.
Kindly see the return statement filed by them, my lord, page number 27.
Page number
27, my lordships. Relevant portion, my lords, is in page number 31. Para number 17, my lords.
Yes.
It is submitted by this defendant that this defendant has proper documents and belongs to the family of Muninanjapan Chikkaman, the plaintiff being the stranger to the family of this defendant, and she is no way related to the defendant's family. Like, this is the contention of them, my lords. And then later, my lords, when I filed the DNA application test, my lords, their version, my lords, kindly see page number 82.
20?
Page number 82, my lords. 84, sorry, my lords. Page number 84.
84 is some order.
Yes, my lords. Our contention is recorded in this here. By the plaintiff herself, under such circumstances, the question of referring the unmarked document to the handwriting expert does not arise. Moreover, the plaintiff is not permitted to mark the said disputed document, and also there is no pleading to that effect in the plaint. That is regarding IA number 19, my lords. In IA number 20, the plaintiff has sought for conducting of DNA test of plaintiff number 2 and LRs of defendant number 1 to prove the relationship between the parties. The learned counsel for the defendants has objected the application by stating that majority of people of Jalige village belong to the Vakkaliga community from the common lineage, and there is every possibility of positive report, and the court cannot rely upon such report to establish the relationship between the same. Their version, my lords, completely changes when I filed the DNA test application.
Yes.
And their objections, my lords, kindly see page number 76. 76, my lords. Page number 76. The said 50% of the Vakkaliga community, including the plaintiffs and the defendants performing Bandi Devru and Vasadevru together, as they are hailing from the same lineage, all their DNA must be the one and the same. Just because their DNA is one and the same, all of them cannot become same family members to the claim partition each other. My lords, here when they came to know that, my lords, if the DNA test is allowed, the truth will come out.
Yes.
In order to, my lordships, away from that, my lords, they are opposing for this.
What is the law?
Yes, my lords, I will produce the judgments. Judgment of this court, my lords, exactly in partition suit. In a suit for partition, my lordships. Recent judgment, my lords. Kindly see, my lords, page number 12.
Copy ಕೊಡಿ.
What is the first page of this judgment?
ಈ ಕೋರ್ಟ್ ಇಂದ
Last hearing.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನೀವು ಕೊಟ್ಟಿರೋದು ಈ ಕೋರ್ಟ್
ಕೊಟ್ಟೆ.
ಇಲ್ಲ, ಈ ಕೋರ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ.
ಎರಡು ಕೊಟ್ಟೆ.
ಈ ಕೋರ್ಟ್ ಕೊಟ್ಟಿಲ್ಲ, ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Last occasion, my lords, I have given. Kindly see, my lords, page number 11, para 16. In the facts of the said case are applied to the facts in the present case, the plaintiff who filed the application seeking DNA profiling in a major, aged 43 years, he voluntarily come up with a application in his anxiety to know about his biological root and to claim share over the property. There is no fear of branding the petitioner as illegitimate. Admittedly, both the persons whom the plaintiff is claiming to be his parents are not alive. Even in my case, my lords, both they are not alive. The person who, according to the defendant, is the father of the plaintiff is already examined before the court as PW2 who supported the claim of the plaintiff. Under such circumstances, I do not find any reason to reject the claim of the applicant. As DNA profiling is the procedure scientifically approved to find out the root through DNA, it cannot be said that the defendants will be prejudiced in any manner if such a test is conducted. If an adverse report is received after such DNA profiling, the court will take a call on it as the same will have an effect on the fate of the suit filed by the plaintiff. In that way, such a test will reduce the controversy on the questions of fact, and it will help the trial court to arrive at a just decision. Under such circumstances, I am of the opinion that the application is liable to be allowed.
That is a contention.
I have gone through the impugned order passed by the trial court, which has taken into the consideration the facts and circumstances of the case and passed the impugned order. In view of the above, I do not find any substance in the contention taken by the petitioner defendant number 6, who is the only aggrieved party, to challenge the impugned order. If the request for DNA profiling is not accepted, the right of the plaintiff to seek the status of the family members of the defendants to be son of the late LP Gauss Beg and Umar Bai and to claim share in the suit property will be denied. On the other hand, no prejudice would be caused to the petitioner or any other defendants if DNA profiling is conducted. Therefore, I am of the opinion that is no merit in the contention taken by the petitioner. Regarding the contention that order passed by the trial court lacks details as to who has to give blood samples, when it is to be given, who has to collect the blood samples, and how the court is to be submitted to the court. I am of the opinion that the trial court may be directed to specify all those details for the purpose of collecting the blood samples and for filing the report in accordance with law. Accordingly, I proceed to pass the following order. Writ petition is dismissed.
What is the law in Ajinkya?
That is, my lords, pertaining to the matrimony.
On facts, what is the law regarding
ಆ ಕೇಸಲ್ಲಿ matrimonial dispute, my lords.
matrimonial dispute? What is the law regarding conducting DNA test? Is it violative of Article 21?
In that case, my lords, both parents, my lords, were alive.
So what is the law? You know what is Article 21? 21 ಅಂತ ಏನಂತ ಗೊತ್ತಿದ್ಯಾ?
Privacy.
ಅದ್ರ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವರು?
Page number 14. Page number 39, my lords. The right of children not to have their legitimacy questioned previously in courts of law. The default position in India is that for many reasons, parents are presumed to be the decision makers for their children. Insofar as healthcare, consent for genetic testing, etc. are concerned, justifications for this
Please
position.
come to paragraph 43.4. Page 804.
My lords. Sorry, my lords.
Paragraph 43.4. Page 804. ಯಾವ್ದು SCC ತಂದಿದ್ಯಾ ಯಾವ ತಂದಿದ್ಯಾ?
ಇದು. This is.
ಕೊಡ್ರಿ ಅವ್ರು. ತೊಗೊಳ್ಳಿ, ಕೊಡಿ.
May I read? Merely because either of the parties have disputed a factum of paternity.
First in the oath, paragraph 43 in the oath.
Having regard to the aforesaid discussion.
ನಿಮಿಷ ಒಂದು ಸ್ವಲ್ಪ ಗಾಳಿ ತಗೋ. ಕಂಟಿನ್ಯೂಸ್ ಆಗಿ ಇಂಜಿನ್ ಸ್ಟಾಪ್ ಇಲ್ದಂಗೆ ಓದ್ಬೇಡ, ಗಾಳಿ ತಗೋ.
Having regard to the aforesaid discussion, the following principles could be culled out as to the circumstances under which a DNA test of minor child may be directed to be conducted. That a DNA test of minor child is not to be ordered routinely in a matrimonial disputes. Proof by way of DNA profiling is to be directed in matrimonial disputes involving allegations of infidelity only in matters where there is no other mode of proving such assertions. DNA tests of children born during the subsistence of valid marriage may be directed only when there is sufficient prima facie material to dislodge the presumption under section 112 of Evidence Act. Further, if no plea has been raised as to non-access, in order to reboot the presumption under section 112 of the Evidence Act, a DNA test may not be directed. A court would not be justified in mechanically directing a DNA test of a child in a case where the paternity of the child is not directly an issue, but is merely collateral to the proceeding. Merely because either of the parties have disputed a factum of paternity, it does not mean that the court should direct DNA test or such other test to resolve the controversy. The party should be directed to lead evidence to prove or disprove the factum of paternity, and only if the court finds it impossible to draw an inference based on such evidence or the controversy in issue cannot be resolved without DNA test, It may be directed DNA, it may direct DNA test and not otherwise. In other words, only in exceptional and deserving cases where such a test becomes indispensable to resolve the controversy, the court can direct such test.
ಏನಂದ್ರೆ ಅರ್ಥ?
ಅದು if there is no any other possibilities, my lords, then at the such circumstances, my lords, court can direct for DNA test. In this case, my lords,
What should happen? Evidence you have produced documents to show that you are the child of that particular person.
That-
Have you produced some documents or not?
I have produced, my lords, mutation registers. There is no other documents, my lords, it's because of they are illiterate, my lords. Documents of 1980s. There will there will be no documents, my lords, in 1980. ಇದ್ರು ಅಲ್ಲ ಅವ್ರು ಅಷ್ಟೊಂದು ಇಂಟೆಲಿಜೆಂಟ್ ಪರ್ಸನ್ಸ್ ಅಲ್ಲ, ಅವ್ರು ಮೇಂಟೈನ್ ಮಾಡಿಲ್ಲ ಅವಾಗ ಸ್ವಾಮಿ.
ಸರಿನಪ್ಪ, ನಿಮ್ ಊರಲ್ಲಿ ಜನ ಇಲ್ವಾ, ಮನುಷ್ಯರಿಲ್ವಾ?
ಅವ್ರು ಒಬ್ಬರನ್ನ ಮೇಲ್ ಮೆಂಬರ್, ಎಲ್ಡರ್ ಮೇಲ್ ಮೆಂಬರ್ ನ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸಿದೀನಿ ವಿಟ್ನೆಸ್ ಆಗಿ. ಬಟ್ ಅವ್ರು 98
ಅವ್ರು ಬಿಟ್ಟು ಬೇರೆ ಯಾರು ಇಲ್ವಾ? ನಿಮ್ ಊರಲ್ಲಿ ಬೇರೆ ಯಾರು ಇಲ್ವಾ? ಅವ್ರೊಬ್ಬರೇ ನೋಡಿರೋದು ನೀವು ಅವ್ರ ಮಗ ಅಂತ?
ಅಲ್ಲ, ಬೇರೆ ಇನ್ನೊಬ್ರು ಕೋರ್ಟ್ ಬಂದ್ರೆ ದೇ ವಿಲ್ ಬಿಕಮ್ ನರ್ವಸ್, ಮೈ ಲಾರ್ಡ್ಶಿಪ್ಸ್.
ಏನ್ ಮಾಡೋದು?
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ದೇ ವಿಲ್ ಕನ್ಫ್ಯೂಸ್.
ಹಂಗಂತ ನೀವ್ ಹೇಳೋದನ್ನ ಒಪ್ಕೊಳಕ್ ಆಗ್ತದ?
DNA ಟೆಸ್ಟ್ ಇಸ್ ಡನ್, ಮೈ ಲಾರ್ಡ್ಸ್. ಪಾಸಿಟಿವ್ ಬಂತು ಅಂದ್ರೆ ನನಗೆ
ಡನ್ ಅಲ್ಲ, ಕಾನೂನಲ್ಲಿ DNA ಟೆಸ್ಟ್ ನ ಜಸ್ಟ್ ಲೈಕ್ ದಟ್ ಮಾಡಂಗಿಲ್ಲ ಅಂತ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನವ್ರು ಹೇಳೋದು, ಅರ್ಥ ಆಯ್ತಲ್ವಾ?
ಇಲ್ಲ, ಆ ಕೇಸಲ್ಲಿ ಅವ್ರ ಏನ ಅಪ್ಪ ಅಮ್ಮ ಇಬ್ರು ಬದುಕಿದ್ದಾಗ ಮಗ
43.4 ಇನ್ನೊಂದ್ಸತಿ ಓದಪ್ಪ.
ನೆಗೆಟಿವ್ ಅಂತ ಏನಾದ್ರು ಬಂದ್ರೆ ಅನ್ನೋ ಕಾರಣಕ್ಕೋಸ್ಕರ ಮಾಡಲ್ಲ.
ಟೇಕ್ ಅಡ್ವಾಂಟೇಜ್ ಆಫ್ ಇಟ್ ಮಿಸ್ಟರ್.
ವಿಚ್ ಪ್ಯಾರಮ್?
43.4 ನ ಇನ್ನೊಂದ್ಸತಿ ನಿಧಾನಕ್ಕೆ ಓದು.
Please. Merely because either of the parties have disputed a factum of paternity, it does not mean that the court should direct DNA test or such test to resolve the controversy. The party should be directed to lead evidence to prove or disprove the factum of paternity, and only if the court finds it impossible to draw an inference based on such evidence or the controversy in issue cannot be resolved without DNA test, it may direct DNA test and not otherwise. In other words, only in exceptional and deserving cases where such a test becomes indispensable to resolve the controversy, the court can direct such test.
What does the court now say? Trial court ನವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ? What does the trial court say?
Trial court says, my lords, page number 82, 84, my lords.
Eighty?
83 ಇಂದ ರೆಲೆವೆಂಟ್.
84.
ಇದನ್ನ ಸಿಗ್ನೇಚರ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಅನ್ರಿಜಿಸ್ಟರ್ಡ್
ಅದು
ಪಾರ್ಟಿ.
ಎರಡು ಐಎಗಳು ಸ್ವಾಮಿ, ಒಂದು ಐಎ ನಂಬರ್ 19 ಅಂಡ್ ಐಎ ನಂಬರ್ 20 ಮೇಲೆ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ. One is for handwriting expert, another is for DNA.
IA number 19 ಏನು? 19 is for handwriting expert.
Yes, my lord.
IA 20 is for
DNA test.
DNA test.
ಹೇಳಿ, DNA ಟೆಸ್ಟ್ ಬಗ್ಗೆ ಏನ್ ಹೇಳ್ತಾರೆ?
DNA test ಬಗ್ಗೆ lordship ಮೇ
Number 84, my lordships.
Yes, both.
10th line from the bottom, my lordships. Relationship between the parties. After that, it is to be noted that as per section 50 of Indian Evidence Act, when the court has to form an opinion as to relationship of one person to another person, the opinion expressed by conduct as to existence of such relationship of any person as a member of the family or otherwise as special means of knowledge on the subject is relevant. Under such circumstances, the plaintiff has to establish the relationship between the parties by examining the witnesses who have special means of knowledge regarding the relationship between the parties. It is pertinent to note that the present
We'll keep this application alive. We'll set aside this order. We'll keep this application alive. ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡಿ.
ಅಲ್ಲ, ಎವಿಡೆನ್ಸ್ ಎಲ್ಲ ಆಗ್ಬಿಟ್ಟದೆ.
ಎವಿಡೆನ್ಸ್ ನಿಮ್ದು ಆಗಿದ್ಯಾ?
ನಮ್ದು ಆಗ್ಬಿಟ್ಟದೆ, ಅವ್ರದ್ದು ಆಗ್ಬಿಟ್ಟದೆ.
ಈ ಅಪ್ಲಿಕೇಶನ್ ತೀರ್ಮಾನ ಮಾಡುವಾಗ ಎವಿಡೆನ್ಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿರ್ಲಿಲ್ಲ. DW1 and DW2 ಫರ್ದರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಇತ್ತು.
ಹೌದು ಸ್ವಾಮಿ,
ಅವತ್ತಾಗಿರ್ಲಿಲ್ಲ.
ಹೌದು.
Let the court decide this application after the evidence is recorded.
ಅಲ್ಲ, ನಾನು I have produced sufficient documents before.
ಕೋರ್ಟ್ ನವ್ರು ತೀರ್ಮಾನ ಮಾಡಬೇಕು. Let the court decide after the evidence is adduced. ಬರ್ಕೊಳ್ಳಿ.
again that for fresh order to be passed on the same application.
Good. The plaintiff in OS number so and so is before this court challenging an order dated so and so, passed on an application filed under section 20 order 26 rule 10A to conduct a DNA test of the plaintiff number 2 and the LRs of the defendant number 1. Full stop. Next para. The suit in OS number 683 of 2014 was filed for partition separate possession of the plaintiff's share in the suit real property. Full stop. The suit was contested by the respondents who denied that the plaintiff belonged to their family. Full stop. Based on these contentions, the suit was set down for trial. When the suit was listed for further cross-examination of DW1 and DW2, an application was filed by the plaintiff under Order 26 Rule 10A of CPC to conduct a DNA test of the plaintiff number 2 na.
Plaintiff number 2.
2 yaru?
2. Is the son of first plaintiff. ಅದರಲ್ಲಿ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ರಿಟ್ ಪಿಟಿಷನ್ ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಪ್ಲೈಂಟಿಫ್ಸ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು.
ಅಲ್ಲ ಸೂಟ್ ಅಲ್ಲಿ ಪ್ಲೈಂಟಿಫ್ ನಂಬರ್ 2 ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ?
ಇದಾರೆ. ಅದೇ ಅದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಅವರನ್ನ ಆಮೇಲೆ ತಗೊಂಡ್ ಬಂದ್ರು. ಅದು ಮುಂಚೆ ಇದ್ದ ಪ್ಲೈಂಟ್ ಅನ್ನೇ ತಗೊಂಡು ಅವ್ರು ರಿಟ್ ಪಿಟಿಷನ್ ಮಾಡಿದ್ದಾರೆ. ಇಂಪ್ಲೀಡ್ ಮಾಡಿ ಆದ್ಮೇಲೆ ಆ ರಿಟ್ ಪಿಟಿಷನ್ ಇದನ್ನ ತಗೊಂಡಿಲ್ಲ.
Of plaintiff number 2 and the LRs of the defendant number 1. Full stop. This application was opposed by the defendants who contended single double unit comma, who contended inter-alia as follows. Further, so far as IA filed praying to send the plaintiff number 2, so far as IA filed praying to send the plaintiff number 2 and defendant 1A to C to conduct DNA test to determine the relationship, comma, it is respectfully submitted that in Jalige village, more than 50% of Vokkaliga community hail from the same lineage. All the said 50% of the Vokkaliga community, including the plaintiffs and the defendants, perform Bandi Devaru and Hosadevaru together, full stop. As they hail from the same lineage, comma, all their DNA must be one and the same, full stop. Just because their DNA is one and the same, all of them cannot become same family members to claim partition each other. Inverted comma, close. I don't know why you can't take advantage of this, mister.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ ಸ್ವಾಮಿ,
ಇದನ್ನ ಅಡ್ವಾಂಟೇಜ್ ಯಾಕೆ ತಗೊಳಕ್ಕಾಗಲ್ಲ ನೀನು?
ಇಲ್ಲ ಆಗಲ್ಲ, ಅವ್ರು ಯಾಕಾಗಲ್ಲ ಅಂತಂದ್ರೆ ನಾನು ಐ ಹ್ಯಾವ್ ಎಕ್ಸಾಮಿನ್ಡ್ ದ 2 witnesses. They says that very clearly.
Trial court, after considering the contentions, comma, rejected the application in terms of the impugned order on the ground, double inverted comma, the plaintiff, on the ground that the plaintiff has to establish the relationship between the parties by examining witnesses who have special means of knowledge regarding the relationship between the parties, full stop. It is pertinent to note that the present applications came to be filed when matter was posted for further cross-examination of DW1 and DW2. Full stop. It is also settled law that the court can appoint commission after evidence of both the parties is recorded, when the court is of the opinion that there is ambiguity in the evidence led by the parties, inverted comma, close. Full stop. In this case, the evidence of the defendants is not yet completed, and the court has not yet formed opinion that there is ambiguity in the evidence, inverted comma, close. Being agreed with the aforesaid order, comma, the plaintiffs are before this court. Next para. The learned counsel for the plaintiffs contended that the plaintiffs are unable to establish. The plaintiffs have adduced some evidence before the trial court to establish the relationship with deceased Ramaya. However, he contends that in order to authoritatively establish that the plaintiff number 1 is the wife and plaintiff number 2 is the son of late Ramaya, comma, the only way is to compare, do a DNA profiling of the plaintiff number 2 and the LRs of defendant number 1. Full stop. He therefore contends that the court must have allowed the application. This apart, he contends that the defendants who initially denied the relationship have slowly moved from that defense and have claimed that even if the DNA matches, they cannot be said to belong to the same family or that the plaintiff number 2 is the son of late Ramaya. Full stop. Per contra, the learned counsel for the defendants submitted that the plaintiff was bound to establish the relationship with late Ramaya as provided under Section 50 of the Evidence Act. He submits that the defendants have produced enormous evidence to establish that the plaintiff belongs to another family and not to and is not the wife of late Ramaya.
No, not like that, my lord. He's not the one. I'm not saying that he is not the wife of Ramaya. He is not belongs to the ancestors of my family. You're the plaintiff is not belongs to ancestors of my family ಅನ್ನೋದು ನನ್ನ ಕಂಟೆನ್ಷನ್. ಹಂಗಂದ್ರೆ ಸ್ವಾಮಿ ನನ್ನ ಮುತ್ತಾತನ ಕಾಲದಲ್ಲೂ ನನ್ನ ಇನ್ನು ಅವ್ರಕ್ಕಿಂತ ಹಿಂದಿನ ಜನರೇಷನ್ ಅಲ್ಲೂ ಒಂದೇ ಫ್ಯಾಮಿಲಿ ಇತ್ತು. ಅದಾದ್ಮೇಲೆ ಅವರು ಡಿವೈಡ್ ಹಾಕೊಂಡು ನಾನು ಅದನ್ನ ಯುವರ್ ಆನರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಟೇಕ್ ಮೈ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್. ಒಂದೇ ಒಂದು ನಿಮಿಷಕ್ಕೆ ಸ್ವಾಮಿ, ಒಂದು ನಿಮಿಷಕ್ಕೆ ನನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂಬಿಡಿ ಸ್ವಾಮಿ. ನನ್ನ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ ಜೊತೆ ಒಳಗಡೆ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಫ್ಯಾಮಿಲಿ ಟ್ರೀಸ್. ಅವ್ರದ್ದು ಫ್ಯಾಮಿಲಿ ಟ್ರೀ, ನಂದು ಫ್ಯಾಮಿಲಿ ಟ್ರೀ.
Consider the objections filed before the trial court, not what is filed here.
ಅಲ್ಲ, both are marked as exhibits. So these family trees are
whatever that you have filed before the trial court, only that will look into it.
ಅಲ್ಲ, ನಂದು ಡಾಕ್ಯುಮೆಂಟ್ಸ್
to this application.
ಅಲ್ಲ, ಅಬ್ಜೆಕ್ಷನ್ ಅರ್ಧ ಓದಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನನ್ಗೆ ಇನ್ನೊಂದು ಅರ್ಧ ಓದ್ಲಿಕ್ಕೆ ತಾವು ಅವಕಾಶ ಕೊಟ್ರೆ. ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ 84 ಪೇಜ್ ನಂಬರ್ ಅದ ಸೇಮ್ ಅವ್ರು ಏನ್ ಓದಿದ್ರಲ್ಲ ಅದನ್ನೇ ನಾನು ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀನಿ.
Take your time.
ಅಲ್ಲಿ ಏನು ಇಟ್ ಈಸ್ ಟು ಬಿ ಅಂತೇಳಿ 84 ಅಲ್ಲಿ ಒಂದ್ ಕಡೆ ಶುರುವಾಗ್ತದೆ ಸ್ವಾಮಿ. ಇಟ್ ಈಸ್ ಟು ಬಿ ನೋಟೆಡ್ ದಟ್ ಆಸ್ ಪರ್ ಸೆಕ್ಷನ್ 50 ಆಫ್ ದಿ ಎವಿಡೆನ್ಸ್ ಆಕ್ಟ್, ವೆನ್ ದ ಕೋರ್ಟ್ ಹ್ಯಾಸ್ ಟು ಫಾರ್ಮ್ an opinion as the relationship one person to another person, the opinion expressed by conduct as to the existence of such a relationship of any person who as member of family or otherwise they has special means of knowledge on the subject is relevant. Under such circumstances, the plaintiff has to establish the relationship between the parties by examining the witnesses. ಅದಕ್ಕಿಂತ ಹಿಂದಿನ ಪೇಜ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ from 6th, 7th line, it is also admitted fact that the unregistered partition deed claimed by the plaintiff is not that is in relation. Lordship may kindly take my statement of objection filed to the application.
Page 73.
Page 73, 5 ದಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 5 ಇಂದ ಓದ್ತೀನಿ ಸ್ವಾಮಿ. Further, so far as IA filed praying to send the plaintiff number 2, defendant number, common objection to the both the applications is ಸ್ವಾಮಿ ಇದು. NA, conduct DNA test to the determine the relationship. It is respectfully submit that the Jalige village, more than 50% of the Vakkaliga community hailing from the same lineage, the said 50% of the Vakkaliga community, including the plaintiffs and the defendants, performing Bandi Devuru and Vasadevuru together, as they hailing from the same lineage, all their DNA must be the one and the same. Just because their DNA is one and the same, all of them cannot become same family members to claim partition each other. The plaintiffs have closed their side evidence, both oral and documentary evidence, clearly substantiates that the plaintiffs are claiming under Bhairappa as their family head, Exhibit P42. Contrarily, the defendants are claiming under Bachappa, which is evidenced by the documents produced and marked as D1 to D19. Lordship, these documents ಫ್ಯಾಮಿಲಿ ಟ್ರೀಸ್
ರೆಕಾರ್ಡ್ ಮಾಡ್ತೀನಿ ಬನ್ನಿ.
ಅಲ್ಲ, ಬಚ್ಚಪ್ಪ ಭೈರಪ್ಪ ನಮ್ಮ ಫ್ಯಾಮಿಲಿನಲ್ಲಿ ಭೈರಪ್ಪ ಅನ್ನೋರು ಯಾರು ಇರ್ಲಿಲ್ಲ. ಅವ್ರದ್ದು ಆನ್ಸಿಸ್ಟರ್ ಭೈರಪ್ಪ, ನಂದು ಆನ್ಸಿಸ್ಟರ್ ಬಚ್ಚಪ್ಪ.
Full stop. He contends the plaintiff, he further contends that the plaintiffs claim that they belong to, the plaintiffs contend that, sorry, he further contends that plaintiffs trace their lineage to Bhairappa, while the defendants trace their lineage to Bachappa, which is evident from exhibit D1 to D19, D25 and D26. Therefore, he contends that documents produced by the defendants establish that the plaintiffs are not related to the defendants in any manner whatsoever.
Sorry for the interruption,
Therefore,
my
he
lord.
contends that the trial court is right in holding that the application for scientific investigation, cannot be considered. Next para. A perusal of the impugned order shows that the trial court, having held that the applications were filed even before the evidence of the parties had concluded, and that the court is yet to decide whether there is ambiguity in the evidence led by the parties or not, necessitating the appointment of a scientific investigation, the court ought not to have proceeded to reject the application filed by the plaintiff. On the contrary, it should have awaited the cross-examination of DW1 and DW2, and thereafter must have applied its mind to the application filed by the plaintiff. In that way of the matter, full stop. The apex court in the case of Aparna Ajinkya Firodia versus Ajinkya Arun Firodia, 2024 part 7 SEC, page number in Redo. What is the page number?
773, my.
773. 773. Held as follows. Para 43.4, copy of. In that way of the matter, the impugned order passed by the trial court, so far as rejecting IA number 20 is concerned, deserves to be interfered with. Consequently, this writ petition is allowed in part. The impugned order passed by the trial court rejecting application number 20 filed by the plaintiff under order 26 rule 10A is set aside. The application before the trial court is restored. Application in IA number 20 is restored on the file of the trial court. The trial court shall consider the said application after the conclusion of evidence of the defendants and thereafter dispose of the application in accordance with law.
Time limit may kindly.
Since the suit is filed in the year 2014, and in view of the directions issued in WP number,
my lord.
so and so, the trial court is requested to dispose of the suit as early as possible, at any rate within a period of 6 months from the date of receipt of a copy of this order.
WP number 42-733 of 2019.
42-733 of 2019. Yes, next verse.
Connected.
Connected ಏನಿದು?
Same, ಅದು IA number 19. That is for the handwriting expert to certify the signature on the unregistered document.
That will permit you to.
That is not marked before the court.
Is dismissed. However, liberty is reserved to the petitioner to raise this as a ground in an appeal that may be filed against the decree that may be passed in the suit. Yes, next. Yeah. Yes, so many days ಅಂದ್ರೆ ಎಷ್ಟು? 1 ದಿನ, 2 ದಿನ, 5 ದಿನ, 10 ದಿನ, 1 ತಿಂಗಳು, 1 ವರ್ಷ. ಅದೇನ್ ತಿಳ್ಕೊಂಬನ್ರಿ. ಇದೆ ಗೌರ್ಮೆಂಟ್ ಆಸ್ಪತ್ರೆ ಹೆಂಗ್ ಕೆಲಸ ಮಾಡ್ಬೇಕು ಹಂಗೆ ಮಾಡ್ತಿದ್ದೀರಪ್ಪ ನೀವು. ಗೌರ್ಮೆಂಟ್ ಹಾಸ್ಪಿಟ್ಲ್ ಹೆಂಗ್ ಕೆಲಸ ಮಾಡ್ಬೇಕು ಹಂಗೆ ಮಾಡ್ತಿದ್ದೀರ ನೀವು. ಮತ್ತೆ ನಿಮ್ಮ ಇಂಥ ಹಾಸ್ಪಿಟ್ಲ್ ಇಟ್ಕೊಂಡು ಉಪಯೋಗ ಏನು? What is the fun in having this kind of a hospital which doesn't have a place to store and preserve? We will pass an order. ಅದಕ್ಕೆಲ್ಲ ಏನ್ ಬೇಕೋ ಸೆಕ್ಯೂರಿಟಿ ಎಲ್ಲ ಮಾಡ್ತೀವಿ. And we will keep the ಯಾರು responsible authority ಅದನ್ನ responsible ಮಾಡ್ತೀವಿ. Medical superintendent responsible for that safe keeping. ಕಳೆದೋಯ್ತು ಒಡೆದೋಯ್ತು ಅದೆಲ್ಲ ಇಲ್ಲ. Medical superintendent will be responsible. ಏನು ಹೆಚ್ಚು ಕಡಿಮೆ ಆದ್ರೆ ಅವ್ರ ತಲೆ ಮೇಲೆ ಬರುತ್ತೆ. He has to ensure the safe keep. ಡ್ರಾ ಮಾಡಿ ಬರ್ಕೊಳ್ಳಿ. ಏನಾಯ್ತು? ಬಂದಿದಾರಾ?
ಇದಾರೆ. ಇಬ್ರು ಇದಾರೆ.
Next ಬರ್ಕೊಳ್ಳಿ. The team from the boring hospital, pursuant to the information forwarded to the medical superintendent, Boring Hospital, Bengaluru, to send a team to draw the blood sample of the petition number 1, the medical team headed by Dr. Subramanian. Dr. Subramani, ಏನಾಗಿರೋದು ನೀವು? Senior specialist, Boring Hospital. ಆಮೇಲೆ Dr. Ramesh Babu, physician. ನೀವು ಬಿಡಿ ಹೈಕೋರ್ಟ್ ನಿಮ್ನ ಹೈಕೋರ್ಟ್ ನೀವ್ ಹಾಕ್ಬೇಕು. ಬೋರಿಂಗ್ ಹಾಸ್ಪಿಟಲ್ ಯಾರು ಬಂದಿದ್ರಿ? ಮಿಸ್ಟರ್ ವೆಂಕಟೇಶ್ ಮೂರ್ತಿ, ಬೋರಿಂಗ್ ಹಾಸ್ಪಿಟಲ್ ಲ್ಯಾಬ್ ಟೆಕ್ನಿಷಿಯನ್. ಆಮೇಲೆ ಅಟೆಂಡ್ ನೀನ್ ಇಟ್ಕೊಂಡಿ. ಇಬ್ರೇನಾ ಆರ್ ಪ್ರೆಸೆಂಟ್. Full stop. They, on securing instructions, submit that this is a one-off case where they're requested to draw the blood sample and preserve it. Full stop. He submits after securing instructions from the medical superintendent that if this court directs the preservation of the blood sample, steps would be taken to preserve the blood sample and also follow directions that may be issued by this court. Full stop. In that view of the matter, the sample of the petition number 1,
Petitioner number 1.
Sample of the petitioner number 1
And
is
point number 1. ಅವ್ರದ್ದು ಅವ್ರದ್ದು ಬೇಕಾದ್ರೆ ಆಮೇಲೆ ಕೊಟ್ಕೋಬಹುದು.
ಅಲ್ಲ ಅವ್ರದ್ದು ಅವ್ರು ಹೋದ್ರೆ ಎಲ್ಲ ಹೋಯ್ತಲ್ಲ.
Petitioner number 1 ತೊಳಿ.
Petition number 1 is ordered to be drawn. Full stop. The Registrar General is directed to affix his seal and signature on the sample drawn.
Case number also.
Along with and also affix the case number. Full stop. You also want to affix your signature? ನಿಮ್ಮ client ಹಾಕ್ಸ್ತೀರಾ?
Yes, your
Full
lordship.
stop. It is open for the respondent number 1, na?
ಅವ್ರದ್ದೇನು ಬೇಕಿಲ್ಲ ಅದಕ್ಕೆ.
ಹೌದು ಆಗ್ಲಿ ಅವ್ರದ್ದು authenticity. It is open for the respondent number 1 to affix his signature to the sample that may be drawn. Full stop. The medical superintendent is directed to preserve the sample safely and to ensure that the same is produced before the court whenever called upon. The medical superintendent shall solely be responsible for the safety and security of the sample so drawn and shall not allow access to any third party except unless orders are passed by this court. Full stop. Yes. ಯಾವತ್ತು ಎವಿಡೆನ್ಸ್ ಯಾವತ್ತು ಮಾಡ್ತೀರಿ ಹೇಳಿ?
ಅಲ್ಲ ಈಗ ನಮ್ದು ಎವಿಡೆನ್ಸ್
ಯಾವತ್ತಿಗಿದೆ?
January 27th ಇದೆ.
January
24th.
24 January.
24th ಅಲ್ಲ. 25th. 25th.
May I make submission, my lord? So far as the issue, the trial court may be directed to frame the issue.
Will get the suit advanced.
That's true.
ನಿಮ್ evidence ಮಾಡ್ಬಿಡಿ ನಿಮ್ದು.
ಅಲ್ಲ ಮಾಡ್ತೀವಿ. That is
ಹಾ.
the reason. Now your lordship, last again suggested that you'll direct, pass an order to lead evidence. Before leading evidence, issues has to be framed. So that's the reason trial
I'll
court.
frame an issue. I'll also frame an issue. I'll ask the trial court to record the evidence of petition number 1.
On the basis of pleadings.
On the basis of pleadings, obviously.
And
ಬರ್ಕೊಳ್ಳಿ. Next para. So, main order ಮಾಡಿ. The defendants 1, 2 and 3 in OS number so and so on the file of so and so are before this court. Challenging the correctness of an order dated so and so by which the court ordered a DNA profiling
Yes, DNA. To draw
of the
blood test
petition
and
number 1
conduct DNA.
with the respondent number 1. Next para. The suit in OS number 6393 of 2024 was filed for partition and separate possession of the plaintiff's share in the suit shall properties. Full stop. The plaintiff contended that the petition, that the defendant number 1 was his father and plaintiff number 2 was his wife. Full stop. They contended that the suit properties were the properties of the joint family and that they were entitled for an equal share in the suit properties. However, the suit was contested by the defendants 1, 2 and 4. Denying that plaintiff number 2 was married to the defendant number 1. They also denied they contended that the plaintiffs had filed OS number 4928 of 2024 against the defendants for the very same reliefs, but withdrew it by filing a memo on 9/8/2024. They did not seek liberty to file a fresh suit. Full stop. Therefore, they contended that the plaintiffs are not entitled to file a fresh suit for the very same reliefs. They also claimed that the suit A property belonged to one Narayan Reddy and others, and they sold it in favor of the defendant number 1 in terms of a sale deed dated 5/6/2008. And thus, it was his self-acquisition. Full stop. The suit B to D properties were the ancestral properties in the hands of the defendant number 1, which he derived it at a partition on 3/3/2020. Full stop. They contended that defendant number 1 had married the defendant number 2, and from the wedlock, defendant 3 and 4 were born. Full stop. They denied that the plaintiff number 1 is not the son of the defendant number 1, and that the second plaintiff number 2 had created some documents to seem as if plaintiff number 1 was the son of the defendant number 1. Full stop. Next para. With these contentions, comma, based on these contentions, comma, an application was filed base para. In view of these contentions, comma, an application was filed by the plaintiff under order 26 rule 10A.
At the first instance itself, before
Plaintiff ಜೊತೆನೆ ಹಾಕಿದ್ರಾ?
plaint ಜೊತೆನೆ ಹಾಕಿರೋದು. ಹೌದು.
Full stop all. Along with the plaint, comma, the plaintiff had filed an plaintiff had filed an application
That is because
under
of
order
his
26
health
rule
condition.
10A.
That is because of his health condition was
26
deteriorating.
rule
day by
10A.
day.
To direct the defendants 2 to 4 to allow to direct a DNA profiling of the defendant number 1 and compare it with the plaintiff number 1. Full stop. In the affidavit accompanying the application, it was stated that the defendant number 1 is suffering from serious health issues and his health is deteriorating day by day, and therefore, in order to prove the relationship of plaintiff number 1 with defendant number 1, comma, it was necessary that a DNA test was conducted. Full stop. This application was opposed by the defendants, again reiterating that the plaintiff number 1 was not the son of the defendant number 1, and that the plaintiffs cannot seek appointment of a seek for scientific investigation even before the evidence in the suit had commenced. Full stop. The trial court, after considering the contentions urged, comma, allowed the application in terms of the impugned order. Impugned order.
Annexure A.
ಅದೇ ಅದು ನೋಡಿ.
28/11/2024.
Impugned order. Yeah, what is it for observation?
Observation is the
Impugned order.
third paragraph. Here in the present case also, because of denial of relationship between the plaintiff, number 1, defendant number 1, the plaintiff number 1 himself has come forward to go for
Impugned
DNA.
order relying upon the judgment passed by a coordinate bench of this court in WP number 112825/2019 and the judgments of the Honorable Apex Court, and held that having regard to the case and counter case of the plaintiff and defendants respectively, and since the plaintiff himself had come forward to undergo the DNA test, comma, it held that the plaintiff, defendant number 1, would not suffer any prejudice if the application was allowed. So consequently, it allowed the application, directed the defendant number 1 to undergo a DNA test. Stop. Being agreed with the aforesaid order, comma, the defendant number 1, 2, 3 have filed this writ petition. Next para. The learned counsel for the defendants submitted that the application for a scientific investigation was filed by the plaintiffs along with the plaint, thereby indicating that they were fully aware that they were not related, that plaintiff number 1 was not related to the defendant number 1. He also contends that this application could not have been entertained even before the plaintiffs had adduced evidence to conform to section 50 of the Evidence Act. Full stop. He contends that the trial court had allowed the application prematurely and even before the evidence in the suit was recorded. Full stop. He referred to the judgment of the Apex Court in case of Ajinkya so-and-so, and where the Apex Court, while considering the need for conducting a DNA test, held as follows, para 43(4). Therefore, he contends that unless the evidence of the parties is adduced, comma, the court should not venture to conduct DNA test, as there are no special circumstances warranting such conduct, full stop. Per contra, the learned counsel for the plaintiffs contended that the need for conducting a scientific examination arose in view of the precarious health condition of the defendant number one. He contends that the defendant number one himself volunteered to undergo the DNA test, and therefore the trial court was justified in allowing the test. Full stop. Next, but I have considered submissions made by the learned counsel for the defendants and the learned counsel for the plaintiffs. Next para. As rightly contended by the learned counsel for the defendants, the plaintiffs had filed this application along with the plaint without really disclosing the need for such a without really disclosing the need for such test. Full stop. The plaintiffs merely stated that the health condition of the defendant number one is deteriorating. Full stop. That in itself would not be a strong ground for conduct of a DNA examination, more particularly when the defendant number one has children out of the marriage from the defendant number two. Full stop. Be that as it may, since the evidence of the parties is not yet adduced, and as held by the apex court in the case referred above, the DNA test has to be resorted to in exceptional circumstances. There is no, except claiming that the defendant number one, except claiming that the health condition of the defendant number one is precarious, no other circumstance is pointed out to justify the conduct of a test. Be that as it may, since in order to ensure full stop. Next para. This court, in order to ascertain the health condition of the petitioner, defendant number one, called upon the learned counsel for the defendant number one to keep the defendant number one present in the court. Full stop. Accordingly, the defendant number one appeared before the court on 19/12/2024. Full stop. This court noticed that this court noticed that the health condition of the defendant number one was fragile, and therefore felt it appropriate to first draw the blood sample of the defendant number one and preserve it for future use after the evidence of the parties is adduced before the trial court. Full stop. Therefore, full stop. This court has also directed the blood sample of the defendant number one to be drawn and preserved in the Boring Hospital, Bangalore, which could be used later after the evidence is adduced before the trial court, if it is necessary. Full stop. Having regard to the fact that the defendant number one, having regard to the fact that the health condition of the defendant number one is very fragile, this court is of the opinion that in order to have his evidence before the parties go for a trial on the other issues in the suit, the trial court should be directed to record evidence of the defendant number one only insofar as the relationship of the plaintiff number one with the plaintiffs with the defendant number one. Thus in order, full stop. Under Order 18 Rule 16 of CPC, the court is invested with the power to examine a witness immediately at any time after the institution of the suit. Full stop. This is one such case where the court must record the evidence of the defendant number one, lest it would be lost in perpetuity, and the plaintiffs will be deprived of an opportunity to prove their relationship with the defendant number one. In that way of the matter, this writ petition stands disposed of on the following terms. Number one, the petition is allowed in part. The impugned order passed by the trial court is set aside. The application filed by the plaintiffs under Order 26 Rule 10A is restored on the file of the trial court. The said application shall be considered after the evidence of the parties is adduced, and in the event of a need to conduct a DNA test, the court may pass appropriate orders directing the sample drawn and preserved at Boring Hospital to be sent for comparison with the blood sample of the plaintiff number one to the concerned laboratory. Number three, the trial court shall record evidence on the following issue. Shall record evidence of the defendant number one on the following issue. Whether the plaintiffs prove that the plaintiff number two is the plaintiff number one proves, whether the plaintiff number one proves that he is the son of the defendant number one. Question mark. The trial court shall record evidence of the defendant number one on the aforesaid issue, and thereafter proceed to frame other issues and record the evidence of the parties. Yes.
And direction may be issued.
ಕರ್ಕೊಂಡು ಹೋಗ್ರಿ, ದಯವಿಟ್ಟು ಕರ್ಕೊಂಡು ಹೋಗಿ ಅವ್ರನ್ನ ಯಜಮಾನ್ರನ್ನ. ಅವ್ರಿಗೆ ವೀಲ್ ಚೇರ್ ಬೇಕಾ?
ಇದೆ, ಇಟ್ಟಿದ್ದಾರೆ. ಎಲ್ಲ ಕಿಟ್ ತಂದಿದ್ದಾರೆ, ಇಲ್ಲೇ ಡ್ರಾ ಮಾಡ್ಬೋದು.
ಮಾಡ್ಬೋದಾ ಇಲ್ಲೇನೆ? ಅಥವಾ ಡಿಸ್ಪೆನ್ಸರಿ ಕರ್ಕೊಂಡು ಹೋಗ್ಬಿಡಿ, ಯಾಕೆ?
ಹೌದು,
ಕರ್ಕೊಂಡು ಹೋಗಿ ಡ್ರಾ ಮಾಡಿ. ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರೇ, ಇದೆಲ್ಲ ತುಂಬಾ ಸ್ಪೆಷಲ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್. ಇಂಥ ಕೇಸಸ್ ಅಲ್ಲಿ ನೀವು ತೋರಿಸ್ಬೇಕು ನೀವು. ಏನೋ ಹೇಳಿದ್ರೆ ಬೇಜಾರು ಮಾಡ್ಕೋಬೇಡಿ. ಇದೆಲ್ಲ ಸ್ಪೆಷಲ್ ಸರ್ಕಮ್ಸ್ಟೆನ್ಸ್, ಎಲ್ಲರಿಗೂ ಸಿಗಲ್ಲ ಆಪರ್ಚುನಿಟಿ. ನಿಮಗೆ ಇದೇನೋ ಒಂದು ಅಪರೂಪವಾದಂತ ಒಂದು ಆಪರ್ಚುನಿಟಿ ಸಿಕ್ಕಿದೆ. ಪ್ಲೀಸ್ ಪ್ಲೀಸ್.
Order may be communicated to the medical superintendent.
ಅದು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತೀವಿ. ಅಲ್ಲ, ಇದನ್ನ ನಿಮಗೆ ನಾವು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತೀವಿ. ಆರ್ಡರ್ನ ನಿಮ್ಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತೀವಿ. ನಿಮ್ಮ ಮೆಡಿಕಲ್ ಸೂಪರಿಂಟೆಂಡೆಂಟ್ಗೆ ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡ್ತೀವಿ. ನೀವು ತಗೊಂಡೋಗಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್ ಅವರು ಸೈನ್ ಮಾಡಿ, ಇವ್ರ ಲಾಯರು ಸೈನ್ ಮಾಡ್ತಾರೆ ಆ ಸ್ಯಾಂಪಲ್ ಮೇಲೆ. ಮಾಡ್ಬೋದಲ್ಲ? ಮಾಡ್ಬಿಟ್ಟು ಅದನ್ನ ನೀವು ತಗೊಂಡೋಗಿ ಆ ಲೆಟರ್ ನಾನು ಕಳಿಸ್ಕೊಡ್ತೀವಿ. ಆಯ್ತು, ಲೆಟರ್ ಕೊಡ್ತೀವಿ ಅದು. ಪ್ಲೀಸ್ ಪ್ಲೀಸ್ ಪ್ಲೀಸ್. ಎಸ್.
Number 41, Venkatesh Somreddy.
For the petitioner, my lords. On the last date of proceeding, the Honorable Court has directed both the parties to present before for the better possibility of settlement.
Yes, 25,000.
Already.
Let the matter may be referred to the mediation centers.
This is.
What is there to mediate?
When I went for the respondent was admitted in the hospital in Bangalore. And the meantime, he was discharged. I was not communicated to.
I to forget it. We'll permit you to reside in a different house. Let them pay the maintenance.
25,000.
25,000 every month.
Let them have a matter may be referred to the mediation center.
Not mediation.
This can never be mediated. Yeah, what is challenged?
Lords, the order in the appellate court, MA, Lords, which had granted an injunction, my lords, in our favor, restraining her from entering. That has been stayed by this court.
Having regard to the acrimony court. Having regard to the acrimony between the parties, this court is of the tentative opinion that it is not safe for the petitioner to reside in the shared household under the circumstances, until disposal of the proceedings before the trial court, the until disposal of this writ petition, the respondents 1 and 2 shall provide a rented accommodation in Mangalore city, na?
Mangalore City.
In
Mangalore
Mangalore
City.
city, in Mangalore city.
Your lordship may say respond.
2 BHK rented accommodation in Mangalore city.
Respondent 1 anta madi. Father-in-law, our father-in-law brother, father-in-law only will provide.
Respondent number 1 anta madi. 1 and 2 ಇನ್ನೇನು ಎಲ್ಲ ಒಂದೇ ತಾನೆ. Shall provide a 2 BHK rented accommodation in Mangalore city or
Monthly.
and continue to pay rent until the disposal of this writ petition, or pay a sum of rupees 25,000 rupees every month towards the rent to the petitioner. Full stop. And so, full stop. However, this will not come in the way of the petitioner claiming maintenance or any other entitlement in accordance with law. ಮಾಡ್ಕೊಳ್ಳಿ friend.
ಆಯ್ತು.
ಇಲ್ಲ 25,000 ರೂಪಾಯಿ ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ ಮನೆಗೆ.
ಅದೇ lords, the interim order is modified to this extent. There is a- because there is a stay of the MA order.
This is stay of the MA order.
ಹೌದು.
The interim order of stay granted by this court on so and so is modified to the above extent.
Please.
Yes.
Number 42.
Krishna Vyas.
Counsel for petitioner, my lord.
ಇಷ್ಟೊಂದು
Urgent, my lord, after vacation, my lord. My senior, some health issues, my lord.
Yes, your lordship.
List after vacation.
Interim order extension, my lord.
Interim order granted as extended till the next 8 years. Siddharth Suman.
Siddharth Suman.
The application is just an amendment application because interim prayer was not, that one portion got cut off, my lord.
Yes.
That's only for that. I'll carry out the amendment today itself. May I just go on the merit, my lord?
Yes.
Please, my lord. My lord, this pertains to a petition filed under section 92 CPC, where, my lord, a public trust, 2 lifetime trustees file a petition before the Honorable Civil Court, my lord. They're seeking for certain reliefs and again, relief or liberty to go and file a suit, my lord. Now, my lord, both of them pass away. I produced the death certificate also of both of them, my lord. Both of them passed away in 2022. And my lords will kindly appreciate mandate insofar as section 92 is concerned. 92 would require either the Advocate General or 2 trustees who are interested in the trust to then prosecute. 2022 itself, it was rendered infructuous. 2024, 3, my lord, I would call them utter strangers, file an application saying that we are so and so, so and so, so and so, have nothing to do with the trust. My lords may kindly see the IA itself, IA number 8. It's at ink page 56. They are absolute strangers. They say that the plaintiffs have passed away. We know about the trust. We know about the objectives of the trust. We are now interested in the trust, so make us a party instead of the plaintiffs. Well, the application is allowed. Complete strangers, my lord.
They say that they are related to N.K. Ramaswamy Iyengar.
How they are related also, my lord? Absolutely nothing. Then, my lords may kindly see 5 and 6. One is a retired public servant. One is a mathematics professor. One more, my lord, if my lords were to kindly see B in mechanical engineering. What do they have? My lords may also kindly see paragraph 8. I say that the impleading applicants volunteer to take responsibility, carry out the wishes of the authors to the trust and render effective.
Take out emergent notice.
My lord, at least proceedings may be stayed till then, my lord, because
what will happen?
the issue is this, my lord, complete strangers who have nothing because other trustees have already been.
What will happen if the
Other trustees are already there here, my lord.
Let us take out notice, issue
Till
emergent.
then, my lord, because till then.
Issue emergent notice. In addition, learned counsel for the petitioner is directed to serve. The learned counsel who represents the respondents before the trial court. List
Please,
immediately
because
after
now
vacation.
they've been impleaded and my lords may also kindly see the amended petition.
List it immediately after vacation.
The only thing is, my lord, the next date, I think, is just after.
What
vacation.
happens?
My
You have
lord,
to
no,
file your
they'll
objection.
go to the evidence, my lord. Next is evidence.
The suit itself is not registered.
Please, but I understand, but in this petition also, they have no locus standi at all, complete
That is right.
strangers.
The court is yet to decide.
Petitioners, they had stated that one of the lifetime trustees, at least their claim was that they're the only two lifetime trustees who are alive. One Chidambaram, he's still alive today. That is suppressed.
Yes.
They say he's no more. He's not even made a party to these
But if
proceedings.
it's a public trust, it
Please.
has to be, a second view has to be taken. Let us, please take out notice. Next.
Please, I'll do that.
44, Swatantha
Raj.
Petitioner is the plaintiff before the trial court.
Hmm.
Filed an application for amendment that came to be dismissed. Agreed by the same, the petitioners before your lordship. I produced the IA in page 29. Initially, my lords, the plaintiff has filed a suit for bare injunction. The defendant has filed a statement contending that the defendants are the owner in respect of half portion of the suit schedule property.
ಯಾವ ಸ್ಟೇಜ್ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
Further chief of PW1 evidence comments ಆಗಿತ್ತು.
Issue emergent notice, interim stay of further proceedings. Yes, next.
Number 45, Kavita Damodaran.
Kavita Damodaran. Kavita Damodaran, no representation, list after vacation. Chokka Reddy,
Number 46, Surgeon 47.
Nagaraja.
For the petitioner.
Lord, 3 acres of agricultural land, Lord, is the subject matter. Lord, at ink page, Lord, 36 is the disputed property, my lord. Lord, we filed a suit for declaration and injunction. Along with the suit, we maintained an application for temporary injunction. Lord, the dispute between the poor woman farmer and the forest department. Lord, in the year 1994, my lord, my vendor was granted, Lord, this land. Lord, as per annexure A, Lord, ink page 38, my lord. That committee, yes.
Any proceedings are initiated by the department?
Lord, they have initiated, forest department have initiated proceedings saying that we have encroached it. But my property comes within the deemed forest area. Lord, therefore, my lord, your lordship, I cordially invite your lordship attention at ink page 40, my lord. That is the sketch, my lord, identifying latitude and longitude of my land, which was granted by the authority in the year 1994, my lord. Then, my lord, as per annexure B, my lord, the grant certificate was issued. Ink page 44, my lord.
Yeah, but what is there to show that this property belonged to the revenue department?
Not, my lord, forest department they are claiming. Lord,
who has granted you this land?
The revenue department.
The revenue department ಅಂತ ತೋರ್ಸೋದಕ್ಕೆ ಏನಿದೆ?
Lord, that I have produced, my lord, there are so many correspondences, my lord.
ಏನಿದೆ?
My lord, annexure. My lord, annexure P, my lord, there is a letter, my lord, by the forest department to the assistant commissioner. Lord, annexure ink page 76, my lord. This is, my lord, ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ತಮ್ಮಲ್ಲಿ ತಿಳಿಯಬಯಸುವುದೇನೆಂದರೆ ಡೀಮ್ಡ್ ಅರಣ್ಯ ಪ್ರದೇಶಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಹಾಸನ ಉಪ ನಿರ್ದೇಶಕರು ಭೂದಾಖಲೆ ಹಾಗೂ ಕೆಳೆಯ ಸಹಿದಾರರು ಉಲ್ಲೇಖ 1ರ ಸರ್ಕಾರಿ ಆದೇಶದಂತೆ ಹಾಸನ ಜಿಲ್ಲೆಯಲ್ಲಿರುವ ಡೀಮ್ಡ್ ಅರಣ್ಯ ಪ್ರದೇಶಗಳ ಗ್ರಾಮವಾರು ಸರ್ವೆ ನಂಬರ್ ವಿಸ್ತೀರ್ಣವಾರು ಮಾಹಿತಿಯ ವರದಿಯನ್ನು ಉಲ್ಲೇಖ 2ರ ಜಿಲ್ಲಾ ಮಟ್ಟದ ಸಮಿತಿಯ ಅಂತಿಮಗೊಳಿಸದಂತೆ ಸಹಿಯೊಡನೆ ದೃಢೀಕರಿಸಿ ರಾಜ್ಯ ಸರ್ಕಾರಕ್ಕೆ ಸಲ್ಲಿಸಲಾಗಿರುತ್ತದೆ. ಯಥಾ ಪ್ರತಿಯ ನಕಲನ್ನು ಇದಕ್ಕೆ ಲಗತ್ತಿಸಿ ಕಳಿಸಲಾಗಿದೆ. ಬ್ಲಡ್ ಇನ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಬ್ಲಡ್ ಇಂಕ್ ಪೇಜ್ ಬ್ಲಡ್ 78 ಬ್ಲಡ್.
ದಯವಿಟ್ಟು ಮುಂದಕ್ಕೆ ಹೋಗ್ತೀರಾ? ಪ್ಲೀಸ್ ರೀಡ್ ಇಟ್ ಫರ್ದರ್. ಸದರಿ ವರದಿಯಲ್ಲಿ ಸೇರ್ಪಡೆಗೊಂಡಿರುವ
ಸೇರ್ಪಡೆಗೊಂಡಿರುವ ಡೀಮ್ಡ್ ಅರಣ್ಯ ಕ್ಷೇತ್ರಗಳಿಗೆ ಕಂದಾಯ ಮಂಜೂರಾತಿಯಾಗಲಿ ಅಥವಾ ಕಲ್ಲುಗುಣಿಗೆ ಮಂಜೂರಾತಿಯಾಗಲಿ ಇನ್ನಿತರ ಯಾವುದೇ ಅರಣ್ಯ ಚಟುವಟಿಕೆಗಳಿಗೆ ಕಾನೂನಡಿ ಅವಕಾಶ ಇರುವುದಿಲ್ಲವಾದ್ದರಿಂದ ಇನ್ನು ಮುಂದೆ ಈ ಪತ್ರದಲ್ಲಿ ಲಗತ್ತಿಸಿರುವ ಡೀಮ್ಡ್ ಅರಣ್ಯ ಪ್ರದೇಶದ ಸರ್ವೆ ನಂಬರುಗಳಿಗೆ ಯಾವುದೇ ರೀತಿಯ ಅನುಮತಿಗಳನ್ನು ನೀಡಬಾರದೆಂದು ಕೋರಿದೆ. Lord, this is the letter in the year 2015. Lord, we were granted in the year 1994. Lord, for along with this letter, I lordship may not kindly turn to my lord ink page 78. Ink page 78, Gyarahalli survey number 161, my lord, 7.84 hectares. That means to say that, my lord, 19 acre, 37 guntas is the deemed forest area. My lord, total extent of the property in survey number, my lord, in page 82, my lord, as per their own version. In for 82, my lord. ಡೀಮ್ಡ್ ಅರಣ್ಯ ಮತ್ತು ಸಾಗುವಳಿದಾರರ ವಿವರಗಳು ಗ್ರಾಮ ಗ್ಯಾರಹಳ್ಳಿ ಸರ್ವೆ ನಂಬರ್ 161 ವಿಸ್ತೀರ್ಣ 31-17 ಎಕರೆ ಸಾಗುವಳಿದಾರರಿಗೆ ಮಂಜೂರಾಗಿರುವ 11.20 ಎಕರೆ ಬಿಲೋ ಮಿಲಾಡ್ ಲಾಸ್ಟ್ ಮಿಲಾಡ್ ಮಹಾಲಕ್ಷ್ಮಿ ಮಿಲಾಡ್ ದಟ್ ಇಸ್ ದಿ ಪೆಟಿಷನರ್ but 3 acres of land milord it was already milord found at the time of recommending the government for declaring as a deemed forest because milord we were granted in the year 1994 milord. Then, my lord, as per annexure, my lord, annexure T.
Please tell us what is the stage of the proceedings initiated by the department? ಏನ್ proceedings initiate ಮಾಡಿದ್ದಾರೆ?
My lord, they have issued a notice, my lord. Notice, my lord.
Have you mentioned that in the plaint?
Yes, my lord. I have mentioned in the plaint and as well my writ petition also, my lord, stating that they are attempting to causing interference by issuing. Alleging that we have encroached the deemed area. No, my lord, there are abundant material, my lord. That deemed forest is different from the land which granted to us, my lord. That, my lord, their document itself. Therefore, in the first document, annexure A, my lord, they have shown what actually the property granted to me.
Yes.
But in the present, my lord, annexure T, based on annexure T, they have claimed, my lord, we have encroached it. But annexure T, my lord, they have not identified total acres of land of a deemed forest area.
Take out notice, issue emergent, government ಇದು.
Also, forest department, I have served, my lord.
AG is directed to accept notice for the respondents, list immediately after vacation.
My lord, let there be a protection for, my lord, for disposition. At least status, at least let them not precipitate anything, my lord, till disposal. Your lordship may kindly.
Next state of hearing, the respondents are directed not to precipitate the issue. Yes.
Oblige me.
List on date for the after vacation.
16th January.
Oblige me. 16.
48.
According to the petitioner, my lord, 48, 49 and 50 are connected matters. Kindly pass over, my lord.
Madam, it's already 4:39.
My lord, I'm ready to make submissions if required.
If you are ready, please argue.
My lord, this is, the suit was one for injunction. Ex parte decree was sought for, the ex parte injunction was sought for. Annexure A is the impugned order, my lord. I have produced my sale deed. Over 20 years, I've been in possession, my lord. My sale deed is produced at annexure E, my lord, page number 29.
Yes.
And at annexure F, my lord, I produced my GPA as well. The GPA holder has executed sale deed in my favor. This is more than 20 years ago, my lord. After this, my lord, all the RTC's revenue documents are in my favor. I got the property converted. As against the father, I had filed previously a suit, my lord, and interim orders were provided.
As
However,
against your father.
No, as against the father of the petitioners in the respondents in 48, 49 and 50, my lord. They're all family members. As against the father, I have interim orders. However, subsequently, when I filed a suit against the...
Where is that interim order?
It's at page annexure J, my lord, page number 52. At page number 54, my lord, may I read the...
Yes.
Para 3, my lord. The plaintiff has produced copy of the sale deed dated 1/10/2003, power of attorney dated 12/1/1995, mutation registered, conversion order, encumbrance certificate, RTC, and copy of the IH. This IHC shows the name of the my vendors, my lord.
What is the stage of this suit?
Ex parte interim, I just filed the suit, my lord. Ex parte interim orders were sought for. The court has not granted ex parte interim orders. But however, I'm seeking protection, my lord. May I continue, my lord?
Issue notice.
My lord, ex parte.
In addition, learn counsel for the, issue notice. In view of the order passed in WP, in OS number 1709 of 2024 by the Principal Civil Judge, Bengaluru Rural District, Bengaluru, the respondent is restrained from interfering with the possession of the petitioner in the social property till the next date of hearing.
Much obliged.
Counsel for the petitioner is directed to serve, take out, to comply order 13 rule 3A. Yes.
Much obliged.
What about the next one?
Same, my lord. She's a wife. So
Why
that-
have you filed it in installment wise, madam?
It was required by the party, my lord. Party required the same. We have
You are
filed three
taking
suits.
chance, get one injunction in one case and
No,
thereafter.
no, my lord, no, my lord.
No, this is not
because
fair.
of- Because of heavy interference by the.
Madam, one suit you filed against the father, another suit against the son, one more suit against the wife. Which is the other one?
That's the daughter, my lord,
Daughter.
daughter.
Vidu,
My
What
lord,
else?
what has happened is 2 months ago.
there is no dog in their house.
Well,
Huh? This is enough. We will not entertain this. This looks like you are taking a chance.
No, my lord.
File 5 suits. In one suit, if you get an injunction, you should be happy. Then repeat it in other suits.
I understand, my
Oh,
lord.
no. Yes, issue emergency notice. See number 50 and 51. Sorry, 50,
49.
49 and 50. Yes, next.
51, Krishna B.
The petitioner in this case, my lordship.
Uh,
The petitioner filed an application under section 151 before the trial court, IA number 5. Both the side heard, my lordship, reserved for orders on 12/12/2023. Even after lapse of 20 hearing, the learned trial court is failed to pass the orders. Hence, I sought direction to the trial court to dispose of the IA number 4 in accordance with law within 1 month, my lordship.
Judge change agilva?
ಇಲ್ಲ
Huh?
ಜಡ್ಜ್ ಇಲ್ಲ ಅವರೇ ಇದ್ದಾರೆ
ಅವರೇ ಇದ್ದಾರೆ.
ಅವರೇ ಇದ್ದಾರೆ
Are you
ಆರ್ಡರ್ಸ್
sure?
ಆರ್ಡರ್ಸ್ ಆರ್ಡರ್ಸ್
Are you sure that there is no
ಸ್ಪೇಸ್ my lordship.
same judges
Same
continue?
judges is there.
ಎಲ್ಲಿ ಹೇಳಿದಿರ? Purple issue emergent notice in additional learned counsel for the petitioner is directed to serve the learned counsel who represents the respondent before the trial court. List immediately after vacation. Yes.
Any date may be fixed, my lordship. First week.
Check ಮಾಡ್ಕೊಳ್ಳಿ ಇದೆಲ್ಲ ಇದೆ.
Please.
Mr. N. Srinivas.
Let's I appear for the petitioner's counsel.
Ah.
Lord suit, Lords, initially, the respondents, my lords, herein filed one suit for injunction. Ex parte order of injunction was granted, my lords, in respect of, there is a composite property of 1 acre, 9 guntas, consisting of 14 guntas and 35 guntas. In respect of 14 guntas, he filed a suit. He got an ex parte injunction order. Thereafter, my lords, we filed a suit for, he came and interfered with the possession. A suit for declaration, my lords, was filed and injunction. In that, my lords, we got an order not to alienate, my lords, and not to interfere with the possession. Thereafter, my lords, he entered appearance. Matter was heard, my lords, not to alienate was confirmed. And not to interfere, my lords, was made a status quo because we have a running business establishment there. Thereafter, my lords, now he has filed without disclosing those two suits. One more suit is filed. Ex parte order of injunction, my lords, has been granted. Immediately, my lords, we advanced the matter. We filed objections to the IA. Matter, my lords, was heard. Injunction was granted on 7/12. We advanced it to 13/12, filed objections. Matter was heard on 13/12, our arguments, posted for 17/12. And then, my lords, it has been adjourned to 9/1 with an order of injunction. Now, I'll just pass on, my lords, the photographs, my lords, of the status of the property. May I just pass on, my lords? Lords, this is a composite property with an established, my lords, a BPO business that is going on, my lords, and I'm running it. All the drone shots, my lords, and the photographs, my lords, are there. Now, after he gets the injunction, ex parte injunction here, my lords, which is at page number 9, my lords, 9 onwards, my lords, the plaintiff number 2's photo is there. CCTV footage is there. He barges in. 9, my lords, 9-2, my lords, may kindly see 9, 10 onwards. 10 ಅಲ್ಲಿ then he pulls the gate. 11 ಅಲ್ಲಿ gate ಎಳ್ದಾಕ್ತಾರೆ. And then, my lords, then they try to barge into the property. And that day we came to know, my lords, that the ex parte injunction has been granted. We move the trial court immediately, advance it, argue our side, and it is posted for their arguments. But on 17/12, matter is adjourned to 9/1 beyond 30 days. And now, my lords, without disclosing the earlier two suits, my lords, another suit is filed. So I am faced, my lords, with the situation where today, my lords, there is an ex parte injunction, my lords, though there is a status quo order in respect of the composite property 14 guntas.
Where is that?
Please, my lords.
Where is the status quo order?
My lords, status quo order, page number 97. It starts, my lords, at page 85. Starts at 85, 97 is operative portion. This has been confirmed in the MA. I'll just read 97.
Whether the plaintiff in the other suit is party to this suit.
Please, my lords, he is the defendant, my lords. Parties
that-
are the same in both the suits. But in the composite property, we have two properties. One is 14 guntas, 35 guntas. but it is, entrance is same, everything is same. It is, now kindly see, my lords, operative portion. Application number IA2 filed, we are the plaintiffs in that. Order 39 rule 1 and 2 is hereby allowed. The defendants, their men, their agents, or anybody by order temporary injunction registered from alienating or creating any third party rights encumbering the application scheduled property pending disposal of the suit. The application IA3 filed by the plaintiffs under order 39 rule 1 and 2 is hereby partly allowed. Both the parties to the suit shall maintain status quo pending disposal of the suit.
Now,
I have filed a,
who is the plaintiff who has now filed a fresh suit?
he is the defendant, my lords, in this case. The defendants,
What
which
is
is
his
that,
name?
Chitrakala and Akshay. That, my lords, get it at page 122. He presents suit to plaint. Chitrakala and Akshay. Chitrakala is the plaintiff, Akshay. Here he does not disclose those two suits. We have filed a miscellaneous petition and both the suits are clubbed and posted for trial. Issues have been framed. Now this is in respect of the other portion of the composite
What are
property.
related to these people?
My lords, Chitrakala, Akshay is the employee, my lords, of Vijay Shankar. And my lords, he was given a GPA, and on the basis of that, my lords, there was some transaction that he had made. Now he, in this case, I have given a gift deed, my lords. Vinay Shankar has given a gift deed of the scheduled property to his son, Viren Vijay Singh. He now files a declaration suit seeking for that gift deed to be not binding on him. And in that he obtains an injunction. And my lords, my only concern is this: 30 days, we may be permitted to even move the vacation bench. But till that time, my lords, some protection may be granted. We'll move the vacation court. Vacation court may be directed to dispose of my IA also. Kindly see the order sheet, my lords, for a moment. Order sheet. My lords, 135 may kindly be seen. Order sheet. 135. It starts at 135. My lords, 136 ali on 7/12, ex parte injunction order is granted. Now kindly see, my lords, in page 137, bottom of the page, 13/12 it is advanced. And then, my lords, case called out on being advanced, SN advocates file wakat for D1 and D2. Further, he also files objection to IA number 1, memo along with documents. Heard counsel for defendants on IA number 1. Then counsel for plaintiff seeks time for arguments on IA number 1, call on 17/12. 17/12, we requested the court to dispose of the IA. Case called out, learned advocate for the plaintiffs filed IA. In view of the same TI order granted stands extended. Counsel for the plaintiff seeks time for arguments. Call on
Issue emergent notice till the next date of hearing, the order dated 7/12/2024, 17/12/2024, passed by the 7th additional city civil and session judge, 7th additional senior civil judge and JMFC Mysore in OS number 1672 of 2024 is state.
It's ordered at 7/12.
ಎರಡು ಇದೆ continuation ಇದೆಯಲ್ಲ.
Please, grateful.
Next.
53 Kumar SJ.
SJ Kumar.
This case, I filed the application immediately to summon the document.
Sir, in previous matter, hand delivery may be ordered, ma'am.
Yes, next.
My lords, in this case, the petitioners are before your lordships challenging the order passed by the court below, seeking summoning of the original document exhibit P21, my lords. Exhibit P21 is the document which is said to be executed by my father, petitioner, original plaintiff, stating that he has executed the sale deed. He had not executed the sale deed. The legal heirs of the plaintiff had deposed before the court, stating that it was not executed by the original plaintiff Jairam. Now, my lords,
Why do you need the original sale deed? For what purpose?
To compare the signature, because in the sale deed of the year 1984, it says that Jairam had put the LTM in the sale deed, which I have denied. Plaintiff himself has.
Suit ಯಾವ stage ಅಲ್ಲಿ ಇದೆ?
ಇವಾಗ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜ್ಗೆ ಹೋಗಿದೆ. Immediately after the examination of the cross examination of defendant, I have filed the application.
2004 suit, I will not grant stay, but please
My
take
lords,
out
here
notice.
on 4th it is there, my lords. It is
Not
posted
grant
for
stay,
argument.
sir. No, no,
It is
no.
posted
ಇದೆಲ್ಲ-
for arguments.
These are all old suits, Mr.
My lords,
2004,
your
20
lordship-
years, 20 years in a
Your lordship,
man's life is one third.
Your lordship may kindly turn to the same
I
place,
will
my
not
lord.
grant stay.
My lord,
Therefore,
your
issue
lordship-
emergent notice. In addition, learned counsel for the petition is directed to serve the learned counsel represents the defendant number 4 yaar.
He is defendant number 7, respondent number 7. before
Respondent
your
number 7.
lordships here.
Notice to the other respondents is dispensed.
My lords, if
List
interim
on-
order is not there,
No interim order.
the court would not summon.
Will not grant
My lord,
interim
your
order
lordship
in
may kindly
these
see
old
what the
suits.
learned judge has said, my lord. Your lordship may kindly
Mr.
turn.
Kumar, 2004 suit ಅಲ್ಲಿ please don't compel the court to grant an interim order.
But if.
All of you, all of us will have to strive to ensure that these old suits are disposed of.
Comparison
Suit-
is not
no,
there, my
sorry,
lord.
sorry.
If it is
Next,
not,
next,
they
next,
did
next,
not
next.
produce the original sale deed, my lord. That's the reason, my lord.
5 o'clock. ಆಯ್ತು ಕರೀರಿ ಇನ್ನೊಂದು
Till next date at least.
No,
it may be
sorry.
said, statement.
ಸಾರಿ ಮಿಸ್ಟರ್ ಕುಮಾರ್ ಸರ್ವ್ ಮಾಡ್ಕೊಂಬನ್ನಿ ಆಮೇಲೆ ನೋಡೋಣ.
54 Keshav Murthy B.
At least date may be given, my lord, in
ಸರ್ವ್
January,
ಮಾಡ್ಕೊಂಬಂದು ಮೂವ್ ಮಾಡಿ.
please.
We'll take it up.
My lord, petitioner is the plaintiff before the trial court, my lord. Filed an application for impleading the Tahsildar that came to be,
ತಹಸೀಲ್ದಾರ್ ಏನಕ್ಕೆ?
my lord, in
Suit
this
is for
case,
what?
suit is for declaration, my lord.
ತಹಸೀಲ್ದಾರ್ ಏನಕ್ಕೆ?
My lord, what has happened, my lord, the land in question has been granted to this plaintiff, my lord. My lord, this same records have been manipulated in the name of the defendant.
How is ತಹಸೀಲ್ದಾರ್ necessary?
The office of the Tahsildar, my lord.
ಏನಕ್ಕೆ?
Since the documents
Well,
in the
yeah,
office, my lord, the documents in the office of the Tahsildar has been manipulated. As such,
ಅವ್ರ
and
ಮೇಲೆ
on that basis, the defendant is claiming, my lord.
dismissed. Next.
55. So plaintiff's petition, application seeking amendment of plaint was rejected, my lords. Application was filed at the stage of cross of DW2, my lords. By virtue of the amendment, plaintiffs they sought to plead that defendant number 1, who is their father, had executed an Oppige Kararu Krayapatra in their favor, my lords. So pleading in respect of the said document was not there.
What stage you file this application?
Like cross of DW2, my lords.
Cross of?
Cross of DW2.
What is it you want to insert?
The
What do you want to amend by?
father of defendant number 1, who is father of plaintiffs, he had executed an Oppige Kararu Patra in favor of the plaintiffs, my lords. In respect of the said document, they sought to incorporate the pleadings, my lords.
That you are not aware when the suit was filed.
Actually, there was change of counsel also, my lords.
Change of counsel is no ground. Please read the amendment that you want. Plaintiff chasing that there should be no trouble.
In page annexure E, my lords, page number 37. In the plaint in page number 2, after para number 2, the following para number 3A is to be inserted. In fact, the defendant Rangashamaya, the father of plaintiffs, with the chaste intention that there should not be trouble.
Barkol, petition is dismissed.
57, 56 urgent, 57 P Narayana.
This matter, please. My lord, this is a shoot for partition, wherein both the dependents and the plaintiff entered into one of the memo for settlement. They issued checks. However, after issuance of checks, they did not make payment. Therefore, the plaintiff needs relief from this honorable court in order to.
What is it you are challenged?
The challenge is before this honorable court, the annexure. Some idರಲ್ಲಿ ರಾಜಿ ಆಗಿದೆ, ರಾಜಿಗೆ ಅಮೌಂಟ್ ಬರ್ಲಿಲ್ಲ ಅನ್ನೋ ಚೆಕ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ, ಯಾವ್ದು ಡ್ರಾಗ್.
ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ, ಹೈಕೋರ್ಟ್ಗೆ ಏನಕ್ಕೆ ಬಂದಿದ್ದೀರಾ?
ಈ ಜ್ಯೂರಿಸ್ಡಿಕ್ಷನ್ ಇಲ್ಲ ಅಂತೇಳಿ ಅವರು ಚೆಕ್ಸ್ ಕೊಳ್ಳಿಲ್ಲ. ಬಿಫೋರ್ ದ ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಮುಂದೆ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಎಷ್ಟು ತೋರಿಸಿದ್ರೆ 2 lakhs ತೋರಿಸಿದ್ದಾರೆ ಯಾರು ಪ್ಲೈಂಟಿಫ್ಸ್. ಈಗ ಡಿಪೆಂಡೆಂಟ್ಸ್ ಕಾಸು ಯಾಕೆ ಕೊಡ್ತಾ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಜೂನಿಯರ್ ಡಿವಿಷನ್ಗೆ ಹೋಗ್ತಾ ಇದೆ, ಇದು ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಮುಂದೆ.
ಎಲ್ಲಿದೆ ಇಂಪ್ಯೂನ್ಡ್ ಆರ್ಡರ್? ಎಲ್ಲಿದೆ
ಇಂಪ್ಯೂನ್ಡ್? ಇನ್ ಪೇಜ್ ನಂಬರ್ 45. Memo filed by the plaintiff according to suit is dismissed as settled out of court.
Page 45, memo filed by plaintiff according to suit is dismissed. ಏನ್ ಮಾಡ್ಬೇಕು?
ಮೆಮೊ ಫೈಲ್ ಮಾಡಿ ಚೆಕ್ಸ್ ಮೂಲಕ ನೀವು ಕೊಡ್ತೀವಿ ಕಾಸು ಅಂತ ಹೇಳಿ ಕೊಳ್ಳು ಇಲ್ಲ, ಏನು ಇಲ್ಲ.
ಏನ್ ಮಾಡ್ಬೇಕು?
ಅದಕ್ಕೋಸ್ಕರ ಆರ್ಡರ್ ರೆಸ್ಟೋರ್ ಮಾಡಿದ್ರೆ ನಾನು ಸೀನಿಯರ್ ಡಿವಿಷನ್ ಮುಂದೆ.
ಅದಕ್ಕೆ ಒಂದೇನೋ ಜಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ, ಜೆಟ್ ಪ್ಲೈವುಡ್ ಕೇಸ್ ಅಂತ ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ, ತಗೊಂಡು ನೋಡಿ ಬರ್ಕೊಳ್ಳಿ. ಎಲ್ಲೆಲ್ಲಾದ್ರು ಜೆಟ್ ಪ್ಲೈವುಡ್ dismissed. Next.
58.
I appeal for the petitioners, my lord.
I am for the respondent, my lord.
Petition.
They have not served the copy, my lord. So not served the respondent copy.
Abhiraj Chengti.
Yes, my lord.
Yes, you have not served a copy.
No, my lord.
My lord, we changed the respondent, my lord. Earlier we made Honorable Additional Civil Judge Tarikere as a party, my lord. objection was raised. Later, we made parties in the suit. Here also, we made them as party, my lord. Court is no longer party in this petition, my lord.
So you're not served a copy to the other side.
Well, this is for the first time it's coming on board, my lord.
No, but why are you saying that you're not served? You have entered caveat.
No, my lord.
You know, how did
They
you
have
enter
not-
appearance? Who asked you to come?
Respondent one, my lord. We
But
are
who has
not-
asked you to come? We're not issued notice to you.
No, my lord.
Then how did you come on record? Yes, Mr. Chengti.
My lord, the petitioner filed partition suit on 26/7/2022 before the Honorable Additional Civil Judge Tarikere, my lord. They filed IA 2 of 22 for a temporary injunction against the defendants therein, my lord. They concluded their side of arguments on IA 2 of 22 on 16
Any
to
objection to allow this petition, madam?
Yes,
We'll
my
issue a
lord.
direction
After-
to the trial court to dispose of the application.
My lord, after vacation.
Barcode. The plaintiff number 1 in OS number so and so is before this court seeking for a direction to the trial court to dispose of IA number 2 of 2022 filed in OS number 322 of 2022. It is the case of the petitioner that an application filed in OS number 322 of 2022, though was posted on several dates for hearing, the said application is not considered. Full stop. The order sheet produced by the learned counsel for the petitioner does establish that the trial court has not considered the application filed by the petitioner, namely IA number
2 of 22, my lord.
22. In that way of the matter, this petition stands disposed of, directing the trial court to consider IA number 2 of 2022 in accordance with law, at any rate within a period of 3 months from the date of reopening of the courts after winter vacation. Yes.
59.
Grateful, my lord.
Dr. S. Armugam.
Mr. Armugam.
Yes, ma'am.
Hmm.
My lord, the petitioner has availed 20 lakhs rupees loan from the respondent bank. It is a cooperative bank. Regarding that, there is an award. It was passed in 2022. 2019 was the loan. And it is against a hypothecation of the fishing boat. It is the mechanized boat. Against that, he has taken it. The boat, due to the rough weather, on 5/8/2023, drowned inside the waters, my lord. It is beyond recovery by the insurance company also. We had the insurance claim. There I had 20 lakhs rupees insurance. And I am a fisherman, poor man. I don't have any other things other than the income of that. Only that is the whole. Now, due to the hypothecation, the bank became the owner of the property. I am only in possession. Now I have asked the possession due to natural calamity.
No,
I cannot pay. I have told.
What happened to the insurance?
I will pay it. Now I have claimed for the insurance, and for the direction I have written another. This one repetition is pending before the court. I have made the insurance also as a party that I have informed it to this honorable court. Therefore, what I am requesting now, the boat is not there. They have reported there is no boat. Under the circumstances.
You give the particulars of the insurance. You give the particulars of the insurance. Furnish the particulars of the insurance.
Insurance is there for 20 lakhs. I have produced there the insurance policy, annexure F, G. Last.
Annexure?
I have produced it.
Annexure?
Annexure. Annexure G2, Mahila. Before that, what it has drawn, I have produced the photos also. It is in force. It is in a line. 20 lakhs rupees is the total claim.
What is the?
It is mentioned in page number 46.
What is the impugned order? You get somebody along with you, sir. What is the?
How I can't pay anything.
Sir, what is the impugned order? ಅವ್ರಿಗೆ ಹೇಳ್ರಿ ಅವ್ರಿಗೆ.
ಏನಾದ್ರೂ ಚಾಲೆಂಜ್ ಮಾಡಿದಾರೆ ಅಂತ ಕೇಳ್ತಾ ಇದಾರೆ.
Yes, yes, they have collected from me every warrant. I am paying 75,000 rupees. I have
Madam.
put it, the order sheet is.
Tell him, ask him what is the impugned order.
Order ಅಲ್ಲಿ they have asked for the attachment of the boat and also sale, auction sale of it.
So the boat is already gone. So what will they attach?
No, we have, then it is reported by the, it is not having any, there is no boat. For that, the court is going on issuing the NBW. We are paying 75,000 every time and we are coming out of it. That's the only thing
So
nowadays.
what should be done? Either you pay up the insurance money,
I have to,
you continue to pay that 75,000. Yen ಮಾಡ್ತೀರಾ?
no, it may be till I am getting the insurance claim.
Therefore, you ask him,
Further
tell him
proceedings,
to furnish the insurance details in before the executing court so that the notice can be issued to the insurance company.
I will produce, till then there may be, because
Till
now-
then ಅಲ್ಲ sir, ರೈತರ ಕೊಡಕ್ಕಾಗಲ್ಲ. Please furnish the details of the insurance company. We'll direct the executing court to implead the insurance company as a garnishee. Suppose if you get your money, we can ask the executing court to recover it from the insurance. Tell him,
but meanwhile,
madam, you tell him, madam, he'll keep on asking for the same thing. Hear you. List immediately after vacation. Kodi, next. Sai Kiran.
yes,
I'm for the petitioner in this case, Your Worship. So I'm questioning the impugned order, which is MA, final order
Please
in the MA.
Tell him, madam, tell him
yes.
and take him. Take him. Yes.
It's a, this is a defendant's petition against the plaintiff with regard to the ex parte judgment and degree passed without
How
service.
much money will you pay?
ನಾವು ಇನ್ಶೂರೆನ್ಸ್ ಎಲ್ಲವನ್ನು ಕೊಟ್ಟು ಬಿಡ್ತೇವೆ ಅವರಿಗೆ.
ಅಲ್ಲ ಎಷ್ಟು ಇವಾಗ ಕಟ್ತೀರಾ? ಸ್ಟೇ ಕೊಡೋದಕ್ಕೆ ಎಷ್ಟು ಕಟ್ತೀರಾ?
ಈಗಲ್ಲ ಈ ನಾಮಿನಲ್ ರೀತಿ, ಬಿಕಾಸ್ ಐ ಹ್ಯಾವ್ ಟೋಲ್ಡ್ ಮೈ ಪೊಸಿಷನ್.
ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಹೇಳಿ?
I can take something from others and I can pay some money.
ಅಷ್ಟೇ ಹಂಗೆ ಮಾಡಿ ಎಷ್ಟು ಕೊಡ್ತೀರಿ?
Your lordship may be very considerable.
ಕೊಡ್ತೀರಾ?
ಕೊಡ್ತೇನೆ.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
ಒಂದು every month I can pay 5,000 rupees.
No, ಹಂಗೆ ಜೈಲ್ಗೆ ಹೋಗಿ.
Not maybe.
No,
insurance claim till then only.
No, better you go to jail then.
Your lordship may fix it then.
No.
I will do it.
50,000 rupees.
15.
50,000.
It will be little more.
You are paying 75,000 every month.
Some 30,000 rupees. I will pay.
Issue notice in interim stay of the impugned proceedings in EP number so and so, subject to the petitioner depositing rupees 50,000 every month before the executing court. Yes, next.
Your Lordship, for the petitioners, this is a defendant's petition against the ex parte judgment and degree passed in the OS of 13. Now they have also filed I had filed a miscellaneous petition which came to be dismissed, and I filed over that an MA before the district court, and that has also been dismissed. That is the impugned order before this honorable court.
What is the suit for?
Suit for monies. And it's a strange suit. The defendants said that they had a transaction.
How much will you deposit?
I had already deposited the agreed amount in the execution case. That's my case.
Entire amount is deposited.
Yes, entire amount is deposited and is fixed deposited in the bank till the disposal of MA. Now the MA has been disposed of, and the decree holder, the respondents are trying to withdraw that amount. That is the reason I'm seeking the interim bill of stay, Your Lordships.
But you stay ಕೇಳ್ತದ OS decree ಅಲ್ವಾ?
Yes, Your Lordship, that's been executed before in the execution case.
Correct, but you're not seeking for stay of release of the amount. What do you want?
Stay of the release of the amount.
Therefore, issue emergent notice. Have you deposited the entire money?
Yes, Your Lordship.
ಎಲ್ಲಿದೆ?
ನನ್ನ ಹತ್ರ ಸೆಪರೇಟ್ ಇದರಲ್ಲಿ ಇದೆ.
Issue emergent notice. In addition, the learned counsel for the
read it, Your Honor.
petitioner is directed to serve. The learned counsel represented the respondent in MA 73 of 2022. Till the next date of hearing, any amount deposited by the petitioner in OS number 1023 of 2013 on the file of the 7th Additional Senior Civil Judge, Bangalore Rural District, Bangalore, is shall not be released. Yes.
Number 61, Manjunath SV.
Obligation.
Yes. Manjunath SV,
I am for the respondent.
P. Prasad.
Yes, I am for the last
ಎರಡು
occasion.
ನೀವು ಎಸ್ ಅಂತೀರಾ?
Yes, sorry, I am for the respondent.
Manjunath,
ಬಂದಿಲ್ಲ ಸ್ವಾಮಿ. Last occasion is avoiding
no
the same.
representation for the petitioner list
ಅಲ್ಲ,
after
ಒಂದ್
vacation.
ಸ್ವಾಮಿ sir. Last already is heard the matter for stamp duty ಮೇಲೆ. The court has
ಆಯ್ತು ಇವಾಗ ಆಯ್ತು ಟೈಮ್ ಆಯ್ತು ಬಿಡ್ರಿ ಇವಾಗ.
please.
ಜ್ಯೋತಿ ಎಸ್ಕೆ. Yes, madam.
Impleading applicant before the trial court, my lord.
Please use the mic.
My lord, I'm the impleading applicant before the trial court. I'm challenging the rejection of my impleading applicant, my lord. The trial court is rejected only on the basis of a typographical error in which survey number 35 is the subject matter and there was 53 is what mentioned in the IA application. Kindly see the page, number 91 to 93, the annexure F, my lord, which clearly shows the survey number 35 in my
This matter was
father's
listed
name.
yesterday.
No, this is
ನಿನ್ನೆ ಬಂದಿತ್ತಲ್ವಾ?
first time.
Hmm.
Annexure F at page 91 to 93.
What is the suit filed for?
Suit filed for partition, my lord.
Who are you?
The plaintiff is my paternal uncle. He is also deceased during the course of the trial.
Madam, who are you? Who are you?
I'm the relative of the plaintiff, my lord.
How are you related? How are you related?
Plaintiff is my paternal uncle, my lord.
Plaintiff is your paternal uncle.
Please, my lord.
Ah,
And the item.
take out notice,
the
issue
subject
emergent
matter
notice.
is Item number 6 and 10, which is
Huh?
only 2 items is the disputed that I'm claiming, my lord.
Hmm.
And I have supporting documents at annexure F and F1, which shows my father's name clearly, Shantappa.
ಆಯ್ತು ನೋಟಿಸ್ ತಗೊಳ್ಳಿ. Please take out notice, issue emergent
Evidence
notice.
stage ಅಲ್ಲಿ ಇದೆ, my lord. The
Huh?
evidence stage ಅಲ್ಲಿ ಇದೆ, OS.
ಅದ್ ನೋಟಿಸ್ ಸರ್ವ್ ಮಾಡ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ.
It seemed relief of stay and ಅವ್ರ ಮುಂದೆ ಹೋಗ್ಬಿಟ್ರೆ.
Huh?
Stay ಕೇಳ್ತಾ ಇದ್ದೀನಿ, my lord.
ಆಯ್ತು interim stay, yes. Interim stay
Grateful.
of further proceedings before the trial court.
Grateful, my lord.
63 article, number 64, Chandrakant R. Patel.
Yes, Chandrakant Patel.
Appearing for the petitioner.
Hmm.
Previous
Appearing for
occasion,
the-
my lordship
Again,
directed
settle
my
ಆಯ್ತು
client
ಈಗ.
to produce, my lord, TC ತಗೊಂಡಿರೋದ್ರ ಬಗ್ಗೆ ಏನಾದ್ರು ಇದ್ರೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ. On my lord, 11/10/2019.
ಕೊಡ್ರಿ ತಗೊಳ್ರಿ. ಏನಿದೆ?
On 11/10/2019, they obtained TC for 5 HP.
ಇದೆಲ್ರಿ ಟಿ ಸಿ ಅಂತ ಹೇಳಿ. You know what is a TC?
ಅಲ್ಲ, ಅದು ಮೇಲೆ ಅಕೌಂಟ್ ಐಡಿ ಅಂತಿದೆ. CNKIP 17139. That is the ID number.
ಟಿ ಸಿ ಬಗ್ಗೆ ಎಲ್ಲಿದೆ? IP ಸೆಟ್ಟಿಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ಇದಷ್ಟೇ. IP ಸೆಟ್ಟಿಗೆ ಸರ್ವಿಸ್ಡ್.
ಹೌದು.
ಟಿ ಸಿ ಅಂದ್ರೆ ಏನು?
ಅಲ್ಲ,
ಯು ಸೆಡ್ ಟ್ರಾನ್ಸ್ಫಾರ್ಮರ್ಗೆ ಹಾಕ್ಸಿದೀವಿ ಅಂತ ಅಂದ್ರಿ ನೀವು.
ಹೌದು.
ಎಲ್ಲಿದೆ
ಅಲ್ಲ,
ಟ್ರಾನ್ಸ್ಫಾರ್ಮರ್?
ಇದು ನಾವು ಆ ಲ್ಯಾಂಡಿಗೆ 5 HP ನಾವು ಕನೆಕ್ಷನ್ ತಗೊಂಡಿರೋದಕ್ಕೆ.
ಇದ್ರಲ್ಲಿ ಏನು ಇಲ್ಲ ಆ ಲ್ಯಾಂಡಿಗೆ ಅಂತ. ಎಲ್ಲಿದೆ?
ಅಲ್ಲ, ಆ ಲ್ಯಾಂಡ್ಗೆ ಅಂತೇಳಿ ಎಲ್ಲೂ ಹಾಕಲ್ಲ ಇದ್ರೊಳಗಡೆ.
ಮತ್ತೆ ಎಲ್ಲಿದೆ? ಹೌ ಡು?
ಅಲ್ಲ, ಶಿವಗಿ ಬಾಯಿ ವೈಫ್ ಆಫ್ ರಾಮನಾಯ್ಕ.
ಬಟ್ ಈ ಸರ್ವೆ ನಂಬರ್ಗೆ ಅಂತ ಎಲ್ಲಿದೆ? ಇಲ್ಲಿ ಸರ್ವಿಸ್
ಸರ್ವೆ ನಂಬರ್ಗೆ ಅಂತಿಲ್ಲ.
ಮತ್ತೆ
ಈಸ್ ಹ್ಯಾವಿಂಗ್ ಓನ್ಲಿ ದಿಸ್ ಲ್ಯಾಂಡ್, my lord.
ದಟ್ ವಿ ಡು ನಾಟ್.
ಅಲ್ಲ, ಅದನ್ನ ಕೈಂಡ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್, my lord, ನಾನು ಅದನ್ನ
ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
please.
ಪಾರ್ಟೀಸ್ ಬಂದ್ರೆ ಸ್ವಾಮಿ.
ಹಾ?
ಪಾರ್ಟೀಸ್ ಬಂದರೆ ಲಾಸ್ಟ್ ಟೈಮ್
ನಿಮ್ಮವ್ರು ಬಂದಿಲ್ವಾ? ಏನ್ ರಾಜಿ ಮಾಡ್ಕೋತೀರಪ್ಪ? ಏನಾದ್ರು ರಾಜಿ ಮಾಡ್ಕೋತೀರಾ? ಏನೋ ಸ್ವಲ್ಪ ದುಡ್ಡು ಕಾಸು ಕೊಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಒಂದೇ ಊರಲ್ಲಿ ಇರೋದು
ಸ್ವಾಮಿ.
ಜಾಸ್ತಿ ಜಗಳ ಆಡ್ಕೊಳಕ್ ಹೋಗ್ಬೇಡಿ. They have borrowed the loan from the bank on that property while pendency of the
ಆಯ್ತು ಬಿಡ್ರಿ.
litigation 2 ಲಕ್ಷ ಅವರೇ
ಬಿಡ್ರಿ.
loan ತಗೊಂಡಿದ್ದಾರೆ. Even though loan
ಎಲ್ಲ
is not
ಸುಮ್ನೆ
repaid.
ಹಳ್ಳಿಲಿ ಇರೋದು ಜನ ಸುಮ್ನೆ ಹೊಡೆದಾಡೋದು ಬೇಡ. ಏನೋ ಕೂತ್ಕೊಂಡು ರಾಜಿ ಮಾಡ್ಕೊಂಡು ಇಬ್ರು ಹೋಗ್ರಿ. ಒಂದ್ ಸ್ವಲ್ಪ ದುಡ್ಡು ಕಾಸು ಕೊಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡ್ತೀರಾ? ಮಾತಾಡಂಗಿರ ಮಾತಾಡಿ ಇವಾಗ.
ಏನ್ ನೋಡೋಣ after vacation ಹಾಕಿ ನೋಡ್ ದುಡ್ಡು
ಕಳ್ಕೊಳ್ಳಿ. ಏನೋ ಇದಕ್ಕೆ ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಮಾಡ್ಲಾ?
mediation refer ಅಂತಂದ್ರೆ ಪೊಸಿಷನ್ ನಮ್ಮ ಹತ್ರನೇ ಇದೆ.
ನೀವ್ ಬಿಡ್ರಿ, ಅವ್ರು ಒಪ್ಕೊಂಡಿದಾರ್ರಿ, ರಾಜಿ ಯಾಕೆ ರೆಡಿ ಇದಾರೆ, ನೀವ್ ಯಾಕೆ ಮಧ್ಯ ಬರ್ತೀರಾ? ಅವ್ರು ರೆಡಿ ಇದಾರೆ ರಾಜಿ ಮಾಡ್ಕೊಳಕ್ಕೆ.
ಅಲ್ಲ mediation refer
ಇಟ್ಸ್ ನಾಟ್ ಅಬೌಟ್ ಒನ್ ಕೇಸ್ ಗೆಲ್ಲದಲ್ಲ, ಒಂದು ಫ್ಯಾಮಿಲಿ, 2 ಫ್ಯಾಮಿಲಿ.
ಇಲ್ಲ ಅವ್ರು ಸುಮ್ಮನೆ harassment from the 15 years.
That is okay. They also understand. They also understand. Settlement ಮಾಡಕ್ಕೆ ಅವ್ರು ರೆಡಿ ಇದಾರೆ. Why do you come in the way?
mediation refer ಮಾಡಿ.
ಕುತ್ಕೊಂಡು ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
ಅಲ್ಲ ನಮ್ದೇನು
ಹೇಳಿ ಮಾತಾಡಿ.
ಹೇಳಿ.
ಈಗ ಲ್ಯಾಂಡ್ಗೆ ಅಂತಾನೆ ಡೆವಲಪ್ಮೆಂಟ್ ಲೋನ್ ಅಂತಂದು ಇದರಲ್ಲಿ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಲೋನ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್. ಅದನ್ನು ಕಟ್ಟಿಲ್ಲ, ಅದು ಡಿಫಾಲ್ಟ್ ಆಗಿದೆ ಸರ್, ಹಾಗೆ ಉಳಿದಿದೆ.
ಎಷ್ಟಿದೆ?
ಅವರು ಬ್ಯಾಂಕ್
ಎಷ್ಟಿದೆ?
2 lakh ಇದೆ ಸರ್ ಅದು.
ಆಮೇಲೆ
ಬೇರೆ ಬೇರೆ ಇತರೆ ಖರ್ಚು ಅಂತಂದು ನಾವೇ ಇದ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಸರ್.
ಎಷ್ಟು ಎಕರೆ ಜಮೀನು?
5 ಎಕರೆ 16 ಗುಂಟೆ ಸರ್.
ಎಲ್ಲಿರೋದು?
ಚಿನ್ನಿಕಟ್ಟೆ ಗಡಿಯಲ್ಲಿ ಇದೆ ಸರ್. ಚಿನ್ನಿಕಟ್ಟೆ ಗಡಿಯಲ್ಲಿ ಇದೆ ಸರ್.
ಯಾವ ಊರು?
ನ್ಯಾಮತಿ ತಾಲೂಕು, ಹೊನ್ನಾಳಿ
ಹೊನ್ನಾಳಿ. ಏನೊಂದು ರಾಜಿ ಮಾಡ್ಕೊಳ್ಳಿ, ಒಂದಿಷ್ಟು ಅಷ್ಟು ಕಾಸು ಕೊಡಿ. ಇವಾಗ ನೀವು ಕೇಸ್ ಗೆದ್ದಿದ್ದೀರಾ, ಇಲ್ಲ ಅಂತಲ್ಲ. ಸುಬರ್ದ್ ತಗೊಂಡಿದಿರೋ ಇಲ್ವೋ ಅನ್ನೋದು ಪ್ರಶ್ನೆ. ಸುಬರ್ದ್ ನೀವಿದಿರೋ ಅವ್ರಿದಿರೋ ಗೊತ್ತಿಲ್ಲ. ಇದೇನ್ ಡ್ಯಾಮ್ ನೀರ್ ಬರ್ತದ ಇದಕ್ಕೇನಾದ್ರು?
ಅಲ್ಲ ನಾವೇ ಸುಬರ್ದಿದ್ದೀವಿ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲಿಗೆ ಡ್ಯಾಮ್ ನೀರಿಲ್ಲ.
ಡ್ಯಾಮ್ ನೀರಿಲ್ವಾ ಇದಕ್ಕೆ?
ಡ್ರೈ ಲ್ಯಾಂಡ್
ಭದ್ರಾ ನೀರ್ ಬರಲ್ಲ.
ಇಲ್ಲ, ಭದ್ರಾ ನೀರ್ ನಮ್ ಭದ್ರಾವತಿ, ಚನ್ನಗಿರಿ ಅರ್ಧ ಭಾಗ ದಾವಣಗೆರೆಗೆ ಹೋಗುತ್ತೆ. ಇಲ್ಲಿಗಿಲ್ಲ,
ಈ ಕಡೆ ನೀರಿಲ್ಲ.
ಅಲ್ಲಿಗಿಲ್ಲ.
ಯಾವ್ದು ನೀರಿಂದ ಏನು ಇದಿಲ್ಲ ಸರ್.
ಏನ್ ಬೆಳಿತೀರಾ?
ಅದ್ರಲ್ಲಿ ಈಗ ಅಡಿಕೆ ಇದೆ ಸ್ವಾಮಿ, ಮೆಕ್ಕೆಜೋಳ ಇದು ಮಾಡ್ತಾರೆ.
ಅಡಿಕೆ,
ಮೆಕ್ಕೆಜೋಳ,
ಅಡಿಕೆ ಇನ್ನು ಇದು ಬೆಳೆ ಬರ್ತಾ ಇದೆಯಾ?
ಇನ್ನೂ ಬಂದಿಲ್ಲ.
2011 ಅಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಮಹಾಜರ್ ಸ್ವಾಧೀನ ಕೊಡ್ಸಿದ್ದಾರೆ. ಒಂದ್ ನಿಮಿಷ ಸರ್. 2011 ವಿ ಆರ್ ಇನ್ ಪೊಸೆಷನ್. ನಾವೇ ತೋಟ ಕಟ್ಟಿದೀವಿ, ನಾವೇ IP ಸೆಟ್ಸ್, ಬೋರ್ವೆಲ್ ಮಾಡಿಸಿದೀವಿ.
ಚಂದ್ರಕಾಂತ್,
ಐ ಅಗ್ರಿ ಮೈ ಲಾರ್ಡ್.
ಒಂದ್ ನಿಮಿಷ ತಾಳಿ. ಲೆಟ್ ಅಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಅಸ್ ಪ್ರಾಕ್ಟಿಕಲ್. ಅವರು ಸರಿನೋ ತಪ್ಪೋ ದುಡ್ಡು ಕೊಟ್ಟು ನಿಮ್ ಜಮೀನ್ ತಗೊಂಡಿದ್ದಾರೆ.
ಪ್ಲೀಸ್ ಅಗ್ರಿ ಮೈ ಲಾರ್ಡ್.
ದುಡ್ಡು ಕೊಟ್ಟ ಮೇಲೆ ಸುಬರ್ದು ತಗೊಳ್ಳದೆ ಯಾರು ಇರಲ್ಲ. ದುಡ್ಡು ಕೊಟ್ಟ ಮೇಲೆ ಸುಬರ್ದು ತಗೊಳ್ಳದೆ ಯಾರು ಇರಲ್ಲ.
ಅಲ್ಲ,
ಸುಬರ್ದ್ ತಗೊಂಡಿದ್ದಾರೆ.
ಹೌದು, ಪೊಸೆಷನ್ ಅಟ್ ದ ಟೈಮ್ ಆಫ್ ಸೇಲ್ ಡೀಡ್ ಅವ್ರು ತಗೊಂಡಿದ್ದಾರೆ.
ತಗೊಂಡ್ಮೇಲೆ ನೀವು ಕೇಸ್ ಹಾಕಿದಿರಿ.
ಹೌದು,
ಕೇಸ್ ನಡೆದಿದೆ.
30 ವರ್ಷ ಆದ್ಮೇಲೆ
ನಿಮಿಷ ತಡ್ರಿ, ಹೈಕೋರ್ಟ್ ಬಂದು ಸೆಟಿಸ್ಫೈಡ್ ಆಗಿದೆ.
ಹೌದು
ಅಲ್ವಾ? ಸೊ ದೇರ್ಫೋರ್, except on paper, what is there to show that you have taken actual possession?
But one thing, my lord, subsequent to the assistant commissioner order, we take possession. Since from 2011, we are in possession. Anyhow, my lord,
that is on paper, mister.
ಆಯ್ತು.
That is on paper.
3 ಮತ್ತೆ ರೂಲ್ ಸೆಕ್ಷನ್ 5 ಕೆಳಗಡೆ ನಮಗೆ ಸ್ವಾಧೀನನು ಬಿಡಿಸ್ಕೊಟ್ರು. ಅದಾದ್ಮೇಲೆ ರಿಟ್ ಅಪೀಲ್ ಆಯ್ತು. ರಿಟ್ ಅಪೀಲ್ ನಾವು ಅವ್ರು ಸಕ್ಸೀಡ್ ಆದ್ರು, ಎಲ್ಲದೂ ಆಯ್ತು. ಬಟ್ ಸ್ವಾಧೀನ ತಗೊಬೇಕಂತ ಅಂದ್ರೆ ನಾಟ್ ಬೈ ಫೈಲಿಂಗ್ ಬೇರ್ ಇಂಜಂಕ್ಷನ್ ಸೂಟ್. ಅಲ್ಲಿ ಇಂಜಂಕ್ಷನ್ ತಗೊಂಡು ಪೊಲೀಸ್ ಪ್ರೊಟೆಕ್ಷನ್ ತಗೊಂಡು ಅವರು
ಖಾಲಿ ಜಮೀನಲ್ಲಿ ಪೊಸೆಷನ್ ಫಾಲೋಸ್ ಟೈಟಲ್.
ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್
ಏನ್ ಮಾಡ್ತೀರಿ ನೋಡಿ.
ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ಇಸ್ ಆಲ್ಸೋ ಇನ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಬೈ ನೇಮ್.
ನಾನು
if any one of us decide this case,
please
your client will get nothing.
I agree, my lord.
Your client will get nothing.
I agree.
So ದಯವಿಟ್ಟು ಪ್ಲೀಸ್.
ಅಲ್ಲ, ನಾನು ಸಿನ್ಸಿಯರ್ ಆಗಿ ನಾನು ಅವರಿಗೆ ಸಜೆಸ್ಟ್ ಮಾಡಿ ಅವ್ರಿಗೆ ಕಾಂಪ್ರಮೈಸಿಂಗ್ ನಾನೇ ಒಪ್ಸಿದೀನಿ. ನಾನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಹತ್ರ ನಾನೇ ಮಾತಾಡಿ ಅವ್ರಿಗೆ ಒಪ್ಸಿದೀನಿ.
ಕೇಸ್ ತೀರ್ಮಾನ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಧಾರಾಳ
ರೆವಿನ್ಯೂ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಅಂಡ್ village accountant is not a authority to hand over the position, my lord. If the order passed by the assistant commission,
ರಾಜಿ ಬೇಡ ಅಲ್ವಾ?
ಆರ್ಡರ್ ಕಾಪಿ
ರಾಜಿ ಬೇಡ ಅಲ್ಲ?
ವೆಕೇಶನ್
ತೀರ್ಮಾನ
ಅಲ್ಲ, ಅವ್ರ ತಂದೆನು
ತಂದೆ
ಅಜ್ಜಿ ಹೆಸರಲ್ಲಿ
ತೀರ್ಮಾನ ಮಾಡೋಣ ಬನ್ನಿ.
ಅಲ್ಲ, ಅವ್ರ ತಂದೆ ಅಜ್ಜಿ ಹೆಸರಲ್ಲಿದೆ. ಈ ಹುಡುಗನ್ ಕೇಳೋದು ನಾವು ಅಷ್ಟು ಸರಿ ಕಾಣೋದಿಲ್ಲ. ಕಳ್ಸಿದ್ದಾರೆ ಇವತ್ತು.
ಈ ಹುಡುಗನ್ ಒಬ್ಬನಿಗೆ ಸ್ವಲ್ಪ ಇರೋದು ಅನ್ಸುತ್ತೆ.
ಅಲ್ಲ, ನನ್ನ ಪ್ರಕಾರ ಕೈಂಡ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅವರ ತಂದೆ ಅಜ್ಜಿ ಕರ್ಸ್ ಮಾತಾಡ್ತೀನಿ.
ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿ ಸ್ವಾಮಿ.
ನಾನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ಹತ್ರನು ಮಾತಾಡ್ತೀನಿ.
ಆಫ್ಟರ್ ವೆಕೇಶನ್
ಪ್ಲೀಸ್.
ಇಂಜಂಕ್ಷನ್ ಇದೆಯೇನಾದ್ರು?
ಹೌದು, ಇಂಜೆಕ್ಷನ್ ಇದೆ.
MA ಪೆಂಡಿಂಗ್ ಇದೆ.
ರೆವಿನ್ಯೂ ರೆಕಾರ್ಡ್ಸ್ ನಾಟ್ ಟು ಇಂಟರ್ಫಿಯರ್ ಅಂತ.
ಇಲ್ಲಿ ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನಂತ ಆರ್ಡರ್
ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೋ ಆರ್ಡರ್.
ಮತ್ತೆ ಬಿಡಿ. Yes.
ಏನ್ ಆರ್ಡರ್? ಏನ್
MA ಕೂಡ
ಆರ್ಡರ್?
ಪೆಂಡಿಂಗ್ ಇದೆ.
65 ಕೇಶವಮೂರ್ತಿ ಬಿ.
And for the petitioner, my lord, before the trial court in FTP proceeding, despite number 4, appointing of the Talak surveyor and partition by the Talak surveyor has been challenged before this court, my lord.
ಏನ್ ಹೇಳಿ?
Talak surveyor has been appointed in a partition suit
ಹಾ.
and he made a partition in contravention to the provision of section 54 of the CS.
Where is the order appointing the taluk?
My lord, page number 13, 12 and 13, page number 13 is the survey sketch prepared by the surveyor.
ಅಲ್ಲಲ್ಲ, where is the order passed by the FDP court? Order passed by the FDP court appointing a taluk surveyor.
Yes. Page number 13 ಅಲ್ಲಿ ಇವರು that copy is now only survey report is then, madam.
One
Survey
copy
report
for
itself is there, page number 40, 13. Survey report itself is there, that itself is challenged before this court.
Order ಏನಂತ ಇದೆ ಅಂತ ನನಗೆ. Where is the order passed by the FDP court? ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ?
In order to partition, it is suit for partition.
ಯಾರನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ?
Talak surveyor has been appointed by the trial court.
Where is that order?
That copy, order sheet is not forthcoming, but
Don't
survey
consider-
report is there, my lord.
Crown Counsel for the petitioners directed to place on record the order passed by the final decree court appointing a taluk surveyor to suggest a scheme of partition. List after the same is done. Yes.
Number 66, SP Total.
Unless the petitioner is challenging, my lords, the dismissal of the application for correction of the names in the judgment and decree. The trial court has dismissed the application, my lords. My lords, the order is at page 181. My lords, the facts is that, my lords, the respondent filed a suit for partition. And in that, the names of these defendants 3, 4, 5 were wrong, my lords. Again, and the suit came to be decreed, against which I preferred an appeal.
ಹೆಂಗ್ರಿ ಹೆಸರು ಚೇಂಜ್ ಮಾಡೋದು? 152 ನಲ್ಲಿ ಹೆಸರು ಹೆಂಗ್ರಿ ಚೇಂಜ್ ಮಾಡ್ತೀರಾ? 152 ನಲ್ಲಿ ಡಿಫರೆಂಟ್ ಹೆಸರನ್ನೇ ಹೆಂಗ್ ಚೇಂಜ್ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ, ಡಿಫೆಂಡೆಂಟ್ ಆ ಹೆಸರುಗಳು ತಪ್ಪಾಗಿದೆ ಅಷ್ಟೇ. ತಪ್ಪಾಗಿದೆ. Then that.
ತಪ್ಪಂದ್ರೆ ಏನು?
My lords, at page
181.
178, my lords. The third line, my lords, rectify the name of defendant number 3, 4 and 5 in the judgment and decree. Rectifying the name of defendant number 3 as Syed Hassan, son of
Defendant number 3
Syed
ಏನಂತ
Muhammad.
ತೋರಿಸಿದ್ರಾ? Defendant number 3 Syed Hassan Mia.
Please, my lords.
Hasu Mia.
And even I preferred an appeal with respect to the correct names, my lords.
Sharif. Syed Muzamil.
Muzamil,
ಆಮೇಲೆ
Syed Zain
Zaibun
Din.
Syed Zainullah Budin. ಅವ್ರು ಡಿಫೆಂಡ್ ನಂಬರ್ 5.
Please.
ಹೆಸರೇ ಚೇಂಜ್ ಆಗ್ತದಲ್ರಿ? ರಿಜ್ವಾನ್ಗೂ ಸೈಯದ್ಗೂ
And when I preferred an appeal, my lords, I mentioned the correct names.
Sir.
And the judgment and decree also is in the same, my lords, against which and the appeal came to be dismissed, and I preferred an RSA. In that RSA, my lords,
ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕಿದ್ ಹೆಂಗಾಗತ್ತೆ? ಡಿಫೆಂಡೆಂಟ್ ಚೇಂಜ್ ಮಾಡಕ್ಕೆ ಹೆಂಗಾಗತ್ತೆ 152 ನಲ್ಲಿ?
because they doesn't cooperate, my lords, now they are, because the appeal is also dismissed, now they doesn't come and cooperate with the correction of the names, my lords.
ಕರೆಕ್ಟ್, ನಾ ಕೇಳ್ತಿರೋದು ಸೂಟ್ ಡಿಸೈಡ್ ಆಗೋಯ್ತು,
Suit decide.
RA ಡಿಸೈಡ್ ಆಗೋಯ್ತು. ಇವಾಗ ಡಿಫೆಂಡೆಂಟ್ ಹೆಸರನ್ನೇ ಚೇಂಜ್ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಿದ್ದೀರಾ?
ಅಲ್ಲ, because RL ನ ಕರೆಕ್ಟ್ ಆಗಿ ಹೆಸರುಗಳು ಕೊಟ್ಟಿದ್ದೀನಿ, ನಮ್ಮ ಹೆಸರು ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದೀನಿ RA ಹಾಕೌತ್ನಲ್ಲಿ. Judgment and decree is in the judgment and decree of the
RA
RA.
is filed by the defendants.
Yes, my lords. ಅದ್ರಲ್ಲೂ ಕರೆಕ್ಟ್ ನೇಮ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ನಮ್ದು. ಇನ್ನು judgment and decree of the trial court, that is wrong, my lords. That's only should be corrected.
Issue emergent notice. Yes.
ಅಲ್ಲ, notice.
Yes.
Because there are several.
And 68.
There are
ಅಷ್ಟೇ ನೋಟಿಸ್ ಅಷ್ಟೇ, ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗ?
ಕೃಷ್ಣಮೂರ್ತಿ ಡಿ.
ನೋಟಿಸ್ ಒಂದೇ ತಾನೇ ಮಾಡಕ್ಕಾಗೋದು.
Date may be fixed, my lord, so that.
Yes, next.
69.
I
Krishnamurthy.
appear for petitioner, my lord, sir. This yesterday's case, my lord, sir, that direction to dispose of the RA, my lord, sir. In that, my specific prayer is to consider my compromise petition and to pass orders, my lord, sir. Since November 2023, my compromise petition is not considered. One of the defendant objects for the compromise, all the plaintiffs and defendants settled the matter and they have filed a compromise petition on 2011-2023, my lord. Thereafter, no orders has been passed on compromise petition as well as RE is also pending, my lord.
We'll take it immediately after vacation.
Please.
Just immediately after vacation. Yes, next.
70, yes, Kalyan was not.
Okay, for the petitioner, my lords.
Hmm.
30 impleading applications have been dismissed by a common order, my lords. The impleading applicants are all allottees of sites. One, B. alias Timraya was granted land and then eventually his legal heirs were re-granted the same land, my lords. Out of the said land, society was formed and allottees were allotted sites.
What is the suit for?
Suit for declaration. Now the plaintiffs before the trial court are claiming that they are the legal heirs. Eventually, the matter went up to Supreme Court and Supreme Court issued a direction to the plaintiffs telling that go file a suit before the trial court seeking declaration that you are the legal heirs. The society was impleaded. The trial court strikes off the society. This honorable court, my lords, has passed an order telling that society has an interest in it. The order, my lords, will find at page number 403, Annexure E. 411 that operative portion of where the this court finds finding that they have an interest in this case. It is also not in dispute that if the suit records a finding relating to either of the branches as being the legal representatives of the office holder, the rights that flow to the defendant number one, that is the society, would be affected either adversely or his rights would be affirmed. The court having impleaded him on 14/12/2018, this court finds that the order of striking him off from arraying as party may not have been necessary, considering the stage of the suit as well as the nature of the issue. So the court sets aside that order. Now, my lords, the society has not cross-examined plaintiff witnesses. The society has not led in evidences. We are all allottees of the sites.
Take out notice.
Well, that's the 16th final arguments. Final arguments on 6th of January. It was there today. It's gone to 6th of January for final arguments because we are all allottees of the sites formed out of the layout. Maybe I'll serve it on the council appearing before the trial court.
But what is there to show that you're interested in the suit?
Well, I purchased the sites formed out of this one. The sites which was regranted was the land. The land was formed out of the same like this one. If my last make only to plaint, my lord. Plaint is at Annexure B. Plaint ali. If my last make 374, page number 374 ali. Lands bearing survey numbers 28, 185, 198, 113, 158, and 161. These are all the lands which was regranted. And survey number 28 in the sites form agide. I have produced the sale deeds also.
So what is your right? You please tell that.
I have purchased the sites which
from whom are
from the AECS layout. Respondent number 20, defendant number 22 before the trial court.
22. What is the suit filed for?
Suit is for declaration.
Saying what?
Declaration that the plaintiffs are the legal heirs of the original grantee B. alias Timaya. The defendant number 1 to 21 are the ones in whose favor it was regranted.
Where are the suit reliefs?
Suit relief is for declaration, my lords. At plaint at page 386. That page is missing, but it is a declaration suit. In fact, the trial court at Annexure D also may kindly see page 388 at para 6, my lords.
Correct. If that suit is only for declaration that they are the legal heirs.
If it is declared that the plaintiffs are the legal heirs, the land which has been granted.
So no, what are the reliefs sought for in the suit?
Suit is the declaration that one name shape, my lords, may kindly see para 6 of page 388.
Para?
6. Page 388. Prior to going to the facts of the case, it is necessary to say that the suit is not filed for relief subject to any scheduled property. It is true that the parties have claimed ownership over survey number 28, 185, 198, 113, 158, and 161 in the body of the plaint. The suit is very well crafted to ensure that the declaration as regards the land is not sought. If it is declared that the plaintiffs are the legal heirs of the original grantee, then the alienation made by...
issue emergent notice in addition so and so till the next date of hearing, further proceedings in the trial court is stayed. List on date.
20th January, serial number 71 urgent, serial number 72.
DP acknowledgement.
CP
CP Mahesh.
Petitioner. Defendant's petition, my lord, application seeking permission to file written statement. After the delay is 9 months, my lord, the trial court rejected the application and case is posted for arguments day before yesterday and today it is filed.
Evidence madidara?
Evidence they have led in view of the non-filing of written statement, my lord.
What
It
is
is
the suit
taken as
filed? What is the suit filed for?
suit for declaration, possession and means profit. I have filed the application along with
lord,
the
the-
written statement.
Any objection?
When the application was filed, my lord, the matter was posted for defense evidence. And the reasons, my lord.
Such a substantive relief you have sought for, right or wrong is not filed the written statement. Just cost ಹೇಳಿ ಅಷ್ಟು will impose it and close it.
I leave it to my lordship.
ಎಷ್ಟು? Where is the suit property? Kasba Hubli, Davangere district.
Petitioner is the institution, my lord, education institution running
ಎಷ್ಟು ಕೊಡ್ತೀರ?
5,000.
5,000 education institution.
They are in possession, my lord.
They are in
25,
10,000.
25,000. Petition is allowed.
My lordship, any
Impugned
time
order
frame.
set aside.
23.
Impugned order set aside, the application filed by the defendant, sole defendant
Sold
is allowed and the written statement filed madidira.
along with application.
And the written statement filed by the defendant is taken on record. Is ordered to be taken on record, subject to the defendant paying cost of rupees 25,000 to the plaintiff before the trial court on the next date of hearing. Yes.
My lord, expeditious disposal.
2023 in enta. Please,
Obliged.
don't be so greedy, Mr.
Obliged.
Kalyanar.
Appears for the petitioner. The petitioner has challenged, my lord, the charge sheet and the order of taking charge sheet.
ಏನಿದು?
My lord,
Yes, madam.
pursuant
This
to
is
the
yesterday's matter. Few days, 16th, Yes, madam.
The previous occasion, once for the petitioner was submitting that the other accused has been quashed, but he has not submitted.
not other accused, identical matter under identical
No,
matter.
you refer to
before-
some judgment passed by me.
My lord, your lordship had passed, my lord, judgment is that, my lord, with regard to this, the other accused, a petition filed under 482 came to be withdrawn.
No. You told on the last date that I have passed some order quashing the proceedings again.
Not by my lord, my lord. Coordinate bench in the identical matter where
Last
under
time, I
section.
think you pointed out to some order.
Yes, I have passed on the order sheet also, my lord. That matter is disposed, but the order copy is not yet released. There the order,
ಅದಲ್ಲ ಕಲ್ಯಾಣ್,
my lord, I have this,
ಯಾವ್ದೋ ಒಂದು order where I had passed.
my lord, lordship.
Correct ಅಲ್ವಾ?
Allah, this.
ಆಯ್ತು
this
ಹೇಳಿ
one,
ಏನು?
lord, is-
Yes, please argue.
My lord, the petitioner, challenge, my lord, the petitioner is accused number 13. My lord, the complaint is page number, my lord, 28. My lord, the incident which occurred on 29/5/2004, my lord, that an accident occurs, my lord, where the KSRTC bus meets with an accident, my lord, near Kunigal Circle. My lord, a case came to be registered, my lord, before the, my lord, Nelmangla police. The injured were taken to the Nelmangla government hospital. They were treated and subsequently, my lord, several injured persons filed claim petitions. Some of the claim petitions came to be allowed. Subsequently, on the basis of the internal, my lord, investigation, my lord, that is the preliminary investigation by the KSRTC, a complaint came to be lodged, my lord, at page number 28, that is on 4/5/2006.
Yes.
My lord, in this case, my lord, they have referred to several, my lord, motor vehicle act, the MVC cases which were filed before the MACT at Bangalore. And the allegation is that, my lord, some of the petitioner claimants who were not at all injured in the said accident have filed false claim petitions
ಆಯ್ತು.
on the basis of, my lord, created and fabricated.
Hmm.
Now, my lord, the question for consideration for my lords would be that, my lord, whether the allegations made would fall within section 195, my lord, of CRPC
195
in relation to a court proceedings. in relation to a court proceedings.
No, in relation to a court proceeding, ಹೆಂಗಾಗುತ್ತೆ ಇದು?
The allegations are that, my lord, on the basis of a fabricated documents, by giving false evidence before the court, judgments are obtained. Therefore,
Oh, this is MVC cases ಎಲ್ಲ ಡಿಸೈಡ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲ, MVC cases register ಆಗಿದೆ, they have referred the cases numbers also.
ಆಯ್ತು, ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ, ಬಟ್ ಡಿಸೈಡ್ ಆಗಿದೆಯಾ ಅಂದೆ.
Several cases are decided, and that's what the allegations made in the petition also. And also they say false evidence were given before the court. I would like to draw your lordship's attention to page number 43. My lord, the third para, it begins the word, the petitioners filed. My lord, third para. The petitioners filed false affidavit giving evidence in support of their claim before MACT, and also produced false medical, giving false evidence whether that would fall under 195, whether that requires the court to, my lord, to pass an order to register a case. My lord, for a moment, my lord, may I draw your honor's attention to my lordship attention to section 195.
ಕೊಡ್ರಿ. You are saying that there should be a complaint.
Complaint. In relation to 195, coordinate bench, my lord, where a discharge application was filed, against which a CR, my lord, revision was filed. Subsequently, a criminal petition and 482 was filed. By interpreting 195, that has been allowed. My lord, prosecution for contempt of lawful authority of public servants for offences against public justice and for offences relating to documents given in evidence. No court shall take cognizance of any offence punishable under section 172 to 188 of Indian Penal Code, of any abatement of or contempt, attempt to commit such offence, or of any criminal conspiracy to commit such offences, except on the complaint in writing of the public servant concerned of some other public servant to whom he is administratively subordinate.
Yes.
Of any offence punishable under any of the following sections of the Indian Penal Code, they could not be applicable. B1, B2, of any offences described in section 463 are punishable under section 471, section 475, or section 476 of the said code, when such offence is alleged to have been committed in respect of a document produced or given in evidence in a proceedings in any court. The allegation is that, my lord, those fabricated documents are used in producing before the court and giving false evidence.
But charge sheet is filed for what offence?
Charge sheet is filed, my lord, for the offence punishable under section, my lord, 465. My lord, 420, 465, 468, 471, 511, 120B.
ಆಗಿದೆಯಾ? ಅದು ತಗೊಂಡ್ರ ಅದು? ತಗೊಂಡ್ರ? ಸಿಗ್ನೇಚರ್ ಮಾಡಿಸ್ಕೊಂಡ್ರ? ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್ ಆಗಿದೆಯಾ? ಮಾಡಿಸ್ರಿ ಇದು. ಆಯ್ತು, ಇಲ್ಲಿ ಅವ್ರ ಲಾಯರ್ ಎಲ್ಲಿ ಹೋದ್ರು? ಮೇಡಮ್, ನೀವು ಸೈನ್ ಮಾಡಬೇಕು. ನೀವು ಸೈನ್ ಮಾಡಬೇಕು. Your sign? You put your name?
Yes.
RG ಹೇಳ್ರಿ. Order copy ಕಳ್ಸಿ ಇದನ್ನು.
Your lordship, even the petitioner sign is required. The sign that is it.
ಅವ್ರೇನ್ ಬೇಕಾಗಿತ್ತು? They are not, they have drawn the blood sample. Please seal it, ಮಾಡಿ, seal ಮಾಡಿ. ಇದನ್ನ ದಯವಿಟ್ಟು ಒಂದು ಇನ್ಫಾರ್ಮೇಶನ್ ತಕೊಳ್ಳಿ, ಎಷ್ಟು ದಿನ ಇಡ್ಬೋದು? ಆರ್ಡರ್ ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ. Yes.
My lord, the charge sheet is filed for the offence 420, 465, 468, 471, 511. The allegations are that, my lord, the created documents are utilized in obtaining the order from the court and giving false evidence.
Yes.
Therefore, my lord, under section 195.
No, why do you go under 195? 195 is if the court feels.
My lord, not feels. If allegation, if the complaint, my lord, if the incident occurred in giving, my lord, in relation to a court proceedings.
You take it after vacation.
My lord, after vacation, my lord, it's a special order case, it has to come before my lord.
fake own certificates for accused number one.
Anyway, it will come before me only. So let's list after.
But date may kindly be fixed.
ನನ್ ಮುಂದೆ ಮೂವ್ ಮಾಡಿ ನಾವು ಕಲಬುರಗಿಲಿ ಇರ್ತೀನಿ ಮೂವ್ ಮಾಡಿ VC ಮುಖಾಂತರ.
Lord, any Friday, please have.
Pursuant to the information forward to the medical supervisor, medical team of board also. And they on securing instruction submit that this is one of case where they are requested to drop at chance securing instruction. This court order to be drawn. The director of fix seal and signature on the blood sample, also fix the case number. To fix the blood sample that may be drawn. The medical superintendent board is director to preserve blood sample safely and ensure same is produced before the court whenever called upon. Shall solely be responsible for the safety and security of the blood sample and should not allow access to any third party unless orders are passed by this court. Else court put even. You hold one copy for the. Yes. Number 74. 74. Elizabeth Rodriguez.
Phone number 124.
Can we take it after vacation? After vacation. We'll take it after vacation.
One submission is there. With regard to RP 541 of 2022, the SLP is dismissed in limine without consideration of merit. It is not decided on merit.
We'll consider it, madam. We'll consider after vacation, list after vacation. All other cases, some other, Mr. Yenaitu, Raghavendra, Yenaitu, settlement in Aita?
We are for settlement. They did not appear before the mediator at all.
Appear for respondent, your lordships.
Yaar, other side, yaar. Ritvish.
Lordships appear for respondent.
Ritvish.
Lordships appear for respondent.
Yes, any settlement?
No, lordships, your lordships have already heard the matter. Your lordships may reserve it for orders, your lordship.
No, I will not reserve it. I am going to Dharwad, Kalburgi, so I will not reserve any matter.
It may be
Instead, on
treated
the
as.
last date that you people will consider settlement.
Please. Then it may be had after vacation, lordships.
After vacation, yes.
I'm grateful.
This is for further arguments.
Huh?
This is for further arguments, not for dictation.
Released from parted?
Yes,
List after for vacation.
Yes.
Adidu tane?
Yes, ma'am.
Final decree proceedings, sir. Belated.
Copy.
Interim order extend ಮಾಡ್ತೀಯ.
Serial number 979.
One matter, my lord, it was listed to the order to be listed today, it was not listed. I have moved the matter, the file has come, my lord. In that matter, Pawan Jowli appears for the petitioner. That matter, my lord, only request, my lord, is my submission was noted and he was granted a relief. The subject matter of this writ petition is an immovable property. That can be left aside. He said that movables have been attached, so I can't sell, I am not able to pay. So I said, I will permit them to inspect. Now that consent I may be permitted to withdraw, my lord. I may be permitted to bring the movables for sale.
Serial number 81.
I was requesting them from a long time, Your Honor. If that attachment has been waived off, then I'll sell the machineries and repay. As on I got the information.
How much more opportunity should be granted to you?
My client has told me on the opening day they
Don't even come with some money.
25 lakhs they are going to pay on the 6th of
25 lakhs is nothing against the outstanding 4 crores, huh?
2 crores 60 lakhs as of now.
As per the last date which I had filed my memo, Your Lordship, if the memo had been
25
considered,
lakhs.
let them.
My consent may be permitted to be withdrawn, Lord. I will. ಅಲ್ಲ ಅವ್ರು ಏನಿಲ್ಲ ಅವ್ರು ಹೇಳೋ ಅವ್ರಿಗೆ ಏನಂದ್ರೆ ಈ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಮೂವಬಲ್ಸ್ ತಂದ್ಬಿಟ್ಟಿದ್ದಾರೆ ಈಗ ಬಿಕಾಸ್ ಆಫ್ ಮೈ ಕನ್ಸೆಂಟ್ ಅಂಡ್ ಅವ್ರ ಪ್ರಾಬ್ಲಮ್ ಏನಂದ್ರೆ ದೇ ಆರ್ ನಾಟ್ ಗಿವಿಂಗ್ ಪೊಸಿಷನ್. There is a decree now for possession. ಅಪೀಲ್ ಹಾಕೊಂಡಿದ್ದಾರೆ 6 ತಿಂಗಳಿಂದ.
List on 6th, subject to the condition that the petitioner pays rupees 25 lakhs on 6th, failing which the court shall, failing which it will be open for the court to decide about continuation of the interim order.
8th, Your Honor, Your Lordship.
At the same time, movables are not involved in this petition. Movables
ಇವು ನೀವು 6ನೇ ತಾರೀಕು ನೀವೇನು ಮಾಡಕ್ ಆಗಲ್ಲ.
immovable property is in that.
ಮೂವಬಲ್ಸ್ ಆಗಲಿ, can you proceed against movables
ಇಲ್ಲ.
now?
ನಾನ್ ಹೇಳ್ಬಿಟ್ಟಿದ್ದೀನಿ ಅಂತ my client is
ಇಲ್ಲ, sir.
ನಾನ್ ಕೋರ್ಟ್ ಮುಂದೆ ಕನ್ಸೆಷನ್
ಆಯ್ತು. We can always recall it. 6ನೇ ತಾರೀಕು ದುಡ್ಡು ಕೊಡ್ತಾರೆ ಅಂತ ನೋಡ್. If they pay some 25 lakhs, let us see. ಆಮೇಲೆ ಬೇಕಾದ್ರೆ ಪರ್ಮಿಷನ್ ಮಾಡೋದು ಏನೋ ಕೊಡೋದು ಏನೋ ಮಾಡಕ್ ಆಗುತ್ತೆ.
Lordship, one more submission. Ali, CT scan machine, buyer has come. In another couple of days, he's going to take that machine and pay some amount. If that attachment is waived, I can buy.
I have serious
not-
objections.
we have-
Attachment will, it is not a question, subject matter.
Will not,
ಅಲ್ಲ ಅವ್ರು ನಿಧಾನಕ್ಕೆ ಹಂಗೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
They don't want
sir,
to
we
do the
will not,
attachment.
we will not budge an inch from this position. Whatever you want to do it within the permitted limits. Anything more, don't expect. ಇಲ್ಲ ದುಡ್ಡು ಕೊಟ್ಬಿಡಿ, 1 ಕೋಟಿ ಕೊಡಿ, ತಗೊಳ್ಳಿ, whatever reliefs you want.
I am,
So we are also trying.
I am mentioning
Condition, your lordship.
relating to serial number 81.
ಹಾ,
This matter was listed yesterday
ಹ್ಮ್,
and prior to that 4 or 5 times the matter has.
ಏನ್ ಮಾಡ್ತೀರಾ?
ನಾನು ಏನು ಹೇಳ್ತಾ ಇಲ್ಲ. ಯಾಕೆಂತಂದ್ರೆ the court is insisting for directing the document, disputed document to send to the handwriting expert. Suit for specific performance. I am the first defendant and who is also the sister-in-law of the plaintiff. There was no transaction at all and no payment. In fact, he says, I paid the entire amount of 9,50,000.
ಕುಮಾರ,
as-
KG ಕುಮಾರ, KG ಕುಮಾರ್,
81. KG Kumar for respondent.
ಏನ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ ಇಲ್ಲಿ? ಮತ್ತೆ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯ ಏನಕ್ಕೆ?
ಕೊಟ್ಟಿಲ್ಲ, ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಟ್ಟಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರವಾಗಿ ನಾನು ಕೇಳ್ತಾ ಇರೋದು. ಎಂಟ್ರಿ ಮಾಡಿ
ಅಗ್ರಿಮೆಂಟ್ ಡಿನೈ ಮಾಡಿದೀರಾ?
ಅಗ್ರಿಮೆಂಟ್ ಡಿನೈ ಮಾಡಿದೀನಿ. The
ಎವಿಡೆನ್ಸ್ ಆಗಿದ್ಯಾ?
evidence agi, then the matter was posted for argument. At that stage, application has been filed for appointment of a commissioner by the. It is only for the collection of the evidence on behalf of the plaintiff. There is no other reason because he has admitted, several admissions have come in the evidence in the cross-examination to the effect that on a particular date when the alleged agreement of sale is stated to have taken place, it was a second Saturday, but he says right from the beginning that I got the document executed in the presence of the sub-registrar's office, which was open and all that. So many things have come in evidence. Therefore only I am submitting before this honorable court, the order passed by the trial judge.
No, given to me, I am going to dismiss this petition, sir. Please take a chance after vacation. List of.
Serial number-
4, my lord. Serial number 4, my lord.
Uh,
I'm the JDA. They have
At
taken.
the end of the list, Allah Bakash.
Please, my lord, for the petitioner, my lord.
My lord,
In this
serial
matter,
number
my lord,
80,
last week, my lord, on 14th February, my lord,
Hmm.
defendant 1 to 6, my lord, are my vendors, my lord, selling, colluding with the plaintiffs, my lord, in the local, they have compromised the matter, my lord. In the suit for partition, I am the registered agreement holder, my lord. My agreement was under challenge, my
You
lord.
said you have a sale deed.
Registered agreement of sale,
When you moved in the morning, you said you have a sale deed.
my lord.
You said you had a sale
But
deed.
all the parties were not present or not parties to the
My
matter,
dear,
I said.
my dear friend, when you moved the petition at 2:30 today,
My lord,
you said you are the owner, you have a sale deed. The parties have entered into some kind of a collusive settlement
please, my
and
lord,
they have included
this-
your property.
my
So
property.
now you say it's an
Please,
agreement of sale
I am, my lord, I have
after
the,
vacation. Sorry.
my lord,
serial
Lord,
number.
my lord, the
Now,
agreement, my lord, the
Without
plaintiff
asking a
advocate, my
question,
lord,
without asking a question, we'll take it at 2:30.
my lord, plaintiff advocate, my lord, he himself has entered
Sorry.
into now agreement of sale, my lord. He himself
You
has entered
mention
into
ಮಾಡುವಾಗ
agreement,
correct ಆಗಿ ಹೇಳಿದ್ರೆ
lord,
we'll take it.
my lord,
Sorry, I'm sorry.
registered, he himself has entered
Sorry.
into registered agreement of sale, my lord.
Sorry.
Serial number 4.
Mr. ನೀವು
I apologize, my lord. I
Think that you
intend
are
to say, my
smart.
lord,
If
the
you think-
advocate who was
Mr. Tari,
representing, my lord, he himself has entered into registered agreement of sale with my,
if you think you are smart,
no, my
we
lord,
are smarter than you.
please, my lord, I apologize, my lord.
So therefore, don't be under the impression that you can pull a fast one.
Please, my
I'm sorry. Please take your chance after vacation.
For the
Lord, I
ಬೆಳಿಗ್ಗೆ move
apologize,
ಮಾಡೋದು
my-
ನನಗೆ ಮರ್ತೋಗ್ತೀನಿ.
I apologize,
ಅಲ್ಲ
my lord.
ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡೋದು ನಾ ಮರ್ತೋಗ್ತೀನಿ.
I apologize.
mister.
I intend to say, my lord, the,
Your intention could be
Agreement-
anything, but don't
Okay.
mislead the court.
my lord, please, my lord, I did,
Don't mislead the
Please, my-
court.
please, my lord.
Hmm.
The
Yes.
advocate, my lord, now he himself has entered into agreement of sale with the
Sorry,
property
mister.
which I
Sorry,
have.
mister.
Petitioner, my lord. I'm the JDA.
ಯಾರು?
Serial number 4, my lord.
See number 4.
My lord.
Lordship said disposed of a writ petition.
DHR already taken position. Yes. Symbolic position, my lord.
Not
Symbolic
position,
position, my lord.
ಆಯ್ತು ನೀವು ಮಾಡಿ ಹೇಳಿ ಸರ್, ನೀವು ಹೇಳಿ ಸರ್. ಸಿಂಬಾಲಿಕ್ ಪೊಸಿಷನ್ ತಗೊಂಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ನನ್ನ ಐಟಮ್ಸ್ ಎಲ್ಲ ಒಳಗಡೆ ಇದಾವೆ. ಐ ನೀಡ್ 6.5 to vacate the entire things.
6 months in symbolic position ಏನಿದೆ?
ಮನೆ ಮೂರ್ ಫ್ಲೋರ್ ಮನೆ ಕಟ್ಟಿದೀವಿ ಸರ್ ನಾವು. ಡಿಕ್ಲರೇಷನ್ ಹಾಕೊಂಡಿದ್ರು, ದೇ ಓನ್ ದಿ ಕೇಸ್ ಅಂಡ್ ಎವ್ರಿಥಿಂಗ್ ಇಸ್. ನಾ ಈಗ ಕೀನು ಕೊಟ್ಬಿಟ್ಟಿದ್ವಿ ಸರ್ 26/11/2024 ಕೀನು ಕೊಟ್ಬಿಟ್ಟಿದ್ವಿ. ಅಲ್ಲಿ ನಮ್ ಬಿಲಾಂಗ್ಸ್ ಎಲ್ಲ ಇದೆ. ಪಕ್ಕದ ಮನೆ ಕಟ್ತಾ ಇದೆ ಸ್ವಾಮಿ. ಕೀ ಕೊಟ್ಟಿಲ್ಲ. ಹಸುಗಳೆಲ್ಲ ಇದಾವೆ. ಬೇರೆ ಕಡೆ ಮನೆ ಸಿಗಲ್ಲ ಸರ್. ಹಸುಗಳು ಅವೇ ಅಲ್ಲ. ಅದಕ್ಕಾಗಿ ಎಲ್ಲ ಆಲ್ಟರ್ನೇಟಿವ್ ಶೆಲ್ಟರ್ ಮಾಡ್ಕೊಳ್ತಾ ಇದ್ದೀವಿ ಸರ್. ಐ ನೀಡ್ 6.5 ಮಾಡಿ ಅಷ್ಟೇ, ಬಿಟ್ಟು ಏನಿಲ್ಲ ಸರ್.
4 rounds of litigation, not 4 writ petitions. The last writ petition was disposed of by my lordships. And they filed a petition. They filed a memo on 29/11 last month.
Given undertaking that henceforth ಇನ್ನು ಮುಂದೆ ಈ ಕೇಸಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ, ಈ ಆಸ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಇಡೀ ಭಾರತ ದೇಶದಲ್ಲಿ ಎಲ್ಲೂ ನನ್ನ ಕೇಸ್ ಹಾಕಲ್ಲ ಅಂತ ಒಂದು ಅಂಡರ್ಟೇಕಿಂಗ್ ಕೊಡಿ.
Position has been taken over on 29/11.
ಆಗ್ಲಿ, ನಿಮ್ಮ ಅಪ್ಪ ಆಗ್ಲಿ, ನಿಮ್ಮ ಅಮ್ಮ ಆಗ್ಲಿ, ನಿಮ್ಮ ಮಕ್ಕಳು
today they have filed an application before the trial court saying that ಮನೇಲಿ ಚಿನ್ನ ಇದೆ, ಕಳ್ತನ ಆಗಿದೆ ಅಂತ. That the trial court is dismissed. Very cantankerous minutes.
ಇದೆಯಾ ಆ ತರ ಇದೆಯಾ?
No, this is last month's order minutes where they have said position
ಕಳ್ತನ ಆಗಿದೆ ಅಂತ ಕೊಟ್ಟಿದಾರಾ?
ಇವತ್ತು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ it has been dismissed.
This is application copy ಕೊಡಿ.
ನಮ್ ಚಿನ್ನ ಇದೆ, ಎಲ್ಲ ಚಿನ್ನ ಕಳ್ತನ ಆಗಿದೆ ಅಂತ ಹೇಳಿಲ್ಲ. ಯಾಕಂದ್ರೆ
ಇಲ್ಲ,
ತಗೊಂಡೋಗ್ರಿ ಸರ್.
ನೀವು ಆ ತರ ಹಾಕಿದ್ರೆ you will not entertain this. ತರ ಏನೋ ಹಾಕಿದ್ರೆ
ಇದೆ ಅಂತ ಹೇಳಿದಾರೆ. They have said that.
I don't know anything about that, but just from morning ಇಲ್ಲೇ ಇದೀನಿ ಸರ್. 6 months time ಕೊಟ್ರೆ ನಾನು ಎಲ್ಲ ವೇಕೇಟ್ ಮಾಡ್ಕೊಳ್ತೀನಿ because of execution. ದನ ಕರುಗಳೆಲ್ಲ ಇದೆ.
Let them move the vacation bench, but I shall tender my detailed objections if it is need. If there is so much of an hurry, let them move the vacation bench. They have served the writ petition on me today. 1 o'clock.
ಆಯ್ತು, ಏನ್ ಅಪ್ಲಿಕೇಶನ್? ಚಿನ್ನದ ಬಗ್ಗೆ ಏನ್ ಅಪ್ಲಿಕೇಶನ್?
ಚಿನ್ನ ಇದೆ ಮನೆಯಲ್ಲಿ, ಅದನ್ನ ಇದು ಕಳುವಾಗ್ಬಿಡುತ್ತೆ ಅಂತ ಹೇಳಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕುದು ಇವತ್ತು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಮುಂದೆ. ಪೊಸಿಷನ್ ಹ್ಯಾಸ್ ಬಿನ್ ಡೆಲಿವರ್ಡ್ ಅಂತ ಹೇಳಿ ಲಾಸ್ಟ್ November ನಾಟ್ ಸಿಂಬಾಲಿಕ್ ಪೊಸಿಷನ್, ಫಿಸಿಕಲ್ ಪೊಸಿಷನ್.
ನಾನು ಇಲ್ಲ ಅಂತ ಹೇಳಿದೆ ಸರ್.
ಯಾವತ್ತು ಖಾಲಿ ಮಾಡ್ತೀರಾ?
ಖಾಲಿ ಆಗೋಗಿದೆ.
6 months
ಇಲ್ಲಿ ಖಾಲಿ ಆಗೋಗಿದೆ. ಫೈಲ್
ಬಿಲಾಂಗ್ಸ್ ಎಲ್ಲ ಒಳಗಿದೆ ಸರ್.
This is the memo which they filed before your lordship.
ಬಿಲಾಂಗ್ಸ್ ಎಲ್ಲ ಒಳಗಿದಾವೆ.
ಯಾರು ಖಾಲಿ ಮಾಡಿದ್ದು?
ದನ ಕರುಗಳೆಲ್ಲ ಇದಾವೆ. ಅವ್ರನ್ನೆಲ್ಲ ನಾವು ಬೇರೆ ಕಡೆ ಕಟ್ಕೋಬೇಕು. ಐಟಮ್ ನಂಬರ್ 2 ದನ ಕರುಗಳಿದಾವೆ. ಅದು ಸರ್ 28/11/2024 ನಾವೊಂದು ಮೆಮೊ ಹಾಕಿದ್ವಿ ಸರ್. ಯಾಕಂದ್ರೆ ಅವರು ಔಟ್ ಆಫ್ ಕೋರ್ಟ್ ಸೆಟಲ್ಮೆಂಟ್ಗೆ ಎಲ್ಲ ಬಿಟ್ಕೊಟ್ಬಿಟ್ಟು.
ಗೌರಮ್ಮ ಅಂದ್ರೆ ಯಾರು? ಗೌರವ್ ನೀವೇನಾ? ನೀವೇ
ಒಪ್ಕೊಂಡಿದ್ದೀವಿ ಸ್ವಾಮಿ. ಯಾಕೆ ಅಂತ ಅವರು ಹೇಳಿದ್ರು ಮಾತುಕತೆಯಲ್ಲಿ, ನಿಮ್ ಬಿಟ್ಕೊಟ್ಬಿಡ್ತೀವಿ ಬೈ ವರ್ಡ್ಸ್ ಅಂತ ಹೇಳಿದ್ರು. ಅಗೇನ್ ಮತ್ತೆ ಅವ್ರು ಇಲ್ಲ ಅಂತದಕ್ಕೆ ನಾನು ಬಂದಿದ್ದೆ ಸ್ವಾಮಿ. ಅಷ್ಟೇ ಬಿಟ್ಟು ಬೇರೆ
you can't be blowing hot and cold.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದಕ್ಕೇನು ಇಲ್ಲ ಸ್ವಾಮಿ. 6 months time ಸ್ವಾಮಿ. ಯಾಕಂದ್ರೆ
petition is dismissed. Next.
Your lordship kindly ballad.
ಇದು ಒಂದು ಕಾಪಿ ಕೊಡಿ. ಇದು ಸುನಿಲ್.
Your lordship serial number 80, my lord, wherein the suit is filed by me for declaration and injunction.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿರಲ್ಲ?
ಅಲ್ಲ, ಒಂದು 2 ನಿಮಿಷಕ್ಕೆ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. ಒಂದ್ ನಿಮಿಷಕ್ಕೆ ಮುಗಿಸ್ಬಿಡ್ತು.
ಕಬ್ಬನ ಬುಡದವರೆಗೂ ತಿನ್ನಕ್ ಹೋಗ್ಬಾರ್ದು.
ಗೊತ್ತಾಯ್ತು.
ಬುಡದವರೆಗೂ ತಿನ್ನಕ್ ಹೋದ್ರೆ ಮಣ್ಣು ಸಿಗುತ್ತೆ.
ಅಲ್ಲ, 1 ನಿಮಿಷಕ್ಕೆ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ. ಎಂಟ್ರಿ ಮಾಡಿ ಟು ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
ಸ್ವಲ್ಪ ಇದಿಲ್ವಲ್ರಿ, ನೀವು ಕನಿಕರನೇ ಇಲ್ವಲ್ರಿ? 1.25 ಗಂಟೆ ಕೆಲಸ ಮಾಡಿದೀನಿ ಜಾಸ್ತಿ.
Serial number 79
number 65 ಅಲ್ಲಿ ಕಮಿಷನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಕಾಪಿ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ಐ ಹ್ಯಾವ್ ಟ್ರೇಸ್ಡ್ ಔಟ್. ತಾಲೂಕ್ ಸರ್ವೇಯರ್
serial number 79.
ತಾಲೂಕ್ ಸರ್ವೇಯರ್ ತೋಳಿ ಸರ್. ತಾಲೂಕ್ ಸರ್
ಅರ್ಜನ್ ಆಗಿದೆ, ಆಮೇಲೆ ಮಾಡಿ ಮೂವ್ ಮಾಡಿ.
serial number 79. Lordship, may I make on submission? Lordship, may I make on submission? Serial number 79.
Hey, let the judge have a vacation. Let the judge also.
ಹೇಳಿ, ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್?
79 sir.
79
sir, date could be sir.
70 after vacation.
Date could be sir.
Immediately after vacation.
ಇಷ್ಟಾಗಲ್ಲ hearing ಅಲ್ಲಿ ಇದೆ. Date could be sir. ದಯವಿಟ್ಟು.
ಸರ್ 7 ಅಲ್ಲ ಎಂಟ್ರಿ ಮಾಡ್ರ ಬರ್ಸ್ತೀನಿ.
ಸರ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಸರ್ ಅಲ್ಲಿ. serial number 79 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಸರ್.
ಮಂಜುನಾಥ್ ರೆಡ್ಡಿ ಸರ್ ಬನ್ನಿ. ಏನು ನಡೆಯಲ್ಲ, ಎಲ್ಲ ವೆಕೇಶನ್ ಆದ್ಮೇಲೆ.
ನಮ್ದು ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಕಂಟಿನ್ಯೂ ಮಾಡಪ್ಪ.
ಮಂಜುನಾಥ್ ರೆಡ್ಡಿ ಅವರು ಅಲ್ಲೇ ಇದಾರೆ, ವೆಕೇಶನ್ಗೂ ಅಲ್ಲೇ ಇರ್ತಾರೆ.
ಸರ್ serial number 17 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕು ಸರ್. ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
Sir, 77 ಅಲ್ಲಿ entry ಮಾಡ್ಬೇಕು. Entry ಮಾಡಿದ್ರೆ ಆಗುತ್ತೆ. Dictating orders ಅಂತ ಇದೆ. ಏನ್ reserved ಆ? Reserved ಆ ಅದು? Entry ಮಾಡಿದ್ರೆ ಆಗುತ್ತೆ.
Serial number 61. Bench officer.
ರಿಸರ್ವ್ ಆಗುತ್ತಾ ಇಲ್ಲ ಮತ್ತೆ ಅದಕ್ಕೆ ಬರುತ್ತವ ಇವ್ರಿಗೆ ಸಾಹೇಬ್ರಿಗೆ ಬರುತ್ತೆ.
Bench officer.
ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕಿತ್ತು ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಹೌದು ಸರ್ ನಿಮ್ಗೆ ಬೆಳಗ್ಗೆನೇ ಆಯ್ತು. ಹೇಳಿ ಸರ್. ಬೆಳಗ್ಗೆನೆ ಯಾರು ತಗೊಂಡ್ರು ಸರ್ ನಿಮ್ಗೆ ಹೇಳಿಲ್ವಾ?
61 ಇದಾ?
ಯಾವ್ದು ಸೀರಿಯಲ್ ನಂಬರ್?
61.
ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿಲ್ಲ
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 17 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಸರ್.
ಆಗಿರ್ತಾರೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್.
ಯಾರು ಇನ್ನೂ ಇಲ್ಲ
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 17 ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಸರ್.
ಸಬ್ಮಿಷನ್ ಮಾಡಿರೋದು.
ಸರ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ.
ಹಾ ಸರ್ ಸರ್ ಯಾವ್ದಾದ್ರು ವೆಕೇಶನ್ ಡೇಟ್
Serial number 61 ಏನಾಗಿದೆ?
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಸರ್ ಡೇಟ್ ಕೊಡಕ್ ಬರಲ್ಲ.
ಕೋರ್ಟ್ ಆಫೀಸರ್ 61 ಸೀರಿಯಲ್ ನಂಬರ್
ಹಾ
ಏನಾಗಿದೆ?
61 ಏನಾಗಿದೆ ಫೀಡ್ ಮಾಡಿದೀವಿ ನೋಡಿ ಎಂಟ್ರಿ ಮಾಡಿದೀವಿ.
ಎಂಟ್ರಿ ಮಾಡಿದ್ದೀರಾ?
ಹಾ